Acts of Rebellion. Ward Churchill. In memory of Leah Renee Kelly. February 19, 1970 to June 1, 2000. Lost love of my life. Foreword. I want my words to be as eloquent as the sound of a rattlesnake. I want my actions to be as direct as the strike of a rattlesnake. I want the results to be as conclusive as the bite of a beautiful red and black coral snake. Jimmy Durham. Columbus Day. Introduction. Acts of Rebellion. Notes on the interaction of history and justice. As ye sow, so shall ye reap. Galatians 6:7. On September 11, 2001, a date now and forever emblazoned in the shorthand of popular consciousness as a correlation to the emergency dialing sequence, 911, a quick but powerful series of assaults were carried out against the paramount symbols of U.S. global military/economic dominance, the Pentagon and the Twin Towers of New York's World Trade Center. About 1/5 of the former structure was left in ruins, the latter in a state of utter obliteration. Some 3,000 U.S. citizens were killed, along with 78 British nationals, come to do business in the WTC, and perhaps 300 other aliens, the majority of them undocumented, assigned to scrub the floors and wash the windows of Empire Point 1. In the immediate aftermath, while the identities of the attackers was still to some extent mysterious, a vast wail was emitted by the American body politic, asking in apparent bewilderment, who are they and why do they hate us? The answer came shortly, in the form of a videotaped and briefly televised statement by Osama bin Laden, expatriate Saudi head of Al-Qaeda, one of a plethora of terrorist organizations spawned by the CIA over the past half-century to carry out a broad range of dirty assignments for the United States. Point 3. Bin Laden's message was quite clear, for the attacks were carried out in response to blatant and ongoing U.S. violations of the laws of war, together with almost every aspect of international public and humanitarian law. The matter, as he pointed out, is of no mere academic concern. Over the past decade, well upwards of 500,000 Iraqi children and at least 1 million of their adult counterparts have died as the result of palpably criminal U.S. actions against their country. Point 5. United Nations officials have resigned in protest, denouncing what one of them, Assistant Secretary General Dennis Halliday, was widely quoted in the press describing as America's policy of deliberate genocide against the people of Iraq. Point 6. The accuracy of Halliday's and bin Laden's assessment of the situation was, moreover, bluntly corroborated on NBC's 60 Minutes by no less senior a U.S. spokesperson than UN Ambassador, and subsequent Secretary of State, Madeleine Albright. Point 7. Reaction among average Americans to revelations of the horror perpetrated in their name has been to all intents and purposes non-existent. Since it can hardly be argued that the public was uninformed about the genocide in Iraq, its lack of response can only be seen as devolving upon a condition of collective ignorance, that is, of having information but ignoring it because it is considered inconsequential, as profound as it must be intolerable to those whose children lie murdered en masse. How, under these conditions, are the victims to claim the attention necessary to impress upon their tormentors the fact that they, too, count for something, that they are of consequence, that in effect they will no longer accept the lot of being slaughtered, conveniently out of sight and mind or with impunity? It is all well and good to observe, as others have, that those who struck on 9/11 should instead have taken their case before the World Court. 9. Genocide is, without doubt, the worst of all crimes against humanity. In this instance, it has been effectively admitted, and the plaintiffs would thus undoubtedly have received a favorable ruling. These truisms uttered, however, a serious question must be posed: to what effect might the victims have pursued such an option? The U.S., its lofty rhetoric to the contrary notwithstanding, self-evidently disdains the rule of law. 10. It long ago repudiated notions that the venerable International Court of Justice holds the least authority over it. Point 11. The same pertains, and more so, to the newly established International Criminal Court. Point 12. Plainly, the U.S. is a rogue state which 13, like the Third Reich before it, imagines itself possessed of a sovereign right to operate in a manner unfettered by any but its own customs and conventions of comportment. 14. The ICJ might nonetheless have entered a ruling. And then? The issue would immediately become one of enforcement. 15. The means decreed in this regard by the United Nations Charter and numerous other international instruments are mostly constrained to imposing economic and/or diplomatic sanctions upon offenders. 16. It is assumed that such embargoes, pressed with sufficient vigor by the world community, will compel targeted states to correct their behavior. No provision is made, however, for dealing with violators like the U.S., which exercises not only an undeniable global economic suzerainty, but formal veto power over UN sanctions. 17. Other countries are thereby left in the position of having to elect between attempting to militarily enforce international law against the world's only remaining superpower or acquiescing in its ever-expanding pattern of gross illegalities. There is but one route out of this particular box. It traces the trajectory of an obligation inherent in the citizens of each country to do whatever is necessary to ensure that their government complies with the requirements of international law. 18. Enunciated as part of the post-war Nuremberg Doctrine with the Germans in mind, the principle applies no less to Americans. 19. Yet it is precisely the civic/human responsibility upon which Americans have defaulted so conspicuously in the aggregate of their willful ignorance concerning the ghastly toll exacted from Iraq. The question reverts thus to whether, under the conditions at hand, there might have been some more appropriate means by which the victims of U.S. aggression might have conveyed the consequences of their agony. Posing it may best be left to the moral cretins who, having done so much to foment the situation in the first place, now revile and seek to exterminate the messengers, demanding defense against the truth of their statement. 20. For the rest of us, the method of communication employed was what it was, a mere pinprick when measured against the carnage America so routinely inflicts on others, more akin to a wake-up call than anything else. In retrospect it will be seen that September 11, 2001, marked the point at which the U.S. was put on notice that business as usual would no longer prevail. If Americans wish ever again to be secure from the ravages of terrorism, their top priority must at long last become that of preventing their own government from instigating and participating in it. 21. If, in substance, they desire safety for their own children, they will first have to stop killing other people's babies. 22. While there remain tremendous disparities in the scales of lethality involved, a nonetheless unmistakable symmetry is embodied in these grim equations. Some might even call it justice, and from justice there can be no ultimate escape. This said, it must be admitted that there remains a considerable potency to the fantasy of a forum not unlike the Nuremberg trials in which America's international criminals would take their proper place in the defendant's dock. While the near-term prospect of any such scenario materializing is virtually nil absent the unlikely emergence of an alliance among secondary powers both capable and willing to literally pound the U.S. into submission, reveries of malignant toads like Henry Kissinger, Madeleine Albright, and Jesse Helms squatting in the shadow of the gallows are simply too pleasant to be suppressed. 23. This gives rise to more serious contemplation of how such worthy objectives might actually be attained over the longer run. Fortunately, there are possibilities in this regard. The trials precipitated by their total military defeat and occupation forced the Germans into an unprecedented form of self-reckoning. Compelled to face what Karl Jaspers termed the question of German guilt because of overwhelming courtroom evidence concerning their societal responsibility for the crimes of Nazism, they were left no viable alternative but to search for a coherent explanation of their behavior. 24. Eventually, the process led them to collectively embrace an internationalization of national history as an antidote to the collective, narcissistic self-exaltation enshrined in previous narratives of German identity. 25. In this manner, the duality of triumphalism and denial forming the Germans' mass psychology of fascism was gradually transformed into its antithesis. 26. By 1959, shortly after West Germany regained its autonomy, their psycho-intellectual denazification had evolved to such an extent that the Germans themselves could undertake the first of what by 1981 would total nearly 6,000 trials of Nazi criminals in their country's domestic courts. 27. Concomitantly, Although its record in this respect remains far from perfect, Germany has voluntarily paid, in fact, continues to pay billions of dollars in compensation to those it victimized during World War II. 28 Imposition of the death penalty has all along been constitutionally prohibited, as has, until very recently, the deployment for any purpose whatever of German troops abroad. One wonders whether the transformative process evident in post-war Germany might not yield similarly constructive results if undertaken through a reverse sequence in the contemporary United States. In theory, rather than international trials serving as the catalyst for a radical reinterpretation of national history, hence national character, a reconfigured history might serve to galvanize popular initiatives culminating in international trials. 29 A surmounting of America's well-nurtured public evasion of such unpleasantness is of course necessary, as it so obviously was in Germany, yet it seems possible that the means are already at hand. Taken together with the growing awareness that there are likely other, much heavier shoes ready to drop unless Americans show signs of getting their house in order, biochemical weapons. A nuclear device, 9.1. One may well have injected the essential element of self-interested incentive to change. 30. Thus must the country at last and in the fullest sense commence the task of coming face to face with the stark horrors of which its historical burden is comprised, not just what has been done to the Iraqis, but, as Ben Laden himself pointed out, to the Palestinians as well. 31 And, to be sure, there are others, the millions of Timorese 32, Guatemalans 33, Indonesians 34 and comparable victims of America's client regime since 1945, 35 the millions of Indochinese slaughtered by U.S. troops during the Vietnam era, 36 the untold numbers of Koreans massacred at places like No Gun Ri, 37 the million-odd Japanese civilians deliberately burned alive not just at Hiroshima and Nagasaki, but in the massive incendiary raids flown against Tokyo and other cities during World War II, 38 the hundreds of thousands of Filipinos butchered during the American conquest of their homeland at the dawn of the 20th century. 39. To this, still more must be added, the millions lost to the Middle Passage, shipped as livestock from Africa to fuel the rise of America's economy through their slavery, 40 the millions of their relatives worked to death as chattel labor, both before and since emancipation, 41 the thousands of blacks lynched during the Klan's century-long post-Reconstruction festival of violence, 42 the Chinese who stood not a Chinaman's chance of surviving their indenture while building America's railroads and sinking its deep shaft mines, 43 the Mexican migrant laborers dead of pesticides in California fields, 44 the 12 million or more third-world kids who perish each year of poverty-induced afflictions, their very subsistence siphoned into providing the cell phones and other paraphernalia now deemed all-important to the average American's quality of life. 45. These are but a few of the highlights. More accurately, the low points of the history American triumphalism has sought not only to silence, but to transmute into the opposite of itself. 46 Recasting the country's narrative self-conception in a form wherein such matters assume their proper place as defining ingredients would go far towards dispelling the illusion that the words innocent and American are synonymous. 47 From there, it should be possible to break down the intricate codes of understanding through which average Americans have come to see themselves, both individually and collectively, as being somehow entitled to possess, control, and/or consume that which belongs to others. 48 On this basis, it would at least be arguable that the U.S. polity had intellectually equipped itself to participate as responsible citizens within the world community it now purports to lead. 49. In search of a method. The question arises of how best to approach the mass of information upon which any radical interpretation of the American experiment must proceed. 50 The sheer volume of what has been shunted aside in canonical recountings threatens to overpower the most intrepid of counter-narratives, dissolving into a fine mist of contrarian detail. How then to give shape to the whole, ordering and arranging its contents in ways that explicate rather than equivocating or obscuring their implications, making the conclusions to be drawn not just obvious but unavoidable? How, in other words, to forge an historical understanding which in itself amounts to an open demand for the sorts of popular action precipitating constructive social change. 51. There are several methodological contenders in this connection, beginning with Howard Zinn's commendable effort in A People's History of the United States to more or less straightforwardly rewrite Samuel Eliot Morrison's Oxford History of the American People in reverse polarity, ephegizing rather than celebrating the status quo. 52 Historical Materialism, 53 Functionalism, 54 Structuralism, 55 Hermeneutics, 56 and even some of the less tedious variants of postmodernism offer themselves as alternatives. 57 So, too, do subgenres of postcolonialism like subaltern studies. 58 Each of these visions of history, at least in some of their aspects, are of utility to the development of a bona fide U.S. historical praxis. 59 At face value, however, none are able to avoid the fate of either descending into a state of hopeless atomization 60 or, alternately, overreaching themselves to the point of producing one or another form of reductionist meta-historical construction. 61 Perhaps the surest route to avoiding these mirrored pitfalls will be found in the Nietzschean method of historical genealogy evolved by Michel Foucault in works such as The Archaeology of Knowledge. 62 This is a highly politicized endeavor in which the analyst, responding to circumstances he finds objectionable in the present, traces its lineage back in time until a fundamental difference is discerned. Having thus situated the source of the problem in its emergence from a moment of historical transition, the analyst can proceed to retrace the unfolding of the specific history at issue forward in time, with an eye toward what would need to be undone and how if the future is to be rendered more palatable than the current state of affairs. In this, whatever set of circumstances prevailed prior to the discontinuity is mined for its potentially corrective features. 63 Instead of condemning the barbarism of pre-modern society, its inhumanity, injustice, and irrationality, Foucault presents the difference of the pre-modern system by demonstrating that, on its own terms, it makes sense and is coherent. The reason for doing so, let it be noted, is not to present a revised picture of the past, nostalgically to glorify charms, but underline the transitory nature of the present system and therefore remove the pretense of legitimacy it holds by dint of a naive, rationalist contrast with the past. 64 Although firmly grounded in Nietzsche, Foucault's model also incorporates a post-structuralist strategy of detotalization oriented to the particularity of the phenomena studied, and a structuralist strategy oriented to remove the analysis from the register of subjectivist humanism. 65 To this might be added occasional forays into a strategy of immanent critique in which the contemporary order is held strictly accountable to the standards and ideals it typically claims as being descriptive of its own composition and character. 66 Overall, the object is to reveal in all their squalor the pretensions of modern mores and institutions, undermining the naturalness in which they seek to cloak themselves, and to make explicit thereby both the necessity and tangible possibility of their being dismantled or transcended. 67 This book follows Foucauldian procedure. In the U.S., irrespective of which among the earlier sketched Grote's queries is emphasized, be it America's voracious greed and genocidal disregard for the well-being of others, the concomitants of militarism and virulent racism, or the weird psychic stew in which imperial/racial arrogance has been blended in equal part with the most sanctimonious professions of peaceful innocence, its lineage traces to precisely the same source, the invasion of native North America by Europeans during the 16th and 17th centuries. 68 Absent that profound and violently imposed rupture in historical continuity, nothing else that is objectionable in American history, slavery, for instance, or in contemporary American life, globalization, to name a salient example, would have been materially possible. The relationship between Euro-Americans and American Indians is therefore the most fundamental of any on the continent. It is the bedrock upon which all else is built, the wellspring from whence all else flows. 69 Hence, in tracing the course and temper of Indian-white relations, a considerable light is shed upon the relationship of the U.S. mainstream population and virtually every other people it has encountered over the past 2¼ centuries, both domestically and abroad. It might indeed be argued that Euro-America's attitude towards and treatment of the peoples indigenous to the homeland it has seized for itself has been in many respects definitive of those it has accorded all others, including not least and in some cases increasingly certain sectors of its own nominal racial/ethnic constituency. 70 The post-invasion history of Native America thus provides the lens through which all of American history must be examined if it is to be in any sense genuinely understood. To put it more personally, it is essential, if one is to truly appreciate the implications of one's own place in American society, that one read them in terms of U.S./Indian relations. 71. It follows that correction of the socio-economic, political, and other repugnancies marking modern American life is, in the final analysis, entirely contingent upon rectification of non-Indian America's abecedarian relationship to American Indians. Here, history provides the agenda concerning what must be done. So long as native North America remains internally colonized, subject to racial codes, unindemnified for the genocide and massive expropriations we've suffered and continue to suffer, genocide, colonialism, racism, and wholesale theft will remain the signal attributes of American mentality and behavior. 72 Insofar as this is so, the U.S. will undoubtedly continue to comport itself in the world as it has in the past. And this, in turn, will inevitably result in responses far more substantial than that made on 9/1/1. Acts of rebellion. Plainly, there are choices to be made. Arriving at the right choices, however, depends to a considerable extent upon being able to see things clearly. Acts of rebellion, then, although it is a reader, and therefore by both intent and design far from comprehensive, is meant to facilitate the attainment of the insights requisite to deciding where one stands on many of the core issues confronting American Indians. Call it, if you will, an exercise in values clarification. In any event, I flatter myself to think that one cannot read it and, without entering into active falsehood, afterwards claim not to know what has been/is being done to native North America. Knowledge, of course, associated as it is with power, demands action. To possess knowledge and ignore its demands is to nullify claims of innocence. Ignorance, in effect, equates to complicity, a variety of guilt. 73. Since the book is a reader, it seeks to accomplish a number of things. Not only does it cover a fairly broad range of discrete but related topics, for instance, but it does so by employing a variety of styles. The majority of the essays the law stood squarely on its head, the nullification of Native America, and a breach of trust, for example, are formal, at least in the sense that they were originally prepared for publication in academic journals and rely upon extensive annotation. Others, such as False Promises and The New Face of Liberation, have been developed from the transcripts of lectures delivered at various universities. Let's Spread the Fun Around was written as an op-ed piece. 74 While Confronting Columbus Day was originally prepared as a legal brief. One object of this eclectic arrangement is to demonstrate that in writing, which may in itself be viewed as a mode of activism, 75, it is unnecessary to pull one's punches, regardless of the venue in which one seeks to publish. A word on annotation is in order. Mine is almost always extensive, sometimes notoriously so. There are reasons for this that go well beyond the scholarly imperative of demonstrating command of the literature bearing upon whatever topic I may be writing. Many of my notes amplify points raised in my texts, offering caveats or digressions that would, if incorporated into the body of the essay itself, disrupt its flow. The notes thus serve in a literal sense as a conscious and deliberate subtext, and should be approached as such. Still, the citations appearing in my notes are quite extensive, and this is because I want no reader to have to simply take my word for anything I say. Anyone wishing to know more than I observe about anything I mention, or apprehend the concrete basis upon which I've said what I've said, is empowered by my citations to examine things for themselves without necessarily having to do 30 years of intensive research in the process and appreciate for themselves how I've connected the dots. Acts of Rebellion is divided into 4 sections. The first, which concerns the application of European/Euro-American legality to North America's indigenous peoples, is designed to debunk the smug lie that the U.S. is or ever has been a nation of laws, not men. 76 Particularly in the law stood squarely on its head, great care is taken to demonstrate exactly how both the law of nations and the constitutional requirements of U.S. domestic law itself have been cynically and consistently subverted by American jurists almost from the inception of the Republic, always for purposes of political/military dominance and material gain. The law has always been used as toilet paper by the status quo where American Indians are concerned, a circumstance to be heeded by anyone naive enough to believe or duplicitous enough to argue without really believing that the problems we face can somehow be resolved through recourse to the sort of due process available to us in the courts of our colonizers. The lesson should be taken especially to heart by other outgroups in American life, all of whom are subject to at least some of the illegitimate juridical principles articulated by the U.S. judiciary vis-a-vis the continent's native inhabitants. 77. The second essay, The Nullification of Native America, explores a specific example of how legalistic rationalizations have lately been employed to subvert the most intimate aspect of native self-determination, the question of identity. The third and final essay of the first section, Confronting Columbus Day, examines, again in a very specific way, the manner in which the tenets of U.S. jurisprudence and statutory legality conflict with the requirements of international law. The latter argument in particular, in that it was successfully employed by the defense in an actual criminal proceeding, can be mined for its utility to others in similar situations. As should have become apparent in reading the first section, if it wasn't already, a purportedly strict adherence to legality has been absolutely central to the false image of itself America has persistently projected to the world. Hence, law serves as an ideal medium by which to perform imminent critique. 78 The reader will find it regularly deployed for this purpose not only in the or to what extent the realities of American comportment differ from its enunciated self-description. 78 The reader will find it regularly deployed for this purpose not only in the opening section, but throughout the remainder of the book. This is especially true in the second section, wherein The Earth is Our Mother investigates the historical process by which Native North Americans were/are dispossessed of some 98% of our property. A Breach of Trust examines America's internal colonial structure in the specific connection of uranium mining, and like Sand in the Wind discusses the creation of an American Indian diaspora in North America. The final essay in the sequence, The Bloody Wake of Alcatraz, details the gruesome counterinsurgency campaign mounted by the Federal Bureau of Investigation and collaborating military and police agencies during the mid-1970s against the American Indian movement on and around the Pine Ridge Reservation in South Dakota. Since many of the techniques employed by the FBI against AIM were patently illegal, even in terms of U.S. law, and because the entire operation was undertaken to prevent AIM from asserting rights held by Native people under a host of treaties, covenants, and conventions, the gulf separating America's often flowery verbiage on law enforcement from the sordid realities of its practice in this regard have seldom revealed themselves in bolder relief. The distinctions will, however, be readily appreciated by similarly targeted dissident groups ranging from the United Negro Improvement Association to the Black Panther Party. 79 and should be studied closely by all who set upon the task of forging a positive future. The third section is devoted to examining the instrumentalities of popular culture through which the settler society has sought to disguise the conditions it has imposed upon Native people, vigorously denying the reality even to itself, meanwhile degrading its indigenous victims in an ever more ubiquitous and refined fashion. The centerpiece of this ugly endeavor has been cinema movies, as is discussed in Fantasies of the Master Race. Film is by no means the sole offender, however, as is brought out in Let's Spread the Fun Around, which deals with the issue of sports team mascots, and Indians Are Us, which takes up the matter of the men's movement and the question of New Age sensibilities more generally. The moral of the story, so to speak, is that words and images do hurt, as is witnessed by the fact that Nazi propagandist Julius Streicher was tried at Nuremberg 80 convicted of crimes against humanity, and executed for having engaged in derogations of Jews no worse than those to which American Indians are routinely subjected. That criminal activities of the sort engaged in by Stryker are protected under the rubric of U.S. domestic law is a circumstance imbued with negative implications for any group suffering the psychic ravages of Euro-America's customary racist discourse. 81. To conclude, 3 essays are offered which explore in various ways the kinds of action and alternatives pointed to in the preceding 3 sections. False Promises endeavors to explain in capsule form exactly how and why Marxism is an unsatisfactory paradigm for the attainment of native rights. The New Face of Liberation explores the indigenist alternative from yet another angle, finding more common ground with anarchism than any other European praxis. The sections and the book's last essay, I Am Indigenist, concerns itself with explaining what the consummation of the indigenist agenda in the U.S. portion of North America might look like, and why no other progressive program can succeed unless something of the sort actually occurs. A message on priorities is obviously embedded therein. As I said, Acts of Rebellion is far from comprehensive. It should, nonetheless, provide sufficient stimulation to set at least some readers on what I see as the right track, empowering them to make contributions of their own. If so, it will have accomplished its purpose. No more can be asked by an author of any book than that it be put to such use. Part I. In matters of law. Although the United States did not have to exercise great legal imagination in incorporating within its boundaries, it made a great effort to do so. From the recognition of the treaty system as the most appropriate method of legal dealings with, to the early 19th century Cherokee cases that gave the legal system meaning, to the plenary power decisions that ended the century and the notion of tribal sovereignty, U.S. law helped structure not only U.S. Indian policy but also Indian-white relations. Law was used to perpetrate murder and land frauds of all sorts, and the legal rights of American Indians were ignored by state and federal courts. The product of this great concern with the legality of 19th-century federal Indian policy was genocide. More than 90% of all Indians died, and most native land was alienated, the balance occupied by Indians owned by the United States. Indian people were under the control of Indian agents, political hacks sent out from Washington to manage the lives of native people and backed by the Army. Sidney L. Herring. Crow Dogs Case. 1. The law stood squarely on its head. U.S. doctrine, indigenous self-determination, and the question of world order. There's no precedent in law for the way American jurists, beginning with Chief Justice of the Supreme Court John Marshall, have elected to assert their country's right to own territories in which the peoples native to this continent had resided since time immemorial. Marshall himself quite simply invented the legal principles upon which he based his doctrine of settler dominion, in the process standing a large portion of existing international law squarely on its head, and his successors have continued to treat these distortions as gospel right up to the present moment. Glenn T. Morris, 1990. As anyone who has ever debated or negotiated with U.S. officials on matters concerning American Indian land rights can attest, the federal government's first position is invariably that its title to authority over its territoriality was acquired incrementally, mostly through provisions of cession contained in some 400 treaties with Indians ratified by the Senate between 1778 and 1871.1, when it is pointed out that the U.S. has violated the terms of every one of the treaties at issue, thus voiding whatever title might otherwise have accrued therefrom. There are usually a few moments of thundering silence. 2. The official position, publicly framed by perennial federal Indian expert Leonard Garment as recently as 1999, is then shifted onto different grounds. If you don't accept the treaties as valid, we'll have to fall back on the doctrine of discovery and rights of conquest. 3. This rejoinder, to all appearances, is meant to be crushing, forestalling further discussion of a topic so obviously inconvenient to the status quo. While the idea that the U.S. obtained title to its domestic sphere by discovery and conquest has come to hold immense currency among North America's settler population, one finds that the international legal doctrines from which such notions derive are all but unknown, even among those holding degrees in law, history, or political philosophy. The small cotter of arguable exceptions to the rule have for the most part not bothered to become acquainted with the relevant doctrines in their original or customary formulations, instead contenting themselves with reviewing the belated and often transparently self-serving interpretations produced by 19th-century American jurists, most notably those of John Marshall, third Chief Justice of the Supreme Court. 4 Overall, there seems not the least desire or sense of obligation to explore the matter further. The situation is altogether curious, given Marshall's own bedrock enunciation of America's self-concept, the hallowed proposition that the U.S. should be viewed above all else as a nation governed by laws, not man. 5 Knowledge of/compliance with the law is presupposed, of course, in any such construction of national image. This is especially true with respect to laws which, like those pertaining to discovery and conquest, form the core of America's oft and loudly proclaimed contention that its acquisition and consolidation of a transcontinental domain has all along been right, just, and therefore legal. 6 Indeed, there can be no questions of law more basic than those of the integrity of the process by which the United States has asserted title to its land base and thereby claims jurisdiction over it. The present essay addresses these questions, examining U.S. performance and the juridical logic attending it through the lens of contemporaneous international legal custom and convention, and drawing conclusions accordingly. The final section explores the conceptual and material conditions requisite to a reconciliation of rhetoric and reality within the paradigm of explicitly American legal understandings. It should be noted, however, that insofar as so much of this devolves upon international law, and with the recent emergence of the U.S. as the world's only remaining superpower, 7 The implications are not so much national as global. The doctrine of discovery. Although there are precursors dating back a further 200 years, the concepts which were eventually systematized as discovery doctrine for the most part originated in a series of bulls promulgated by Pope Innocent IV during the late 13th century to elucidate material relations between Christian crusaders and Islamic infidels. 8 While the pontiff's primary objective was to establish a legal framework compelling soldiers of the cross to deliver the fruits of their pillage abroad to such beneficiaries as the Vatican and church-sanctioned heads of Europe's incipient states, the Innocentian bulls embodied the first formal acknowledgement in Western law that rights of property ownership were enjoyed by non-Christians as well as Christians. In justice, then, it followed that only those ordained to rule by a divine right conferred by the one true God were imbued with the prerogative to rightly dispossess lesser mortals of their lands and other worldly holdings. 9. The law remained as it was until 1492, when the Columbian discovery of what proved to be an entire hemisphere, very much populated but of which most Europeans had been unaware, sparked a renewed focus upon questions of whether and to what extent Christian sovereigns might declare proprietary interest in the assets of others. 10 Actually, the first problem was whether the inhabitants of the New World were endowed with souls, the criterion of humanity necessary for us to be accorded any legal standing at all. This issue led to the famous 1550 debate in Valladolid between Fray Bartolomé de las Casas and Juan Ginés de Sepúlveda, the outcome of which was papal recognition that American Indians were human beings and therefore entitled to exercise at least rudimentary rights. 11. As a corollary to the Valladolid proceedings, Spanish legal theorists such as Franciscus de Vitoria and Juan Matías de Paz were busily revising and expanding upon Innocent's canonical foundation as a means of delineating the property rights vested in those discovered by Christian powers as well as those presumably obtained in the process by their discoverers. 12 In the first instance, Vitoria in particular posited the principle that sovereigns acquired outright title to lands discovered by their subjects only when the territory involved was found to be literally unoccupied. 13 Since almost none of the land European explorers ever came across genuinely met this description, the premise of territorium residential nullius as it was called, was essentially moot from the outset. In places found to be inhabited, it was unequivocally acknowledged in law that native residents held inherent or aboriginal title to the land. 14 What the discoverer obtained was a monopolistic right vis-a-vis other powers to acquire the property from its native owners, in the event they could be persuaded through peaceful means to alienate it. On balance, The formulation seems to have been devised more than anything as an attempt to order the relations between the European states in such a way as to prevent them from shredding one another in a mad scramble to glean the lion's share of the wealth all of them expected to flow from the Americas. 15. Under the right of discovery, the first European nation to discover American lands previously unknown to Europe had what is similar to an exclusive European franchise to negotiate for Indian land within the discovered. International law forbade European nations from interfering with the diplomatic affairs each carried on with the Indian nations within their respective discovered territories. The doctrine thus reduced friction and the possibility of warfare between the competing European nations. 16. That this principle was well developed in international law and understood perfectly by America's founding fathers is confirmed in an observation by no less luminous a figure than Thomas Jefferson. We consider it as established by the usage of different nations into a kind of jus gentium for America, that a white nation settling down and declaring such and such are their limits, makes an invasion of those limits by any other white nation an act of war, but gives no right of soil against the native possessors. That is to say, the sole and exclusive right of purchasing land from whenever they should be willing to sell. 17. The requirement that the consent of indigenous peoples was needed to legitimate cessions of their land was what prompted European states to begin entering into treaties with the natives soon after the invasion of North America had commenced in earnest. 18. While thus comprising the fundamental real estate documents through which the disposition of land title on the continent must be assessed, treaties between European and indigenous nations also served to convey formal recognition by each party that the other was its equal in terms of legal stature. 19. To quote Jefferson again, the Indians full, undivided, and independent sovereignty as long as they choose to keep it, and, this might be forever. 20. Or, as U.S. Attorney General William Wirt would put it in 1828. Once conceded, that the Indians are independent to the purpose of treating, their independence is to that purpose as absolute as any other nation. Nor can it be conceded that their independence as a nation is a limited independence. Like all other nations, they have the absolute power of war and peace. Like any other nation, their territories are inviolable by any other sovereignty. They are entirely self-governed, self-directed. They treat, or refuse to treat, at their pleasure, and there is no human power that can rightly control their discretion in this respect. 21. From early on, the English had sought to create a loophole by which to exempt themselves in certain instances from the necessity of securing land title by treaty, and to undermine the discovery rights of France, whose New World settlement patterns were vastly different from those of England. 22. Termed the Norman yoke, the theory was that an individual or an entire people could rightly claim only such property as they'd converted from wilderness to a state of domestication. 23. Without regard for indigenous methods of land use, it was declared that any area found to be in an undeveloped condition could be declared terra nullius by its discoverer and clear title thus claimed. 24. By extension, any discovering power such as France which failed to pursue development of the sort evident in the English colonial model forfeited its discovery rights accordingly. 25. The Puritans of Plymouth Plantation and Massachusetts Bay Colony experimented with the idea during the early 17th century, arguing that while native property rights might well be vested in their towns and fields, the remainder of their territory, since it was uncultivated, should be considered unoccupied and thus unowned, but the precedent never evolved into a more generalized English practice. 26. Indeed, the Puritans themselves abandoned such presumption in 1629.27. Whatever theoretical disagreements existed concerning the nature of the respective ownership rights of Indians and Europeans to land in America, practical realities shaped legal relations between the Indians and colonists. The necessity of getting along with powerful Indian, who outnumbered the European settlers for several decades, dictated that as a matter of prudence, the settlers buy lands that the Indians were willing to sell, rather than displace them by other methods. The result was that the English and Dutch colonial governments obtained most of their lands by purchase. For all practical purposes, the Indians were treated as sovereigns possessing full ownership of the lands of America. 28. So true was this that by 1750 England had dispatched a de facto ambassador to conduct regularized diplomatic relations with the Haudenosaunee 29 and, in 1763, in an effort to quell native unrest precipitated by his subjects' encroachments upon unceded lands, King George III issued a proclamation prohibiting English settlement west of the Allegheny Mountains. 30 This foreclosure of the speculative interests in western lands held by George Washington and other members of the settler elite and the less grandiose aspirations to landed status of rank-and-file colonials would prove a major cause of the American War of Independence. 31 Although it is popularly believed in the U.S. that the 1783 Treaty of Paris, through which England admitted defeat, also conveyed title to all lands east of the Mississippi River to the victorious insurgents, the reality was rather different. England merely quit-claimed its interest in the territory at issue. All the newly established American Republic thus acquired was title to such property as England actually owned, the area of the original 13 colonies situated east of the 1763 demarcation line, plus an exclusive right to acquire such property as native owners might be convinced to cede by treaty as far westward as the Mississippi. 32 The same principle pertained to the subsequent territorial acquisitions from European or Euroderivative countries, the 1803 Louisiana Purchase and the 1848 impoundment of the northern half of Mexico through the Treaty of Guadalupe Hidalgo, to cite two prominent examples through which the present territoriality of the 48 contiguous states was eventually consolidated. 33 As a concomitant to independence, moreover, the Continental Congress found itself presiding over a pariah state, defiance, much less forcible revocation of crown authority, being among the worst offenses imaginable under European law. Unable to obtain recognition of its legitimacy in other quarters. 34 The federal government was compelled for nearly 2 decades to seek it through treaties of peace and friendship with indigenous nations along its western frontier, all of them recognized as sovereigns in prior treaties with the very European powers then shunning the U.S., meanwhile going to extravagant rhetorical lengths to demonstrate that, far from being an outlaw state, it was really the most legally oriented of all nations. 35 The fledgling country could hardly peddle a strictly law-abiding image while openly trampling upon the rights of indigenous peoples. As a result, although George Washington had secretly and successfully recommended the opposite policy even before being sworn in as President, 36 one of the earliest acts of Congress was to pass the Northwest Ordinance, in which it solemnly pledged that the utmost good faith shall always be observed towards the Indians, their lands and property shall never be taken without their consent, and, in their property, rights, and liberty, they shall never be invaded or disturbed. 37 For the most part, then, it was not until the U.S. had firmed up its diplomatic ties with France, and the demographic/military balance in the West had begun to shift decisively in its favor, 38, that it started to make serious inroads on native lands. The Marshall Opinions. The preliminary legal pretext for U.S. expansionism, set forth by John Marshall in his 1810 Fletcher v. Peck Opinion 39, amounted to little more than a recitation of the Norman yoke theory, quite popular at the time with Jefferson and other American leaders. 40 The proposition that significant portions of Indian country amounted to terra nullius, and was thus open to assertion of U.S. title without native agreement, was, however, contradicted by the country's policy of securing by treaty at least an appearance of indigenous consent to the relinquishment of each parcel brought under federal jurisdiction. 41 The presumption of underlying native land title lodged in the doctrine of discovery thus remained the most vexing barrier to America's fulfillment of its territorial ambitions. In the 1823 Johnson v. McIntosh case, Marshall therefore undertook a major interpretation of the doctrine itself. 42 While demonstrating a thorough mastery of the law as it had been previously articulated, and an undeniable ability to draw all the appropriate conclusions therefrom, the Chief Justice nonetheless managed to invert it completely. Although he readily conceded that title to the territories they occupied was vested in indigenous peoples, Marshall denied that this afforded them supremacy within their respective domains. Rather, he argued, the self-assigned authority of discoverers to constrain alienation of discovered lands implied that prepotency inherent in the discovering power, not only with respect to other potential buyers but vis-a-vis the native owners themselves. 43. Since the sovereignty of discoverers or derivatives like the U.S. could in this sense be said to overarch that of those discovered, Marshall held that discovery also conveyed to the discoverer an absolute title or eminent domain underlying the aboriginal title possessed by indigenous peoples. The native right of possession was thereby reduced at the stroke of a pen to something enjoyed at the sufferance of the discovering sovereign. 44. The principle was, that discovery gave title to the government by whose subjects, or by whose authority, it was made, against all other European governments whose title might be consummated by possession. The exclusion of all other Europeans necessarily gave to the nation making the discovery the sole right of acquiring the soil from the natives, and establishing settlements upon it. In the establishment of these relations, the rights of the original inhabitants were, in no instance, entirely disregarded, but were, to a considerable extent, diminished. Their rights to complete sovereignty, as independent nations, were necessarily diminished, and their power to dispose of the soil, at their own will, to whomever they pleased, was denied by the original fundamental principle. The discovery gave exclusive right to those who made it. The Indian inhabitants are to be considered merely as occupants. 45. However extravagant might appear, Marshall summed up, if the principle has been asserted in the first instance, and afterwards, sustained, if a country has been acquired and held under it, if the property of the great mass of the community originates in it, it cannot be questioned. 46. In other words, violations of law themselves become law if committed by those wielding enough power to get away with them. For all the elegant sophistry embodied in its articulation, then, the Johnson v. Mackintosh opinion reduces to the gutter cliché that might makes right. In this manner, Marshall not only integrated the legacy of 1,000 years of European racism and colonialism directed against non-Western peoples into the canon of American law, but did so with a virulence unrivaled even by European jurists upon whose precedents he professed to base his own. 47. There were of course loose ends to be tied up, and these Marshall addressed through opinions rendered in the Cherokee cases, Cherokee v. Georgia and Worcester v. Georgia. 48. In his Cherokee opinion, the Chief Justice undertook to resolve questions concerning the precise standing to be accorded indigenous peoples. Since the U.S. had entered into numerous treaties with them, it was bound by both customary international law and Article 110 of its own constitution to treat them as co-equal sovereigns. Marshall's verbiage in Mackintosh had plainly cast them in a very different light. Hence, in Cherokee, he conjured a whole new classification of politico-legal entity marked by peculiar and cardinal distinctions which nowhere else exist. 49. It may well be doubted whether those tribes which reside within the acknowledged boundaries of the United States can, with strict accuracy, be denominated foreign nations. They may, more correctly, perhaps, be denominated domestic dependent nations. They occupy a territory to which we assert a title independent of their will. Their relation to the United States resembles that of a ward to his guardian. 50. The Indian Territory is admitted to compose a part of the United States, he continued. In all our maps, geographical treatises, histories, and laws, it is so considered. They are considered to be within the jurisdictional limits of the United States, acknowledge themselves to be under the protection of the United States. 51. What Marshall had described was a status virtually identical to that of a protectorate, yet as he himself would observe in Worcester a year later, the settled doctrine of the law of nations is that a weaker power does not surrender its independence, its right of self-government, by associating with a stronger, and taking its protection. A weak state, in order to provide for its safety, may place itself under the protection of one more powerful, without stripping itself of the right of government, and ceasing to be a state. 52. It follows that a protectorate would also retain its land rights, unimpaired by its relationship with a stronger country. 53. At another level, the Chief Justice was describing a status similar to that of the states of the Union. Yet he, better than most, was aware that if this were so, the federal government would never have had a basis in either international or constitutional law to enter into treaties with indigenous peoples in the first place, a matter which would have invalidated any U.S. claim to land titles accruing therefrom. Small wonder, trapped as he was in the welter of his own contradictions, that Marshall eventually threw up his hands in frustration, unable or unwilling to further define Indians as either fish or fowl. In the end, he simply repeated his assertion that the U.S./Indian relationship was unique, perhaps unlike any two peoples in existence 54. Small wonder, too, all things considered, that the Chief Justice's Cherokee opinion was joined by only one other member of the High Court. 55 The majority took exception, Justices Henry Baldwin and William Johnson writing separate opinions 56 and Smith-Thompson, together with Joseph Story, entering a strongly worded dissent which laid bare the only reasonable conclusions to be drawn from the facts. 57. It is political condition which determines their foreign character, and in that sense must the term foreign be understood as used in the Constitution. It can have no relation to local, geographical, or territorial position. It cannot mean a country beyond the sea. Mexico or Canada is certainly to be considered a foreign country, in reference to the United States. It is the political relation in which one country stands to another, which constitutes it foreign to the other. 58. Nonetheless, Marshall's views prevailed, a circumstance allowing him to deploy his domestic dependent nation thesis against both the Cherokees and Georgia in Worcester. 59. First, he reserved on constitutional grounds relations with all other nations to the federal realm, thereby dispensing with Georgia's contention that it possessed a state's right to exercise jurisdiction over a portion of the Cherokee Nation falling within its boundaries. 60. Turning to the Cherokees, he reiterated his premise that they and by implication all Indians within whatever borders the U.S. might eventually claim occupied a nebulous quasi-sovereign status as distinct, independent political communities subject to federal authority. 61. In practical effect, Marshall cast indigenous nations as entities inherently imbued with a sufficient measure of sovereignty to alienate their territory by treaty when and wherever the U.S. desired they do so, but never with enough to refuse. 62. As legal scholars Vine Deloria, Jr., and David E. Wilkins have recently observed, the cumulative distortions of both established law and historical reality bound up in Marshall's Indian opinions created a very steep and slippery slope, with no bottom anywhere in sight. His original assumption that the federal government is authorized and empowered to protect American Indians in enjoyment of their lands. Once it is implied that this power also involves the ability of the federal government by itself to force a purchase of the lands, there is no way the implied power can be limited. If the government can force the disposal of lands, why can it not determine how the lands are to be used? And if it can determine how the lands are to be used, why can it not tell Indians how to live? And if it can tell Indians how to live, why can it not tell them how to behave and what to believe? 63. By the end of the 19th century, less than 70 years after Cherokee and Worcester, each of these things had happened. Within such territory as was by then reserved for indigenous use and occupancy, the traditional mode of collective land tenure had been supplanted by federal imposition of a more civilized form of individual title expressly intended to compel agricultural land usage. 64. Native spiritual practices had been prohibited under penalty of law. 65. And entire generations of American Indian youngsters were being shipped off, often forcibly, to boarding schools where they were held for years on end. Forbidden knowledge of their own languages and cultures while they were systematically indoctrinated with Christian beliefs and cultural values. 66. The overall policy of assimilation, under which these measures were implemented, readily conforms to the contemporary legal definition of cultural genocide. 67. Meanwhile, American Indians had been reduced to utter destitution, dispossessed of approximately 97.5% of our original land holdings. 68. Our remaining assets held in a perpetual and self-assigned trust by federal authorities wielding what Marshall's heirs on the Supreme Court described as an extra-constitutional or plenary, that is, unlimited, absolute, and judicially unchallengeable power over our affairs. 69. Suffice it here to observe that nothing in the doctrine of discovery empowered any country to impose itself on others in this way. On the contrary, the juridical reasoning evident in the Marshall opinions and their successors has much in common with, and in many respects prefigured, the now discredited body of law repudiated first by an International Court of Arbitration opinion in the 1928 Island of Palmas Case 70, then more sweepingly in the 1945 United Nations Charter and the United Nations 1960 Declaration on the Granting of Independence to Colonial Countries and Peoples 71, which purported to legitimate the imperialism manifested by Europe during the early 20th century. 72. Rights of conquest. Although they are usually treated as an entirely separate consideration, conquest rights in the New World accrued under the law of nations as a subpart of discovery doctrine. Under international law, discoverers could acquire land only through a voluntary alienation of title by native owners, with one exception when they were compelled to wage a just war against native people, by which those holding discovery rights might seize land and other property through military force. 73. The U.S. clearly acknowledged that this was so in the earlier mentioned Northwest Ordinance, where it pledged that indigenous nations would never be invaded or disturbed, unless in just and lawful wars authorized by Congress. 74. The criteria for a just war were defined quite narrowly in international law. As early as 1539, Vittoria and, to a lesser degree, Matthias de Paz asserted that there were only three: the natives had either to have refused to admit Christian missionaries among them, to have arbitrarily refused to engage in commerce with the discovering power, or to have mounted some unprovoked physical assault against its representatives/subjects. 75. Absent at least one of these conditions, any war waged by a European state or its derivative would be unjust. The term was changed to aggressive during the 20th century, and resulting claims to title unlawful. 76. One searches in vain for an example in American history where any of the criteria were realized. A more pragmatic problem confronting those claiming that the U.S. holds conquest rights to native lands is that, while the federal government recognizes the existence of approximately 400 indigenous peoples within its borders, its own count of the number of Indian wars it has fought number 4077. Plainly, the United States cannot exercise conquest rights over the more than 300 nations against which, by its own admission, it has never fought a war. Yet, as is readily evident in its 1955 T-Hitton opinion, the Supreme Court, mere facts to the contrary notwithstanding, has anchored U.S. land title in a pretense that exactly the opposite is true. Every American schoolboy knows that the savage tribes of this continent were deprived of their ancestral ranges by force, and that, even when the Indians ceded millions of acres by treaty in return for blankets, food, and trinkets, it was not a sale but the conqueror's will that deprived them of their land. 78. Particularly in his McIntosh opinion, but also in Cherokee, John Marshall sought to transcend this issue by treating discovery and conquest as if they were synonymous, a conflation evidencing even less legal merit than the flights of fancy discussed in the preceding section. In fact, the High Court was ultimately forced to distinguish between the two, acknowledging that the English possessions in America were not claimed by right of conquest, but by right of discovery, and, resultingly, that the law which regulates, and ought to regulate in general, the relations between the conqueror and conquered, incapable of application by the U.S. to American Indians. 79. A further complication is that as early as 1672 legal philosophers like Samuel Pufendorf had mounted a serious challenge to the idea that even such territory as was seized in the course of a just war might be permanently retained. 80. Although Hugo Grotius, Emmerich de Vattel, William Edward Hall, John Westlake, and other such theorists continued to aver the validity of conquest rights through the end of the 19th century, 81 by the 1920s a view very similar to Pufendorf's had proven ascendant. Oddly, given its stance concerning American Indians, as well as its then recent forcible acquisitions of overseas colonies like Hawaii, Puerto Rico, and the Philippines, 82 the U.S. assumed a leading role in this respect. Although the Senate refused to allow the country to join, President Woodrow Wilson was instrumental in creating the League of Nations, an organization intended to substitute diplomacy for war in the resolution of international disputes. 83 In some ways more important was its centrality in crafting the 1928 General Treaty on the Renunciation of War, also known as the Kellogg-Briand Pact or Pact of Paris. 84. With the, almost all the powers of the world, including all the great powers, renounced the right to resort to war as an instrument of state policy. By Article 1, high contracting parties solemnly declare, in the names of their respective peoples, that they condemn war for the solution of international controversies, and renounce it as an instrument of national policy in their relations with one another. By Article 2, the parties agree that the settlement or solution of all disputes or conflicts, of whatever nature or of whatever origin they may be, which may arise among them, shall never be sought except by pacific means. 85. In 1932, Secretary of War Henry Stimson followed up by announcing that the U.S. would no longer recognize title to territory seized by armed force. 86 This new dictum of international law, 87 shortly to be referred to as the Stimson Doctrine of Non-Recognition, was expressly designed to effectively bar the legality hereafter of any title or right sought to be obtained by pressure or treaty violation, and lead to the restoration of rights and titles of which have been unjustly deprived. 88. Within a year, the doctrine's blanket rejection of conquest rights had been more formally articulated in a League of Nations resolution and legally codified in the Chaco Declaration, the Savard-Alamas Pact, and the Montevideo Convention on the Rights and Duties of States. 89 In 1936, the Inter-American Conference on the Maintenance of Peace also declared a proscription of territorial conquest and that, in consequence, no acquisition made through violence shall be recognized. 90 The principle was again proclaimed in the Declaration on the Non-Recognition of the Acquisition of Territory by Force advanced by the Eighth Pan-American Conference in 1938. As a fundamental of the public law of America, the occupation or acquisition of territory or any other modification of territorial or boundary arrangement obtained through conquest by force or non-pacifistic means shall not be valid or have legal effect. The pledge of non-recognition of situations arising from the foregoing conditions is an obligation which cannot be avoided either unilaterally or collectively. 91. By the time the Supreme Court penned its bellicose opinion in THIRD, the Stimson Doctrine had already served as a cornerstone in formulating the charges of planning and waging aggressive war pressed against the major Nazi defendants at Nuremberg and the Japanese in Tokyo. 92 It had also served as a guiding principle in the establishment of both the Organization of American States and the United Nations, entities which by their very charters, like the ill-fated League of Nations before them, are devoted to the progressive codification of law, for purposes of preventing war. 93 Correspondingly, Stimson's new dictum found its most refined and affirmative expression in the Charter's provisos, reiterated almost as boilerplate in a host of subsequent UN resolutions, declarations, and conventions, concerning the equal rights and self-determination of all peoples. 94. Contradictory as the THIRD Court's blatant conquest rhetoric was to the lofty posturing of the U.S. in the international arena, it was even more so with respect to a related subterfuge unfolding on the home front. By 1945, the United States was urgently seeking a means of distinguishing its own record of territorial expansion from that of the Nazis it was preparing to hang for having undertaken very much the same course of action. 95 The workhorse employed in this effort was the so-called Indian Claims Commission, established to make retroactive payment to indigenous peoples whose property had been unlawfully taken over the years. 96 The purpose of the commission was, as President Harry Truman explained, upon signing the enabling legislation on August 14, 1946, to foster an impression that the U.S. had acquired none of its land base by conquest. This bill makes perfectly clear what many men and women, here and abroad, have failed to recognize, that in our transactions with Indian tribes we have, set for ourselves the standard of fair and honorable dealings, pledging respect for all Indian property rights. Instead of confiscating Indian lands, we have purchased from the tribes that once owned this continent more than 90% of our public domain. 97. The game was rigged from the outset, to be sure, since the ICC was not empowered to return land to native people even in cases where its review of the manner in which the US had acquired it revealed the grossest sorts of illegality. The terms of compensatory awards, moreover, were restricted to payment of the estimated value of the land at the time it was taken, often a century or more before, without such considerations as interest accrual or appreciation in land values during the intervening period. 98 Still, despite its self-serving and mostly cosmetic nature, the very existence of the ICC demonstrated quite clearly that, in terms of legality, U.S. assertion of title to / jurisdiction over Indian country can no more be viewed as based in conquest rights than in rights of discovery. All U.S. pretensions to ownership of property in North America must therefore be seen as treaty-based. Through the lens of the law. When Congress established the ICC in 1946, it expected within 5 years to resolve all remaining land rights issues concerning American Indians. 99 The Commission was to identify and catalog the basis in treaties, agreements, and statutes by which the U.S. had assumed lawful ownership of every disputed land parcel within its purported domain, awarding just compensation in each case where the propriety of the transaction documented might otherwise be deemed inadequate. 100 By 1951, however, the 200-odd claims originally anticipated had swelled to 852.101. The lifespan of the ICC was extended for another 5 years, then another, a process which was repeated until the third generation of commissioners finally gave up in exhaustion. 102. By the time the Commission suspended operations on September 30, 1978, it had processed 547 of the 615 dockets into which the 852 claims had been consolidated, none in a manner satisfactory to the native claimants. 103 Title to virtually the entire state of California, for instance, was supposedly quieted in the Pitt River land claim settlement of the mid-1960s by an award amounting to 47 cents per acre, despite the fact that the treaties by which the territory had ostensibly been ceded to the U.S. had never been ratified by the Senate. 104. Most important, in its final report the ICC acknowledged that after 3 decades of concerted effort, it had been unable to discern a legal basis for U.S. title to what the Federal Public Lands Law Review Commission had already described as 1/3 of the nation's land. 105. The fact is that about half the area of the country was purchased by treaty or agreement at an average price of less than $1 per acre, another third of acres, mainly in the West, was confiscated without compensation, another 2/3 of acres was claimed by the United States without pretense of a unilateral action extinguishing native title. 106. There can be no serious question of the right of indigenous nations to recover property to which their title remains unclouded, or that their right to recover land seized without payment equals or exceeds that of the United States to preserve its territorial integrity by way of paltry and greatly belated compensatory awards. 107 Restitution rather than compensation is, after all, the guiding principle of the tort provisions embodied in international public law. 108 Nor is this the end of it. Within the area ostensibly acquired by the U.S. through treaties or agreements, many of the instruments of cession are known to have been fraudulent or coerced. These must be considered invalid under Articles 48-53 of the Vienna Convention on the Law of Treaties. 109. A classic illustration of a fraud involves the 1861 Treaty of Fort Wise, in which not only did federal commissioners forge the signatures of selected native leaders, several of whom were not even present during the negotiations, but the Senate altered many of the treaty's terms and provisions after it was supposedly signed, then ratified the result without so much as informing the Indians of the changes. On this basis, the U.S. claimed to have obtained the consent of the Cheyennes and Arapahoes to its acquisition of the eastern half of what is now the state of Colorado. 110 Comparable examples abound. Examples of coercion are also legion, but none provides a better illustration than does the 1876-77 proceeding in which federal authorities suspended distribution of rations to the Lakotas, at the time directly subjugated by and therefore dependent upon the U.S. military for sustenance, and informed them that they'd not be fed again until their leaders had signed an agreement relinquishing title to the Black Hills region of present-day South Dakota. 111 Thus did the Congress contend that the 1851 and 1868 treaties of Fort Laramie, in each of which the Black Hills were recognized as an integral part of the Lakota homeland, had been superseded and U.S. ownership of the area secured. 112. Without doubt, North America's indigenous nations are no less entitled to recover lands expropriated through such travesties than they are the territories already discussed. Although it is currently impossible to offer a precise estimate regarding the extent of the acreage involved, to do so would require a contextual review of each U.S./Indian treaty, and a parcel-by-parcel delineation of the title transfers accruing from invalid instruments. It is safe to suggest that adding it to the 35% of the continental U.S. which was never ceded would place something well over half the present gross domestic territoriality of the United States. 113. The U.S. of course holds the power to simply ignore the law in inconvenient contexts such as these. Doing so, however, will never serve in itself to legitimate its comportment. Instead, its continued possession of a vast expanse of illegally occupied territory, 114, an internal colonial empire, as it were, 115, can only destine it to remain what it was at its inception, an inherently criminal or rogue state. 116. It is through this lens that U.S. pronouncements and performance from Nuremberg to Vietnam must inevitably be evaluated. 117. So, too, President George Herbert Walker Bush's 1990 rhetoric concerning America's moral/legal obligation to kill more than 1 million Iraqis, while militarily revoking their government's forcible annexation of neighboring Kuwait. 118. On the face of it, the only reasonable conclusion to be drawn is that the unsavory stew of racial/cultural arrogance, duplicity, and abiding legal cynicism defining U.S. relations with indigenous nations from the outset has come long since to permeate America's relationship to most other countries. How else to understand Bush's 1991 declaration that the display of U.S. military might he'd ordered in Iraq was intended more than anything else to put the entire world on notice that, henceforth, what we say, goes. 119. In what other manner might we explain the fact that while Bush claimed the New World Order he was inaugurating would be marked by nothing so much as the rule of law among nations, the United States was and remains unique in the consistency with which it has rejected both the authority of international courts and any body of law other than its own. 120. For the past 50 years, federal policymakers have been increasingly adamant in their refusal of the proposition that the U.S. might be bound by customs or conventions conflicting with its sense of self-interest. 121. More recently, American delegates to the United Nations have taken to arguing that new codifications of international law must be written in strict conformity to their country's constitutional and even statutory requirements, and that, for interpretive purposes, the distortions of existing law advanced by American jurists such as John Marshall be considered preeminent. 122. In effect, the U.S. is seeking to cast an aura of legitimacy over its ongoing subjugation of American Indians by engineering a normalization of such relations in universal legal terms. A salient example will be found in the ongoing U.S. rejection of language in the United Nations Draft Declaration on the Rights of Indigenous Peoples and a similar declaration drafted by the OAS reiterating that self-determination is guaranteed all peoples by the UN Charter. 123. Instead, American diplomats have been instructed to insist that indigenous peoples the world over must be accorded only a right of internal self-determination which is not synonymous with more general understandings of self-determination under international law but which conforms perfectly with those set forth in the United States' own Indian Self-Determination and Educational Assistance Act of 1975. 124. Most specifically, as was stated in an official cable in January 2001, the U.S. understanding of the term internal self-determination indicates that it does not include a right of independence or permanent sovereignty over natural resources. 125. The standard explanation offered by U.S. officials when queried about the legal basis for their government's position on native rights has been that while the United States once recognized American Indian as separate, distinct, and sovereign nations, it long since stopped doing so. 126. This, however, is the same, legally speaking, as saying nothing at all. According to no less an authority than Lasse Oppenheim, author of the Magisterial International Law, voluntary relinquishment is the sole valid means by which any nation may be divested of its sovereignty. 127 Otherwise, recognition, once given, is irrevocable unless the recognized ceases to exist. 128 As always, the US is simply making up its own rules as it goes along. As should be obvious, the implications of such maneuvers are by no means confined to a foreclosure upon the rights of native peoples. The broader result of American unilateralism is that, just as it did with respect to North America's indigenous nations, the US is now extrapolating its presumptive juridical primacy to global dimensions. 129 The initiative is especially dangerous, given that the place now held by the US within the balance of world military power closely resembles the lopsided advantage it enjoyed against American Indians during the 19th century. 130 The upshot is that, should the present trend be allowed to continue, the United States will shortly have converted most of the planet into an equivalent of Indian country. 131 In fact, especially with regard to the so-called Third World, this has already to all practical intents and purposes come to pass. 132 The nature of modern empire. It's an old story, really, writes Phyllis Bennis, one of a strategically unchallenged dominion, at the apogee of its power and influence, rewriting the global rules for how to manage its empire. 2,000 years ago, Thucydides described how Milos, the island the Greeks conquered to ensure stability for their empire's golden age, was invaded and occupied according to laws wholly different from those governing democratic Athens. The Roman Empire followed suit, creating one set of laws for Rome's own citizens, imposing another on its far-flung possessions. In the last couple of hundred years the sun never sets on us. British Empire did much the same thing. And then, at the end of the 20th century, having achieved once unimaginable heights of military, economic, and political power, it was Washington's turn. 133 The American-style fin de 20th siècle law of empire took the form of the U.S. exempting itself from unbrokered treaties and other agreements that it demanded others accept. It was evident in Washington's rejection of the International Criminal Court in 1998, its refusal to sign the 1997 Convention Against Antipersonnel Landmines, its failures the Convention on the Rights of the Child, the Law of the Sea, the Comprehensive Test Ban Treaty and more. 134 Actually, the roots of the current U.S. posture run much deeper than Bennis suggests. As its record concerning the earlier mentioned California Indian treaties readily demonstrates, the United States had by the mid-1850s already adopted a policy of selectively exempting itself from compliance with treaties to which it asserted others were nonetheless bound. 135 The Supreme Court's 1903 opinion in Lone Wolf v. Hitchcock effectively extended this procedure to encompass all treaties and agreements with indigenous nations. 136 From there, it became only a matter of time before the U.S. would begin to approach the remainder of its foreign relations in a comparable manner. 137 This parallels the attitude, first explicated with regard to Indians and now displayed quite prominently on the global stage, that America is endowed with a plenary authority to dictate the permissible forms of other countries' governmental and political processes, the modes of their economies, and so on. 138 Legal scholar Felix S. Cohen once and accurately analogized American Indians as a miner's canary, providing early warning of the fate in store for other sectors of the U.S. populace. 139 The principle can now be projected to worldwide proportions. Given the scale of indignity and sheer physical suffering the U.S. has inflicted and continues to inflict upon indigenous peoples trapped within its domestic domain. 140 It is self-evidently in the best interests of very nearly the entire human species to forcefully reject the structure of unjust legality by which the U.S. is attempting to rationalize its ambition to consolidate a position of planetary suzerainty. 141 The only reasonable question is how best to go about it. Here, the choice is between combating the endless array of symptoms emanating from the problem or going after it at its source, eradicating it root and branch, once and for all. Again, the more reasonable alternative is self-revealing. Unerringly, then, the attention of those desiring to block America's increasingly global reach must be focused upon unpacking the accumulation of casuistic jurisprudence employed by the U.S. as a justification for its own geographical configuration. 142 Since, as has been established herein, there is no viable basis for the United States to assert territorial rights based on the concept of terra nullius or any other aspect of discovery doctrine, and even less on rights of conquest, it is left with a legally defensible claim to only those parcels of the continent where it obtained title through a valid treaty. As has also been shown herein, this adds up to something less than half its professed North American land base. To its overseas possessions such as Guam, Puerto Rico, and Hawaii, the U.S. holds no legal right at all. 143. Viewed from any angle, the situation is obvious. Shorn of its illegally occupied territories, the U.S. would lack the critical mass and internal jurisdictional cohesion necessary to impose itself as it does at present. This is all the more true in that even the fragments of land still delineated as Indian reservations are known to contain up to 2/3 of the uranium, 1/4 of the readily accessible low-sulfur coal, 1/5 of the oil and natural gas, and all of the zeolites available to feed America's domestic economy. 144 Withdrawal of these assets from federal control would fatally impair the ability of the U.S. to sustain anything resembling state corporate business as usual. By every reasonable standard of measure, the decolonization of native North America must thus be among the very highest priorities pursued by anyone, anywhere, who is seriously committed to achieving a positive transformation of the global status quo. 145. A major barrier to international coalescence around this sort of deconstructionist agenda, among sworn enemies of the U.S. no less than its allies, has been the exclusively statist world order. 146 or world system, as Immanuel Wallerstein terms it. 147 in which both sides are invested. Only states are eligible for membership in the United Nations, for instance, a conflation which once caused American Indian movement leader Russell Means to quip that the organization would more rightly have been called the United States, but the name was already taken. 148 Although it may be no surprise to find a veritable U.S. appendage like Canada citing John Marshall's Macintosh opinion as the locus class sicut of the principles governing Aboriginal title in the formulation of its own judicial doctrine. 149 It is quite another matter to find the then still decolonizing countries of Africa adopting the thinking embodied in Cherokee to ensure that the national borders demarcated by their European colonizers would be preserved in international law. 150. This came about during United Nations debates concerning the 1960 Declaration of the Granting of Independence to Colonial Countries and Peoples. Belgium, in the process of relinquishing its grip on the Congo, advanced the thesis that if terms like decolonization and self-determination were to have meaning, the various tribal peoples whose homelands it had forcibly incorporated into its colony would each have to be accorded the right to resume independent existence. Otherwise, the Belgians argued, colonialism would simply be continued in another form, with the indigenous peoples involved arbitrarily subordinated to a centralized authority presiding over a territorial dominion created not by Africans but by Belgium itself. 151 To this, European-educated Congolese insurgents like Patrice Lumumba, backed by their colleagues in the newly emergent Organization of African Unity, counterposed what is called the Blue Water Principle, that is, the idea that to be considered a bona fide colony and thus entitled to exercise the self-determining rights guaranteed by both the Declaration and the UN Charter, a country or people had to be separated from its colonizer by at least 30 miles of open ocean. 152. Although the Blue Water Principle made no more sense during the early 1960s than it had when Justice Smith Thompson rebutted John Marshall's initial iteration of it in 1831, it was quickly embraced by UN member states and Third World revolutionary movements alike. 153 For the member states, whether capitalist or socialist, adoption of the principle served to consecrate the existing disposition of their internal territoriality, irrespective of how it may have been obtained. For the Third World's Marxian revolutionaries, it offered the same prospect, albeit quite often with regard to positions of post-colonial state authority to which they were at the time still aspiring. 154 For either side to acknowledge that a fourth world comprised of indigenous nations. 155 Might possess the least right to genuine self-determination would have been and remains to dissolve the privileged status of the state system to which both sides are not only conceptually wedded but owe their very existence. 156 The stakes embodied in this denial are staggering. There are 20 different indigenous peoples along the peninsula British colonizers called Malaya, 380 in post-colonial India, 670 in the former Dutch/Portuguese colony of Indonesia. 157 In South America, the numbers range from 35 in Ecuador to 210 in Brazil. 158 There are scores, including such large nationalities as the Yi, Manchus, and Miao, encapsulated within the People's Republic of China. 159 In Vietnam, 24 Montagnard tribes of the Annamese Cordillera have been unwillingly subsumed under authority of what the Vietnamese constitution unilaterally proclaims a multinational state. 160 The same situation prevails for the Mongs of Laos. 161 Not only the Chechens of the south but at least 36 smaller northern peoples remain trapped within the Russian rump state resulting from the breakup of the Soviet Union. 162 In Iraq and Turkey, there are the Kurds. 163 In Libya and Morocco, the Bedouins of the desert regions. 164 Throughout sub-Saharan Africa, hundreds more. Many of them partitioned by borders defended at gunpoint by statist regimes, share the circumstance of the rest. 165 Similar situations prevail in every quarter of the earth. 166 Observed from this standpoint, it's easy enough to see why no state, regardless of how bitterly opposed it might otherwise be to the United States, has been or could be willing to attack the U.S. where it is most vulnerable. The vulnerability being decidedly mutual, any precedent thus established would directly contradict the attacking state's sense of self-preservation at the most fundamental level. Hence, the current process of militarily enforced politico-economic globalization. 167 World imperialism, by any other name. 168 Must be viewed as a collaborative endeavor, involving even those states which stand to suffer most as a result. It follows that genuine and effective opposition can only accrue from locations outside official venues, at the grassroots, among those who understand their interests as being antithetical not only to globalization, per se, but to the entire status structure upon which it depends. 169 Returning the law to its feet. It's not that native peoples are especially accepting of their lot, as has been witnessed by such bloody upheavals as Katanga and Biafra since 1960. 170 In 1987, cultural anthropologist Bernard Nietzschmann conducted a global survey in which he discovered that of 125 armed conflicts occurring at the time, fully 85% amounting to a Third World War, in his view were being fought between indigenous nations and states claiming an inherent right to dominate them. 171 Among the sharper clashes have been the ongoing guerrilla struggles waged by the Kurds, the Nagas of the India/Burma border region. 172 The southern Karens and northern Kashans of Burma. 173 The Tamils of Sri Lanka. 174 The Pacific Islanders of Palau, Fiji, and elsewhere. 175 The so-called Moro peoples of the southern Philippines. 176 The Timorese and Papuans of Indonesia. 177 As well as the Mosquito and other native peoples of Nicaragua's Atlantic coast. 178 To this list may now be added the series of revolts in Chechnya. 179 And the recent Mayan insurgency in the Mexican province of Chiapas. 180 The list extends as well to the venerable states of Western Europe. In Spain, the Basques, and to a lesser degree the Catalans, have been waging a protracted armed struggle to free themselves from incorporation into a country of which they never consented to be a part. 181 In France, aside from the Basques around Navarre, there are the Celtic Bretons of the Channel coast. 182 The Irish are continuing their 8-century-long military campaign to reclaim the whole of their island. 183 While, on the English Isle itself, the Welsh, Scots, and Cornish Celtic peoples all have increasingly taken to asserting their rights to autonomy. 184 So, too, the Celtic Manxmen on the Isle of Man. 185 Far to the north, The Samis are also pursuing their right to determine for themselves the relationship of some island vis-a-vis Norway, Sweden, Finland, and Russia. 186 In Greenland, the primarily Inuit population, having already achieved a home rule arrangement with their Danish colonizers, are pushing for full independence. 187 In Canada, there have been armed insurgencies by native peoples at Oka, Gustafson Lake, and elsewhere, as well as the emergence of a tentatively autonomous Inuit territory called Nunavut. 188. Those who see dismantlement of the present U.S. territorial/power configuration as the pivot point of constructive change are thus presented with the prospect of linking up with a vibrantly global Fourth World Liberation movement, one which has never been quelled, and which cannot be satisfied until what Leopold Kohr once called the breakdown of nations, by which he actually meant the breakdown of states, has been everywhere accomplished. 189 Dire predictions concerning the horrors supposedly attending the coming anarchy. 190 Blink the fact that the hegemony of statism has generated an estimated 50 million corpses from wars alone over the past half-century. 191 Adding in those lost to the underdevelopment and diseconomies of scale inherent to the world system as it is now constituted would increase the body count at least 20 times over. 192 Also to be considered is the radical and rapidly accelerating truncation of fundamental rights and liberties undertaken by all states. The freedom-loving U.S. far more than most of those it condemns as totalitarian in order to concretize and reinforce their imposition of centralized authority. 193 As well, the massive and unprecedented degree of cultural leveling entailed in the systematic and state-anchored transnational corporate drive to rationalize production and unify markets the world over. 194 Rectifying John Marshall's seminal inversion of international legal principle, negating his negation, so to speak. 195 And thus returning the law to its feet. 196 Would serve to undermine one of the most potent components of the master narrative through which statism and its imperial collaterals have been presented as though they were natural, inevitable, and somehow beneficial to all concerned. 197 General exposure, in their own terms, of the falsity intrinsic to such truths stands to evoke a legitimation crisis of such proportions and intractability that the statist system could not sustain itself. 198 This end of world order. 199 Or, more accurately, transformative reordering of international relations. 200 In favor of a devolution of state structures into something resembling the interactive clusters or federations of many nationalisms. 201 Which were the norm before the advent of European hegemony. 202 Restoring human scale and bi-original sensibility to the affairs of peoples can only be seen as a positive trajectory. 203 Putting a name to it is a more difficult proposition, however. Insofar as its thrust centers in a wholesale assertion of the rights of Fourth World peoples, such a path might correctly be depicted as an indigenist alternative. 204 Still, given so sweeping a reconfiguration of humanity's relationship with itself and its habitat must encompass those who are of the Fourth World in neither identity nor present orientation, the old standby of anarchism might well prove a more apt descriptor. 205 Regardless of its labeling, the result will inevitably be far more just, and thus more liberatory, than that which it will replace. 2. The nullification of Native America. An analysis of the 1990 American Indian Arts and Crafts Act. An Indian is an Indian no matter what kind of Indian is. E. Allen Morinus, 1982. On November 29, 1990, Public Law 104-644, titled An Act for the Protection of American Indian Arts and Crafts Act, and best known as simply the Arts and Crafts Act, was signed by U.S. President George Bush. 1 Through this measure, the federal government of the United States arrogated unto itself and its state-level subordinates the ultimate authority to determine who is not entitled to identify themselves as an American Indian for purposes of selling arts and crafts, usurping and in fact criminalizing the self-determining prerogatives of indigenous peoples in the process. According to Sector 104-1159 of the Act, it is unlawful to offer for sale or display any good, with or without a government trademark, in a manner that falsely suggests it is Indian produced, an Indian product, or the product of a particular Indian or Indian tribe or Indian arts and crafts organization, resident within the United States. Whoever knowingly violates subsection shall, in the case of a first violation, if an individual, be fined not more than $250,000 or imprisoned not more than 5 years, or both, and if a person other than an individual, be fined not more than $1 million, and, in the case of subsequent violations, if an individual, be fined not more than $1,000,000 or imprisoned not more than 15 years, or both, and, if a person other than an individual, be fined not more than $5 million. As used in this section, the term Indian means any individual who is a member of an Indian tribe, or for purposes of this section is certified as an artisan by an Indian tribe. The terms Indian product and product of a particular tribe or Indian arts and crafts organization has the meaning given in regulations which may be promulgated by the Secretary of the Interior. The term Indian tribe means any Indian tribe, band, nation, Alaska Native village, or other organized group or community which is recognized as eligible for the special programs and services provided by the United States to Indians because of their status as Indians, or any Indian group that has been formally recognized as an Indian tribe by a state legislature or by a state commission of similar organization legislatively vested with state tribal recognition authority. And the term Indian Arts and Crafts Organization means any legally established arts and crafts marketing organization composed of members of Indian tribes. Plainly, while certain things are spelled out reasonably well in the legislative language, criminal penalties, for example, and a highly restrictive definition of what it means to be Indian in the United States, the matter of what constitutes, or is meant to constitute, arts and crafts is left not merely ambiguous but virtually unaddressed. This, in turn, has led a number of observers to question whether the intent of the Act's sponsors, and thus of Congress itself, was to cast the net far more widely than it appears on the surface. Are arts and crafts to be construed in a more or less conventional sense, i.e., painting, drawing, printmaking, sculpture, ceramics, photography, beadwork and jewelry, basketry, weaving, and the like, or should they be considered more broadly, as including such things as dance, music, drama, cinema, poetry, and literature? If the latter is to be considered an art form, as it usually is, shouldn't the production of non-fiction writing, history, for instance, or philosophy, or political theory also be included? After all, fiction, non-fiction, and even technical writing are all produced through essentially the same craft process. The dominoes keep right on falling. If it is so easily conceivable that scholarly, journalistic, and scientific writing might be taken as falling within the Act's provisions, then how about the professional occupations associated with such publishing? This might be taken as encompassing everyone from reporters to research technicians and university professors. And, if the latter are at issue, then what about elementary and secondary school teachers? Educational administrators? Public speakers and commentators of all sorts? Daycare workers? School bus drivers and custodial staff? The question of where all this stops, or even where it is supposed to stop, is far from clear, a matter compounded by the fact that organizations devoted to enforcing the Act's constraints upon definitions of native identity have recently emerged, not only in connection with what would normally be seen as arts and crafts production, but filmmaking, acting, and university-level teaching as well. Point 2. Active discussions are also occurring in pre-existing organizations concerned with science and engineering, journalism, and the like. Point 3. At least some of the Act's original supporters have openly called for its expansion to explicitly encompass each of these areas and more. Point 4. The slippery slope embodied in the 1990 Arts and Crafts Act is thus readily apparent. In the end, as critics point out, it requires no great flight of fancy to imagine a setting in which anyone desiring, for whatever reason, to identify themselves as an American Indian would be required to obtain what amounts to the express permission of the U.S. government or its delegates to do so. In the alternative, they would face criminal prosecution, hefty fines, and the possibility of imprisonment. That any such development would set in place the mechanism for nullifying one of the last vestiges of genuine self-determination among the indigenous nations of North America, that of deciding for ourselves the composition of our respective polities, is, or at least should be, self-evident. 5. Proponents of the act, on the other hand, variously pooh-pooh the idea that any such dire results might occur, and argue, often vociferously, that it is in any event worth the risk. The reason for this, they claim, is that passage of the measure has in itself served to drive a number of counterfeit Indians out of the commercial venues in which native arts and crafts are sold, thereby opening up increased sales opportunities for real Indians. Expansion of the law into other areas of activity, advocates continue, along with rigorous enforcement, would stand to amplify and extend such beneficial effects across the board, alleviating the dire poverty they accurately describe as presently afflicting far too many native people. 6. Perhaps predictably, the mutual exclusivity of the two positions has engendered a sharp polarization among Indians in the U.S. and, to a lesser extent, in Canada as well. Marked by squadrons of self-styled and appointed purity police on the one side, and increasingly angry denunciations of such tactics on the other, the resulting turmoil has proven extraordinarily ugly and divisive. 7. Nor does it show signs of abating at any point in the foreseeable future. The purpose of this essay is to attempt a clarification of the situation by lifting the veil of sheer contentiousness which has shrouded the 1990 Act from its inception, offering instead a more balanced assessment. The method selected is that of cost-benefit analysis. What have American Indians lost as a consequence of the law, and what have we gained? The intent of the endeavor is, as it should be, to provide a better and more comprehensive basis for reasonable people to go about making reasoned rather than emotional choices on whether and to what extent they should support either the current law or some evolutionary counterpart in the years ahead. Alternatives to it are suggested in the concluding section. Opening rounds. Probably the first thing of consequence happening in the wake of the Act's passage was that the Cherokee Cultural Heritage Center outside Tahlequah, Oklahoma, was forced to dose its doors. It seems that the facility's central exhibit, a large sculpture in wood depicting the Cherokees' Trail of Tears, had been carved by the late Willard Stone, a man who'd never entered his name on the tribal rolls. Under the new law, this made Stone an ethnic impostor and the Cherokee Museum guilty of perpetrating ethnic fraud by displaying his work despite the fact that he'd always been conceit-aired unquestionably Cherokee by Cherokees. Indeed, Stone is generally considered to have been the preeminent Cherokee woodcarver of his era, a standing which led to his having been asked to render the Great Seal of the Cherokee Nation. 8. Nor was Stone the only artist or craftsperson at issue in the museum's collection. Given the sustained history of resistance to enrollment manifested in some of the more traditional sectors of Cherokee society, it was soon discovered that literally scores of offenders were involved. 9. Although we Cherokees have long since devised our own methods of determining the validity of claims to Cherokee identity, the new law not only nullified but criminalized us. In order to reopen the museum and, presumably, to continue using its own Great Seal, the Cherokee Nation of Oklahoma was compelled to implement a special procedure whereby Stone and many of his contemporaries could be posthumously certified or enrolled. 10. The living were and remain another matter entirely. Often decrying the insult to their ancestors of imposing upon them after death something they'd rejected in life, a number of currently practicing Cherokee artists have refused to enroll even though they may be eligible to do so. Such people are hardly cultural/aesthetic also-rans. One of them, the accomplished painter Gene Walker Rorex, is Willard Stone's niece. 11 Another is Cherokee master artist Bert Seaborn. 12 Still another is Jimmy Durham, a man whose mixed media and installation work is very prominent in the conceptual art scene, and whose postmodernist theoretical writings on hybridity have been internationally embraced as exceedingly important. 13. Durham's experience is in many ways indicative. Scheduled for a solo exhibition at the U.S. Bureau of Indian Affairs sponsored Gallery of American Indian Contemporary Arts in San Francisco at the time the act was passed, he suddenly found himself cancelled. Upon inquiry, he was informed that, while the gallery's all-native staff fully accepted his self-identification as a Wolf Clan Cherokee, and that they had fought hard for the right to mount show as planned, the BIA had confronted them with the stark alternatives of either calling it off or suffering an abrupt and complete withdrawal of the federal funds upon which the gallery's very existence depended. 14. Although an ad hoc group of Native community members quickly took up a collection, rented private loft space, printed a poster and carried through with DOM's exhibition on their own, both the official cancellation and the nakedly coercive means by which it had been achieved emboldened other elements to launch a concerted drive aimed at purifying such events throughout the Bay Area. 15. In short order, this self-proclaimed body of identity police had adopted a strategy of disrupting often physically all manner of Native activities, refusing in each case to disengage until participants produced satisfactory proof that they met the standard of Indianness articulated in the Arts and Crafts Act. 16. For the next 3 years, the list of such interventions lengthened and expanded to include, not just arts-related events, but numerous powwows and public lectures, the local Leonard Peltier support group, various church-supported shelters and community outreach centers, programming at Pacifica radio station KPFA and other local broadcast facilities, as well as the San Francisco School District's Title V Indian Education Program and the Native American Studies Department at San Francisco State University. 17. It was not until the spring of 1994 that the situation began to ease, and then only because the occupation and resulting suspension of services by a Native AIDS clinic led to the death of one of the facility's clients. 18. Faced with the possibility of felony murder charges, and finding it impossible to explain how such results could in any way be construed as beneficial to the victim or his counterparts, the group quickly de-escalated the physical dimension of its effort in favor of a lower-keyed and less risky, but in some ways more insidious, whispering campaign conducted via the internet, as well as such time-honored expedients as letters, phone calls, and word of mouth. As one longtime resident of the San Francisco Native community recently put it, "It got so bad out here for a while that nobody could do or say anything without somebody else popping up to claim they weren't an Indian. It's as if the people doing it, whoever they are, a lot of them like to operate anonymously, are of the opinion that if you've actually accomplished something, or if you actually have things to say that people might find worth hearing, then by that definition alone you must not be a real Indian." And that, of course, raises the question of whether these so-called identity policers are themselves really Indians. I, for one, suspect that a lot of them aren't, but to say so is just to join the vicious circle we've gotten trapped in. 19. They've got us chasing our tails, another San Franciscan concludes. It's humiliating. It's frustrating. We're Indians. We're supposed to know who we are, and to be proud of it. But the appearance is not only that we don't, but that we need the goddamned federal government to sort it out for us. The whole thing just makes us all look like a bunch of idiots. You can almost hear the white man snickering at the spectacle we're presenting. Now I ask you, where's the pride in that? 20. Escalation. While eastern Oklahoma and San Francisco may represent particularly striking examples of the internecine squabbling unleashed by the act, they are neither alone nor necessarily the worst. Santa Fe, New Mexico, for instance, was another flashpoint. There, a sort of roving patrol composed of members of a locally based group touting itself as the Native American Artists Association went virtually from gallery to gallery, demanding to see proof of identity for each allegedly Indian artist or craftsperson exhibited therein. 21. Among the NAAA's more noteworthy accomplishments was heading off a prospective show by Phoenix area mask maker El Zarco Guerrero, whom they accused of being a Chicano, not an Indian. A comparable success was registered when the group's head, David Bradley, managed to engineer the rejection of paintings by imprisoned American Indian movement leader Leonard Peltier, an unenrolled Chippewa/Sioux, from a group exhibit at Santa Fe's Institute of American Indian Arts Museum. 23. Soon, NAAA was seeking to extend its reach internationally. In 1992, for instance, members attempted to convince the curator of a landmark exhibition of First Nations art at the National Gallery of Canada to remove work by Jimmy Durham in favor of that produced by someone within their own ranks. 24 Although this and similar maneuvers have proven unsuccessful over the short run, it has become apparent that a longer-term strategy may be involved. At Alberta's University of Lethbridge, for example, Santa Fe expatriate Alfred Youngman uses his faculty position to indoctrinate students, native and non-native alike, with Arts and Crafts Act-style definitions of Indianness. 25. Meanwhile, back in the United States, Indian Country Today, a widely circulated publication which strongly supported passage of the Act, inaugurated a series of exposés concerning the non-enrolled status of several well-published Native authors, most prominently the award-winning Modoc writer, Michael Doris. 26 This, in turn, generated a spate of similar revelations in such lesser publications as News from Indian Country and the now-defunct Smoke Signals during 1994 and 95. 27 For his part, ICT publisher and nationally syndicated columnist Tim Jago helped things along by repackaging what was appearing in the native press for consumption by the readers of more mainstream papers. 28. Those who resisted the onslaught were themselves targeted. My own case is in many ways illustrative. In 1991, I published a strong defense of Jimmy Durham which included sharp criticism both of the 1990 Act and of motives I saw as prompting identity policers to conduct themselves as they did. 29 As a consequence, although I am an enrolled Kituwa Band Cherokee and served as co-director of the Colorado chapter of the American Indian Movement since 1980, 30 I was subjected to a concerted campaign to brand me an imposter, both nationally and in my hometown press. 31 My publishers were contacted by representatives of the Indian community who threatened dire consequences unless my books were withdrawn, and I was dropped from their rosters of authors. 32 Agencies handling my public appearances were approached in much the same fashion, while universities and other fora at which I was scheduled to speak were informed that disruptive protests would occur unless they cancelled my talks. 33 I was included in ICE's series on pseudo-Indian writers, showcased in one of Jago's columns, and was for a time the focus of sustained controversy in News from Indian Country. 34 Needless to say, the internet came alive with all manner of unsubstantiated assertions. 35 In early 1993, a small group met secretly with administrators at the University of Colorado to demand that I be summarily fired from my faculty position on grounds of ethnic fraud. 36 Failing this, they quickly submitted a list of allegations ranging from embezzlement to physical intimidation of students in hopes of forcing my dismissal. 37 Although I was eventually exonerated on all counts, Colorado law is such that this could occur only by way of an official inquiry. Meanwhile, the fact that a mandated investigation process had been convened was itself used by my accusers to cast an aura of validity over their charges. 38 For me, things have not worked out badly at all. Somewhat ironically, the stench of McCarthyism surrounding the situation may have contributed to my receiving a major teaching award from my college during the year of the Great Investigation, and I've since been promoted to full professor. I've published 8 new books since 1993, revised editions of 2 others, seen translation of still another, and have 3 more in press. 39 I also continue to receive more invitations to lecture publicly than I can possibly handle. 40 An untenured junior faculty member would likely not have fared so well, however. Nor would a writer less established than I. Or a young painter, journalist, or filmmaker. Even a senior professor with solid publishing or gallery connections, but less seasoning in the incessant sectarian backbiting and duplicity of both institutional and radical politics, might well have found him or herself in serious trouble. And, of course, an undetermined number have. More problematic yet is the fact that universities and publishers, museums and art galleries, for that matter, are hardly solicitous of the kinds of headaches mine experienced. Given the choice between bringing aboard an undistinguished Indian bearing proper proof of pedigree on the one hand, and a promising but uncertified scholar or writer, sculptor or painter on the other, many may choose to do without native participation altogether. 41 Benefits, real and imaginary. Advocates of the Arts and Crafts Act argue that the ill effects sketched above are more than offset by the benefits which have already accrued to Indians as a result of its passage. In this connection, they often point first to a 1985 Commerce Department report estimating that the importation of ersatz Indian crafts from Korea, Taiwan, and other foreign sources siphons off somewhere between 10 and 20% of the annual $400 to $800 million industry value of such goods from the native craftspeople who should have received it. 42 Unquestionably, the potential revenue lost each year to people as endemically impoverished as American Indians is a problem of the first magnitude. With that said, however, there is no indication that the act has had the least favorable impact on the situation, or that it really lends itself to such a result. This is perhaps because, if the intent of policymakers had been to staunch the flow of Asian-produced items, or at least to prevent them from being foisted off by unscrupulous dealers as Indian-made, there was no particular reason to write new legislation pertaining to Indian arts and crafts, per se. Instead, weight might have been more fruitfully placed on beefing up the Tariff Act of 1930, which already required that all imported products be clearly labeled with their countries of origin. 43. Such convenient rationalizations or diversions aside, the real thrust of the 1990 Act is, as it clearly states, to sharply restrict the range of persons allowed to identify themselves as being American Indians within the United States itself. As one NAAA spokesperson framed the sentiments of its supporters in a letter submitted during the fact-finding process leading up to the Act's passage. Too long have I observed and yes, voiced my outrage over the non-Indian who pushes and elbows the real Indian artist out of Indian art shows, galleries, museums and historical places. Many of these silver, fork-tongued non-Indians, and most of us know who they are, have risen to prominence through fraudulently representing themselves as Indian artists. These frauds have one object, and that is to make money. 44. Indeed. Apart from the writer's uncomfortably whiny tone, suggesting as it does that real native artists are somehow inherently inferior to and therefore can't be expected to compete with non-Indian pretenders, there are other problems embedded in the missive. These begin with the question of exactly what economic stakes for Native America undergird such animus projection. The answer, as even the NAAA's most dogmatic adherents were ultimately forced to concede, is not much. 45 While nothing resembling a solid estimate exists, a situation which in itself seems an odd basis upon which to enact federal laws, the best guess advanced has been that it might add up to several $1 million per year. 46. Then there is the matter of who, exactly, it is who's risen to prominence on the basis described by the NAAA. Parsing out people like Seaborn, Rorex, and Durham, the strongest example the organization could come up with of someone who is absolutely not an Indian, but who demonstrably makes a living by claiming otherwise, was an obscure individual in Oklahoma who calls himself John Redtail Free Soul, peddles sacred pipes and, more often, hawks native ceremonies. 47 Others, like Paul Pletka, whose name came up, and who did in fact achieve a certain prominence during the 1970s while painting neo-surrealist depictions of indigenous subject matter, have never actually identified themselves as being Indians. 48. By the same token, a respectable number of indisputably Indian artists over the past generation have not only achieved prominence in their field, but have become rather wealthy in the bargain. These include the late T.C. Cannon, Fritz Skolder, R.C. Gorman, and the now deceased Earl Biss, to name but an obvious handful. 49 Taken in combination with the examples offered by Pletka and others, this suggests that certain forms, styles, or manners of expression, and perhaps even content itself, are likely to sell if well executed, regardless of the ethnicity claimed by the artist producing it. 50 It also presents the possibility that, as one rather successful and enrolled Oklahoma painter recently put it, if these guys would spend half as much time in the studio improving the quality of their art as they do running around worrying about other people's identity cards, they'd have a hell of a lot less to complain about. 51. The acrimony attending NAA's denunciation of an artistic nobody like Free Soul suggests that many of those provoking the organization's ire are involved in arts and crafts production only peripherally, if at all. Instead, they belong to a growing legion of plastic medicine men and New Age hucksters whose increasingly lucrative trade consists of peddling bogus Native American rituals and or pseudo-religious tracts designed to share ersatz renderings of beliefs and practices which indigenous societies all but invariably hold to be most sacred. The problems here are manifest. First of all, there is nothing at all in the 1990 Act which prohibits these activities by non-Indians impersonating Indians. Even if there were, or the Act were somehow expanded to encompass such things, the fact is that many of the worst offenders, the late Sun Bear, for example, Eagle Man and numerous others, are themselves enrolled in federally recognized tribes. 52 Conversely, few if any of the non-Indians involved, Lynn Andrews, Robert Bly and Carlos Castaneda to name but three of the more prominent from a steadily lengthening list, have ever pretended that they themselves are Indians. 53. At issue in this connection are matters mostly of attitude and content rather than identity. 54 It follows that the best antidote to the malady, and probably the only one available in a country like the United States, where even the most objectionable expressions of New Age sensibility are swathed in a blanket of First Amendment protections, will be found not in legislation but within the arena of public discourse. Ironically, some of those who have proven most committed and effective in this respect I feel no hesitancy about including myself in any such list, along with people like Cherokee anthropologist Raina Green, have been undermined by identity police attacks resulting from their opposition to the 1990 Act. 55 The situation has, in turn, been seized upon by New Age polemicists like Stephen Harrod Burner as a means of bolstering their own positions. 56 Further contradictions. In 1992, conservative non-Indian columnist James J. Kilpatrick, writing with reference to the situation of Gene Rorex, remarked that the Arts and Crafts Act appeared to have more to do with restraint of trade than it did with ensuring the legitimacy of arts and crafts. 57 In this, he was to some extent reflecting a view expressed 2 years earlier by Wilma Mankiller, who observed that many of the Act's most vociferous supporters seemed to be motivated more by the prospect of personal financial gain and or resolving psychological insecurities concerning their own identities than by any discernible interest in reinforcing indigenous sovereignty. 58 The example used by Chief Mankiller was that of a man who was an artist himself, a 1/64th degree Cherokee who has been a member of the Cherokee Nation for only 2 years. Prior to that time, he entered several Indian art shows. Now, he is attempting to prevent others from doing the same. 59 Such a characterization would certainly appear to fit a number of key players, beginning with the Act's primary congressional sponsor, Colorado Representative Ben Campbell, who has been quoted as saying that only a few so-called Cherokees who could not prove their ancestry have complained that it is unfair. 60 Long before he was enrolled as a Northern Cheyenne in 1980, Campbell, working under the name Ben Nighthorse, fashioned a highly lucrative career as an American Indian jeweler in the Southwest. By his own account, Campbell's impersonation of an Indian during the period in which he was neither enrolled nor otherwise certified resulted in his averaging $150,000 per year in profits. This translated into an opulent lifestyle graced by an upscale ranch near Durango, Colorado, a collection of thoroughbred horses and expensive sports cars that he bought new every year. 61 Moreover, although he contends that a real Indian should have no problem tracing his background in compliance with the Act. 62 Campbell's own experience readily attests to the opposite. After expending what he himself has estimated as 14 years and $40,000 in a quest to document his identity, sums of both time and money which are surely beyond the means of most people, he failed rather spectacularly to do so. 63 This is doubly interesting in that, while rules governing Northern Cheyenne enrollment require documentation that applicants be at least one-half Cheyenne by blood, Campbell has publicly conceded that he is unsure of his own quantum and that therefore no specific percentage of Indian blood is claimed. 64 The situation is complicated even further by the fact that the one tenuous bit of evidence linking Campbell to any native ancestry suggests he is more likely of Jicarilla Apache, Ute, or Puebloan and Cheyenne descent. In the winter of 1916, a boy calling himself Albert Valdez appeared at the Crow Agency, in Montana. When questioned by agency superintendent Even W. Estep, the boy said he thought he was part Jicarilla Apache. On this very meager basis, never verified, Estep enrolled the boy as a half Apache in the reservation boarding school. There, young Valdez remained only 3 months before running away to take up residence with the Black Horse family at nearby northern Cheyenne. Then, on July 10, 1919, he enlisted in the Army under the name Albert B. Campbell, turned his back on his Indian ancestry, and eventually sired Ben Campbell. Based upon the name used by his father upon enlistment, Ben Campbell has adduced that little Albert Valdez was actually Alexander Valdez, son of a Mexican immigrant named Venceslao Valdez and Fortunata Campbell, who lived in Tierra Amarilla, New Mexico, and Pagosa Junction, Colorado, near the Jicarilla Apache Reservation. While Fortunata may well have been a Genizaro, there is no evidence that she was actually of Jicarilla rather than Ute or Puebloan extraction. Indeed, her mother, Ramona Mestas, grew up in Taos and, while Mestas is certainly the name of a Genizaro family to which she may or not have belonged, it is associated with the Utes, not the Jicarillas. As to the supposed Cheyenne connection, aside from young Valdez's 2-year stint with the Black Horses from which Ben Campbell's night horse obviously derives, it is based upon the thoroughly speculative assumption that Ramona Mestas was actually a young Cheyenne woman whom the Cheyennes themselves record as having been killed during the 1864 Sand Creek Massacre. Although there is absolutely nothing to support his contention, Ben Campbell claims to have just sort of accepted the proposition that, instead, she survived, made her way to Taos, and was then adopted into one or another Mestas family. As the senator himself now declaims with staggering circularity of logic, Indians have their own ways of putting things together. And this is the man who professes a belief that others' unproven assertions of native identity constitute fraud. 65. One can, and probably should, feel considerable sympathy for the senator's plight. No more so, however, than for the many others in the same situation mentioned by Little Bighorn Community College President Janine P. Windyboy while remarking upon Campbell's example. 66 The fact is that these many others are not customarily privileged to resolve their difficulties by enrolling on the basis of such nebulous documentation as Campbell's. On the contrary, people with far better proof that they are who they say they are routinely turned down by tribal enrollment committees. This raises the question of why the Northern Cheyennes opted to treat Campbell in such preferential fashion. The answer, unfortunately, may be as simple as the fact that, as he himself has recounted, he has long been strategically lavish in his bestowal of gifts upon them, for example the creation of a handsome ceremonial pipe, richly inlaid with stones and silver and decorated with beads and feathers for the tribe as a whole, the crafting of a drum and minting of 50 commemorative medals for the politically important Crazy Dog Society, the fashioning of a beautifully inlaid buffalo skull for the reservation's Dull Knife Community College, the making of a unique gold and blue coral ring for a key elder, and so on. 67 An additional incentive may be discerned from the view expressed by Cheyenne Elder Austin Two Moons that it might be useful for the Cheyennes to have one of their own in Washington, D.C., even if he weren't, strictly speaking, a Cheyenne. 68 While naturalization of citizens is of course the right of any nation, indigenous no less than any other, the context at issue here obviously opens up the prospect of rich and powerful non-Indians being officially enrolled as tribal members while powerless and impoverished Indians are regularly denied the recognition of their identity conveyed by such enrollment. By all appearances, then, an exception of the sort not readily available to more run-of-the-mill applicants was made when it came time to process the senator's paperwork. Much the same reputedly pertains to the enrollment as a Southern Cheyenne of federal lobbyist Susan Schoen Harjo, elsewhere described as one of the prime movers behind the Indian Arts and Crafts Act 69. Although Harjo has publicly denied having been enrolled by the Southern Cheyennes long after she'd established herself as a professional American Indian spokesperson, she also identifies herself as a Muskogee, a people with whom she is not enrolled at all. 70 While it may be true that there is Nothing intrinsically wrong with the latter practice. Harjo is undeniably related to the Muskogees by marriage. Hers is exactly the sort of unauthorized self-identification she has proven so vituperative in denouncing as ethnic fraud when employed with equal or greater validity by others. 71 Such problems attend the status of virtually every major figure among the identity police. 72 Nor do supporters of the act fare better when extending claims that they are somehow defending native aesthetic tradition from encroachment or corruption by outsiders. 73 Ben Nighthorse, for one, has stated explicitly that he considers traditional styles to be overworked and worn out, and that the whole point of his own jewelry designs as well as those of the famed Charles Liloma, Preston Monongai and others has been to depart from traditional patterns by incorporating both new materials and influences as diverse as Tiffany, Cellini, Boucheron, and Faberge. 74 With respect to the fine arts approach to aesthetic expression embraced by virtually all members of the NAAA, as well as their counterparts in cinema and photography, there is quite literally no tradition either to defend or to depart from. As J.J. Brodie framed the matter more than a quarter century ago. Except for a few years at San Ildefonso Pueblo, Indian easel painting was always a non-tribal art with only the most tenuous roots in any tribal art system. Produced for urban industrial consumers, it was assumed to be tribal, but as it developed in non-tribal, anti-tribal, or pan-Indian environments, its forms could never be anything but non-tribal, anti-tribal or pan-Indian. If ever an art can be described as schizoid, it was Indian easel painting until it reached its most recent phase. In this phase, the problem ceased to exist. It has no style, manner, tradition, nor anything else that identifies it as Indian, the artist simply happens to be Indian. 75 This is not to say that specifically native values and perspectives cannot be brought to bear with good effect in such work, just that there is nothing inherently Indian in the media themselves. Further, for a displaced and thoroughly assimilated Chippewa like the NAAA's David Bradley, adopted by a white family at a very early age, never a functioning part of his own culture and unable as a result even to speak his language or practice his ceremonies, to advance himself as a sort of repository/protector of traditional values and perspectives is ludicrous to the point of insult. Fraud, be it said, comes in many forms. 76 On the matter of sovereignty, probably the strongest, or at least most appealing, argument put forth by proponents of the 1990 Act concerns the need to reinforce the sovereignty of indigenous nations. As Bradley articulated the idea, we are sovereign nations, and we have the right to determine who is a member of our nation and who is a citizen of our nation. We need to protect not because of its economic impact, but for the preservation of the Indian people. You talk about culture. The majority of Native American Indian artists are involved because of culture. As a sovereign nation, we have a right to protect our rights. 77 Speaking on behalf of the National Congress of American Indians, of which she was then executive director, Susan Harjo seconded such sentiments in 1989, informing the House panel convened to hear concerns regarding the then proposed legislation that we see this as a sovereign issue involving recognition of the inherent sovereign right of the Indian nations to determine sovereignty. 78 And again, to quote a representative of the 8 Northern Pueblos Council during the same hearings, we feel strongly that tribes should determine who is Indian or who is recognized by the tribe. Statements were made about the Indianness of various individuals. I strongly feel and relate that to other racial and ethnic groups. I think there's a very strong distinction here. Tribes are recognized by the federal government as sovereign nations, and we're the only racial or ethnic group that's recognized. So I don't think it's fair to compare one's ethnicity and one's racial background. And so we strongly feel that tribes should determine who is a member and who is not a member, whether they're recognized by the government or not recognized by the government. 79 To put it most charitably, such statements, and the record is filled with many more, are simply incoherent. First of all, despite the radical rhetoric with which Harjo larded her presentation, decrying the terms of colonialism imposed upon native peoples in the U.S., the reality is that the very term tribe, which she and her colleagues bandy about so freely, is itself a colonialist imposition. 80 In addition, the paradigm of federal recognition/authority they sought to invoke via the Act constitutes the essential doctrinal apparatus rationalizing U.S. colonial dominion over native North America. 81. Second, contrary to assertions made by the Pueblo representative and many others, the United States did not enter into treaties with or otherwise recognize the sovereign standing of American Indian peoples as racial or ethnic groups. By constitutional provision, the federal government has always been legally precluded from entering into treaty relations with any entity, including tribes, aside from other nations. 82 As recently as 1977, the U.S. Supreme Court has unequivocally reaffirmed this crucial distinction in U.S. v. Antelope. Federal regulation of tribes is governance of one sovereign political communities. It is not to be viewed as legislation of a racial group consisting of Indians. 83. Third, and most important, proponents' wholesale confusion of the political with the cultural and both with the racial in the formulation of federal identity criteria threatens to undermine what little residual sovereignty has been left to indigenous nations at the dawn of the 21st century, most especially with respect to our ability to determine the composition of our own citizenry. 84 This is because, at base, it is no more logically necessary for a person to be an enrolled member of a federally recognized tribe to be ethnically Indian than it is for another person to be a citizen of a European country in order to be construed as Euro-American, or of Italy in order to be described, with greater ethnic precision, as an Italo-American. 85. Italian nationals are, of course, imbued with a spectrum of rights, privileges, entitlements, and responsibilities which are not automatically shared by their non-citizen ethnic Italian counterparts. Precisely the same principle of differentiation pertains with respect to enrolled and unenrolled American Indians. The two groups are politically distinct, or at least distinguishable, even though they in many ways hold a cultural/historical heritage in common. 86 And, whatever the differences in respective political standings, neither group is sociologically/anthropologically more valid than the other. 87. A serious legal rub enters into the 1990 Act's substitution of nationality for ethnicity when it is taken in combination with its advocates' contention that the law is necessary to protect their version of native identity as an intellectual property right and/or marketable commodity. 88 Since such rights are vested primarily in individuals rather than in governments, the conjuncture at issue makes it virtually inevitable that at least some indigenous governments will end up being defendants in legal challenges by disgruntled non-members who are denied certification or who are certified but question the assumed authority of the tribe over them. 89. If Indian identity is property, in which one has intellectual property rights, then the question arises whether those individuals who have a legitimate claim to being Indian by some accepted standard, but who are not Indians under the statute, have been deprived of their property without due process of law. 90. It might be argued, as it has been by Harjo and others, that due process guarantees accrue under the Fifth Amendment to the U.S. Constitution and thus have no bearing on the internal mechanisms by which tribal governments determine their enrollment procedures. The 1978 Martinez opinion is often cited as evidence in this regard. Martinez, however, concerned how such governments went about defining their own constituents, while the Arts and Crafts Act is expressly aimed at non-members. 91 Moreover, in demanding promulgation of a federal statute on the matter of native identity, both tribal officials and independents like Harjo implicitly conceded federal jurisdiction over such questions. Litigation will therefore necessarily occur in federal courts, subject to inquiries as to whether the Act creates a legal classification based upon race. Since leaving aside statements like that of the above-quoted Pueblo Council spokesperson, the requirement for enrollment in the vast majority of all federally recognized tribes at this point begins with some minimum degree of Indian blood, there can be no serious doubt that it does. 92 From there, since all such classifications are inherently suspect under U.S. law, the question becomes whether, subject to the most exacting scrutiny required by the 14th Amendment to its Constitution, the federal government can demonstrate to a juridical certainty that the classification is necessary to a compelling interest, not of indigenous governments but of the United States itself. 93. For native peoples, this is, completely and utterly, a no-win situation. While our side, which in this instance can only be construed, with ultimate absurdity, as our federal colonizers may prevail in a few or even many potential cases, the unfortunate truth is that any law, statutory or not, has the potential to change the entire legal structure of its context. Law and social change is not a one-way street, but interactional. 94. In other words, it will likely require only a single loss in court for all racial constructions of Indian identity, including those pertaining to tribal enrollment, to be ruled impermissible. At that point, federal intervention will be judicially mandated, not with respect to the self-identification of ethnic Indians, but with regard to how native governments themselves go about determining the qualifications for indigenous citizenship. The United States will then be back in the business of directly administering tribal roles in exactly the same sense it was a century ago, during the era of allotment and the Dawes Commission's. 95 assertions, or, more properly, reassertions of native sovereignty will be set back 100 years or nullified altogether. Worst of all, perhaps, it can be said with no small measure of accuracy that this time we asked for it. The magnitude of ethnicity. It's not that there haven't been ample warnings. Beyond the statements of native leaders like Wilma Mankiller, unenrolled artists like Durham and Jean Rorex, and academic activists like myself, even a U.S. Senator, Jeff Bingaman of New Mexico, offered a thoroughly negative assessment in 1991 as to what implementation of the act might mean. It is simply not sufficient or logical, he argued, to say that non-enrolled Indians can continue with their art, so long as they refrain from talking about it in connection with their heritage. 96. The act appears to create the odious spectacle of requiring American citizens to carry paperwork establishing their racial or ethnic purity before they can fully practice their chosen professions. 97. Bingaman went on to predict that suits would arise on the basis of the First, Fifth, and 14th Amendments, and that the courts would be unlikely to uphold the statute in the face of such challenges. The outcome, he suggested, might well be an infringement upon rather than a bolstering of the sovereignty presently enjoyed by native governments. 98. Meanwhile, all efforts by ad hoc identity policers to finesse the situation by articulating some sort of definitional reconciliation between the parameters of ethnicity and the constraints of tribal enrollment have failed. Representative of the genre was the postulation offered by self-styled Cherokee genealogist David Cornsilk when he opined in 1991 that, to be considered Indian in even a generalized ethnic sense, one must be directly and demonstrably descended from persons who stayed with the tribe, enrolled when required to, and otherwise lived an Indian life. 99. Apart from the fact that in this rendering living an Indian life comes dangerously close to doing what one is told to do, whenever one is told to do it, a concept which would undoubtedly prove startling to some of Native America's more significant historical figures, Cornsilk begs even the most obvious questions. As analyst Gail K. Sheffield has pointed out, the American Indian experience also includes people who, because they were Indian, were separated from the tribal context. In addition to those who chose to avoid government roles, there were significant dislocations created by the federal government through policies that encouraged adoption of Indian children by whites and relocation of rural Indians to cities. 100. What of them? On these equally authentic Indian experiences, Cornsilk and his colleagues remain alternately silent and contemptuously dismissive, postures which leave the ethnics little recourse but to take to the courts now that such arbitrary denials of their identity have become law. 101. The magnitude of the threat to indigenous sovereignty thus posed may in some ways be calibrated in direct proportion to the size of the ethnic Indian population comprising the pool of potential plaintiffs. Here, a 1991 statement by Jonathan Taylor, then Principal Chief of the Eastern Band of Cherokee, is instructive. There are many people in this country, including an inordinate percentage of whom live in the Southeast, that have varying degrees of Indian blood in their veins. There are, without question, hundreds of thousands of people in the Southeast and in Oklahoma who have some degree of Cherokee ancestry and who are proud of that ancestry. 102. Comparable observations might be made, of course, about a number of other federally or state-recognized peoples besides the Cherokees. 103 Further, there are a number of nations such as the Klamaths whose federal recognition was terminated pursuant to House Resolution 108 during the 1950s, and who therefore, although they continue to be considered Indians for certain purposes pertaining to treaty rights, are no longer Indians within the meaning of the 1990 Act. 104 Finally, there are literally hundreds of groups, sometimes whole peoples, whose existence has, for whatever reason, never been formally acknowledged by either a state or the federal government. The Abenakis of the Maine/Vermont area are a prime example of the latter. 105. Exactly how many people fall into the overall category of unenrolled ethnic Indians is open to discussion and has been subject to broad interpretation. Of the 1,878,285 persons initially identified as American Indians in the 1990 U.S. Census, only 746,175 were actually enrolled. 106 While this data suggests that the number of ethnics is approximately 1.1 million, it is also true that several million others were identified as having some degree of native ancestry. 107 Analysts like Joanne Nagel and demographer C. Matthew Snip have demonstrated rather convincingly that a realistic working estimate would be something on the order of 7 million. Ethnic Indians. 108 Native demographer Jack D. Forbes has also dealt seriously with the question, and his preliminary total comes in at around 15 million. 109. However many genuine ethnic Indians there may be, it is clear that their numbers greatly exceed those of their formally enrolled and recognized relatives. Certainly, there are more than enough to visit a virtually endless rain of lawsuits upon the heads of the 400 or so existing tribal councils, should the latter display the effrontery of attempting to employ federal law as a means of suppressing or negating ethnic Indians' sense and expression of indigenous identity. If nothing else, the expense of defending against the potential proliferation of legal actions stands to vastly outstrip any possible financial benefit the councils anticipated as accruing from their support of the Arts and Crafts Act. 110. Alternatives? As the internationally acclaimed but unenrolled Mescalero Apache painter John Nieto foresaw in his 1989 testimony before Congress, the hair-splitting among Indian people invited by efforts to legislate Indianness is both divisive and counterproductive. 111 At present, while it is difficult to name a single bona fide non-Indian artist or craft worker whose career has been seriously disrupted by the 1990 Act or, for that matter, a single native artist whose career has tangibly benefited from it, the toll it has taken on indigenous people is readily apparent. 112 This is true, not only in terms of the severity of the bickering passage of the Act has provoked between and within enrolled and non-enrolled communities, but in the legal/political/financial jeopardy we have incurred in its wake. Objectively, any law carrying with it the combination of such heavy losses and meager gains as the Arts and Crafts Act is one that native North America should vigorously and collectively oppose. But, beyond even the possibility of repealing the specific statute at issue, or otherwise affecting its neutralization, there is a compelling need to address the festering complex of attitudes and misunderstandings which led far too many Native people to support such legislation in the first place. 113 In the alternative, the problematic outlooks which gave rise to the Act will inevitably linger, continuing to flare up from time to time, always manifesting themselves in concrete forms of self-defeat. Topping the list of things in need of correction is the binary and simplistic apples/oranges, is/is not construction which uniquely pervades the U.S. discourse on native identity. 114 An expansion of descriptive vernacular to at least the extent evident in Canada, where both status and non-status Indians are officially recognized as being indigenous, albeit occupying different politico-legal niches, would go far in this direction. 115 Adoption of the Canadian classification of Métis that is, of a specific strata of biologically/culturally mixed people might also prove quite useful, at least in analytical terms. 116 For any such transition in thinking to occur, however, it is imperative that holdovers from the long discredited tradition of 19th century Euro-American scientific racism be jettisoned by Indians themselves. 117 Not only does the internalization and adherence by a frightening number of native people to such antiquated racialist myths as blood quantum serve to preclude understandings of Indianness in political, cultural, or even genealogical terms, they are already proving suicidal for a number of indigenous nations when used as enrollment criteria. 118. Put bluntly, American Indians have, overall, long experienced far and away the highest rate of outmarriage of any racial group in North America. 119 The net result, throughout the 20th century, has been a steady decline in the pool of pure or full-bloods while the number of native offspring displaying ever more mixed lineage has increased explosively. 120 At this point, the proportion of full-bloods within most indigenous populations is minimal and declining among the Minnesota/Wisconsin Chippewa, for example. It is estimated to have dropped to a mere 5% or already non-existent. 121 Given this context, exclusive racial definition of membership will gradually cause a tribe to die out. 122. Efforts to cope with this harsh reality while nonetheless clinging to conceptions of race have led some tribal councils to venture into the realm of the sublime. Consider the example of the Umatilla, a small people in Washington state. When informed by a consultant that enforcement of enrollment criteria requiring applicants to document 1/4 degree of Umatilla blood would result in their virtual extinction within 50 years, they revised their enrollment guidelines to require proof of any degree of Umatilla blood in combination with at least 1/4 degree in some other federally recognized tribe. 123 As one critic of such maneuvers has observed, they've completely lost touch. I'd really like to see them go before a judge, which is exactly what they're going to have to do if they actually try to enforce this thing against people who are demonstrably of Umatilla descent while admitting those with other native pedigrees, and try to explain how being genetically linked to the Lakotas or Mohawks makes a person one whit more Umatilla than being full-blood Irish, Bantu, or Japanese. This has nothing to do with culture or sovereignty. It's a transparently racist construction, no more defensible than any other. 124. A more tenable approach may be found in that of the Cherokee Nation of Oklahoma, which dropped blood quantum in favor of genealogy as the decisive criterion for enrollment during the 1970s. What the CNO achieved as a result might well serve as an example worthy of replication or adaptation across the continent. The Oklahoma Cherokee, without a reservation land base, have been able to survive tribally by an inclusive definition of what it is to be Cherokee. Their definition allowed relatively large numbers of people with Cherokee lineage but relatively small amounts of Cherokee blood into the tribe. This allowed the tribe to re-establish itself after virtual dissolution and to achieve political power in Oklahoma. The tribe, in turn, has protected a smaller group of full-blood, more traditional Cherokee from American non-Indian ways of life. 125. Responding to arguments that the CNO model has led to an unnecessary degree of acculturation, genetic dilution, and comparable maladies, historian Mary Young points to a multitude of peoples such as the Yamasee who seem to have gone out of existence altogether while pursuing other, more exclusionary strategies. The Cherokee people today still have a tribal identity, a living language, and at least tribal government bodies, she says. That's more than one can say of the Yamasee. 126. Although no other people has as yet adopted inclusive policies of enrollment to the extent evident among the Cherokees, there are signs that some are considering and in a few cases experimenting with their own variations. Both the Yankton Sioux tribe of South Dakota and the Oklahoma Tonkawas have, for instance, issued certifications of Indian identity to craftspeople who, although not biologically native, had been adopted and raised by enrolled tribal members from an early age. 127 The Sault Ste. Marie Chippewa in Michigan have also expressed interest in developing guidelines which would allow for the certification of such individuals. 128. These signs augur the possibility that there may yet be a way to bridge more generally the now widening chasm separating the core population of American Indians from a much larger body of Americans of Indian descent, who can recall, legitimately, some amount of Indian ancestry, and those who have, through marriage, adoption, or other forms of naturalization been incorporated into indigenous societies? 129 If so, it seems likely that the threats to native sovereignty posed by the Arts and Crafts Act will prove transitory, as will much of the duplicity, hypocrisy, and sheer maliciousness which has marked the behavior of many of its more outspoken proponents. Thus may the identity police be consigned to their proper place in history's dustbin. Such would be one of the strongest imaginable reassertions of indigenous tradition because, in the end, what seems important, is that American Indians be allowed to do their own defining, either as individuals or as tribes. This may occur on the individual level through self-identification, it may occur on the tribal level through formal membership. One may object that self-identification allows considerable variation among individuals defined as American Indian, but American Indians have always had tremendous variation among themselves, and the variations have in many ways been increased, not reduced, by the events of history, demographic and other. Allowing self-identification and the differences it encompasses is simply to allow American Indians to be American Indians, something done all too infrequently in the short history of the United States. 130. 3. Confronting Columbus Day. An argument based in international law. The fact that domestic law does not punish an act which is an international crime does not free the perpetrator of such crime from responsibility under international law. International Law Commission Report of Principles. UN Doc. A/1706, December 13, 1950. The following is a brief supporting a motion to dismiss charges against the author, Russell Means, Glenn T. Morris, and Kawir Red Elk, principal leaders of the American Indian Movement of Colorado, for having halted a Columbus Day celebratory parade near the Colorado State Capitol building in Denver, on October 12, 1991. Having stopped the parade for approximately 45 minutes, the defendants, supported by more than 300 other protesters, refused police directives to remove themselves from the street until we were arrested. The four of us were then charged with refusing to obey a lawful police order, obstructing a public thoroughfare, and disturbing the peace, offenses carrying a combined potential of 2 years incarceration. The charges were not dismissed on the basis of the arguments contained herein. At trial, however, we were allowed considerable latitude in presenting them to the jury. In the end, we were not only acquitted on all counts, but the jury foreman read into the record a stinging indictment, concurred in unanimously by his colleagues, of the parade organizers, police and city officials, the local press, and the whole notion that either Columbus or his legacy are worthy of public commemoration. In the aftermath, it was decided that I should publish the brief insofar as it stands to be adaptable to other contexts, not only among those who would seek to confront the spectacle of Columbus Day, but others who wish to take comparable positions with regard to the public agitation by the Ku Klux Klan, American Nazi Party, and similar organizations of the racist right. It is also felt that the material may well lend itself, not only to utilization by defendants in criminal proceedings, but to public education and potential litigation against groups which, directly or indirectly, endorse racism, colonialism, genocide, and aggression as acceptable forms of behavior. The brief. The defendants contend that we were engaged in entirely lawful conduct on October 12, 1991, and that such charges as are presently lodged against us as a result of our actions on that date are invalid. We anchor this contention in various elements of international law and legal doctrine, most specifically the 1948 Convention on Prevention and Punishment of the Crime of Genocide, to which the United States is by its own assertion and comportment bound. Genocide and the Genocide Convention. The crime of genocide is usually understood in the United States as being more or less exclusively associated with the forms and programs developed by Nazi Germany in its drive to physically exterminate such untermenschen as the Slavs, Gypsies, and, especially, the Jews. This is an entirely erroneous view. The meaning of the term, coined by the Polish jurist Raphael Lemkin in 1944, is something very much broader, both in temporal scope and in terms of the techniques employed. Although the word itself was constructed by combining the Greek genos and the Latin citium, according to Lemkin it describes a process considerably more multifaceted and sophisticated than simple mass murder. Indeed, mass murder may or not be present within the genocidal context. Generally speaking, genocide does not necessarily mean the immediate destruction of a nation, except when accomplished by mass killing of all the members of a nation. It is intended rather to signify a coordinated plan of different actions aimed at destruction of the essential foundations of the life of national groups, with the aim of annihilating the groups themselves. The objective of such a plan would be disintegration of the political and social institutions, of culture, language, national feelings, religion, and the economic existence of national groups, and the destruction of personal security, liberty, health, dignity, and the lives of individuals belonging to such groups. Genocide is the destruction of the national group as an entity, and the actions involved are directed against individuals, not in their individual capacity but as members of the national group. 1. Reinforcement of the view that genocide often entails methods radically different than the outright murder of large numbers of people is found in Lemkin's observation that, genocide has two phases, 1, destruction of the national pattern of the oppressed group, the other, the imposition of the national pattern of the oppressor. Too clearly, the latter imposition could not occur if it were a definitional requirement that all or even most members of the oppressed group be killed in order for a genocide to have occurred. To the contrary, as it was put by the Lebanese delegate to the United Nations Committee which produced the draft Convention on Punishment and Prevention of the Crime of Genocide in 1947, what is at issue is the destruction of a human group, even though the individual members survive. 3. This guiding conceptualization of genocide as the creation of conditions inducing the coerced disappearance of discrete cultural entities resulted in a formulation within the initial UN Draft Convention on Genocide which focused not only upon mass killing, but upon actions and policies which brought about the disintegration of the political, social, or economic structure of a group or nation and the systematic moral debasement of a group, people, or nation. 4. In the subsequent draft convention produced by the UN Secretariat in 1948, genocide was defined in a twofold way, as destruction of a group and as preventing its preservation and development. 5. All in all, the construction of international law expressly prohibiting genocidal conduct followed, as the Lebanese delegate put it, the idea that distinct human groups should be treated as absolute entities, which it would be criminal to attack. 6. In the end, Article 2 of the U.N.'s 1948 Convention on Prevention and Punishment of the Crime of Genocide, December 9, 1948, effective January 12, 1951, specifies 5 categories of activity, only one of which involves outright killing, to be genocidal when directed against an identified national, ethnical, racial, or religious group, and therefore criminal under international law. Killing members of the group. Causing serious bodily or mental harm to members of the group. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. Imposing measures intended to prevent births within the group. Forcibly transferring children of the group to another group. Under Article 3, the Convention makes the following acts punishable under the law. Genocide. Conspiracy to commit genocide. Direct and public incitement to commit genocide. Attempt to commit genocide. Complicity in genocide. Article 4 states that all persons shall be held accountable for acts committed under Article 3, whether they are constitutionally responsible rulers, public officials, or private individuals, while Article V calls upon the nations of the world to enact the necessary legislation to give effect to the present convention and, in particular, to provide effective penalties for persons guilty of genocide or any of the other acts enumerated in Article 3. Because the convention was intended to prevent as well as punish commission of genocide, a broad latitude of meaning, centering in notions of advocacy, has been associated with the provisions concerning incitement of and complicity in genocide and or genocidal processes. 7. In situations where there is disagreement as to the meaning of such terms, or in which a given government professes confusion concerning the substance of the law, the Convention provides under Article 9 for interpretation and adjudication by the International Court of Justice. U.S. response to the Genocide Convention. It is instructive that, although more than 100 nations rapidly ratified the Genocide Convention, the United States declined to do so for a period of 40 years. The reason for this extensive delay resides primarily, as revealed in the records of Senate debate of the Genocide Convention after it was referred to that body by President Truman in 1950, in congressional concern that a broad range of federal policies vis-a-vis minority populations in the U.S. might be viewed as genocidally criminal under international law. 8 Considerable anxiety was expressed by various senators and expert witnesses over the years that certain activities of subordinate governments and private parties, each of them sanctioned and/or protected by the federal government, might well violate the terms of the convention. Examples include the persistence of Jim Crow laws in various southern states despite the extreme and well-recognized mental harm such statutes imposed upon African American and other readily identifiable minority populations. 9 Another illustration is found in official toleration of the organizing activities of the Ku Klux Klan and comparable groups, despite their advocacy of patently genocidal principles and frequent resort to physical violence against racially defined target groups. 10 Other issues specifically concerning American Indians, such as involuntary sterilization programs and the massive forced transfer of children, will be covered below. When the United States Senate finally ratified the Genocide Convention during the closing days of the 100th Congress, it was largely on the basis of a growing belief that the U.S. was forfeiting moral leadership in world affairs as a result of its non-ratification. 11 And on the basis of the Genocide Convention Implementation Act of 1988, a statute which incorporated certain language designed to narrow the intent of the internationally accepted convention in its application to the United States. 12 Further, the instrument of treaty ratification which the Senate instructed President Ronald Reagan to deposit with the UN Secretary-General in November of 1988 contained a resolution of ratification, adopted February 19, 1986, and otherwise referred to as the Lugar-Helmholtz Sovereignty Package. The resolution contained a reservation stating, "Authing in the Convention requires or authorizes legislation or other action by the United States of America prohibited by the Constitution of the United States as interpreted by the United States." It is thus plain that the Senate sought, even while enacting legislation to implement the Genocide Convention and effecting a corresponding ratification of its terms by treaty, to exempt the U.S. from the implications of international legal custom and convention. In effect, it sought to elevate the U.S. Constitution to a status above that of international law. As has been noted elsewhere, the acknowledged purpose of the sovereignty package was to reduce the convention to nothing more than a mere symbol of opposition to genocide. This fact alone raises the question of whether the United States ratified in good faith. 13 The package has been described by a Senate committee as an embarrassment to the United States insofar as it clearly suggests that the U.S. formally seeks to retain prerogatives to engage in or sanction policies and activities commonly understood as being genocidal, even while professing to condemn genocide. 14. Legal validity of the U.S. posture on genocide. There is abundant evidence that the Senate was aware, even as it advanced its sovereignty package purporting to subordinate the Genocide Convention to the U.S. Constitution, that the gesture contradicted the requirements of the Constitution itself. Not the least indicator of this lies in the testimony of an expert witness, American Bar Association Representative George Finch, in his testimony before the Senate Foreign Affairs Committee during its 1950 hearings on the matter. After observing that a formal treaty would be required in order for the U.S. to become a party of record to the convention, Finch observed that, by the United States Constitution, treaties are the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. 15 In other words, the government would be unable to unilaterally legislate exceptions for itself with regard to the terms, provisions, and understandings of the Genocide Convention if it were ratified by treaty. On its face, the problem might seem to have been resolved, domestically at least, by a Supreme Court opinion rendered in Reed v. covered that any treaty provision that is inconsistent with the United States Constitution would simply be invalid under national law. Under Article 27 of the 1969 Vienna Convention on the Law of Treaties, however, no state can invoke the provisions of its internal law as a reason for not abiding by a treaty obligation. 16 Although the United States has not yet ratified the Vienna Convention, it has officially recognized it as being the definitive promulgation of international law with regard to treaty relations. 17 Hence, the Senate's attempt to carve out exemptions for itself from the force of international law has no legal integrity, and is subject to protest or renunciation by other parties to the Genocide Convention. Indeed, a decade before the Senate's sovereignty package was submitted to the UN Secretariat, the rapporteur of an Economic and Social Council working group studying problems in the Genocide Convention's implementation worldwide reviewed the draft language of the various proposed U.S. reservations and understandings, and officially concluded that Article I was invalid insofar as it failed to conform to Vienna Convention standards. 18 The sovereignty package was nonetheless submitted in 1988, with the result that by December 1989 9 European allies of the United States, Denmark, Finland, Ireland, Italy, the Netherlands, Norway, Spain, Sweden, and the United Kingdom had entered formal objections to Article I. 3 of these nations, Denmark, the Netherlands, and the United Kingdom, also entered strong objections to Article I of the package, in which the Senate attempted to reserve unto itself the right to determine when and if the ICJ might have authority in dispute resolution involving the U.S. The Netherlands declined to recognize the United States as a party to the Genocide Convention until such time as these difficulties are corrected. The other 8 nations elected to hold this matter in abeyance, pending discussions. 19 As has been observed elsewhere, the convention has already been ratified by over 100 states, and under international rules of treaty law these states have a say in determining whether or not the U.S. conditions are acceptable. Why insisting on adoption of the sovereignty package, the Senate effectively gutted U.S. ratification of the convention. 20 Moreover, it is legally irrelevant whether or not the United States ever attempted to ratify the Genocide Convention, or whether it manages to accomplish such ratification in a valid fashion in the future. Genocide has come to be seen as a crime within customary law, and the convention is thus binding upon the U.S. whether or not it chooses to formally acknowledge the fact. 21 This is a matter tacitly recognized by the federal government itself, as is indicated in the authoritative restatement of the Foreign Relations Law of the United States. 22 Further, the Charter of the United Nations, to which the U.S. is a signatory, assumes that the organization can declare principles of international law, which are binding, even upon non-member states. 23 The concept of offenses against the law of nations was recognized by the classical text writers on international law and has been employed in national constitutions and statutes. It was regarded as sufficiently tangible in the 18th century so that United States federal courts sustained indictments charging acts as an offense against the law of nations, even if there were no statutes defining the offense. Early in the 19th century it was held that criminal jurisdiction of federal courts rested only on statutes, though the definition of crimes denounced by statutes might be left largely to international law. Thus piracy as defined by the law of nations is an indictable offense in federal courts, and all offenses against the law of nations are indictable at common law in state courts. 24 Perhaps the clearest U.S. recognition of this principle came during preparation for the trial of Nazi criminals at Nuremberg, a process exclusively initiated and subsequently spearheaded by the United States. 25 A U.S. working group chaired by Supreme Court Justice Robert H. Jackson decided that the Nazi leadership should be held accountable to the full measure of international law, despite the fact that much of what was at issue had never seen formal codification, never mind official acceptance by Germany. 26 Following from a passage in the 1907 Hague Convention, the Jackson Group stipulated that international law shall be taken to include the principles of the law of nations as they result from usages established among civilized people, from the laws of humanity, and the dictates of public conscience. 27 This precedent-setting formulation of customary international law was laid before the representatives of Britain, France, and Soviet Russia at the London Conference in June 1945 and served as the foundation of the London Charter, the international agreement which established the juridical predication upon which the Nazis were later tried. 28 In an interesting role reversal, Justice Jackson served as chief U.S. prosecutor in the trial of the major Nazi criminals at Nuremberg during 1945 and 1946, while Attorney General Francis Biddle served as senior U.S. tribunal member. 29 Jackson was thus in effect mandated to articulate his government's formal international legal positions through presentations against the defendants, while Biddle was charged with implementing these articulations through his rulings on points of law, votes as to the guilt or innocence of the various defendants on specific charges, and votes concerning imposition of sentence on those convicted. 30. Both men consistently went on record during the proceedings as rejecting arguments entered by counsel for the defendants that the charges against their clients were invalid because they represented enforcement of ex post facto law. 31 The U.S. position devolved upon the principle that customary international law was binding upon all governments. It is worthy of note that neither this posture, nor any other adopted by its representatives during the trial, has ever been renounced by the United States. Rather, a dictum elaborated by Justice Jackson during his opening remarks to the tribunal that in order for the standards of legality enunciated at Nuremberg to have integrity, they must be applied as much to the victors as to the vanquished has seen continuous and approving reiteration by U.S. jurists and officials. 32 The implication is obvious, having articulated international legal doctrine upon which others were tried, convicted, and sentenced, the United States is bound both legally and morally to comply with its strictures. 33. Hence, the apparent intent of the Senate's sovereignty package, to allow the United States set its own agenda and be accountable to no one with regard to its comportment on genocide, is quite invalid on both constitutional and a range of international legal grounds. 34 Further, while doing nothing to alter the force or substance of international legality, such a stance carries with it obvious overtones of Hitlerian diplomacy, compounding the impression abroad, already engendered by the Reagan administration's 1986 disavowal of ICJ authority vis-a-vis U.S. foreign policy, that the United States is becoming an outlaw nation. 35 It is, of course, incumbent upon the courts at every level to constrain government to adhere to the rule of law, international no less than any other, rather than to unrestricted prerogatives of power. Any other course of conduct on the part of the judiciary would be repugnant to both the letter and spirit of U.S. juridical doctrine. The question of First Amendment rights. Implicit to the charges against the defendants is a contention by the city of Denver that those against whom the accused directed our actions of October 12, 1991, were engaged in lawful activities protected by the First Amendment of the U.S. Constitution. The defendants contest this assumption on the basis that First Amendment guarantees of free speech and peaceful assembly are not absolute or unqualified. Such rights must be balanced against, among other things, the 14th Amendment guarantees of the right to equitable social treatment of all citizens. Other constraints center in the famous dictum that it is illegal for one to falsely shout fire, in a crowded theater. Similarly, it is well-established law that it is criminally actionable behavior to make statements which threaten the life of the President of the United States or other officials, and so forth. A range of existing statutes and regulations, long upheld by U.S. courts, concerning hate speech, harassment, verbal assault, and misrepresentation might also be cited in this regard. 36. The defendants, all American Indians, maintain that the Columbus Day festivities which were conducted in Denver on October 12, 1991, constituted a celebration of the genocide perpetrated against our people, beginning with the Columbian landfall on October 12, 1492. Insofar as this is true, it follows that the Columbus Day celebration constitutes advocacy of genocide within the meaning of Article 3 of the Genocide Convention. Further, to the extent that at least some of the elements of the genocidal process initiated by Columbus remain in evidence, the celebration constitutes complicity in genocide within the meaning of Article 3 of the Convention. Such activities, of course, are unlawful by accepted international definition, binding upon the United States and its various levels of government. Thus, not only did the participants in the Columbus Day celebration lack a lawful right to engage in the activities at issue, the city of Denver lacked legal authority to grant them a permit for this purpose. It will no doubt be argued by the prosecution that the defendants overreach in these contentions, and that the juridical waters they seek to navigate are in any event uncharted. This is untrue. Precedents, accruing from the first Nuremberg trial 37 do exist in which the United States clearly revealed its doctrinal posture with regard to the specific actions alleged here. These precedents must be considered binding upon American courts at every level. 3 examples will be used as illustration. In the case brought by the United States against Nazi Party ideologist Alfred Rosenberg at Nuremberg, Justice Jackson argued at length that the defendant was guilty of crimes against humanity on the basis of his articulation during the 1930s of ideological/philosophical theses which laid the theoretical foundation for and helped shape public opinion to accept a policy of genocide which emerged during the following decade. It is instructive that, although the British, French, and Soviet members of the tribunal declined to convict Rosenberg on this basis, the U.S. member, Francis Biddle, entered a guilty vote in behalf of his government. Rosenberg was ultimately convicted and hanged for his subsequent role in implementing criminal policies during the Nazi occupation of the Western USSR in the 1940s. 38. A similar case was brought by Jackson against pre-war Hitler youth leader Baldur von Schirach, because of his role in indoctrinating German young people to accept the premises which led to genocide and aggressive war. Ideological and emotional preparation was the central issue of the American case. In this instance, Biddle joined the other tribunal members in voting to acquit, but only on the basis that the case had not been made. Von Schirach was ultimately sentenced to 20 years imprisonment because of his wartime role in deporting Jews to extermination facilities while serving as head of the Nazi regime in Vienna. 39. Jackson made an almost identical crimes against humanity case against propagandist Julius Streicher, despite the fact that he was aware Streicher was never a member of the inner ring of Nazis, and had nothing to do with the formulation of Nazi policy. The accusations against him consisted solely of his having sometimes penned and often published virulently anti-Semitic materials. Insofar as he was found to have participated directly in no aspect of the physical extermination of the Jews, he was convicted only of having participated in the psychological conditioning of the German public which led to a genocidal outcome. On this basis, he was hanged. 40. From these 3 cases, it seems indisputable that the United States government, through participating judicial officials, committed itself firmly to both the conception and implementation of international law which proscribes advocacy of genocide even when the immediate physical implementation of genocidal policies are absent. In part, this can only be attributed to a desire, explained by Justice Jackson in his predication to the Nuremberg Tribunal's creation, not simply to punish those guilty of given offenses, but to establish an international legal groundwork barring revival of such power as had led to the Nazi genocide. 41 In the latter connection, matters of advocacy become an all-important consideration. For this reason, the United States, along with the other 3 Allied powers, complemented the proceedings at Nuremberg by implementing occupation regulations subsequently incorporated into German domestic law at the behest of the occupying powers prohibiting all celebratory demonstrations of Nazism, the display of Nazi symbols and regalia, portraits of Adolf Hitler and other Nazi leaders, and so forth. The premise of these laws and regulations was/is that celebration of a perpetrator of genocide can only be construed as advocacy or endorsement of the genocide itself. 42. Columbus and the beginning of genocide in the New World. It has been contended by those who would celebrate Columbus that accusations concerning his perpetration of genocide are distortive revisions of history. Whatever the process unleashed by his discovery of the New World, it is said, the discoverer himself cannot be blamed. No matter his defects and offenses, they are surpassed by the luster of his achievements. However tragic or unfortunate certain dimensions of his legacy may be, they are more than offset by the benefits even for the victims of the resulting blossoming of a superior civilization in the Americas. 43 It should be noted before continuing that essentially the same arguments might be advanced with regard to Adolf Hitler. Hitler caused the Volkswagen to be created, after all, and the Autobahn. His leadership of Germany led to jet propulsion, significant advances in rocket telemetry, laid the foundation for genetic engineering. Why not celebrate his bona fide accomplishments in behalf of humanity rather than dwelling so persistently on the genocidal byproducts of his policies? To be fair, Columbus was never a head of state. Comparisons of him to Nazi SS leader Heinrich Himmler, rather than Hitler himself, are therefore more accurate and appropriate. It is time to delve into the substance of the defendant's assertion that Columbus and Himmler, Nazi Lebensraumpolitik, and the settlement of the New World bear more than casual resemblance to one another. This has nothing to do with the Columbian discovery, not that this in itself is completely irrelevant. Columbus did not sally forth upon the Atlantic for reasons of neutral science or altruism. He went, as his own diaries, reports, and letters make clear, fully expecting to encounter wealth belonging to others. It was his stated purpose to seize this wealth, by whatever means necessary and available, in order to enrich both his sponsors and himself. 44 Plainly, he prefigured, both in design and by intent, what came next. To this extent, he not only symbolizes the process of conquest and genocide which eventually consumed the indigenous peoples of America, but bears the personal responsibility of having participated in it. Still, if this were all there was to it, the defendants would be inclined to dismiss him as a mere thug along the lines of Al Capone rather than viewing him as a counterpart to Himmler. The 1492 voyage of discovery is, however, hardly all that is at issue. In 1493 Columbus returned with an invasion force of 17 ships, appointed at his own request by the Spanish crown as viceroy and governor of and the mainland of America, a position he held until 1500.45. Setting up shop on the large island he called Española, he promptly instituted policies of slavery and systematic extermination against the native Taino population. 46 Columbus' programs reduced Taino numbers from as many as 8 million at the outset of his regime to about 3 million. In 1496.47 perhaps 100,000 were left by the time of the governor's departure. His policies, however, remained, with the result that by 1514 the Spanish census of the island showed barely 22,000 Indians remaining alive. In 1542, only 200 were recorded. 48 Thereafter, they were considered extinct, as were Indians throughout the Caribbean basin, an aggregate population which totaled at least 14 million at the point of first contact with the Admiral of the Ocean Sea, as Columbus was known. 49. This, to be sure, constitutes an attrition of population in real numbers every bit as great as the toll of 12 to 15 million, about half of them Jewish, most commonly attributed to Himmler's slaughter mills. Moreover, the proportion of indigenous Caribbean population destroyed by the Spanish in a single generation is, no matter how the figures are twisted, far greater than the 2/3 of European Jews usually said to have been exterminated by the Nazis. 50 Worst of all, these data apply only to the Caribbean basin. The process of genocide in the Americas was only just beginning at the point such statistics become operant, not ending, as they did upon the fall of the Third Reich. All told, it is probable that more than 100 million native people were eliminated in the course of Europe's ongoing civilization of the Western Hemisphere. 51. It has long been asserted by responsible scholars that this decimation of American Indians which accompanied the European invasion resulted primarily from disease rather than direct killing or conscious policy. 52 There is a certain truth to this, although starvation may have proven just as lethal in the end. It must be borne in mind when considering such facts, however, that a considerable portion of those who perished in the Nazi death camps died, not as the victims of bullets and gas, but from starvation, as well as epidemics of typhus, dysentery, and the like. Their keepers, who could not be said to have killed these people directly, were nonetheless found to have been culpable in their deaths by way of deliberately imposing the conditions which led to the proliferation of starvation and disease among them. 53 Certainly, the same can be said of Columbus' regime, under which the original residents were, as a first order of business, permanently dispossessed of their abundant cultivated fields while being converted into chattel, ultimately to be worked to death for the wealth and glory of Spain. 54. Nor should more direct means of extermination be relegated to incidental status. As the matter is framed by Kirkpatrick Sale in his book, The Conquest of Paradise. The tribute system, instituted by sometime in 1495, was a simple and brutal way of fulfilling the Spanish lust for gold while acknowledging the Spanish distaste for labor. Every Taino over the age of 14 had to supply the rulers with a hawksbill of gold every 3 months. Those who did were given a token to wear around their necks as proof that they had made their payment. Those who did not were, as says discreetly, punished by having their hands cut off, as Las Casas says less discreetly, and left to bleed to death. 55. It is entirely likely that upwards of 10,000 Indians were killed in this fashion alone, on Española alone, as a matter of policy, during Columbus' tenure as governor. Las Casas Brevísima Relation, among other contemporaneous sources. 56 is also replete with accounts of Spanish colonists hanging Tainos en masse, roasting them on spits or burning them at the stake, hacking their children into pieces to be used as dog feed and so forth, all of it to instill in the natives a proper attitude of respect toward their Spanish betters. Made bets as to who would slit a man in two, or cut off his head at one blow, or they opened up his bowels. They tore the babes from their mother's breast by their feet and dashed their heads against the rocks. They spitted the bodies of other babes, together with their mothers and all who were before them, on their swords. 57. No SS trooper could be expected to comport himself with a more unrelenting viciousness. And there is more. All of this was coupled to wholesale and persistent massacres. A Spaniard suddenly drew his sword. Then the whole 100 drew theirs and began to rip open the bellies, to cut and kill men, women, children, and old folk, all of whom were seated, off guard and frightened. And within 2 credos, not a man of them there remains alive. The Spaniards enter the large house nearby, for this was happening at its door, and in the same way, with cuts and stabs, began to kill as many as were found there, so that a stream of blood was running, as if a great number of cows had perished. 58. Elsewhere, Las Casas went on to recount how, in this time, the greatest outrages and slaughterings of people were perpetrated, whole villages being depopulated. The Indians saw that without any offense on their part they were despoiled of their kingdoms, their lands and liberties, and of their lives, their wives and homes. As they saw themselves each day perishing by the cruel and inhuman treatment of the Spaniards, crushed to earth by the horses, cut in pieces by swords, eaten and torn by dogs, many buried alive and suffering all kinds of exquisite tortures, fled to the mountains. 59. Such descriptions correspond almost perfectly to those of systematic Nazi atrocities in the Western USSR offered by William Shirer in Chapter 27 of his The Rise and Fall of the Third Reich. 60 But, unlike the Nazi extermination campaigns of World War II, the Colombian butchery on Española continued until there were no Tainos left to butcher. Evolution of the Colombian legacy. Nor was this by any means the end of it. The genocidal model of conquest and colonization established by Columbus was to a large extent replicated by others such as Cortés and Pizarro during the following half-century. 61 During the same period, expeditions such as those of Ponce de Leon in 1513, Coronado in 1540, and de Soto during the same year were launched with an eye towards effecting the same pattern on the North American continent. 62 In the latter sphere, the Spanish example was followed and in certain ways intensified by the British, beginning at Roanoke in 1607 and Plymouth in 1620. 63 Overall, the process of English colonization along the Atlantic coast was marked by a series of massacres of native people as relentless and devastating as any perpetrated by the Spaniards. One of the best-known illustrations drawn from among hundreds was the slaughter of some 800 Pequots at present-day Mystic, Connecticut, on the night of May 26, 1637.64. During the latter portion of the 17th century, and throughout most of the 18th, Great Britain battled France for colonial primacy in North America. The resulting sequence of French and Indian wars greatly accelerated the liquidation of indigenous people as far west as the Ohio River Valley. During the last of these, concluded in 1763, history's first documentable case of bacteriological genocide occurred against Pontiac's Algonquian Confederacy, a powerful military alliance aligned with the French. Sir Geoffrey Amherst, Commander-in-Chief of the British forces, wrote in a postscript of a letter to Bouquet that smallpox be sent among the disaffected tribes. Bouquet replied, also in a postscript, I will try to them, with some blankets that may fall into their hands, and take care not to get the disease myself. To Bouquet's postscript Amherst replied, you will do well to the Indians by means of blankets as well as to try every other method that can serve to extirpate this execrable race. On June 24, Captain Aquier, of the Royal Americans, noted in his journal, we gave them 2 blankets and a handkerchief out of the smallpox hospital. I hope it will have the desired effect. 65. It did. Over the next few months, the disease spread like wildfire among the Mingo, Delaware, Shawnee, and other Ohio River nations, killing perhaps 100,000 people. 66 The example of Amherst's action does much to dispel the myth that the post-contact attrition of Indian people through disease introduced by Europeans was necessarily unintentional and unavoidable. There are a number of earlier instances in which native people felt disease had been deliberately inculcated among them. For example, the so-called King Philip's War of 1675–76 was fought largely because the Wampanoag and Narragansett nations believed English traders had consciously contaminated certain of their villages with smallpox. 67 Such tactics were also continued by the United States after the American War of Independence. At Fort Clark on the upper Missouri River, for instance, the U.S. Army distributed smallpox-laden blankets as gifts among the Mandan. The blankets had been gathered from a military infirmary in St. Louis where troops infected with the disease were quarantined. Although the medical practice of the day required the precise opposite procedure, Army doctors ordered the Mandans to disperse once they exhibited symptoms of infection. The result was a pandemic among the Plains Indian nations which claimed at least 125,000 lives, and may have reached a toll several times that number. 68. Contemporaneous with the events at Fort Clark, the U.S. was also engaged in a policy of wholesale removal of indigenous nations east of the Mississippi River, clearing the land of its native population so that it might be settled by racially superior Anglo-Saxon pioneers. 69 This process assumed the form of a series of extended forced marches some more than 1,000 miles in length in which entire peoples were walked at bayonet point to locations west of the Mississippi. Rations and medical attention were poor, shelter at times all but non-existent. Attrition among the victims was correspondingly high. As many as 55% of all Cherokees, for example, are known to have died during or as an immediate result of that people's Trail of Tears. 70 The Creeks and Seminoles also lost about half their existing populations as a direct consequence of being removed. 71 It was the example of 19th-century U.S. Indian removal policy upon which Hitler relied for a practical model when articulating and implementing his Lebensraumpolitik during the 1930s and 40s. 72 By the 1850s, U.S. policymakers had adopted a popular philosophy called manifest destiny by which they imagined themselves enjoying a divinely ordained right to possess all native property, including everything west of the Mississippi. 73 This was coupled to what has been termed a rhetoric of extermination by which governmental and corporate leaders sought to shape public sentiment to embrace the eradication of American Indians. 74 The professed goal of this physical reduction of inferior indigenous populations was to open up land for superior Euro-American pioneers. 75 One outcome of this dual articulation was a series of general massacres perpetrated by the United States military. A bare sampling of some of the worst must include the 1854 massacre of perhaps 150 Lakotas at Blue River, the 1863 Bear River massacre of some 500 Western Shoshones, the 1864 Sand Creek Massacre of as many American Samoa 250 Cheyennes and Arapahoes, the 1868 massacre of another 300 Cheyennes at the Washita River, the 1875 massacre of about 75 Cheyennes along the Sapa Creek, the 1878 massacre of still another 100 Cheyennes at Camp Robinson, and the 1890 massacre of more than 300 Lakotas at Wounded Knee Point 76. Related phenomena included the Army's internment of the bulk of all Navajos for 4 years under abysmal conditions at the Bosque Redondo, during which about half the population of this nation is known to have perished of starvation and disease. 77 Even worse in some ways was the unleashing of Euro-American civilians to kill Indians at whim, and sometimes for profit. In Texas, for example, an official bounty on native scalps, any native scalps, was maintained until well into the 1870s. The result was that the indigenous population of the state, once the densest in all of North America, had been reduced to near zero by 1880. As it has been put elsewhere, the facts of history are plain: most Texas Indians were exterminated or brought to the brink of oblivion by who often had no more regard for the life of an Indian than they had for that of a dog, sometimes less. 78 Similarly, in California, the enormous decrease from about 250,000 to less than 20,000 is due chiefly to the cruelties and wholesale massacres perpetrated by miners and early settlers. 79. Much of the killing in California and southern Oregon Territory resulted, directly and indirectly, from the discovery of gold in 1849 and the subsequent influx of miners and settlers. Newspaper accounts document the atrocities, as do oral histories of the California Indians today. It was not uncommon for small groups or villages to be attacked by immigrants, and virtually wiped out overnight. 80. All told, the North American Indian population within the area of the 48 contiguous states of the United States, an aggregate group which had probably numbered in excess of 12 million in the year 1500, was reduced by official estimate to barely 237,000 4 centuries later. 81 This vast genocide, historically paralleled in its magnitude and degree only by that which occurred in the Caribbean basin, is the most sustained such process on record. Corresponding almost perfectly with this upper 90th percentile erosion of indigenous population by 1900 was the expropriation of about 97.5% of native land by 1920. The situation in Canada was/is entirely comparable. 83 Plainly, the Naziist dynamics set in motion by Columbus in 1492 continued, and were not ultimately consummated until the 20th century. The Columbian legacy in the United States. While it is arguable that the worst of the genocidal programs directed against native North America had ended by 1900, it seems undeniable that several have been continued into the current period. One obvious illustration is that of the massive compulsory transfer of American Indian children from their families, communities, and societies to Euro-American families and institutions, a policy which is quite blatant in its disregard for Article 2 of the 1948 Convention. Effected through such mechanisms as the U.S. Bureau of Indian Affairs boarding school system 84 and a pervasive policy of placing Indian children for adoption with non-Indians, such circumstances have been visited upon as many as 3/4 of all indigenous youth in some generations after 1900. 85 The stated goal motivating such policies has been to bring about the assimilation of native people into the value orientations and belief system of their conquerors. 86 Rephrased, the objective has been to bring about the disappearance of indigenous societies as such, a patent violation of the terms, provisions, and intent of the Genocide Convention. An even clearer example is that of a program of involuntary sterilization of American Indian women by the BIA's Indian Health Service during the 1970s. While the federal government, in announcing that the program had been terminated, acknowledged having performed several thousand such sterilizations, independent researchers have concluded that as many as 42% of all native women of childbearing age in the United States had been sterilized by that point. 87 That the program represented a rather stark and very recent violation of Article 2 of the 1948 Convention seems beyond all reasonable doubt. More broadly, Implications of genocide are quite apparent in the federal government's self-assigned exercise of plenary power and concomitant trust prerogatives over the residual Indian land base pursuant to the Supreme Court's Lone Wolf v. Hitchcock opinion. This has worked, with rather predictable results, to systematically deny Native people the benefit of our remaining material assets. At present, the approximately 2 million Indians recognized by the government as residing within the U.S., when divided into the 50 million-odd acres nominally reserved for our use and occupancy, remain the continent's largest landholders on a per capita basis. 88 Moreover, the reservation lands have proven to be extraordinarily resource-rich, holding an estimated 2/3 of all U.S. domestic uranium reserves, about a quarter of the readily accessible low-sulfur coal, as much as a fifth of the oil and natural gas, as well as substantial deposits of copper, iron, gold, and zeolites. 89 By any rational definition, the U.S. Indian population should thus be one of the wealthiest if not the wealthiest population sectors in North America. Instead, by the federal government's own statistics, we comprise far and away the poorest. As of 1980, American Indians experienced, by a decided margin, the lowest annual and lifetime incomes on a per capita basis of any ethnic or racial group on the continent. Correlated to this are all the standard indices of extreme poverty, the highest rates of infant mortality, death by exposure and malnutrition, incidence of tuberculosis and other plague diseases. Indians experience the highest level of unemployment, year after year, and the lowest level of educational attainment. The overall quality of life is so dismal that alcoholism and other forms of substance abuse are endemic, the rate of teen suicide several times that pertaining to the nation as a whole. The average life expectancy of reservation-based Native American males is less than 45 years, that of reservation-based females less than 3 years longer. 90. It's not that reservation resources are not going unexploited, or profits unaccrued. To the contrary, virtually all uranium mining and milling occurred on or immediately adjacent to reservation land during the life of the Atomic Energy Commission's ore buying program, 1952, 81, 91. The largest remaining enclave of traditional Indians in North America is currently undergoing forced relocation in order that coal may be mined on the Navajo Reservation. 92. Alaska Native peoples are being converted into landless village corporations in order that the oil under their territories be tapped, and so on. 93. Rather, the BIA has utilized its plenary and trust capacities to arrange contracts in behalf of its Indian wards with major mining corporations which pay pennies on the dollar of conventional mineral royalty rates. 94. Further, the BIA has typically exempted such corporations from an obligation to reclaim whatever reservation lands have been mined, or even to perform basic environmental cleanup of nuclear and other forms of waste. One outcome has been that the National Institute for Science has recommended that the two locales within the U.S. most heavily populated by Native people, the Four Corners region and the Black Hills region, be designated as national sacrifice areas. 95 Indians have responded that this would mean their being converted into national sacrifice peoples. 96. Even such seemingly innocuous federal policies as those concerning Indian identification criteria carry with them an evident genocidal potential. In clinging insistently to a eugenics formulation dubbed blood quantum ushered in under the 1887 General Allotment Act while implementing such policies as the Federal Indian Relocation Program, the government has set the stage for a statistical extermination of the indigenous population within its borders. 97 As the noted Western historian Patricia Nelson Limerick has observed, set the blood quantum at 1/4, hold to it as a rigid definition of Indians, let intermarriage proceed, and eventually Indians will be defined out of existence. When that happens, the federal government will finally be freed from its persistent Indian problem. 98 Ultimately, there is precious little difference, other than matters of style, between this and what was once called the final solution of the Jewish problem. Confronting genocide in America. Were the genocide of American Indians initiated by Christopher Columbus and carried on with increasing ferocity by his successors a matter of only historical significance as with the Nazi extermination campaigns, it would be utterly inappropriate, and unlawful, to celebrate it. Insofar as aspects of the genocide at issue are demonstrably ongoing not just here, but in Central and South America as well, this becomes all the more true. 99 The indigenous people of the Americas have an unquestionable, absolute, and vitally urgent need to alter the physical and political circumstances which have been and continue to be imposed upon us. In the alternative, we face, collectively, a final eradication through a number of means. Given contemporary demographic disparities between indigenous and non-indigenous populations in the Americas, and the power relations which attend these, it seems self-evident that a crucial aspect of native survival must go to altering the non-Indian sensibilities which contribute to either by affirming the rightness of, or acquiescing in the continuing genocide against Native America. Very high on any list of those expressions of non-indigenous sensibility which contribute to the perpetuation of genocidal policies against Indians are the annual Columbus Day celebrations, events in which it is baldly asserted that the process, events, and circumstances described above are, at best, either acceptable or unimportant. More often, the sentiments expressed by participants are, quite frankly, that the fate of Native America embodied in Columbus and the Columbian legacy is a matter to be openly and enthusiastically applauded as an unrivaled boon to all mankind. 100 Undeniably, the situation of American Indians will not, in fact, cannot change for the better so long as such attitudes are deemed socially acceptable by the mainstream populace. Hence, such celebrations as Columbus Day must be stopped. On the basis of the Genocide Convention and other elements of international law, American Indians have a right to expect the support of all levels of governance in the United States, from the federal executive to local mayors, in putting a stop to celebration/advocacy/incitement of our destruction. It follows that we have the same right to expect support from the judiciary, from the Supreme Court to county and municipal courts. Further, we have the same right to expect support from the various law enforcement agencies in this country, from the Federal Bureau of Investigation and U.S. Marshals Service to the Denver Police Department. In other words, under the law, the city of Denver should under no circumstances have issued a permit for the conducting of activities celebrating Columbus Day on October 12, 1991. The courts should have intervened to enjoin such activities, and the police should have enforced the prohibition of such activities against anyone attempting to violate it. Of course, none of these official actions occurred. The executive branch of government, the courts, and the police all defaulted upon their legal responsibilities. The illegal activities of the participants in the public celebration of Columbus Day in Denver, Colorado, were not only allowed, but to all appearances endorsed by those mandated to prevent them. 101. The rights and responsibilities of individual citizens in such situations are not mysterious. During the course of the Nuremberg proceedings, Justice Jackson and his associates repeatedly queried how it was that average Germans had simply stood by while their government pursued a policy of crimes against humanity. 102 Given the legitimation of precisely these crimes under then prevailing German law, one can only conclude that Jackson meant individual German citizens had shirked a binding obligation under a higher law to do whatever was necessary to prevent such crimes from occurring. Such a principle is not inconsistent with U.S. domestic laws concerning the right to effect citizens' arrests and so forth. 103 Moreover, it is now universally embodied in covenants relieving all persons, including active duty soldiers and police, of any responsibility to comply with unlawful orders, regulations, or statutes. 104 Indeed, it is arguable that, after Nuremberg, a legal requirement was incurred by each individual citizen to vigorously and, when necessary, physically oppose the commission of a crime against humanity by any party, official, or otherwise. 105 As Ben Whitaker, senior American diplomat, framed the matter before the United Nations in 1985. Hence wider public education about this doctrine is highly crucial for the aversion of future genocide. Explicit wording should be added to the convention, perhaps at the end of Article 3, that in judging culpability, a plea of superior orders is not an excusing defense. Similarly, wider publicity should be given to the principle in national codes governing armed forces, prison staffs, police officers, doctors, and others, to advise and warn them that it is not only their right to disobey orders violating human rights, such as to carry out genocide or torture, but their legal duty to disobey. Such precepts should be taught in the schools, and the United Nations Educational, Scientific, and Cultural Organization might be asked to encourage this internationally. 106. In essence, then, the defendants cannot be convicted of any crime in the instant case insofar as they comported themselves in an entirely lawful manner. We cannot have refused to obey a lawful order by a police official insofar as the order in question to allow an illegal activity to proceed unhampered was itself unlawful. It was therefore our legal duty to disobey it. We cannot have obstructed a public thoroughfare insofar as said thoroughfare was already obstructed by an illegal assembly. We merely met the legal requirement of attempting to put a stop to the unlawful activity already occurring. We cannot have disturbed the peace insofar as the peace was already disturbed by the already mentioned unlawful assembly, which included, among other things, brass bands. Again, we simply met the legal requirement of attempting to halt the commission of a crime against humanity. In addition, we were engaged in a form of the very educational activity concerning the Genocide Convention called for by Mr. Whittaker. There being no basis to the charges leveled against the defendants, we collectively demand that all charges be immediately dismissed. Part 2. Struggles for lands and lives. Of course, our whole national history has been one of expansion. That the barbarians recede or are conquered, with the attendant fact that peace follows their retrogression or conquest, is due solely to the power of the mighty civilized races which have not lost their fighting instinct, and which by their expansion are gradually bringing peace into the red wastes where the barbarian peoples of the world hold sway. Theodore Roosevelt. The Strenuous Life, 1901. 4. The Earth is Our Mother. Struggles for American Indian Land and Liberation in the Contemporary United States. The inhabitants of your country districts regard wrongfully, it is true, Indians and forests as natural enemies which must be exterminated by fire and sword and brandy, in order that they may seize their territory. They regard themselves and their posterity, as collateral heirs to all the magnificent portion of land which God has created from Cumberland and Ohio to the Pacific Ocean. Pierre Samuel Dupont de Nemours letter to Thomas Jefferson. December 17, 1801. Since the inception of the American Republic, and before, control of land and the resources within it has been the essential source of conflict between the Euro-American settler population and indigenous nations. In effect, contentions over land usage and ownership have served to define the totality of U.S./Indian relationships from the first moment, shaping not only the historical flow of interactions between invader and invaded, but the nature of the ongoing domination of native people in areas such as governance and jurisdiction, identification, recognition, and education. 1. The issue of a proprietary interest of non-Indians in the American Indian land base has also been and remains the fundament of popular conceptions of who and what Indians were and are, whether we continue to exist, and even whether we ever really existed. 2. All indications are that these circumstances will continue to prevail over the foreseeable future. As should have become quite evident in reading the essay entitled "The Law Stood Squarely on Its Head" in this volume, a rather vast amount of intellectual energy has been expended by Euro-American legal theorists over the years in an unending effort to make the armed expropriation of native land on a continental scale seem not only natural and therefore inevitable, but right and just, which is to say lawful. 3. All questions of jurisprudence aside, the hegemonic function embodied in any such trajectory of legalistic rationalization is unmistakable. 4. Plainly, the exercise has been harnessed not to the task of extending and perfecting the set of humanitarian and explicitly anti-imperialist principles to which the United States laid claim in 1787, but rather to a diametrically opposing purpose. Meanwhile, it has been all along insisted that the opposite of this opposite is true. The result can only be described as comprising, at best, an unremitting juridical subterfuge. 5. While this pattern of prevarication has always worked well enough within what the U.S. has proclaimed as its own domestic sphere, the situation became considerably more complex during the early to mid-20th century, during the course of the country's emergence as a bona fide world power. 6. In the main, The objective of American foreign policy during this period can be seen as an undermining of the conceptual cornerstones by which the classic European mode of external colonialism was purportedly legitimated, thereby creating openings in the former colonies comprising what has become known as the Third World for a more refined form of neocolonial exploitation at which the United States all along figured to excel. 8 The trick, of course, was to devise some practical means of discrediting Europe's conquest/colonization of peoples abroad that would not simultaneously demolish the inherently self-contradictory justification with which America larded its continuing subjugation of indigenous nations within its home territory. 9. The crunch came in 1945, when the U.S. sought to assert its moral leadership on a planetary basis by formulating and forcing upon its allies a plan to prosecute surviving officials responsible for Nazi expansionism during World War II. 10 Charged with having committed crimes against peace, waging aggressive war, and crimes against humanity as a result, the Germans initially professed a certain bewilderment, their first line of defense being that they'd done nothing the United States itself hadn't done to American Indians. 11 Although the presiding judges dodged this bullet by accepting at face value the transparently false assertion advanced by U.S. representatives that, unlike Germany's gunpoint expropriations, their own country's territorial acquisitions had occurred mainly by purchase and always with the consent of prior owners. 12 America's vulnerability to allegations that it was in many respects no better than the Third Reich was glaringly apparent. The Indian Claims Commission. One upshot of this circumstance was the abrupt passage, on August 2, 1946, of an act establishing what was dubbed the Indian Claims Commission, an entity mandated to review all outstanding grievances expressed by native peoples within the U.S. domestic sphere concerning wrongful takings of our property. 13 The idea was plainly to put the United States, however belatedly, on precisely the footing it had already announced it stood, thus creating an appearance that the U.S. record was decisively distinct or at least distinguishable from that of the Nazis it was busily hanging in Nuremberg. 14 As President Harry Truman insisted when he signed the bill into law on August 13, creation of the ICC was intended to make perfectly clear what many men and women, here and abroad, have failed to recognize, that, instead of confiscating Indian lands we have purchased from the tribes that once owned this continent more than 90% of our public domain. 15. Predictably, all bets attending this international public relations gesture were from the outset carefully hedged. First off, the U.S. assigned itself rather than a neutral third party the prerogative of determining whether and to what extent each claim might be meritorious. Secondly, even in the most egregious cases, the ICC was empowered only to award monetary compensation for whatever land had been taken from native claimants. Under no circumstances was it authorized to return the land itself. 16. Third, the amount of compensation in each case was restricted to whatever amount the U.S., not the indigenous owners, decided was fair. 17. Reducing the amount of awards still further, the government empowered itself to offset and deduct from payments whatever amount it had previously expended in providing services like police and schools, many of them over the express ejections and often open resistance of native recipients. 18. Federal authorities also reserved unto themselves the prerogative of determining how any remaining sums should be paid. Although they were sometimes distributed as per capita payments, by far the most frequently employed method was to transfer the funds into a federal account wherein they would be administered not by the Indians whose money it was, but by the government's own Bureau of Indian Affairs. 19 Once safely nestled in such accounts, the funds were often permanently misplaced in federal accounts. 20. Finally, it was left to the Indians themselves, most of whom had been long since rendered destitute by the very dispossession they were now supposedly afforded, an opportunity to challenge to come up with the funds necessary to retain the attorneys, historians, and other experts necessary to present their cases. 21. Under such circumstances, it was expressly anticipated by federal legislators that all outstanding claims would be remedied within 5 years and for a relatively paltry sum. 22 In the process, it was expected that the documentary basis for U.S. title assertions would be clarified, parcel by parcel, once and for all. Any other course of action would have, in the words of Henry M. Jackson, chair of the Senate Subcommittee on Indian Affairs, perpetuated clouds upon white men's title that interfere with development of our public domain. 23. Viewed in even the most favorable light, then, the 1946 Act had nothing to do with the dispensation of justice, as its apologists have claimed. 24 Rather, it was at best a self-serving clean-up measure, affording federal authorities an opportunity to reconcile their own ledgers in terms of real estate. 25 More to the point, awards of compensation by the ICC were coupled to what North Dakota Senator Carl Munt described as America's permanent solution to the Indian problem. 26 A procedure wherein, having forced upon them payment of a pittance in exchange for property they never wished to sell, Congress followed up by terminating its relationship with more than 100 native peoples, professing thereafter to consider them extinct. 27. At that, however, the congressional notion of how quickly the Commission's role in getting the U.S. out of the Indian business might be wrapped up proved absurdly short-sighted. 28 While legislators had estimated that at most 200 claims would be presented for consideration, a total of 852 implicating well over half the territory of the 48 contiguous states had been filed with the ICC by the time its original charter expired at the end of 1951. 29 Of these, a mere 26 had been acted upon, and so the ICC was extended for a second 5-year period, then a third. 30 Its lifespan was extended several more times, until finally, in 1978, the Commission was abruptly dissolved. At that point, there were still 68 cases pending. 31. There were, to be sure, substantial reasons underlying this interesting development. As early as 1956, Justice Department personnel assigned to refute claims brought before the ICC, were warning that if it were carried through to its conclusion, the process was likely to produce the opposite of its intended result. 32 Unable to discern a legal or documentary basis upon which to defend the federal interest in scores of cases, they had already resorted to a strategy of seeking to delay the whole procedure, requesting some 5,000 extensions of time in which to file their various pleadings between 1951 and 1955. 33 This clearly obstructionist technique had been perfected to such an extent by 1960 that the ICC's chief commissioner, a former senator and staunch terminationist named Arthur Watkins, complained of U.S. attorneys obtaining 35 separate continuances in a single case. 34 More than a decade later, in 1971, Watkins' successor, Jerome Kuykendall, noted that federal lawyers had sought 6,451 days' worth of extensions in active cases over the preceding 18 months. 35 By the mid-1970s, the source of discomfort among the Attorney General's whiz kids had become apparent for all to see. Try as they might, and no matter how many eminent historians and other archivists they enlisted in the effort, they could muster no evidence that the United States had ever enjoyed a legal right to possess about 35% of the continental territory over which it professed lawful jurisdiction. 36 Overall, as Russell Barsh has summarized, the fact is that about half the land area of the country was purchased by treaty or agreement at an average price of less than $1 an acre, another third of acres, mainly in the West, were confiscated without compensation, another 2/3 of acres were claimed by the United States without pretense of a unilateral action extinguishing native title. 37. Figure 4.1. Indian lands judicially recognized as unceded. Thus, although the aggregate acreage encompassed within reservation boundaries added up to about 2.5% of the total comprising the 48 contiguous states, American Indians remain in a rather straightforward sense the rightful owners of about 1/3 of the nation's land. 38 This proportion, moreover, does not include areas to which U.S. title is predicated upon fraudulent treaties or agreements. 39 Or those into which native peoples entered under extreme coercion. 40 Nor does it address the implications of America's history of non-compliance with reciprocal provisions in treaties of cession which might otherwise be considered valid. 41 Were U.S. title to territory acquired under such circumstances to be considered null as, legally, it must then well over half the country's continental holdings would have to be viewed as occupied America. 42. In other words, it was the Nazi defendants at Nuremberg, not Robert H. Jackson, the Supreme Court justice who prosecuted them, or Francis Biddle, the former Attorney General who sat in judgment of them in behalf of the U.S. who had it exactly right. 43 As to Jackson's famous pronouncement, offered in the course of the trial at Nuremberg, that the United States was not prepared to lay down a rule of criminal conduct against others which we are not willing to have invoked against us, well, some things speak for themselves. 44 No less, Harry Truman's bald 1947 assertion that it should be perfectly clear, that in our transactions with the Indian tribes we have set for ourselves the standard of fair and honorable dealings, pledging respect for all Indian property rights. 45. Cracks in the empire. Well before the ICC process was finally aborted, some American Indians had begun to home in on the vulnerabilities in the U.S. position exposed during the Commissioner's efforts to quiet title to the country's purported domestic land base. As was pointed out by Vine Deloria, Jr., all the Commission managed to do in most instances was update the legal parity of indigenous property rights by clearing out the underbrush previously obscuring an accurate appreciation of who actually owned what in the U.S. portion of North America. 46 Seen in this light, the monetary awards made by the ICC assume more nearly the form of back rent payments on native lands used by the United States than a resolution or settlement of indigenous property interests. 47. Such knowledge fueled a resurgent indigenous national militancy which, with emergence of the American Indian movement during the early 1970s, has led to a series of spectacular extra-legal confrontations over land and liberty with federal authorities. These, in turn, have commanded the very sort of international attention to U.S. territorial claims, and Indian policy more generally, that the ICC was supposed to avert. 48 After 1977, Native North Americans spearheaded for a time by AIM's diplomatic arm, the International Indian Treaty Council have been able to escalate this trend by putting their issues before the United Nations, entering annual reports of official misconduct in both the US and Canada towards Native peoples and our lands. 49. In this changing context, the federal government has once again begun to engage in damage control, allowing a calculated range of concessions in order to bolster what it seeks to project as its image abroad. Notably, in 1974, the U.S. Supreme Court announced for the first time that American Indians have a right to pursue the actual recovery of stolen land through the federal judiciary. 50 Although resort to the courts of the colonizer is hardly an ideal solution to the issues raised by indigenous nations, it does place another tool in the inventory of means by which we can now pursue our rights. It has, moreover, resulted in measurable gains for some of us over the past quarter century. Probably the best example of this is the suit, first entered in 1972 under the auspices of a sponsoring organization, of the basically landless Passamaquoddy and Penobscot nations in present-day Maine to some 12 million acres acknowledged as being theirs in a series of letters dating from the 1790s and signed by George Washington. 51 Since it was demonstrated that no ratified treaty existed by which the Indians had ceded their land, U.S. District Judge Edward T. Gignoux ordered a settlement acceptable to the majority of the native people involved. 52 This resulted in the recovery, in 1980, of some 300,000 acres of land, and payment of $27 million in compensatory damages by the federal government. 53 In a similarly argued case, the Narragansetts of Rhode Island, not previously recognized by the government as still existing, were in 1978 able to win not only recognition of themselves, but to recover 1,800 acres of the remaining 3,200 stripped from them in 1880 by unilateral action of the state. 54. In another instance, the Mashantucket Pequot people of Connecticut filed suit in 1976 to recover 800 of the 2,000 acres comprising their original reservation, created by the Connecticut colony in 1686 but reduced to 184 acres by the state of Connecticut after the American War of Independence. 55 Pursuant to a settlement agreement arrived at with the state in 1982, Congress passed an act providing funds to acquire the desired acreage. It was promptly vetoed by Ronald Reagan on April 11, 1983. 56 After the Senate Select Committee on Indian Affairs convened hearings on the matter, however, Reagan agreed to a slight revision of the statute, affixing his signature on October 18 the same year. 57. Other nations, however, have not fared as well, even in an atmosphere where the U.S. has sometimes proven more than usually willing to compromise as a means to contain questions of native land rights. The Wampanoags of the Mishpi area of Cape Cod, for example, filed suit in 1974 in an attempt to recover about 17,000 later reduced to 11,000 of the 23,000 acres historically acknowledged as theirs. At trial, the all-white jury, each of whom had property interests in the Mishpi area, were asked to determine whether the Wampanoag plaintiffs were a tribe within the meaning of the law. After deliberating for 21 hours, the jury returned with the absurd finding that they were not such an entity in 1790, 1869, and 1870, but that they were in 1832 and 1834. Their claim was then denied by District Judge Walter J. Skinner. 58 An appeal to the U.S. First Circuit Court failed, and the U.S. Supreme Court refused to review the case. 59. Given such mixed results, it is plain that justice in native land claims cases cannot ultimately be expected to accrue through the federal court system. Whatever remedial potential resides in judicial and diplomatic venues must therefore be pursued through bodies such as the United Nations Working Group on Indigenous Populations, which is even now engaged in finalizing a Universal Declaration of the Rights of Indigenous Peoples, 60, and the International Court of Justice, which must interpret and render opinions based in such law. 61 From there, it can be expected that international scrutiny and pressure, as well as changed sentiments among a growing segment of the U.S. body politic, may serve to force the United States to edge closer to a fair and equitable handling of indigenous rights. 62. In the meantime, nearly every litigation of land claims within the federal system adds to the weight of evidence supporting the international case presented by Native people. When we win, it proves we were entitled to the land all along. When we lose, it proves that the due process rights the U.S. insists protect our interests are, at most, inconsistently available to us. Either way, these legalistic endeavors force cracks in the ideological matrix of the American empire. In combination with extra-legal efforts such as refusal to leave their homes by native traditional and physical occupations of contested areas by groups such as AIM, as well as the increasing international work by indigenous delegations, they comprise the core of the ongoing land struggles which represent the future of native North America. 63. Contemporary land struggles. Aside from those already mentioned, there is no shortage of ongoing struggles for land being mounted by native people within the United States today, all of which might be used to illustrate various aspects of the phenomenon. In Florida, the descendants of the Seminole and Miccosukee recalcitrants who had managed to avoid forced relocation to Oklahoma during the 1830s by taking refuge in the Everglades, simply squatted in their homeland for more than 130 years, never agreeing to a peace accord with the U.S. until the mid-60s. Because of their unswerving resistance to moving, the state finally agreed to create a small reservation for these people in 1982, and Congress concurred by statute in the same year. 64 In Minnesota, there is the struggle of Anishinaabe to reassert indigenous control over the remaining 20% 250,000 acres of the White Earth Chippewa Reservation, and to recover some portion of the additional million acres reserved as part of White Earth under an 1854 treaty with the U.S. but declared surplus through the General Allotment Act in 1906.65. In southern Arizona, the Tohono O'odham Nation continues its efforts to secure the entirety of its sacred Baboquavari mountain range, acknowledged by the government to be part of the Papago Reservation in 1916, but open to non-Indian mineral development interests, especially those concerned with mining copper both before and since. 66 In the northern portion of the same state, there have been struggles by both the Hopis and Dine to block the U.S. Forest Service's scheme to convert San Francisco Peaks, a site sacred to both peoples, into a ski resort complex. 67 And, of course, there is the grueling and government-instigated land struggle occurring between the tribal councils of these same two peoples within what was called the Navajo-Hopi Joint Use Area. The matter is bound up in energy development issues, primarily the strip mining of an estimated 24 billion tons of readily accessible low-sulfur coal, and entails a program to forcibly relocate as many as 13,500 traditional Dine, a number of whom have refused to leave their land. 68. In Massachusetts, the Gayhead Wampanoags, proceeding slowly and carefully so as to avoid the pitfalls encountered by their cousins at Mishpee, are pursuing litigation to regain control over ancestral lands. 69. In Alaska, struggles to preserve some measure of sovereign indigenous American Indian, Aleut, and Inuit control over some 40 million oil-rich acres corporatized by the 1971 Alaska Native Claims Settlement Act are sharpening steadily. 70. In Hawaii, the native owners of the islands, having rejected a proffered cash settlement for relinquishment of their historic land rights in 1974-71, are pursuing a legislative remedy which would both pay monetary compensation for loss of use of their territory and restore a portion of it. 72. The fact is that, wherever there are indigenous people within the U.S., land claims struggles are occurring with increasing frequency and intensity. To convey a sense of the texture of these continuing battles, it will be useful to consider a small selection of examples in depth. For this purpose, the claims of the Iroquois Confederation in upstate New York, the Lakota Black Hills land claim, centered in South Dakota, and the Western Shoshone claims, primarily in Nevada, should serve quite well. Although none is especially unique in its overall configuration to that extent, each is fittingly representative of a broad range of comparable efforts they number among the most sustained and intensively pursued. The Iroquois land claims. One of the longest fought and more complicated land claims struggles in the U.S. is that of the Haudenosaunee, or Six Nations Iroquoian Confederacy. While the 1783 Treaty of Paris ended hostilities between the England and its secessionist subjects in the 13 colonies, it had no direct effect upon the state of war existing between those subjects and native peoples allied with the Crown. Similarly, while by the treaty George III had quit-claimed his discovery rights to the affected portion of North America, it was the opinion of Thomas Jefferson and others that this had done nothing to vest title to these lands in the newly born United States. 73. On both counts, the Continental Congress found it imperative to come to terms with indigenous nations as expeditiously as possible. 74. A very high priority in this regard was accorded the Haudenosaunee, 4 nations of which Mohawk, Seneca, Cayuga, and Onondaga had fought with the British. 75. Hence, during October of 1784, the U.S. conducted extensive negotiations with representatives of the Six Nations at Fort Stanwix, in the state of New York. The result was a treaty, reinforced with a second negotiated at Fort Harmar in 1789, by which the Indians relinquished their interest in lands lying west of a north-south line running from Niagara to the border of Pennsylvania, that is to say, their territory within the Ohio River Valley, as well as parcels on which certain military posts had been built. In exchange, the U.S. guaranteed 3 of the 4 hostile nations the bulk of their traditional homelands. The Oneida and Tuscarora were also secured in the possession of the lands on which they are now settled. Altogether, the Haudenosaunee reserved about 6 million acres, about half of the present state of New York, as permanent homelands. 76. Figure 4.2. Iroquois Treaty lands in 1794. This arrangement, while meeting most of the Indians' needs, was also quite useful to the U.S. central government, as has been observed elsewhere. First, in order to sell and settle it, the Continental Congress needed to extinguish Indian title, including any claims by the Iroquois of New York. Second, the commissioners wanted to punish the Senecas. Thus they forced the Senecas to surrender most of their land in New York to the United States. Third, the United States wanted to secure peace by confirming to their remaining lands. Fourth, the United States was anxious to protect its frontier from the British in Canada by securing land for forts and roads along Lakes Erie and Ontario. 77. New York State, needless to say, was rather less enthusiastic about the terms of the treaty. Indeed, it had already attempted, unsuccessfully, to obtain additional land cessions from the Iroquois during meetings conducted prior to arrival of the federal delegation at Fort Stanwix. 78 Further, such efforts were barred by Article 9 of the Articles of Confederation, and subsequently by Article I and the Commerce Clause of the Constitution, all of which combined to render treaty-making and outright purchases of Indian land by states illegal. New York therefore resorted to subterfuge, securing a series of 26 leases, many of them for 999 years, on almost all native territory within its purported boundaries. Its purported boundaries. The Haudenosaunee initially agreed to these transactions because of Governor George Clinton's duplicitous assurances that the leases represented a way for them to keep their land, and for his government to extend its protection over their property against the dealings of unscrupulous white land speculators. The first such arrangement was forged with the Oneidas in a meeting begun at Fort Schuyler on August 28, 1788. The New York commissioners led them to believe that they had lost all their land to the New York Genesee Company, and that the commissioners were there to restore title. The Oneidas expressed confusion over this since they had never signed any instruments to that effect, but Governor Clinton just waved that aside. Thus the Oneidas agreed to the lease arrangement with the state because it seemed the only way they could get back their land. The state received some 5 million acres for $2,000 in cash, $2,000 in clothing, $1,000 in provisions, and $600 in annual rental. So complete was the deception that good Peter thanked the governor for his efforts. 79. Leasing of the Tuscaroras land occurred the same day by a parallel instrument. 80 On September 12, the Onondagas leased almost all their land to New York under virtually identical conditions. 81 The Cayugas followed suit on February 25, 1789, in exchange for payment of $500 in silver, plus an additional $1,625 the next June and a $500 annuity. 82 New York's flagrant circumvention of constitutional restrictions on non-federal acquisitions of Indian land was a major factor in passage of the first of the so-called Indian Trade and Intercourse Acts in 1790. 83 Clinton, however, simply shifted to a different ruse, avoiding such tightening in the mechanisms of federal control over his state's manipulations by backdating them. In 1791, for example, he announced that New York would honor a 999-year lease negotiated in 1787 by a private speculator named John Livingston. The lease covered 800,000 acres of mainly Mohawk land, but had been declared null and void by the state legislature in 1788.84. Concerned that such maneuvers might push the Iroquois, the largely landless Senecas in particular, into joining Shawnee leader Tecumseh's Pan-Indian alliance and physically resisting further U.S. expansion into the Ohio Valley, the federal government sent a new commission to meet with the Haudenosaunee leadership at the principal Seneca town of Canandaigua in 1794. In exchange for a pledge from the Six Nations not to bear arms against the United States, their ownership of the lands guaranteed them at Fort Stanwix was reaffirmed, the state's leases notwithstanding, and the bulk of the Seneca territory in Pennsylvania was restored. 85. Nonetheless, New York officials, obviously undaunted by this turn of events, rapidly parceled out sections of the leased lands in subleases to the very unscrupulous whites it had pledged to guard against. On September 15, 1797, the Holland Land Company, in which many members of the state government had invested, assumed control over all but 10 tracts of land, totaling 397 square miles, of the Fort Stanwix Treaty area. The leasing instrument purportedly extinguished native title to the land, a process which would be repeated many times over in the coming years. 86. Given the diminishing military importance of the Six Nations after the Shawnees' 1794 defeat at Fallen Timbers and the eventual vanquishment of Tecumseh at Tippecanoe in 1811, federal authorities ultimately did little or nothing to correct the situation despite continuous Iroquois protests. 87 New York, along with others of the individual states, was thus emboldened to proceed with wholesale appropriations of native territory. Figure 4.3. land grants, purchases, and Indian reservations within the 1794 treaty area. In 1810, for instance, the Holland Company sold some 200,000 acres of its holdings in Seneca and Tuscarora land to its own accountant, David A. Ogden, at a price of 50 cents per acre. Ogden then issued shares against development of this land, many of them to the very Albany politicians who already held stock in Holland. Thus capitalized, the Ogden Land Company was able to push through a deal in 1826 to buy a further 81,000 acres of previously unleased reservation land at 53 cents per acre. A federal investigation into the affair was quashed in 1828 by Secretary of War Peter B. Porter, himself a major stockholder in Ogden. 88. Under such circumstances, most of the Oneidas requested in 1831 that what was left of their New York holdings, which they were sure they would lose anyway, be exchanged for a 500,000-acre parcel purchased from the Menominees in Wisconsin. President Andrew Jackson, at the time pursuing his policy of general Indian removal to points west of the Mississippi, readily agreed. 89 In the climate created by Jackson's own posturing, an ever-increasing number of federal officials followed Porter's example, actively colluding with their state-level counterparts and private speculators, thereby erasing altogether whatever meager protection of native rights had previously emanated from Washington. D.C. 90. One outcome was that on January 15, 1838, federal commissioners oversaw the signing of the Treaty of Buffalo Creek, wherein 102,069 acres of Seneca land was ceded directly to the Ogden Company. The $202,000 purchase price was divided almost evenly between the government and individual non-Indians seeking to buy and improve plots in the former reservation area. At the same time, what was left of the Cayuga, Oneida, Onondaga, and Tuscarora holdings were wiped out, at an aggregate cost of $400,000 to Ogden. 91 The Haudenosaunee were told they should relocate en masse to Missouri. Although the Six Nations never consented to the treaty, and it was never properly ratified by the Senate, President Martin Van Buren proclaimed it to be the law of the land on April 4, 1840.92. By 1841, Iroquois complaints about the Buffalo Creek Treaty were being supplemented by those of increasing numbers of non-Indians outraged not so much by the loss of land to Indians it entailed as by the obvious corruption involved in its terms. 93 Consequently, in 1842, a second Treaty of Buffalo Creek was drawn up. Under this new and better instrument, the U.S. again acknowledged the Haudenosaunee right to reside in New York and restored small areas such as the Allegheny and Cattaraugus Seneca reservations. The Onondaga Reservation was also reconstituted on a 7,300-acre land base, the Tuscarora Reservation on a paltry 2,500 acres. The Ogden Company, for its part, was allowed to keep the rest. 94. Although the Tonawanda Band of Senecas immediately filed a formal protest of these terms with the Senate, all they received for their efforts was an 1,857 award of $256,000 of their own money with which to buy back a minor portion of their former territory. 95 Ogden, of course, was thus perfectly positioned to reap an extraordinary profit against what it had originally paid the same unwilling sellers. And so it went, year after year. So rich were the rewards to be gleaned from peddling Indian land that, beginning in 1855, the Erie Railway Company entered the picture. While the state legislature quickly approved the company's bids to obtain long-term leases on significant portions of both the Cattaraugus and Allegheny reservations, the state judiciary sensed an even greater opportunity. Playing upon the depth of then prevailing federal enthusiasm for railroad construction, New York's High Court justices engaged in a cynical and rather elaborate ploy meant to persuade Congress to open the door of legitimation to the full range of the state's illicit leasing initiatives. Though the leases were ratified by New York, the state's Supreme Court in 1875 invalidated them. In recognition of this action, the New York legislature passed a concurrent resolution that state action was not sufficient to ratify leases because Congress alone possesses the power to deal with and for the Indians. Instead of setting aside the leases, Congress in 1875 passed an act authorizing The state now made leases renewable for 12 years, and by an amendment in 1890 the years were extended to 99. Later the Supreme Court of New York deemed them perpetual. 96. As a result, by 1889 80% of all Iroquois reservation land in New York was under lease to non-Indian interests and individuals. The same year, a commission was appointed by Albany to examine the state's Indian problem. Rather than suggesting that the appropriation of 4/5 of their land had deterred Indian welfare, the commission criticized the Indians for not growing enough to feed themselves, thereby placing an undue burden on those profiting from their land. Chancellor C.N. Sims of Syracuse University, a commission member, argued strongly that only obliteration of the tribes, conferral of citizenship, and allotment of lands would set things right. 97. Washington duly set out to undertake allotment, but was stunned to discover it was stymied by the underlying title to much of the reserved Haudenosaunee land it had allowed the Ogden Company to obtain over the years. In 1895, Congress passed a bill authorizing a buyout of Ogden's interest, again at taxpayer expense, but the company upped its asking price for the desired acreage from $50,000 to $270,000.98. The plan thereupon collapsed, and the Six Nations were spared the individual/social/political trauma, and the potential of still further land loss, to which they would have been subjected in the allotment process. 99. Not that the state did not keep trying. In 1900, after uttering a string of bellicosities concerning backward savages, Governor Theodore Roosevelt created a commission to re-examine the matter. This led to the introduction in 1902 of another bill aimed at allotting the Seneca reservations with 50,000 acres in all. They were by far the largest remaining Iroquois land areas by paying Ogden $200,000 of the Indians' trust funds to abandon its claims on Allegheny and Cattaraugus. 100. The Senecas retained attorney John Van Voorhis to argue that the Ogden claim was invalid because, for more than 100 years, the company had not been compelled to pay so much as a nickel of tax on the acreage it professed to own. By this, they contended, both Ogden and the government had all along admitted that, for purposes of federal law, the land was really still the property of Indians not taxed. Roosevelt's bill was withdrawn in some confusion at this point, and allotment was again averted. 101. In 1905, the Senecas carried the tax issue into court in an attempt to clear their land title once and for all, but the case was dismissed on the premise that Indians held no legal standing upon which to sue non-Indians. 102. Yet a third attempt to allot the Six Nations reservations foundered in 1914, as did a New York State constitutional amendment, proposed in 1915, to effectively abolish the reservations. Even worse from New York's viewpoint, in 1919 the U.S. Justice Department for the first time acted in behalf of the Haudenosaunee, filing a suit which established a 32-acre reservation near Syracuse for the Oneidas. 103. The state legislature responded by creating yet another commission, this one headed by attorney Edward A. Everett, a political conservative, to conduct a comprehensive study of land title questions in New York and to make recommendations as to how they might be cleared up across the board. 104. The fix again seemed to be in. After more than 2 years of hearings and intensive research, however, Everett arrived at a thoroughly unanticipated conclusion: the Six Nations still possessed legal title to all 6 million acres of the Fort Stanwix Treaty area. He cited international law to the effect that there are only 2 ways to take a country away from a people possessing it: purchase or conquest. The Europeans who came here did recognize that the Indians were in possession and so, in his opinion, thus recognized their status as nations. If then, the Indians did hold fee to the land, how did they lose it? Indians were recognized by George Washington as a nation at the Treaty of 1784. Hence, they were as of 1922 owners of all the land in that treaty unless they had ceded it by a treaty equally valid and binding. 105. In his final report, Everett reinforced his basic finding with references to the treaties of Forts Harmar and Canandaigua, discounted both Buffalo Creek treaties as fraudulent, and rejected not only the leases taken by entities such as the Holland and Ogden companies but those of New York itself as lacking any legal validity at all. 106 The Albany government quickly shelved the document rather than publishing it, but it could not prevent its implications from being discussed throughout the Six Nations. On August 21, 1922, a council meeting was held at Onondaga for purposes of retaining Mrs. Lulu G. Stillman, Everett's secretary, to do research on the exact boundaries of the Fort Stanwix Treaty Area. 107 The Iroquois land claim struggle had shifted from dogged resistance to dispossession to the offensive strategy of land recovery, and the first test case, James Deere v. St. Lawrence River Power Company, was filed on June 26, 1925, in an attempt to regain a portion of the St. Regis Mohawk Reservation taken by New York. The federal government declined to intervene on the Mohawks' behalf, as it was plainly its trust responsibility to do, and the suit was dismissed by a district court judge on October 10, 1927. The dismissal was upheld on appeal in April 1929.108. Things remained quiet on the land claims front during the 1930s, as the Haudenosaunee were mainly preoccupied with preventing the supplanting of their traditional longhouse form of government by tribal councils sponsored by the Bureau of Indian Affairs via the Indian Reorganization Act of 1934.109, probably as a means of coaxing them into a more favorable view of federal intentions under the IRA. Indian Commissioner John Collier agreed towards the end of the decade that his agency would finally provide at least limited support to Iroquois claims litigation. This resulted, in 1941, in the Justice Department's filing of U.S. v. Furness on behalf of the Allegheny Senecas. The suit, ostensibly aimed at eviction of an individual who had refused to pay his $4 per year rent to the Indians for 8 years, actually sought to enforce a resolution of the Seneca Nation canceling hundreds of low-cost, 99-year leases taken in the city of Salamanca on the reservation in 1892. Intervening for the defendants was the Salamanca Trust Corporation, a mortgage institution holding much of the paper at issue. Although the case was ultimately unsuccessful in its primary objective, it did force a judicial clarification of the fact that, in and of itself, New York law had no bearing on leasing arrangements pertaining to Indian land. 110. This was partly corrected, in the state view, on July 2, 1948, and September 13, 1950, when Congress passed bills placing the Six Nations under New York jurisdiction in first criminal and then civil matters. 111 Federal responsibility to assist Indians in pursuing treaty-based land claims was nonetheless explicitly preserved. 112 Washington, of course, elected to treat this obligation in its usual cavalier fashion, plunging ahead during the 1950s while the Indians were mired in efforts to prevent termination of their federal recognition altogether with the flooding of 130 acres of the St. Regis Reservation near Messina, American Samoa, part of the St. Lawrence Seaway Project. 113. The government also proceeded with plans to flood more than 9,000 acres of the Allegheny Reservation as a byproduct of constructing the Kinzua Dam. Although studies revealed an alternative site for the dam that would not only spare the Seneca land from flooding but better serve the greater public good for which it was supposedly intended, Congress pushed ahead. 114 The Senecas protested the project as a clear violation of the Fort Stanwix guarantees, a position with which lower federal courts agreed, but the Supreme Court ultimately declined to decide the question and the Army Corps of Engineers completed the dam in 1967. 115. Meanwhile, the New York State Power Authority was attempting to seize more than half of the Tuscarora Reservation, near Buffalo, as a reservoir for the Niagara Power Project. In April 1958, the Tuscaroras physically blocked access to the site, and several were arrested. A federal district judge entered a temporary restraining order against the state, but the appellate court ruled that congressional issuance of a license through the Federal Power Commission constituted sufficient grounds for the state to exercise eminent domain over native property. 116 The Supreme Court again refused to hear the resulting Haudenosaunee appeal. A compromise was then implemented in which the state flooded only 560 acres, or about 1/8 of the remaining Tuscarora land. 117. By the early 1960s, it had become apparent that the Six Nations, because their territory fell within the boundaries of one of the original 13 states, would not be allowed to seek redress through the Indian Claims Commission. 118 The decade was largely devoted to a protracted series of discussions between state officials and various sectors of the Iroquois leadership. Agreements were reached in areas related to education, housing, and revenue sharing, but on the issues of land claims and jurisdiction, the position of Longhouse traditionalists was unflinching. In their view, the state holds no rights over the Haudenosaunee in either sphere. 119. The point was punctuated on May 13, 1974, when Mohawks from the St. Regis and Kaufnawega reservations occupied an area at Ganique, in the Adirondack Mountains. They proclaimed the site to be sovereign Mohawk territory under the Fort Stanwix Treaty, represent a clout of title not only to 612.7 acres in Herkimer County but to all of northeastern New York, and set out to defend it, and themselves, by force of arms. 120. After a pair of local vigilantes engaged in shooting at the Indians were wounded by return gunfire in October, the state filed for eviction in federal court. The matter was bounced back on the premise that it was not a federal issue, and the New York Attorney General, undoubtedly discomfited at the publicity prospects entailed in an armed confrontation on the scale of the 1973 Wounded Knee siege, let the case die. 121. The state next dispatched a negotiating team headed by future Governor Mario Cuomo. In May 1977, partially as a result of Cuomo's efforts but more importantly because of the Indians' obvious willingness to slug it out with state authorities if need be, the Moss Lake Agreement was reached. Under its provisions, the Mohawks assumed permanent possession of a land parcel at Minor Lake, near the town of Altona, and another in the nearby Macomb Reforestation Area. 122 Mohawk possession of the sites remains ongoing in 2002, a circumstance which has prompted others among the Six Nations to pursue land recovery through a broader range of tactics and, perhaps, with greater vigor than they might otherwise have employed. 123. As all this was going on, the Oneidas had, in 1970, filed the first of the really significant Iroquois land claim suits. The case, Oneida Indian Nation of New York v. County of Oneida, charged that the transfer of 100,000 acres of Oneida land to New York via a 1,795 lease engineered by Governor Clinton was fraudulent and invalid on both constitutional grounds and because it violated the 1,790 Trade and Intercourse Act. It was dismissed because of the usual Indians lack legal standing argument but reinstated by the Supreme Court in 1974. 124 Compelled to actually examine the merits of the case for the first time, the U.S. District Court agreed with the Indians that title still rested with the Oneidas. The plaintiffs have established a claim for violation of the Non-Intercourse Act. Unless the act is to be considered nugatory, it must be concluded that the plaintiff's right of occupancy and possession of the land in question was not alienated. By the deed of 1795, the state acquired no rights against the plaintiffs, consequently, its successors, the defendant counties, are in no better position. 125. Terming the Oneidas a legal fiction, and the lower court's rulings racist, Attorney Alan Van Gestel appealed on behalf of the defendants to the Supreme Court. 126 On October 1, 1984, the High Court ruled against Van Gestel and ordered his clients to work out an accommodation, indemnified by the state, including land restoration, compensation, and rent on unrecovered areas. 127 Van Gestel continued to howl that the common people of Oneida and Madison counties were being held hostage, but, as the Oneida's attorney, Arlen Locklear, put it in 1986. One final word about responsibility for the Oneida claims. It is true that the original sin here was committed by the United States and the state of New York. It is also no doubt true that there are a number of innocent landowners in the area, i.e., individuals who acquired their land with no knowledge of the Oneida claim to it. But those facts alone do not end the inquiry respecting ultimate responsibility. Whatever the knowledge of the claims before then, the landowners have certainly been aware of the Oneida claims since 1970 when the first suit was filed. Since that time, the the landowners have done nothing to seek a speedy and just resolution of the claims. Instead, they have as a point of principle denied the validity of the claims and pursued the litigation, determined to prove the claims to be frivolous. Now that the landowners have failed in that effort, they loudly protest their innocence in the entire matter. The Oneidas, on the other hand, have since 1970 repeatedly expressed their preference for an out-of-court resolution of their claims. Had the landowners joined with the Oneida 16 years ago in seeking a just resolution, the claims would no doubt be resolved today. For that reason, the landowners share in the responsibility for the situation in which they find themselves today. 128. Others would do well to heed these words because, as Locklear pointed out, the Oneida case paved the legal way for other Indian land claims. 129. Not least of these are other suits by the Oneidas themselves. In 1978, the New York Oneidas filed for adjudication of title to the entirety of their Fort Stanwix claim, about 4.5 million acres, in a case affecting not only Oneida and Madison counties, but Broome, Chenango, Cortland, Herkimer, Jefferson, Lewis, Onondaga, Oswego, St. Lawrence, and Tioga counties as well. 130. Then, in December 1979, the Oneida Nation of Wisconsin and the Thames Band of South Gold, Ontario, joined in an action pursuing rights in the same claim area, but naming the state rather than individual counties as defendant. 131. Figure 4.4. Oneida Land Claim, State of New York, 1984. The Cayuga Nation, landless throughout the 20th century, has also filed suit against Cayuga and Seneca counties for recovery of 64,015 acres taken during Clinton's leasing foray of 1,789. 132. The latter case, filed on November 19, 1980, resulted from attempts by the Cayugas to negotiate some sort of land base and compensation for themselves with federal, state, and county officials from the mid-70s onward. By August 1979, they had worked out a tentative agreement that would have provided them with the 1,852-acre Sampson Park in southern Seneca County, the 3,629-acre hectare land use area in the same county, and an $8 million trust account established by the Secretary of the Interior. 133. Although not 1 square inch of their holdings was threatened by the arrangement, the response of the local non-Indian population was rabid. To quote Paul D. Moonen, Sr., president of the local Monroe Title and Abstract Company, the Cayugas have no moral or legal justification for their claim. 134. Wisner Kin, a farmer near the town of Ovid, immediately founded the Seneca County Liberation Organization, a group defined by nothing so much as its propensity to express the most virulent anti-Indian sentiments. SCLO attracted several hundred highly vocal members from the sparsely populated county. 135. A bill to authorize the settlement subsequently failed due to this white backlash, and so the Cayugas went to court to obtain a much larger area, eviction of 7,000 county residents and $350 million in trespass damages. Attempts by attorneys for SCLO to have the suit dismissed failed in 1982, as did a 1984 compromise offer initiated by Representative Frank Horton. The latter, which might well have been accepted by the Cayugas, would have provided them with the 3,200-acre Howland Game Management Reserve along the Seneca River, a 2,850-acre parcel on Lake Ontario possessed by the Rochester Gas and Electric Company, and a 2,000-acre parcel adjoining Sampson State Park. Additionally, the Cayugas would have received well in excess of the $8 million they had originally sought. 136. While SCLO appears by this point to have decided that acquiescence might well be the better part of valor, the proposal came under heavy attack from non-Indian environmentalists and other supposed progressives concerned about the animals in the Howland Reserve. Ultimately, it was nixed by Ronald Reagan in 1987, not out of concern for local fauna, or even as part of some broader anti-Indian agenda, but because was he angry with Horton for voting against his own proposal to fund the Nicaraguan Contras low-intensity war against that country's Sandinista government. 137. Meanwhile, in the town of Salamanca, to which the leases expired at the end of 1991, the Allegheny Senecas also undertook decisive action during the second half of the 1980s. Beginning as early as 1986, they stipulated their intent not only to not renew leasing instruments, but to begin eviction proceedings against non-Indian lease and mortgage holders in the area unless the terms of any new arrangement were considerably recast in their favor. In substance, they demanded clarification of underlying Seneca title to the township, a shorter leasing period, fair rates for property rental, and preeminent jurisdiction over both the land and income derived from it. 138. A further precondition to lease renewal was that compensation be made for all non-payment and underpayment of fair rental values of Seneca property accruing from the then existing lease. Although these demands unleashed a storm of protest from local whites, who, as usual, argued vociferously that the Indian owners of the land held no rights to it, the Senecas were successful both in court and in Congress. 139 With passage of the Seneca Nation Settlement Act in 1990, the more essential Seneca demands were met. These included an award of $60 million, with costs borne equally by the federal, state, and local governments, to reimburse the Allegheny Band for rental monies they should have received over the past 99 years, but did not. 140. The limited but real gains posted thus far, in both the Oneida land claims and with regard to renegotiation of the Salamanca leases, point to a viable strategy for a gradual recovery of Haudenosaunee land and jurisdictional rights in upstate New York during the years ahead. As of this writing, the second Oneida suit remains in process, as does the Cayuga suit. Viewed in light of the sort of settlement achieved in the earlier Oneida win, these seem likely to generate, if not a truly fair resolution of the issues raised, then a marked improvement in the circumstances of both peoples. 141. Also at issue is a long-term lease of Onondaga land upon which the city of Syracuse has been built. Following the pattern evidenced at Salamanca, the Onondagas have been able to secure an agreement in principle with state, local, and federal authorities which would both compensate them for lost rental earnings over the past century and generate a much higher level of income in the future. These monies can, in turn, be invested in the restoration of rural areas adjoining the presently tiny Onondaga Reservation to the nation's use and control. 142. Overall, it seems probable that such efforts at litigation and negotiation will continue over the next 10 to 20 years, and thereby serve to enhance the relative positions of the Tuscarora and Mohawk nations as well as their four confederates. The increasing scope of native jurisdiction in New York, which such a process would necessarily entail, may accomplish a changed sensibility among the state's non-Indian residents, as they discover firsthand that a genuine exercise of indigenous rights does not automatically lead to their disenfranchisement or dispossession of personal property. 143. Indeed, it may be that at least some sectors of New York's non-Indian population may learn that coming under Indian jurisdiction can be preferable to remaining under the jurisdiction of the state. If so, it may be that the ongoing assertion of Haudenosaunee sovereignty within the 1794 treaty territory may develop peacefully and with a reasonably high degree of Indian/white cooperation over the long run, reversing the unrelenting manifestation of Euro-American avarice, duplicity, and racism which has marked this relationship over the past 2 centuries. 144. In the alternative, when the methods of litigation and negotiation reach the limit of the state's willingness or ability to give ground, as surely they must, absent a profound alteration in the attitudes of the interloping white populace, conflicts of the sort previewed at Ganique and Oka must be the inevitable result. 145. Something of a crossroads is thus at hand in northern New York State. Things could go either way. And in the final analysis, the choice is one which resides with the state and its immigrant citizens. The Haudenosaunee own the land there by all conceivable legal, moral, and ethical definitions. 146. They always have, and will continue to until they decide otherwise. As a whole, they have demonstrated a remarkable patience with those who have presumed to take what was and is theirs. But such patience cannot last forever. The Black Hills land claim. A much more harshly fought struggle, at least in terms of physical combat, has been the battle waged by the Lakota Nation to retain their spiritual heartland, the Black Hills. In 1851, the United States entered into the first Fort Laramie Treaty with the Lakota, Cheyenne, Arapaho, Crow, and other indigenous nations of the northern and central plains regions. In large part, the treaty was an attempt by the federal government to come to grips with the matter of Indian property rights within the vast Louisiana Purchase area it had acquired from France earlier in the century. 147 The Lakota were formally recognized in the 1851 treaty as being entitled to a huge tract centering upon their sacred lands, called Pahasapa, including virtually all of the present states of South Dakota and Nebraska, as well as appreciable portions of Kansas, North Dakota, Montana, and Wyoming, and a small portion of Colorado. In sum, the U.S. formally recognized Lakota sovereignty over an area totaling between 6 and 7% of the lower 48 states. 148. It was not long, however, before silver was discovered in the Virginia City portion of Montana Territory, and a short route to these ore fields began to be considered essential to a U.S. economy beset by the demands of the Civil War. Hence, at least as early as 1864, the government openly violated the 1851 treaty, sending troops to construct a series efforts intended to secure what was called the Bozeman Trail, directly through the western portion of the Lakota homeland. The Lakota, under the political leadership of Red Cloud, and Oglala, responded by forming an alliance with the Cheyenne and Arapaho, bringing their joint military forces to bear upon the trail during the winter of 1866–67. By early 1868, the United States, having suffered several defeats in the field, and finding its troops trapped within their forts, sued for peace. 149. This led, that same year, to a second Fort Laramie Treaty in which the federal government once again recognized Lakota sovereignty and national territoriality, this time establishing a Great Sioux Reservation encompassing all of contemporary South Dakota west of the east bank of the Missouri River, and acknowledging that the Greater Sioux Nation was entitled to permanent use of unceded Indian territory involving large portions of Nebraska, Wyoming, Montana, and North Dakota. 150 Further, the new treaty committed U.S. troops to prevent non-Indians from trespassing in Lakota territory, specified that it did nothing to abrogate or annul Lakota land rights acknowledged in the 1851 Treaty 151, and provided that no treaty for cession of any portion of the reservation herein described which may be held in common shall be of any validity or force as against said Indians, unless executed and signed by at least 3/4 of all adult male Indians, occupying or interested in the same. 152. Again, the United States was unwilling to honor the treaty for long. A priest, Jean de Smet, ventured illegally into the Black Hills and afterwards reported to the Sioux Falls Times that he had discovered gold therein. 153 In short order, this led to the government's reinforcing Lt. Colonel George Armstrong Custer's elite 7th Cavalry Regiment and violating both the 1851 and 1868 treaties by sending this heavy military force directly into the hills on a fact-finding mission. Custer's 1874 report that he too had found gold in the Pahasapa, much ballyhooed in the Eastern press, led to another military foray, the Jenny Expedition, during the summer of 1875.154. The fact that there was gold in the heart of Lakota territory, in their most sacred of places, was thus confirmed to the satisfaction of Washington officials. With that, the government sent yet another treaty commission to meet with the Lakota leadership, this time in an effort to negotiate purchase of the Black Hills. 155 When the Lakotas refused to sell, Washington responded by transferring its relations with them from the Bureau of Indian Affairs to the Department of War. All Lakotas were ordered to gather at their assigned agencies within the Great Sioux Reservation by no later than the end of January 1876, although they plainly had every right to be anywhere they chose within their treaty territory. Those who failed to comply with this utterly unlawful federal directive were informed that they would be viewed as having broken the peace and consequently treated as hostiles. Meanwhile, President Ulysses S. Grant completed the government's raft of treaty violations by secretly instructing his army commanders to disregard U.S. obligations to prevent the wholesale invasion of the Lakota heartland by non-Indian miners. 156. Rather than submitting to federal dictates, the Lakotas gathered in the remote Powder River country of southeastern Montana, a part of their unceded territory, to discuss how they should respond. In turn, the army used this gesture of hostility as a pretext for launching a massive assault upon them, with the express intent of crushing Sioux resistance completely, once and for all. The U.S. objective in this was, of course, to simply obliterate any Lakota ability to effectively oppose federal expropriation of the Black Hills. The mechanism chosen to accomplish this task was a three-pronged campaign consisting of some 3,000 troops under Major Generals George Crook and Alfred Terry. Another 1,000 men under Colonel John Gibbon were to approach from the west, and the Lakotas were to be caught between these powerful forces and destroyed. 157. The Army's plan failed completely. On June 17, 1876, Crook's entire column was met by an approximately equal number of Lakotas led by Crazy Horse and Oglala. The soldiers were quickly defeated and sent into full retreat. 158. This was followed, on June 25, by the decimation of Custer's 7th Cavalry, part of Terry's column, in the valley of the Little Bighorn River. 159. For the second time in a decade, the Lakotas had successfully defended Pahasapa, militarily defeating the U.S. Army in what has come to be known as the Great Sioux War. 160. On this occasion, however, the victory was to prove bitter. Vengefully licking its wounds after having been unable to best the Indians in open combat, the Army imported Colonel Ranald Mackenzie, a specialist who had perfected the craft of total war in earlier campaigns against the Kiowas and Comanches on the southern plain of present-day Texas and Oklahoma. The new tactician spent the winter of 1876–77 locating individual Lakota and Cheyenne villages which had been rendered immobile by cold and snow. He then used sheer numbers to overpower each village as it was located, slaughtering women, children, and old people as matter of course. 161. By the spring of 1877, in order to spare their non-combatants further butchery at the hand of the army, most Lakotas decided it was time to stop fighting. Sitting Bull and Gall Hunk Papa leaders took their followers to sanctuary in Canada, not returning until 1881. Having laid down his arms, Crazy Horse, preeminent among Oglala resistance leaders, was assassinated by the military on September 5, 1877, and the era of Lakota defensive warfare was brought to a close. 162. Undoubtedly as a result of the military advantage it ultimately gained over the Lakotas during the Great Sioux War, the Congress felt empowered to pass an act on February 28, 1877, taking for itself a large portion of the Great Sioux Reservation containing the Black Hills. 163. There is strong evidence that the legislators involved were aware that this act was patently illegal, given that they had effected a slightly earlier measure suspending delivery of subsistence rations, to which the Lakota were entitled, both under their treaties and under the laws of war, until such time as the Indians gave up their claim over the Black Hills. 164. In simplest terms, the United States set out to starve the captive Lakota population into compliance with its plan. Even under these conditions, however, a commission headed by George Mennypenny and sent to obtain the Lakota consent was unable to get the job done. While the 1868 treaty required the agreement of 75% of all adult male Lakotas to legitimate any Sioux land cession, Mennypenny's commission came away with the signatures of only about 10% of the Lakota men. Nonetheless, Congress enacted its statute lawfully expropriating the hills. 165. Figure 4.5. Lakota Nation reservations and unceded lands. Over the following 2 decades, erosion of Lakota sovereignty and land base were accelerated by imposition of the Major Crimes and General Allotment Acts. 166. The Lakota economy was thus prostrate, and the political process by which the nation had traditionally governed itself was completely subverted. By 1890, despair at such circumstances had reached a level leading to the widespread adoption of the ghost dance religion, a belief that the rigorous performance of certain rituals would lead to a return of things as they had been before the Euro-American invasion. This phenomenon, dubbed an incipient uprising by Indian agents, provided the government an excuse to declare a state of military emergency during which Sitting Bull was assassinated at his home near Standing Rock, and some 350 of his followers were massacred along Wounded Knee Creek on what is now the Pine Ridge Reservation. 167 Lakota spiritual practices were then outlawed in general. 168 After that, Washington tended to view the victims as being thoroughly broken. During the 1920s and 1930s, Lakota sovereignty was diminished even further through imposition, first of the Indian Citizenship Act, and then the Indian Reorganization Act. 169 The former did much to confuse Lakotan national allegiances, engendering a distorted sort of loyalty to the United States among many younger Indians, especially men, desperate to overcome their sense of personal disempowerment. In practice, such patriotism, common to most colonial systems, has meant Indians being allowed to serve as mercenaries in the military of their oppressors, fighting and dying in disproportionate numbers during the Second World War, Korea, and Vietnam. 170. The IRA was in some ways even more insidious, putting in place a more democratic and representative form of elected council governance, owing its very existence to federal authority, as a replacement for the popular and consensus-oriented traditional councils of elders. 171 As a consequence, divisiveness within Lakota society increased sharply during the 1940s, with progressives in the tribal council orbit pitted by Washington directly against the much larger population of grassroots traditionals. 172. By the mid-1950s, things had deteriorated to such an extent that Congress could seriously consider termination of the Lakota Nation altogether. 173 Although, unlike the situation of the Menominees, Klamaths, and a number of other indigenous nations dissolved during the 1950s, the Lakota termination was never ultimately consummated. By 1967 nearly half the Sioux population had been removed to city slums. Denver, Minneapolis, Chicago, San Francisco, and Los Angeles were the preferred dumping grounds through federal relocation programs designed and intended to depopulate the land base of the reservations. 174 The degeneration of social cohesion resulting from this policy-generated diaspora has created for the Lakota and other impacted peoples staggering problems that have never been resolved. Other effects of advanced colonization were almost as devastating. By the contemporary era, the 1,868 treaty territory had been reduced to a meager 10% of its original area and broken up into a complex of reservations geographically separating the bands from one another. Of the residual land base, assertion of BIA leasing prerogatives under a unilaterally assumed federal trust authority over Lakota property, a matter accommodated within the U.S. doctrine of exercising plenary power over Indian affairs, placed more than two-thirds of the most productive reservation acreage in the hands of non-Indian ranchers, farmers, and corporate concerns. 175. Completely dispossessed of their land and traditional economy, modern Lakotas confront a circumstance on their reservations in which unemployment has hovered in the 90th percentile throughout the past half-century and more. 176 The implications of this situation are both predictable and readily apparent. The poorest county in the United States every year since World War II has been Shannon, on the Pine Ridge Reservation. Todd County, on the adjoining Rosebud Reservation, has kept pace, consistently placing among the 10 poorest locales in the Federal Poverty Index. 177. Many Lakotas, of course, never accepted the fact or circumstances of their colonization. Realizing in the wake of the Wounded Knee massacre that any direct military response to U.S. transgressions would be at best self-defeating, they opted instead to utilize the colonizers' own legal codes and its pretense of being a humanitarian power, bound by the laws of civilized conduct as a means of recovering what had been stolen from them. 178 In 1920, a federal law was passed which authorized the Lakotas to sue the government under treaties, or agreements, or laws of Congress, on the misappropriation of any funds or lands of said tribe or band or bands thereof. 179 The law was hardly altruistic. Realizing that there had been difficulties with the manner in which Lakota consent had been obtained for the 1877 Black Hills land expropriation, the government saw the bill as a handy means to buy the now impoverished Indians off and quiet title to the Pahasapa. This was amply revealed in 1923 when the Lakotas entered their suit with the Federal Court of Claims seeking return of their stolen land rather than the monetary compensation the United States had anticipated would be at issue. Not knowing what to do in the face of this unexpected turn of events, the court stalled for 19 years, endlessly entertaining motions and counter-motions while professing to study the matter. Finally, in 1942, when it became absolutely clear the Lakotas would not accept cash in lieu of land, the court dismissed the case, claiming the situation was a moral issue rather than a constitutional question over which it held jurisdiction. 180 In 1943, the U.S. Supreme Court refused to even review the claims court decision. 181. The litigational route appeared to be stalemated, but in 1946 the Indian Claims Commission Act was passed. The Lakotas therefore filed their suit with the ICC in 1950. The Commission, however, opted to view the case as having been retired by the 1942 Court of Claims dismissal and subsequent Supreme Court denial of certiorari. It likewise dismissed the matter in 1954. 182 The Court of Claims upheld the Commission's decision on appeal from the Lakotas during the same year. 183 Undeterred by this failure of due process, the Lakotas entered a second appeal, and in 1958, the Indian Claims Commission ordered by the Court of Claims to reopen the case on the grounds that the Sioux had previously been represented by inadequate counsel and as a consequence an inadequate record been presented. 184. In 1961, the U.S. Department of Justice attempted to have the Black Hills case again set aside, requesting a writ of mandamus seeking extraordinary relief for the government. The Court of Claims rejected this tactic during the same year. The ICC was thereby forced to actually consider the case. After a long hiatus, the commissioners announced that, having studied the matter, they were reducing the scope of the issue to 3 elements. What land rights were acquired by the U.S. vis-a-vis the Black Hills in 1877? What consideration had been given by the U.S. in exchange for these lands? If no consideration had been given, had any payment been made by the U.S.? 185. Proceeding on this basis, the Commission entered a preliminary opinion in 1974 that Congress had been exercising its power of eminent domain in 1877, and that it had therefore been justified in taking the Black Hills from the Lakotas, although the United States was obligated to pay them just compensation for their loss, as provided under the Fifth Amendment to the U.S. Constitution. 186 The opinion denied any right of the Lakotas to recover the land taken from them, and they therefore objected to it quite strongly. The federal government also took strong exception to the direction things were moving, given its reluctance to pay any large sum of money as compensation for territory it had always enjoyed free of charge. Hence, in 1975, the Justice Department appealed to the Court of Claims, securing a residential judicata prohibition against the ICC reaching the merits of any proposed Lakota compensation package. 187 What this meant, in simplest terms, was that the Commission was formally constrained to awarding the Lakotas nothing beyond the value of the land in question at the time of taking. The stipulation resulted in the Commission's assigning an award of $17.5 million for the entire Black Hills area, against which the government sought to offset $3,484 in rations issued to the Lakotas in 1877.188. The Lakotas attempted to appeal this to the Supreme Court, but the High Court of the United States again refused to consider the matter. 189 Meanwhile, arguing that acceptance of compensation would constitute a bona fide land cession, and invoking the consent clause contained in the 1868 treaty, the Lakotas themselves conducted a referendum to determine whether 3/4 of the people were willing to relinquish title to Pahasapa. The answer was a resounding no. 190. The unexpected referendum results presented the government with yet another dilemma in its continuing quest to legitimize its theft of Lakota territory. In order to make the best of an increasingly bad situation, Congress passed a bill in 1978 enabling the Court of Claims to review the nature and extent of Lakota compensation. 191 This the court did, revising the proposed award in 1979 to include 5% simple interest, accruing annually since 1877, adding up to a total of $105 million. Aggregated with the original $17.5 million principal award, this made the federal offer $122.50 million. 192. The Justice Department again attempted unsuccessfully to constrict the amount of compensation the government would be obliged to pay by filing an appeal with the Supreme Court. In 1980, the High Court upheld the Claims Court's award of interest. 193 The Lakotas, however, remained entirely unsatisfied. Pointing to a second poll of the reservations conducted in 1979 showing that the people were no more willing to accept $122.5 million than $17.5 million in exchange for the Black Hills, and arguing that return of the land itself had always been the object of their suits, they went back to court. 194 On July 18, 1980, the Oglalas entered a claim naming the United States, the state of South Dakota, and a number of counties, towns, and individuals in the U.S. District Court, seeking recovery of the land per se, as well as $11 billion in damages. The case was dismissed by the court on September 12, supposedly because the issue already been resolved. 195. In 1981, the U.S. Eighth Circuit Court affirmed the District Court's dismissal, and, in 1982, the Supreme Court once again declined to hear the resultant Lakota appeal. 196 These decisions opened the way in 1985 for the Court of Claims to finalize its award of monetary compensation as the exclusive available remedy for the Black Hills land claim. 197 In sum, further Lakota recourse in U.S. courts had been extinguished by those courts. The game had always been rigged, and the legal strategy had proven quite unsuccessful in terms of either achieving Lakota objectives or even holding the United States accountable to its own professed system of legality. 198. On the other hand, the legal route did mark solid achievements in other areas, pursuing it demonstrably kept alive a strong sense of hope, unity, and fighting spirit among many Lakotas that might otherwise have diminished over time. Further, the more than 60 years of litigation had forced a range of admissions from the federal government concerning the real nature of the Black Hills expropriations. Judge Fred Nickel, for example, had termed the whole affair a ripe and rank case of dishonorable dealings and a national disgrace in a 1975 opinion written for the Court of Claims. 199 Such admissions went much further toward fostering broad public understanding of Lakota issues than a one-sided Indian recounting of the facts could ever have. 200 Cumulatively, then, the Lakota legal strategy set the stage for both an ongoing struggle and for public acceptance of a meaningful solution to the Black Hills claim. It is likely that the limited concessions obtained by the Lakotas from U.S. courts during the 1970s were related to the emergence of strong support for the American Indian movement on the Pine Ridge and Rosebud reservations during the early part of the decade. At the outset, AIM's involvement on Pine Ridge concerned the provision of assistance to traditional Oglalas attempting to block the illegal transfer of approximately 1/8 of the reservation to the U.S. Forest Service by a corrupt tribal administration headed by Richard Wilson. 201 AIM provided a marked stiffening of the Lakota resolve to pursue land rights by demonstrating a willingness to go toe-to-toe with federal forces on such matters, an attitude largely absent in Indian country since 1890.202. The virulence of the federal response to AIM's criminal arrogance in this regard led directly to the dramatic siege of the Wounded Knee hamlet in 1973, a spectacle which riveted international attention on the Black Hills issue for the first time. In turn, this scrutiny resulted in analysis and an increasingly comprehensive understanding of the vast economic interests underlying federal policy in the region. This process steadily raised the level of progressive criticism of the government and garnered further non-Indian support for the Lakota position. Anxious to reassert its customary juridical control over questions of Indian land rights, the government engaged in what amounted to a counterinsurgency war against AIM and its traditional Pine Ridge supporters from 1973 to 1976. 203. By the latter year, however, it was a bit too late to effectively contain AIM's application of external pressure to the U.S. judicial system. In 1974, the Lakota elders had convened a treaty conference on the Standing Rock Reservation and charged Oglala Lakota AIM leader Russell Means with taking the 1868 Fort Laramie Treaty before the Family of Nations 204. Means therefore formed AIM's diplomatic arm, the International Indian Treaty Council, and set about achieving a presence within the United Nations, not only for the Lakotas, but for all the indigenous peoples of the Western Hemisphere. IITC accomplished this in 1977 largely on the basis of the work of its first director, a Cherokee named Jimmy Durham, when delegations from 98 American Indian nations were allowed to make presentations before a subcommission of the UN Commission on Human Rights at the Palace of Nations in Geneva, Switzerland. 205. In 1981, the United Nations reacted to what it had heard by establishing a working group on indigenous populations, lodged under the Economic and Social Council, an entity dedicated to the formulation of international law concerning the rights and status of indigenous nations vis-a-vis the various states by which they'd been subsumed. 206. The regularized series of hearings integral to working group procedure provided an international forum within which American Indians and other indigenous peoples from Australia, New Zealand, Polynesia, and Micronesia could formally articulate the basis of their national rights and the effects of governmental abridgment of these rights. 207. By the late 1980s, the working group had completed a global study of the conditions under which indigenous peoples were forced to live, and had commissioned a comprehensive study of the treaty relationships existing between UN member states and various native nations. 208. The stated objective of the working group has become the eventual promulgation of the earlier mentioned Universal Declaration of Indigenous Rights, holding the same legal and moral force as the Universal Declaration of Human Rights, the 1948 Convention on Prevention and Punishment of the Crime of Genocide, assorted Geneva Conventions, and other elements of international law. 209. The result of this international approach was to deny the United States the veil of secrecy behind which it had conducted its Indian affairs as a purely internal matter. Exposed to the light of international attention, the federal government was repeatedly embarrassed by the realities of its own Indian policies and court decisions. As a consequence, federal courts became somewhat more accommodating in the Black Hills case than they might otherwise have been. When the Lakotas rejected monetary settlement of their land claim in 1979-80, AIM was instrumental in popularizing the slogan, "The Black Hills are not for sale." 210. This was again coupled with direct extra-legal action when Russell Means initiated an occupation in 1981, the first step in physically reclaiming the Pahasepa, as he put it, of an 880-acre site near Rapid City in the Black Hills. The AIM action again caused broad public attention to be focused upon the Lakota land claim, and precipitated the potential for another major armed clash with federal forces. The latter possibility was averted at the last moment by a federal district judge who, reflecting the government's concern not to become engaged in another Wounded Knee-type confrontation, issued an order enjoining the FBI and U.S. Marshals Service from undertaking an assault upon the occupants of what was by then called Yellow Thunder Camp. 211. Under these conditions, the government was actually placed in the position of having to sue the Indians in order to get them to leave what it claimed was U.S. Forest Service property. 212. AIM countersued on the basis that federal land use policies in the Black Hills violated not only the 1868 treaty, but also Lakota's spiritual freedom under the First Amendment to the U.S. Constitution and the Indian Religious Freedom Act. 213. In 1986, the government was stunned when U.S. District Judge Robert O'Brien ruled in favor of AIM, finding that the Lakotas had every right to the Yellow Thunder site, and that the United States had clearly discriminated against them by suggesting otherwise. The Yellow Thunder ruling was a potential landmark, bearing broad implications for application in other Indian land claims in the United States. However, O'Brien's finding was severely undercut by the Supreme Court's Geo Road decision and was consequently overturned by the Eighth Circuit Court. 214. Like the Lakota legal strategy, AIM's course of largely extra-legal action has proven insufficient in itself to resolve the Black Hills land claim. Nonetheless, it can be seen to have had a positive bearing on the evolution of litigation in the matter, and it has accomplished a great deal in terms of bringing public attention to, and understanding of, the real issues involved. In this sense, the legal and extra-legal battles fought by Lakotas for Pahasepa may be viewed as having been, perhaps inadvertently, mutually reinforcing. And, together, these two efforts may have created the context in which a genuine solution can finally be achieved. By the mid-1980s, the image of the United States regarding its treatment of the Lakotas had suffered so badly that a New Jersey senator, Bill Bradley, took the unprecedented step of introducing legislation the Indians themselves had proposed. 215 with the goal of finally ending the Black Hills controversy. The draft bill, S. 1453, was proposed to reconvey title to 750,000 acres of the hills currently held by the federal government, including subsurface rights, to the Lakotas. Further, it provided that certain spiritual sites in the area would be similarly retitled. These sites, along with some 50,000 of the reconveyed acres, would be designated a Sioux Park. The balance of the land returned would be designated a Sioux Forest. Additionally, considerable water rights within the South Dakota portion of the 1,868 treaty territory would be reassigned to the Lakotas. A Sioux National Council, drawn from all existing Lakota reservations, holding increased jurisdiction within the whole 8.5 million acres of the 1,868 Great Sioux Reservation, would also be established. Timbering, grazing permits, and mineral leasing in the Black Hills would be transferred to Lakota control 2 years after passage of the bill, thus establishing a viable Lakota economic base for the first time in nearly a century. The $122.5 million awarded by the Court of Claims, plus interest accrued since 1980, a total of over $350,216 would be dispersed as compensation for the Lakotas' historic loss of use of their land rather than as payment for the land itself. Finally, the draft bill posited that it would resolve the Black Hills claim only, having no effect on subsisting treaties. In other words, with satisfactory settlement of the Hills issue in hand, the Lakotas would remain free to pursue resolution of their claims to the 1,868 unceded Indian Territory and the 1,851 Treaty Territory. 217. Although the Bradley Bill was obviously less than perfect, compensation remained very low, considering that the Hearst Corporation's Homestake mine alone has extracted more than $18 billion in gold from the Black Hills since 1877-218, and the United States and its citizens are left with considerable land and rights in the area to which they were never legally entitled. It represented a major potential breakthrough not only with regard to the Black Hills land claim, but to U.S. Indian relations far more generally. Although the full Lakota agenda was not met by the bill, it probably came close enough that the bulk of the people would have endorsed it. That, more than anything, was a testament to their own perseverance in struggle in the face of astronomical odds. The bill, however, foundered during the late 80s in the wake of a campaign to improve upon it advanced by a rather mysterious individual named Phil Stevens. Throughout his life, Stevens functioned as a non-Indian, fashioning for himself a highly profitable defense contracting corporation in Los Angeles. Deciding to retire in 1984, he sold his company for an estimated $60 million. Thereupon, he claimed to have discovered he was a direct descendant of a noted Lakota leader and to be consumed with a belated passion to help his people. In 1986, he began to approach certain disaffected elements on the reservation, arguing that with his federal contacts and negotiating expertise, he could better not only the monetary compensation portions of the Bradley Bill, increasing reparations to $3.1 billion, but improve upon its jurisdictional provisions as well. 219 He punctuated his points by spreading relatively small quantities of cash around destitute Lakota communities and stipulated that all he needed was to be designated Great Chief of all the Sioux to get the job done. 220 Resistance to Stevens' posturing was intense in many quarters, especially among those who worked most unstintingly to bring Bradley's initiative into being. Nonetheless, Interest in Stevens' ideas had reached sufficient proportions by early 1988 that Gerald Clifford, chief negotiator and chair of the Black Hills Steering Committee, was compelled to take him to Washington, D.C., to broach his proposals to various key Congresspeople. 221 The timing was most inopportune, given that Bradley had, since introducing his bill for a second time on March 10, 1987, been able to secure support for the legislation even from such notoriously anti-Indian senators as Lloyd Meads. The chairs of both the House and Senate Interior Committees, Representative Morris Udall and Senator Daniel Inouye, had also agreed to serve as co-sponsors. 222. The baleful consequences of Stevens' Washington tour soon became evident. Bradley had no intention of amending his bill to include Stevens' $3.1 billion compensation package or getting caught in the crossfire between competing Sioux factions. With Clifford's reluctant concurrence, Bradley decided to hold his bill in abeyance until the Lakotas settled their internal dispute. 223 The first significant congressional land return initiative in U.S. history now thoroughly in tatters, Stevens quickly quit the field, withdrawing his flow of funds to the reservation communities as well. Meanwhile, liberal South Dakota Senator Tom Dashley capitalized on the situation, founding what he called the Open Hills Committee, designed to counter the long-term campaign by those who seek to replace the 1980 Supreme Court settlement with a massive land and even more massive money transfer. 224 The committee is chaired by Dashley's close friend David Miller, reactionary revisionist historian at Black Hills State University in Spearfish, South Dakota. The Open Hills Committee riled up what Miller himself described as South Dakota's considerable redneck population, people who would just as soon load up shotguns as return any portion of the hills to the Sioux. In a part of the country where many people thought of Indians either as dirty drunks or crazed militants, the Open Hills Committee had no difficulty recruiting. 225. In a context of mounting tension between Indians and whites in South Dakota during 1989, Dashley had no difficulty in teaming up with his fellow senator from South Dakota, Larry Pressler, in securing an agreement from Inouye, by then chair of the Senate Select Committee on Indian Affairs, that there would be no hearings, mark UPS, or other action taken on any Black Hills legislation without the express consent of the South Dakota Senatorial Delegation. 226 In 1990, Pressler sought to follow up by introducing a resolution which would have required yet another reservation-by-reservation poll of the increasingly desperate Lakotas with regard to accepting the Supreme Court's 1980 cash award as final resolution of the Black Hills question. 227. Small wonder that Clifford viewed the emergence of Stevens' program as an unmitigated disaster, the work not of a savior but of a manipulator and salesman, a glory hound whose ties to the tribe were at best attenuated. 228 Russell Means, observing that no provocateur could have done a better job of screwing up the Black Hills land claim, has openly expressed suspicions that Stevens may have been an outright federal agent of some sort, or at least an individual aligned with the opponents of the Lakota land claims. 229 Uncharacteristically, even arch-conservative editor of the Lakota Times Tim Jago agreed with Means, describing Stevens as a ringer, pure and simple. 230. In the end, the question becomes whether some version of the Bradley bill can ever be passed in anything resembling its original form. If so, the Lakotas' long fight for their land, and for their integrity as a nation, will have been significantly advanced. Moreover, a legislative precedent will have been set which could allow other peoples indigenous to what is now the United States to begin the long process of reconstituting themselves. This, in turn, would allow the U.S. itself to begin a corresponding process of reversing some of the worst aspects of its ugly history of colonization and genocide against American Indians. The prospect remains, but it is now only a feeble glimmer of what it was 10 years ago. Only a substantial upsurge of non-Indian support for the concept unlikely, given the typical priorities manifested by even the most progressive sectors of Euro-America would now serve to salvage the legislative option. In the alternative, if comparable remedies are rejected, and thus fail to resolve what by any measure is the best known of all Indian land claims in North America, it will be a clear sign that the United States remains unswervingly committed to its long-standing policy of expropriating Indian assets by whatever means are available to it, and to destroying indigenous societies as an incidental cost of doing business. In that event, the Lakotas will have no real option but to continue their grim struggle for survival, an indication that the future may prove even worse than the past. The crossroads in this sense has already been reached. The Western Shoshone land claim. A differently waged, and lesser known, struggle for land has been conducted by the New, mainly in the Nevada desert region. In 1863, the United States entered into the Treaty of Ruby Valley, agreeing in exchange for new commitments of peace and friendship, willingness to provide right-of-way through their lands, and the granting of assorted trade licenses to recognize the boundaries encompassing approximately 24.5 million acres of the traditional Western Shoshone homeland, known in their language as New Sigabia. 231. The U.S. also agreed to pay $100,000 in restitution for environmental disruptions anticipated as a result of Euro-American commerce in the area. As concerns the ultimate disposition of territorial rights within the region, researcher Rudolf C. Reiser has observed that, nothing in the Treaty of Ruby Valley ever sold, traded, or gave away any part of the new country to the United States of America. Nothing in this treaty said that the United States could establish counties or smaller states within new country. Nothing in this treaty said the United States could establish settlements of U.S. citizens who would be engaged in any activity other than mining, agriculture, milling and ranching. 232. From the signing of the treaty until the mid-20th century, no action was taken by either Congress or federal courts to extinguish native title to New Sigabia. 233. Essentially, the land was an area in which the United States took little interest. Still, relatively small but steadily growing numbers of non-Indians did move into new territory, a situation which was generally accommodated by the Indians so long as the newcomers did not become overly presumptuous. By the late 1920s, however, conflicts over land use had begun to sharpen. Things worsened after 1934, when the U.S. installed a tribal council form of government desired by Washington but rejected by traditional news under provision of the IRA. 234. It was to the IRA Council heading one of the Western Shoshone bands, the Timok, that attorney Ernest Wilkinson went with a proposal in early 1946. Figure 4.6. Traditional Shoshone Territory. Wilkinson was a senior partner in the Washington-based law firm Wilkinson, Cragen, and Barker, commissioned by Congress toward the end of World War II to draft legislation creating the Indian Claims Commission. The idea he presented to the Timok Council was that his firm be retained to represent their interests before the ICC. 235. Ostensibly, his objective was to secure the band's title to its portion of the 1,863 treaty area. Much more likely, given subsequent events, is that his purpose was to secure title for non-Indian interests in Nevada and to collect the 10% attorney's fee he and his colleagues had written into the Claims Commission Act as pertaining to any compensation awarded to native clients. 236. In any event, the Timoks agreed, and a contract between Wilkinson and the council was approved by the Bureau of Indian Affairs in 1947. 237. Wilkinson followed up in 1951 with a petition to the ICC arguing that his representation of the Timoks should be construed as representing the interests of the entire new nation. The commissioners concurred, despite protests from the bulk of the people involved. 238. While such a ruling may seem contrary to popular notions of American justice, it is in fact entirely consistent with the form and function not only of the Commission, but of federal Indian law more generally. As Dan Bommery, head of the Seventh Generation Fund, has explained, when the U.S. succeeded in forcing the Indian Reorganization Act upon tribes, installing puppet governments, the ultimate U.S. aim was to make Indians a resource colony, like Africa was for Europe. Sometimes the issue is coal or uranium and sometimes it's just open land. The role of the Indian Claims Commission is to get the land of tribes who do not have puppet governments, or where the traditional people are leading a fight to keep land and refuse money. 239. It follows that, from the outset, Wilkinson's pleadings, advanced in hearings by his partner, Robert W. Barker, led directly away from new rights over the Ruby Valley Treaty territory. The Shoshone objectives in agreeing to go to court have been explained by tribal elder Saggy Williams, a resident of Battle Mountain. All we wanted was for the white men to honor the treaty. Believed the lawyers we hired were to work for the Indians and to do what the Indians asked. But they didn't. They did as they pleased and told us we didn't have any land. At the time, we didn't talk about selling our land with the lawyer because we had the treaty, which settled the land question. It protected lands. 240. As Glenn Hawley, a Timok leader of the contemporary land claims struggle, puts it, most of our people never understood that by filing with the Claims Commission, we'd be agreeing we lost our land. They thought we were just clarifying the title question. 241. However, Barker filed the claim in 1951, asserting that the Western Shoshones had lost not only their treaty lands, but also their aboriginal land extending into Death Valley, California. He put the date of loss at 1872, and he included in the 24 million acre claim some 16 million acres that the Shoshones insist were not occupied by anyone but Indian bands, and that were never in question. But the Justice Department agreed with Barker's contention. Since opposing attorneys agreed, the Claims Commission did not investigate or seek other viewpoints. 242. Clarence Blossom, one of the new elders who signed the original contract with Wilkinson, and who supported Barker for a time, points out that the land claim was never explained to the people. The old people do not even understand English. It was years later that I read that once you accept money, you lose your land. The government pulled the wool over our eyes. If I had known what was going on, I never would have accepted the attorney contract. 243. As Raymond Yowell, a member of the Timok Band Council and another original signatory, laid it out in a 1978 issue of the Native Nevadan, a majority of the people present objected to the way Barker was giving up the remaining rights to our lands and walked out. Soon after, at meeting, about 80% of the people showed their opposition by walking out. It is important that at these meetings Barker insisted we had no choice as to whether to keep title to some lands or to give them up for claims money. The only choice was whether to approve or disapprove and if we disapproved we would get nothing. 244. Ultimately, the Wilkinson, Cragen, and Barker firm received a $2.5 million federal subsidy for services rendered in its resolution of the matter in a fashion which was plainly detrimental to the express interests of its ostensible clients. 245 Shawnee scholar and activist Glenn T. Morris has summarized the matter in what is probably the best article on the Western Shoshone land struggle to date. In 1962, the Commission conceded that it was unable to discover any formal extinguishment of Western Shoshone to lands in Nevada, and could not establish a date of taking, but nonetheless ruled that the lands were taken at some point in the past. It did rule that approximately 2 million acres of new land in California was taken on March 3, 1853, but without documenting what specific act of Congress extinguished the title. Without the consent of the Western Shoshone Nation, on February 11, 1966, Wilkinson and the U.S. lawyers arbitrarily stipulated that the date of valuation for government extinguishment of Western Shoshone title to over 22 million acres of land in Nevada occurred on July 1, 1872. This lawyers' agreement, entered without the knowledge or consent of the Shoshone people, served as the ultimate loophole through which the U.S. would allege that the New had lost their land. 246. By 1872 prices, the award of compensation to the New for the historic loss of their territory was calculated, in 1972, at $21,350,000, an amount revised upwards to $26,154,600 and certified on December 19, 1979.247. In the interim, by 1976, even the Timoks had joined the other new bands in maintaining that Wilkinson and Barker did not represent their interests. They fired them, but the BIA continued to renew the firm's contract on the Indians' behalf until the Claims Commission itself was dissolved in 1979.248. Meanwhile, the News retained other counsel and filed a motion to suspend commission proceedings with regard to their case. This was denied on August 15, 1977, appealed, but upheld by the U.S. Court of Claims on the basis that if the New desired to avert extinguishment of their land claims, they should go to Congress rather than the courts for redress. The amount of $26,145,189.89 was then placed in a trust account with the U.S. Treasury Department in order to absolve the U.S. of further responsibility in the matter. 249. One analyst of the case suggests that if the United States were honest in its valuation date of the taking of new land, the date would be December 19, 1979, the date of the ICC award, since the could point to no other extinguishment date. The U.S. should thus compensate the Shoshone in 1979 land values and not those of 1872. Consequently, the value of the land that would be more realistic, assuming the Western Shoshone were prepared to ignore violations of the Ruby Valley Treaty, would be in the neighborhood of $40 billion. On a per capita basis of distribution, the United States would be paying each Shoshone roughly $20 million. The has already received billions of dollars in resources and use from new territory in the past 125 years. Despite this obvious benefit, the U.S. government is only prepared to pay the Shoshone less than a penny of actual value for each acre of new territory. 250. The News as a whole have refused to accept payment for their land under the premise articulated by Yoel, now chair of the Western Shoshone Sacred Lands Association. We entered into the Treaty of Ruby Valley as co-equal sovereign nations. The land to the traditional Shoshone is sacred. It is the basis of our lives. To take away the land is to take away the lives of the people. 251. Glenn Hawley concurs. Nothing happened in 1872, he says. No land was taken by the government. We never lost that land, we never left that land, and we're not selling it. In our religion, it's forbidden to take money for land. What's really happening is that the U.S. government, through this Claims Commission, is stealing the land from us right now. 252. We should have listened to our old people, Yoel sums up. They told us Barker was selling out our lands. It took me years to realize it. 253. Giving form to the sentiment, were the sisters Mary and Carrie Dan, who not only refused eviction from their homes by the U.S. Interior Department's Bureau of Land Management, which claimed at that time to own property that had been in their family for generations, but challenged all U.S. title contentions within the new treaty area when the Bureau attempted to enforce its position in court. In 1974, the Dan sisters were herding cattle near their home when a BLM ranger stopped them and demanded to see their grazing permit. The Dans replied that they did not need a permit since they were not on U.S. land, but the land of the Western Shoshone Nation. They were charged with trespassing. I have grazed my cattle and horses on that land all my life, says Carrie Dan, and my mother did before me and her mother before her. Our people have been on this land for thousands of years. We don't need a permit to graze here. 254. The trespassing case was filed in the U.S. District Court for Reno, where the sisters invoked Aboriginal land rights as a defense. The ensuing litigation has caused federal courts to flounder about in disarray ever since. As John O'Connell, an attorney retained by the News to replace Barker, and who has served as lead counsel in defending the Dans, has put it, we have asked the government over and over again in court to show evidence of how it obtained title to Shoshone land. They start groping around and can't find a damn thing. In fact, the relevant documents show the United States never wanted the Nevada desert until recently. There's no doubt in my mind that the Western Shoshones still hold legal title to most of their Aboriginal territory. The great majority of them still live there and they don't want money for it. They love that desert. But if the Claims Commission has its way, the United States may succeed in finally stealing the land legally. 255. In 1977, the District Court ruled that the Dans were indeed trespassers, fining them $500 each, an amount they have steadfastly refused to pay because the Claims Commission had allegedly resolved all title questions. This decision was reversed on appeal to the Ninth Circuit Court in 1978 because, in the higher court's view, the question of land title had not been litigated, and has not been decided. 256. On remand, the district court engaged in a conspicuous pattern of stalling, repeatedly delaying its hearing of the case for frivolous reasons. The judge never wanted trial, O'Connell recalls. At one point I accused the government of deliberately delaying the Dan case long enough to get the Indian claims check written, under the theory that once payment was received Indian title would have been extinguished and the Dans would have been prevented from asserting it. The judge admitted on record that he was sympathetic with the government's strategy in this regard. 257. In the end, this is exactly what was done. In other words, a $26 million payment to Indians who never sought it, tried to stop it, and refused to accept it payment for lands that were alleged by the payer to have been taken in 1872, but which the courts have finally affirmed were never taken at all, is now being used as the instrument to extinguish Indian title. 258. The district court, however, in attempting to reconcile its mutually contradictory determinations on the topic, observed that Western Shoshone Indians retained unextinguished title to their aboriginal lands until December of 1979, when the Indian Claims Commission judgment became final. 259. This, of course, demolished the articulated basis that a title transfer had been effected more than a century earlier for the Commission's award amount. It also pointed to the fact that the Commission had comported itself illegally in the Western Shoshone case insofar as the Indian Claims Commission Act explicitly disallowed the commissioners from extinguishing previously unextinguished land titles. Thus armed, the Dans went back to the Ninth Circuit and obtained another reversal of the lower court's decision. 260. The government appealed the circuit court's ruling to the Supreme Court and, entering yet another official estimation of when new title was supposed to have been extinguished, the justices reversed the circuit court's reversal of the district court's last ruling. Having thus served the government's interest on appeal, the High Court declined in 1990 to hear an appeal from the Dans concerning the question of whether they might retain individual Aboriginal property rights based on continuous occupancy even if the collective rights of the new were denied. 261. Tom Lueben, another of the non-Indian attorneys involved in defending new rights, has assessed the methods of litigation employed by the U.S. It is clear that one of the main strategies the government uses in these cases is simply to wear out the Indians over decades of struggle, he observes. The government has unlimited resources to litigate. If the Indians win one victory in court, the government just loads up its legal guns, adds a new, bigger crew of fresh lawyers, and comes back harder. It is the legal equivalent of what the cavalry did 100 years ago. There is simply no interest in justice. It is hardball all the way. The government has all the time in the world to achieve its goals. The Indians run out of money, they get tired of fighting, they get old, and finally, after 10 to 20 years, somebody says, "The hell with it, let's take what we can." It's really understandable that it worked out that way, but it's disgusting and it's wrong. 262. Thus far, such tactics have proven unsuccessful against the new. A new strategy was hatched to sue the government for mineral and trespass fees from 1872 to 1979, says analyst Jerry Mander. The logic of the argument was that since the courts now recognize that the Shoshones did have legal title until the Claims Commission took it away in 1979, they are entitled to mineral and trespass fees for 109 years. This would amount to billions of dollars due the Shoshones. It was hoped that this amount sufficient to cause the government to negotiate. But the court rejected this new intervention on the technical grounds that the specific interveners were not parties to the original claim. This suit may yet re-emerge. 263. The need for it was punctuated in November 1992, which the Dans sisters' brother, Clifford, took direct action to block impoundment of wild horses and other livestock by the Bureau of Land Management. Stating that in taking away our livelihood and our lands, you are taking away our lives, he doused himself with gasoline and attempted to set himself afire. Quickly sprayed with fire extinguishers by surrounding BLM rangers, Dan was then arrested and, for reasons never adequately explained, charged with assaulting them. On May 17, 1993, he was sentenced to serve 9 months in prison, 2 years probation and a $5,000 fine. 264. For their part, Mary and Carrie Dan have announced their intent to go back into court with a new suit of their own, contending that the continuous use and occupancy evidenced by news on the contested land prior to the authority of the Bureau of Land Management affords them tangible rights to pursue their traditional livelihood. They hope, Mander notes, to carve a hole in the earlier decisions, which might open a doorway for the rest of the Western Shoshones to do much the same thing. 265. The chances were bolstered on March 6, 1998, when the Inter-American Commission on Human Rights of the Organization of American States issued a formal request to the U.S. government that it stay all further action with respect to evictions, impoundment of livestock, and the like, pending an investigation by the Commission into the historical context of the case, the respective rights of the parties involved, and, consequently, the legal validity of current U.S. policies vis-a-vis the News. 266. Perhaps most important, as of this writing, the Dan sisters remain on their land in defiance of federal authority. Their physical resistance, directly supported by most news and an increasing number of non-Indians, forms the core of whatever will come next. Carrie Dan is unequivocal, we have to be completely clear. We must not allow them to destroy Mother Earth. We've all been assimilated into white society, but now we know it's destroying us. We have to get back to our own ways. 267. Corbin Harney, a resistance leader from the Duckwater Shoshone community in northern Nevada, reinforces her position, we don't need their money. We need to keep these lands and protect them. 268. Federal officials tend to be equally straightforward, at least in what they take to be private conversation. Mander quotes one Interior Department bureaucrat, a reputed Jimmy Carter liberal responsible for seeing to it that Indians get a fair shake, as saying in an interview, me tell you one goddamn thing. There's no way we're ever letting any of the Indians have title to their lands. If they don't take the money, they'll get nothing. 269. The accuracy of this anonymous assertion of federal policy is amply borne out by the fact that an offer of compromise extended by a portion of the Shoshone resistance in 1977 that the News would drop their major land claim in exchange for the establishment of a 3 million-acre reservation, guarantee of perpetual access to specified sacred sites outside the reservation, and payment of cash compensation against the remaining 21 million acres was peremptorily rejected by then Secretary of the Interior Cecil Andrus. No explanation of this decision was ever offered by the government other than that the Secretary felt that being relegated to a landless condition would be in the Indians' best interests. 270. Leo Kurlitz, an assistant to Andrus and the Interior Department's chief attorney at the time the compromise offer was rejected, admits that he didn't give the legal issues much thought. 271. Admitting that he was uncomfortable with the very idea that the Shoshones still seemed to possess title to their land, he acknowledges that under no circumstances was I going to recommend that we create a reservation. I saw my job as assessing the resource needs of the Shoshones, but I couldn't recommend that we establish a reservation. 272. Mander's unnamed source says much the same thing, observing that, these Indian cases make me so damned uncomfortable, I wish I didn't have to work on them at all. 273. He professes a certain bewilderment that at least some indigenous nations refuse to be bought off. I really can't understand what these people want. Their lawyers get them great settlements. The Shoshones were awarded $26 million, and the Sioux may get for the Black Hills and Dam if they don't turn around and start talking about land. 274. Such uniform and undeviating adamance on the part of diverse Interior Department personnel that not so much as a square inch of the Nevada desert, other than the minor reservations already designated as such, will be committed for new use and occupancy may seem somewhat baffling on its face. Their collective willingness to lay out not inconsiderable quantities of tax dollars in order to retain absolute control over such barren and lightly populated territory with interest, The Western Shoshone Settlement Award now exceeds $80 million and is increasing steadily, raises further questions as to their motivations. 275. Quite possibly, a hallowed U.S. pseudo-philosophy, extended from the 19th century doctrine of manifest destiny and holding that Indians are by definition disentitled from retaining substantial quantities of real property, has a certain bearing in this connection. 276. Most probably, concern that a significant new land recovery might serve to establish a legal precedent upon which other indigenous nations could accomplish similar feats also plays a role. 277. Another part of the answer can probably be glimpsed in the July 1996 purchase of a 48,437-acre ranch in Crescent Valley by the Oro Nevada Mining Company. 278. Oro Nevada Mining, which also holds mineral rights to an additional 46,606 acres of public lands in the area, is a subsidiary of the Canadian transnational, Oro Nevada Resources, Limited. 279. The parent corporation has been heavily involved in the mining boom which has recently afflicted the Innu and Inuit peoples of Labrador, around Voisey Bay, and in Nitassinan, along the north shore of the St. Lawrence in Quebec. 280. Another subsidiary, Bre-X, was created to explore and develop gold deposits for the Suharto regime in Indonesia. 281. In Crescent Valley, it is believed that Oro is preparing to enter into a collaborative arrangement with Placer Dome/Kennecott subsidiary Cortez Gold, which already operates mines on the Pipeline and Pipeline South gold deposits further north, to extract the mineral from areas immediately adjoining the Dan Ranch. 282. Indeed, there has been talk throughout the mining industry that Crescent Valley may well turn out to be the scene of the next big gold rush. To some extent self-fulfilling prophecies, such rumors have in turn prompted corporations from as far away as Australia to begin acquiring speculative leases. 283. Even more to the point, however, is the fact that federal usurpation of new land rights since 1945 has devolved upon converting their remote and uninhabited territory into a sprawling complex of nuclear weapons testing facilities. In addition to the experimental detonations conducted in the Marshall Islands during the 1950s, and a handful of tests in the Aleutians a few years later, nearly 1,000 U.S. nuclear test blasts have thus far occurred at the Energy Resource and Development Administration's Nevada test site located within the military's huge Nellis Gunnery Range in southern Nevada. 284. At least as recently as July 2, 1997, a subcritical plutonium device was detonated there. 285. This largely secret circumstance has made New Segovia an area of vital strategic interest to the United States and, although the Shoshones have never understood themselves to be at war with the United States, it has afforded their homeland the dubious distinction of becoming by a decisive margin the most bombed country in the world. 286. The devastation and radioactive contamination of an appreciable portion of new property has been coupled to construction of a primary permanent storage facility for nuclear waste at Yucca Mountain, a site well within the Ruby Valley Treaty Area. 287. Moreover, the Pentagon has long since demonstrated a clear desire, evidenced in a series of plans to locate its MX missile system there, for most of the remaining new treaty territory, that vast and vacant geography lying north of the present testing grounds. The latter situation, which involved bringing approximately 20,000 additional non-Indians onto new land, creating another 10,000 miles of paved roads, and drawing down 3.15 billion gallons of water from an already overtaxed water table in order to install a mobile missile system accommodating some 200 nuclear warheads, provoked what may have been the first concerted Shoshone response to military appropriation of their rights. 288. As Corbin Harney put it at a mass meeting on the matter, convened in October 1979 after the Carter administration had made its version of the MX program public, now we are witnessing the real reason why we are being forced to accept money for lands. 289. At the same meeting, Glenn Hawley articulated the implications of the MX project to the news. Water is life, he said, and the MX system will consume our water resources altogether. Another thing the MX will destroy is the natural vegetation, the herbs like the baidba, doza, sagebrush, chaparral, Indian tea, OT only the herbs but other medicines like the lizard in the south, which we use to heal the mentally sick and arthritis. There will also be electric fences, nerve gas, and security people all over our lands. It will affect the eagles and the hawks, the rock chuck, ground squirrel, rabbit, deer, sage grouse, and rattlesnake. If this MX goes through, it will mean the total destruction of the Shoshone people, our spiritual beliefs and our ways of life. 290. On this basis, overt new opposition to nuclear militarism became both pronounced and integral to assertion of their land claims. As the matter was framed in a resolution first published by the Sacred Lands Association during the early 1980s, the Western Shoshone Nation is calling upon citizens of the United States, as well as the world community of nations, to demand that the United States terminate its invasion of our lands for the evil purpose of testing nuclear bombs and other weapons of war. 291. This stance, in turn, attracted attention and increasing support from various sectors of the non-Indian environmental, nuclear freeze, and anti-war movements, all of which are prone to engaging in large-scale demonstrations against U.S. nuclear testing and related activities. Organizations such as SANE, Clergy and Laity Concerned, Earth First, and the Sierra Club were represented at the 1979 mass meeting. Their loose relationship to the Shoshone land claim struggle has been solidified through the work of new activists like the late Joe Sanchez, and reinforced by the participation of groups like Friends of the Earth, the Environmental Defense Fund, the Great Basin Greens Alliance, the American Peace Test, and the Global Anti-Nuclear Alliance. 292. As Mander puts it, there have been some positive developments. Many of the peace groups have belatedly recognized the Indian issue and now request permission from the Western Shoshone Nation to demonstrate on their land. The Indians, in turn, have been issuing the demonstrators safe passage permits and have agreed to speak at rallies. The Western Shoshone National Council has called the nuclear testing facility an absolute violation of the Treaty of Ruby Valley and the laws of the United States. Peace activists are instructed that if they are confronted or arrested by U.S. government officials while on Shoshone land, they should show their Shoshone permits and demand to continue their activities. Furthermore, in case of trial, the defendants should include in their defense that they had legal rights to be on the land, as granted by the landowners. 293. It is in this last connection that the greatest current potential may be found, not only for the News in their struggle to retain their homeland, but for assertion of indigenous land rights more generally, and for the struggles of non-Indians who seek genuinely positive alternatives to the North American status quo. In the combination of forces presently coalescing in the Nevada desert lie the seeds of a new sort of communication, understanding, respect, and the growing promise of mutually beneficial joint action between native and non-native peoples in this hemisphere. 294. For the Shoshones, the attraction of a broad and broadening base of popular support for their rights offers far and away the best possibility of bringing to bear the kind and degree of pressure necessary to compel the federal government to restore all, or at least some sizable portion, of their territory. For the non-Indian individuals and organizations involved, the incipient unity they have achieved with the News represents both a conceptual breakthrough and a seminal practical experience of the fact that active support of native land rights can tangibly further their own interests and agendas. 295. For many American Indians, particularly those of traditionalist persuasion, the emerging collaboration of non-Indian groups in the defense of Western Shoshone lands has come to symbolize the possibility that there are elements of the dominant population that have finally arrived at a position in which native rights are not automatically discounted as irrelevancies or presumed to be subordinate to their own. 296. On such basis, bona fide alliances can be built. Herein lies what may be the most important lesson to be learned by those attempting to forge a truly American radical vision, and what may ultimately translate that vision into concrete reality. Native Americans cannot hope to achieve restoration of the lands and liberty which are legitimately theirs without the support and assistance of non-Indians, while non-Indian activists cannot hope to effect any transformation of the existing social order which is not fundamentally imperialistic, and thus doomed to replicate some of the most negative aspects of the present system, unless they accept the necessity of liberating indigenous land and lives as a matter of first priority. 297. Both sides of the equation are at this point bound together in all but symbiotic fashion by virtue of a shared continental habitat, a common oppressor, and an increasingly interactive history. There is thus no viable option but to go forward together, figuratively joining hands to ensure our collective well-being, and that of our children, and our children's children. Moving forward. The question which inevitably arises with regard to indigenous land claims, especially in the U.S., is whether they are realistic. The answer, of course, is no, they aren't. Further, no form of decolonization has ever been realistic when viewed within the construct of a colonialist paradigm. It wasn't realistic at the time to expect George Washington's ragtag militia to defeat the British military during the American independence struggle. Just ask the British. It wasn't realistic, as the French could tell you, that the Vietnamese should be able to defeat U.S.-backed France in 1954-298, or that the Algerians would shortly be able to follow in their footsteps. 299 Surely, it wasn't reasonable to predict that Fidel Castro's pitiful handful of guerrillas would overcome Batista's regime in Cuba, another U.S. client, after only a few years in the mountains. 300 And the Sandinistas, to be sure, had no prayer of attaining victory over Somoza 20 years later. 301 Henry Kissinger, among others, knew that for a fact. The point is that in each case, in order to begin their struggles at all, anti-colonial fighters around the world have had to abandon orthodox realism in favor of what they knew to be right. To paraphrase Daniel Cohn-Bendit, they accepted as their agenda the goals, objectives, and demands which guided them, a redefinition of reality in terms deemed quite impossible within the conventional wisdom of their oppressors. And, in each case, they succeeded in their immediate quest for liberation. 302 The fact that all but one of the examples used subsequently turned out to hold colonizing pretensions of its own does not alter the truth of this or alter the appropriateness of their efforts to decolonize themselves in the least. It simply means that decolonization has yet to run its course, that much remains to be done. 303 The battles waged by native nations in North America to free ourselves, and the lands upon which we depend for ongoing existence as discernible peoples, from the grip of U.S. internal colonialism is plainly part of this process of liberation. 304 Given that our very survival depends upon our perseverance in the face of all apparent odds, American Indians have no real alternative but to carry on. 305 We must struggle, and where there is struggle there is always hope. Moreover, the unrealistic or romantic dimensions of our aspiration to quite literally dismantle the territorial corpus of the U.S. state begin to erode when one considers that federal domination of Native America is utterly contingent upon maintenance of a perceived confluence of interest between prevailing governmental/corporate elites and common non-Indian citizens. 306 Herein lies the prospect of long-term success. It is entirely possible that the consensus of opinion concerning non-Indian rights to exploit the land and resources of indigenous nations can be eroded, and that large numbers of non-Indians will join in the struggle to decolonize native North America. Few non-Indians wish to identify with or defend the Naziist characteristics of U.S. history. To the contrary, most seek to deny it in rather vociferous fashion. 307 All things being equal, they are uncomfortable with many of the resulting attributes of federal posture and in substantial numbers actively oppose one or more of these, so long as such politics do not intrude into a certain range of closely guarded self-interests. This is where the crunch comes in the realm of Indian rights issues. Most non-Indians have been indoctrinated to believe the officially contrived notion that, in the event the Indians get their land back, or even if the extent of present federal domination is relaxed, native people will do unto our occupiers exactly as has been done to us, mass dispossession and eviction of non-Indians, especially Euro-Americans, is expected to ensue. 308 Hence, even those progressives who are most eloquently inclined to condemn U.S. imperialism abroad and/or the functions of racism and sexism at home tend to deliver a blank stare or profess open disinterest when indigenous land rights are mentioned. 309 Instead of attempting to come to grips with this most fundamental of all issues concerning the continent upon which they reside, the more sophisticated among them seek to divert discussion into higher priority or more important topics like Issues of class and gender equity in which justice becomes synonymous with the redistribution of power and loot deriving from the occupation of native North America even while the occupation continues. 310. Sometimes, Indians are even slated to receive their fair share in the division of spoils accruing from expropriation of their resources. 311. Always, such things are couched and typically seen in terms of some greater good than decolonizing the 0.6% of the U.S. population which is indigenous. 312. Some Marxist and environmentalist groups have taken the argument so far as to deny that Indians possess any rights distinguishable from those of their conquerors. 313. AIM leader Russell Means snapped the picture into sharp focus when he observed that so-called progressives in the United States claiming that Indians are obligated to give up their rights because a much larger group of non-Indians need their resources is exactly the same as Ronald Reagan and Elliott Abrams asserting that the rights of 250 million North Americans outweighs the rights of a couple million Nicaraguans. Colonialist attitudes are colonialist attitudes, and it doesn't make one damn bit of difference whether they come from the left or the 314. Leaving aside the pronounced and pervasive hypocrisy permeating their positions, which add up to a mentality defining settler state colonialism. 315. The fact is that the specter driving even most radical non-Indians into lockstep with the federal government on questions of native land rights is largely illusory. The alternative reality posed by native liberation struggles is actually much different. While government propagandists are wont to trumpet as they did during the Maine and Black Hills land disputes of the 1970s that an Indian win would mean individual non-Indian property owners losing everything, the native position has always been the exact opposite. Overwhelmingly, the lands sought for actual recovery have been governmentally and corporately held. Eviction of small landowners has been suggested only in instances where they have banded together as they have during certain of the Iroquois claims cases to prevent Indians from recovering any land at all, and to otherwise deny native rights. 316. Official sources contend this is inconsistent with the fact that all non-Indian title to any portion of North America could be called into question. Once the dike is breached, they argue, it's just a matter of time before everybody has to start swimming back to Europe, or Africa, or wherever. 317. Although there is considerable technical accuracy to admissions that all non-Indian title to North America is illegitimate, Indians have by and large indicated we would be content to honor the cession agreements entered into by our ancestors even though the U.S. has long since defaulted. This would leave something on the order of half to two-thirds of the continental U.S. in non-Indian hands, with the real rather than pretended consent of native people. The remaining one-third to one-half, to which the U.S. never acquired title at all, should be recovered by its rightful owners. 318. Nonetheless, it is argued, there will still be at least some non-Indians trapped within such restored areas. Actually, they would not be trapped at all. Federally imposed genetic criteria of Indianness to the contrary notwithstanding, indigenous nations have the same rights as any other to define citizenry by allegiance rather than by race. 319. Non-Indians could apply for citizenship, or for some form of landed alien status which would allow them to retain their property until they die. In the event they could not reconcile themselves to living under any jurisdiction other than that of the U.S., they would obviously have the right to leave, and they should have the right to compensation from their own government. 320. Finally, and one suspects this is the real crux of things from the government/corporate perspective, any such restoration of land and attendant sovereign prerogatives to native nations would result in a truly massive loss of domestic resources to the U.S., thereby impairing the country's economic and military capacities. 321. For everyone queued up to wave flags celebrating America's recent imperial adventures in Afghanistan and the Persian Gulf, this prospect may induce a certain psychic trauma. But, for oppositionists at least, it should be precisely the point. When you think about it like this, the great mass of non-Indians in North America really have much to gain, and almost nothing to lose, from native people succeeding in struggles to reclaim the land which is rightfully ours. The tangible diminishment of U.S. material power which is integral to our victories in this sphere stands to pave the way for realization of most other agendas from anti-imperialism to environmentalism, from Afro-American liberation to feminism, from gay rights to the ending of class privilege pursued by progressives on this continent. Conversely, succeeding with any or even all these other agendas would still represent an inherently oppressive situation if their realization is contingent upon an ongoing occupation of native North America without the consent of Indian people. Any North American revolution which failed to free indigenous territory from non-Indian domination would be simply a continuation of colonialism in another form. 322. Regardless of the angle from which you view the matter, the liberation of native North America, liberation of the land first and foremost, is the key to fundamental and positive social changes of many other sorts. One thing, as they say, leads to another. The question has always been, of course, which thing is to be first in the sequence. A preliminary formulation for those serious about achieving radical change in the United States might be first priority to first Americans. Put another way, this would mean, U.S. out of Indian country. Inevitably, the logic leads to what we've all been so desperately seeking, the U.S. at least as we've come to know it can be permanently banished from the planet. In its stead, surely we can join hands to create something new and infinitely better. That's our vision of impossible realism. Isn't it time we all went to work on attaining it? 5. A breach of trust. The radioactive colonization of native North America. There are whole disciplines, institutions, rubrics in our culture which serve as categories of denial. Susan Griffin. A Chorus of Stones. In 1903, the United States Supreme Court opined that, as a racial group, American Indians, like minor children and those deemed mentally deficient or deranged, should be viewed as legally incompetent to manage our own assets and affairs. Indians were therefore to be understood as perpetual wards of the federal government, the High Court held, the government our permanent trustee. With a deft circularity of reasoning, the justices then proceeded to assert that, since it was Indians' intrinsic incompetence which had led to our being placed under trust supervision, we should by the same definition be construed as having no standing from which to challenge the exercise of our trustees' authority over us. 1. Thus did the U.S. formally and unilaterally assign itself plenary, that is, absolute and unchallengeable power over all native lands, lives, and natural resources within the area of 48 contiguous states of North America, as well as Alaska, Hawaii and other external possessions such as Guam and American Samoa. The only curb upon the imagined prerogatives of the United States in this regard is an equally self-appointed fiduciary responsibility to act, or at least claim to act, in the best interests of those it has subjugated both physically and juridically. 2 Although the basic proposition at issue has undergone almost continuous modification and perfection over the years, it remains very much in effect at present. 3. The scale and implications of the situation are in some ways staggering. In its 1978 final report, the government's own Indian Claims Commission conceded that after more than 30 years' intensive investigation, it had been unable to find evidence that the U.S. had ever acquired anything resembling legitimate title to about 35% of its claimed territoriality, all of which therefore remains native property in a legal sense. 4 The approximately 2.5% of U.S. territory currently reserved for Indian use and occupancy, most of it still held in federal trust status, is also extraordinarily rich in mineral resources. 5 As much as 2/3 of the uranium ore the U.S. claims as its own is situated within reservation boundaries, as is about 1/4 of the readily accessible low-sulfur coal, up to 20% of the oil and natural gas, and substantial deposits of molybdenum, copper, bauxite, and zeolite. 6. The Bureau of Indian Affairs, a component of the U.S. Department of Interior, presently administers trust relations with several hundred indigenous peoples and communities encompassing, by official count, some 2 million individuals. 7 Simple arithmetic reveals that when the 50 million odd acres of reserved land is divided by the federal tally of Indians, we end up as the largest land-holding group in North America on a per capita basis. Divide the estimated dollar value of the mineral assets within the land by the number of Indians and you end up with native people as the wealthiest population aggregate on the continent. All of this is, unfortunately, on paper. The practical reality is that American Indians, far from being well off, are today the most impoverished sector of the U.S. population. 8 We experience by far the lowest average annual and lifetime incomes of any group. The poorest locality in the United States for 23 of the past 25 years has been Shannon County, on the Pine Ridge Sioux Reservation in South Dakota, where a recent study found 88% of the available housing to be substandard, much of it to the point of virtual uninhabitability. The annual per capita income in Shannon County was barely over $2,000 in 1995, while unemployment hovered in the 90th percentile. 9. Bad as conditions are on Pine Ridge, they are only marginally worse than those on the adjoining Rosebud Sioux Reservation and a host of others. In many ways, health data convey the costs and consequences of such deep and chronic poverty far better than their financial counterparts. These begin with the facts that, overall, American Indians suffer far and away the highest rates of malnutrition, death from exposure, and infant mortality. 10. The Indian health level is the lowest and the disease rate the highest of all major population groups in the United States. The incidence of tuberculosis is over 400% the national average. Similar statistics show the incidence of strep infections is 1000%, meningitis is 2000% higher, and dysentery is 10,000% higher. Death rates from disease are shocking when Indian and non-Indian populations are compared. Influenza and pneumonia are 300% greater killers among Indians. Diseases such as hepatitis are at epidemic proportions, with an 800% higher chance of death. Diabetes is almost a plague. 11. It should come as no surprise, given the ubiquitousness of such circumstances, that alcoholism and other addictions take an inordinate toll. Although fewer Indians drink than do non-Indians, the rate of alcohol-related accidental deaths among Native people is 10 times that of the general population, while the rate of fetal alcohol syndrome among the newborn is 33 times greater. 12 The suicide rate among Indians is 10 times the national norm, while, among Native youth, it is 10,000% higher than among our non-Indian counterparts. 13. All told, the current life expectancy of a reservation-based American Indian male is less than 50 years in a society where the average man lives 71.8 years. Reservation-based Indian women live approximately 3 years longer than males, but general population women enjoy an average life expectancy 7 years longer than non-Indian men. 14 Hence, every time an American Indian dies on a reservation or, conversely, every time a child is born, it can be argued that about 1/3 of a lifetime is lost. This 30th percentile attrition of the native population has prevailed throughout the 20th century, a situation clearly smacking of genocide. 15. This last is, of course, a policy-driven phenomenon, not something inadvertent or merely unfortunate. Here, the BIA's exercise of trust authority over native assets comes into play. While it has orchestrated the increasingly intensive development of reservation lands since 1945, a matter which might logically have been expected to alleviate at least the worst of the symptomologies sketched above, the Bureau's role in setting the rates at which land was/is leased and royalties for extracted minerals were/are paid by major corporations has precluded any such result. 16. Instances in which the BIA has opted to rent out the more productive areas on reservations to non-Indian ranchers or agribusiness interests for as little as $1 per acre per year, and for as long as 99 years, are legion and notorious. 17 As to mineral royalties, the Bureau has consistently structured contracts in behalf of Indians which require payment of as little as 10% of market rates while releasing participating corporations from such normal overhead expenses as the maintenance of minimum standards for worker/community safety and environmental safeguards. In fact, most such arrangements have not even provided for a semblance of post-operational cleanup of mining and processing sites. 18. Such savings accrue to U.S. corporations in the form of super profits indistinguishable from those gleaned through their enterprises in the Third World, a matter which has unquestionably facilitated the emergence of the United States as the world's dominant economic power in the post-World War II context. 19 Minerals such as uranium, molybdenum, and zeolite, moreover, are not only commercially valuable but strategically crucial, an important factor in understanding America's present global military ascendancy. Point 20. All of this has been obtained, as a matter of policy, at the direct expense of native North America as well as other underdeveloped regions of the world. As Eduardo Galeano once explained to mainstream Americans, with respect to the impact of their lifestyle on Latin America, your wealth is our poverty. 21. The correlation is no less true on American Indian reservations. It holds up even in such superficially more redeemable connections as U.S. efforts to curtail acid rain and other collateral effects of electrical power generation through reliance upon low-sulfur bituminous rather than high-sulfur anthracite coal. The largest and most easily extracted deposit of bituminous coal in North America is located at Black Mesa, in northern Arizona, an area occupied almost exclusively by Navajos. Beginning in 1974, the federal government undertook a program of compulsory relocation to remove some 13,500 resident Navajos from the intended mining area, dispersing them into primarily urban areas and completely obliterating their socio-cultural existence. The land upon which their subsistence economy was based is itself to be destroyed, a circumstance barring even the possibility of their reconstitution as a viable human group at some future date. Point 22. The coal, once mined, is slurried to the Four Corners power plant and other generating facilities where it is burned to produce electricity. This product is then transported over massive power grids to meet such socially vital needs as keeping the air conditioners humming in the Phoenix Valley and the neon lights lit 24 hours a day at Las Vegas casinos. Meanwhile, 46% of the homes on the Navajo reservation have no electricity at all. Point 23. No more fitting illustration of Galeano's equation seems conceivable. Internal colonialism. Historically, the term colonialism has been employed to describe the sort of relationship between nations. Since ratification of the United Nations Charter in 1945, however, such structural domination/exploitation of any nation or people by another, even when it is disguised as the exercise of a perpetual trust, has been deemed illegal within the canons of international jurisprudence. The principle has been clarified, and has received considerable amplification, in subsequent instruments, most unequivocally in United Nations General Assembly Resolution 1514, also known as the Declaration on the Granting of Independence to Colonial Countries and Peoples, 1960-24. The subjection of peoples to alien subjugation, domination, and exploitation constitutes a denial of fundamental human rights, is contrary to the Charter of the United Nations and is an impediment to the promotion of world peace and cooperation. All peoples have the right to self-determination. By virtue of that right they freely determine their political status and freely pursue their economic, social, and cultural development. Inadequacy of political, economic, social, or educational preparedness should never serve as a pretext for delaying independence. All armed action or repressive measures directed against dependent peoples shall cease in order to enable them to exercise peacefully and freely their right to complete independence, and the integrity of their national territory shall be respected. Immediate steps shall be taken in trust or non-self-governing territories or all other territories which have not yet attained independence, to transfer all powers to the peoples of those territories, without any conditions or reservations, in accordance with their freely expressed will and desire, without any distinction as to race, creed or color, in order to enable them to enjoy complete independence and freedom. Any attempt aimed at the partial or total disruption of the national unity and the territorial integrity of a country is incompatible with the purpose and principles of the Charter of United Nations. All states shall observe faithfully and strictly the provisions in the Charter of the United Nations, the Universal Declaration of Human Rights and the present Declaration on the basis of equality, non-interference in the internal affairs of all states, and respect for the sovereign rights of all peoples and their territorial integrity. Point 25. While this would seem straightforward enough, the declaration's universality was muddied by a follow-up provision, General Assembly Resolution 1541, which effectively constrained its applicability to people/territories separated from colonizing powers by at least 30 miles of open ocean. 26 This overseas requirement has seriously undermined assertions of the right to self-determination by American Indians and other indigenous peoples. 27 There are decolonization issues in the international system which are not so easily defined, such as the Palestine question or that of South Africa, while the formation of Pakistan out of Greater India and the separation of Bangladesh from Pakistan did not relate to legalisms but to political realities. On the other hand, separation by water is no guarantee of independence, as in the case of Puerto Rico, which is officially the colony of the United States under United Nations trusteeship. 28 This last could as easily be said of Hawaii, or such protectorates as Guam, American Samoa, or the U.S. Virgin Islands. 29 In any event, the Blue Water Thesis institutionalized in Resolution 1541 has afforded the U.S., Canada, and other UN member states a useful pretext upon which to construct the pretense that their ongoing colonization of indigenous nations/peoples is not really colonialism at all. Rather, they contend, they are merely exercising the prerogative, provided in the UN Charter, of preserving the integrity of their own respective territories. 30 At present, the U.S. in particular is endeavoring to have native rights defined in international law in a manner conforming to its own practice of maintaining American Indians in a condition of domestic subjugation. 31 While it is true that the internal variety of colonialism visited upon native peoples by modern settler states differs in many respects from the classic models of external colonization developed by European empires over the past several centuries, it is colonialism nonetheless. 32 Moreover, it is no less genocidal in its implications and effects than were the forms of overseas colonialism analyzed by Jean-Paul Sartre in his famous 1968 essay on the topic. 33 Indeed, given how seamlessly it has been imposed, how imperfectly its existence and functioning are reflected in even the most ostensibly liberatory political discourses, and how committed to attaining its formal legitimation the great majority of states have lately proven themselves, internal colonialism may well prove to be more so. 34 Predictably, there are a number of ways in which the Sartre-Ryan equation of colonialism to genocide can be brought to bear when examining the situation of contemporary native North America. Several of these were suggested above. Probably the clearest representation will be found, however, in the sorry history of how the United States has wielded its self-assigned trust authority over Indian lands and lives in pursuit of global nuclear supremacy over the past half-century. Radioactive colonization. The origins of U.S. nuclear policy obviously lie in its quest to develop an atomic bomb during World War II. The Manhattan Project was conducted mainly at the Los Alamos National Scientific Laboratory, a huge fortified compound created in 1942 on the Pajarito Plateau, northwest of Santa Fe, New Mexico, on land supposedly reserved for the exclusive use and occupancy of the San Ildefonso Pueblo. 35 Uranium, the key material used in the lab's experiments and eventual fabrication of prototype nuclear weapons, was mined and milled exclusively in the Monument Valley area of the nearby Navajo Reservation. 36 Hanford, a uranium enrichment/plutonium manufacturing facility, was added in 1944, near the town of Richland, on Yakima land in eastern Washington. 37 When the first bomb was detonated on July 16, 1945, it was on the Alamogordo Bombing and Gunnery Range, now the White Sands Test Range, adjoining the Mescalero Apache Reservation. 38 While the official rationale for these site selections has always been that their remoteness from major urban centers was/is essential to protecting the secrecy of the research and production to which they were devoted, this in itself does not account for why they were not situated in such sparsely populated areas as western Kansas. 39 A better explanation would seem to reside in the fact that planners were concerned from the outset that the nuclear program embodied substantial risks to anyone living in proximity to it. 40 Such people as resided in the Central Plains region by the 1940s were mostly members of the settler society, Those at San Ildefonso, Mescalero, and Yakima were almost entirely native. For U.S. policymakers, there appears to have been no real question as to which group was the more readily expendable. That such an assessment is none too harsh is borne out by even the most cursory review of federal comportment in the immediate post-war period. Already possessed of a nuclear weapons monopoly which it believed would allow it to dictate terms to the planet, the U.S. was unsure exactly how much more uranium it needed to acquire. 41 In such circumstances, it was impossible to entice American corporations to engage in uranium extraction. Beginning in 1947, the government's newly formed Atomic Energy Commission solved the problem by arranging for several hundred otherwise destitute Navajos to be underwritten by the Small Business Administration in starting up tiny mining operations of their own. 42 Although it has since been claimed that the AEC was unaware of the dangers attending this occupation, there is ample reason to believe authorities were in possession of sufficient information to realize they were consigning every Navajo they coaxed into going underground to a veritable death sentence. It is important to realize that uranium mining is unlike most other kinds of mining in that during the course of blasting and digging for ore, radioactive radon-222 gas is released. Radon-222 is a natural decay product of uranium with a half-life of about 3½ days. Radon gas by itself poses no real danger. As a noble gas, it is chemically inert and is simply exhaled. But its radioactive daughter products can settle in the lungs and injure the tissues. The primary hazard comes from polonium-218 and 214, alpha-emitting radionuclides that lodge in the lining of the lung. Uranium miners are also bombarded by gamma radiation, but the primary danger, again, stems from the ingestion and inhalation of alpha emitters. Robert J. Roscoe of the National Institute for Occupational Safety and Health has shown that non-smoking uranium miners followed from 1950 to 1984 were 13 times more likely to die from lung cancer than a comparable group of non-smoking U.S. veterans. 43. Dr. Roscoe's test group included a significant proportion of miners who had worked in relatively large, well-ventilated shafts and even open-air uranium stripping operations. The initial group of Navajos worked in tiny, unventilated shafts where radon concentrations were often hundreds of times higher than average. As a consequence, all the AEC/SBA miners were dead or dying of lung cancer and/or other respiratory ailments by the mid-1980s. 44. As early as 1556, Austrian physician Georgius Agricola had described the extraordinary incidence of death by consumption of the lungs among Carpathian silver miners digging ores laced with radium. 45 In 1879, F.H. Harding and W. Hesse correctly diagnosed what had by then become known as Bergkrankheit as lung cancer, and demonstrated that approximately 3/4 of all miners in the Schneeberg region of Saxony died of the disease within 20 years of entering the shafts. 46 By 1924, German researchers P. Ludwig and S. Lorenzer had linked the Schneeberg miners' cancers to radon inhalation. 47 A connection explored more fully by American physician Wilhelm C. Huber, founding director of the American Cancer Institute's Environmental Cancer Section, in his seminal 1942 book, Occupational Tumors and Allied Diseases. 48. Nor was Huber's study the only one readily available to the AEC. In 1944, Egon Lorenz published an article in the Journal of the National Cancer Institute which concluded that the radioactivity of the ore and the radon content of the air of the mines are generally considered to be the primary cause of lung cancer among uranium miners. 49 Occupational cancer expert Fred W. Stewart went further in a 1947 issue of the Bulletin of the New York Academy of Medicine, predicting that there would likely be epidemic cases of cancer and leukemia in our newest group of industrialists, workers in the field of fissionable materials. 50 Even Bernard Wolfe and Merrill Eisenbud, directors of the AEC's own medical division, were warning their superiors of such dangers. 51. The Navajos, of course, were told none of this. On the contrary, when Wolfe and Eisenbud tried to establish minimum safety standards for miners in 1948, they were told by Washington that the health problems of the mines were not the responsibility of the AEC, and, should be left to the jurisdiction of the local authorities. 52. The AEC had been assigned by Congress the responsibility for radiation safety in the nuclear program, but, according to a bizarre interpretation of the 1946 Atomic Energy Act, the Commission was bound only to regulate exposures after the ore had been mined. Responsibility for the health and safety of uranium miners was left up to individual states, a situation that Merrill Eisenbud rightly recognized as absurd, given their lack of equipment and expertise to deal with the expected health problems. 53. Be that as it may, the AEC plainly went to great lengths to ensure that the general public remained equally uninformed. This was accomplished through a regulation requiring that all scientific papers dealing with radiation prepared under the auspices of the National Institutes of Health be cleared by the Commission prior to presentation/publication. Thus, when Hooper sought to present a paper at a 1952 meeting of the Colorado State Medical Society, he was instructed by Shields Warren, the AEC's Director of Biology and Medicine, to delete all references to the hazards of uranium mining. 54. Hooper refused on the grounds that he had not joined the to become a scientific liar. When word got around that he was not silently accepting his censorship, Warren again wrote the director of the NCI, this time asking for Hooper's dismissal. Hooper stayed on but was soon barred from all epidemiological work on occupational cancer. The order came from the Surgeon General. Hooper was henceforth allowed to do only experimental work on animals, and was prohibited from further investigations into the causation of cancer in men related to environmental exposure to carcinogenic chemical, physical, or parasitic agents. 55. Similarly, in 1955 the AEC managed to prevent Nobel laureate H.J. Muller, a geneticist, from speaking at the International Symposium on the Peaceful Uses of Atomic Energy in Geneva because he had concluded that radiation induced mutagenic effects in human organisms. 56. During the early 1960s, the Commission was also able to marginalize the work of Ernest J. Sternglass, whose groundbreaking research demonstrated that the proliferation of radioactive contaminants would lead to increased rates of miscarriage, stillbirth, childhood leukemia, and other cancers. 57. A few years later it brought about the dismissal of John W. Goffman, the discoverer of both uranium-233 and the plutonium isolation process, from his position at the Lawrence Livermore Laboratories. Goffman's offense was determining that, contrary to the AEC's official posture, there was/is really no safe level of exposure to radioactive substances. 58. While the Commission's ability to silence such voices diminished over the years, it never really disappeared altogether. When AEC researcher Thomas F. Mancuso set out in 1977 to publish findings that radiation exposure was causing inordinate rates of cancer among workers at the Hanford Military Complex, he was terminated and his research materials impounded. 59. Much the same fate befell Dr. Rosalie Bertell, albeit indirectly, through the National Cancer Institute, when she began to publish the results of epidemiological research on the effects of nuclear contamination during the late 1970s. 60. And so it went for more than 40 years. Unsurprisingly, given the context, the official stance vis-a-vis uranium miners amounted to little more than quietly tallying up the death toll. Even the Public Health Service, which called in 1957 for immediate application of corrective measures to avert an impending public health disaster spawned by radon inhalation among miners, was shortly subordinated to the AEC's demand that the truth be hidden. 61. Victor E. Archer, an epidemiologist with the PHS's National Institute for Occupational Safety and Health, spelled this out in 1977, during his testimony in a suit brought by a group of terminally ill Navajo miners and survivors of those already dead. Archer testified that he and his colleagues had caved into AEC and PHS pressures not to publicize the hazard. We did not want to rock the boat. He had to take the position that we were neutral scientists trying to find out what the facts were, that we were not going to make any public announcements until the results of our scientific study were completed. Official pressures to monitor the disaster without informing those at risk or forcing companies to reduce the hazard led PHS scientists to characterize their study as a death watch or dead body approach. A federal judge involved in the Navajo case charged that U.S. atomic authorities had failed to warn the miners in order to guarantee a constant, uninterrupted, and reliable flow of uranium ore for national security purposes. 62. An efficient system for delivering huge quantities of uranium had become an especially high priority for the U.S. military when the Soviet Union, years ahead of expectations, tested a nuclear device of its own on September 23, 1949. This set in motion a mad scramble to amass ever greater numbers of increasingly more powerful and sophisticated atomic weapons, as well as a burgeoning number of nuclear reactors, on both sides of the Atlantic. 63 thus guaranteed the sustained profitability of such enterprises, and shortly immunized against any liabilities they might entail. America's major corporations entered with a vengeance into uranium mining, milling, and related activities, completely supplanting the first generation of Navajo miners' mom-and-pop operations by the end of 1951. 64. This sudden and massive corporate tie-in to the expansion of U.S. uranium production did not, however, signal a shifting of the burden of supplying it from the shoulders of native North America. Rather, such weight was increased dramatically. Although only about 60% of uranium deposits in the United States were/are situated on American Indian reservations, most of it in the so-called Grants Uranium Belt of northern New Mexico and Arizona. Well over 90% of all the uranium ever mined in the U.S. had been taken from such sources by the time the AEC's domestic ore buying program was phased out in 1982. 65. Hence, while the USSR and its satellites relied on slave labor provided by hundreds of thousands of political prisoners in meeting their production quotas, the US utilized its internal, indigenous colonies for the same purpose. 66 Not only did the workforce harnessed to the tasks of uranium mining and milling remain disproportionately native, but the vast majority of extraction and processing facilities were situated in Indian country as well, conveniently out of sight and mind of the general public, their collateral health impacts concentrated among indigenous populations. Much the same can be said with respect to weapons research, testing, and the disposal of radioactive waste byproducts. We will examine each of these components of the nuclear process in turn. Mining. The first large-scale uranium mine in the United States was opened under AEC/BIA sanction by the Kerr-McGee Nuclear Corporation in 1952, on the Navajo Reservation, outside the town of Shiprock, New Mexico. 100 Navajos were hired to perform the underground labor at about two-thirds the prevailing off-reservation pay scale for comparable work in what was ostensibly a ventilated mine shaft. 67 When a federal inspector visited the mine a few months after it opened, however, he discovered the ventilator fans were not functioning. When he returned 3 years later, in 1955, they were still idle. 68 By 1959, radon levels in the mine shaft were routinely testing at 90 to 100 times the maximum safe levels, a circumstance which remained essentially unchanged until the ore played out and Kerr-McGee closed the mine in 1970. 69. Of the 150-odd Navajo miners who worked below ground at Shiprock over the years, 18 had died of radiation-induced lung cancer by 1975. 5 years later, another 20 were dead of the same disease, while the bulk of the rest had been diagnosed with serious respiratory ailments. 70 Much the same situation pertained with regard to native employees working in the shaft at Kerr-McGee's second mining operation on Navajo, opened at Red Rock in 1953. By 1979, 15 were dead of lung cancer and dozens of others had been diagnosed with that malady and/or respiratory fibrosis. 71 The same rates prevail among the well over 700 men who worked underground for Kerr-McGee at Grants, New Mexico, the largest uranium shaft mining operation in the world. 72 Of the original 6,000 or so miners of all races employed below ground in the Grants Belt, Victor Archer has estimated 1,000 will eventually die of lung cancer. 73. Nonetheless, such mines proliferated on the reservation throughout the remainder of the 1950s, as the AEC, with the active complicity of the BIA, entered into a host of additional contracts, not only with Kerr-McGee, but with corporations like Atlantic Richfield, Amex, Foot Mineral Utah International, Climax Uranium, United Nuclear, Union Carbide, Gulf, Conoco, Mobil, Exxon, Getty, Sun Oil, Standard Oil of Ohio, and Rockwell International. 74 As of 1958, the Bureau of Indian Affairs reported that more than 900,000 acres of tribal land were leased for uranium exploration and development. 75 From 1946 to 1968, well over 13 million tons of uranium ore were mined on Navajo, some 2.5 million tons at Shiprock alone, and still the rate of increase increased. 76 By late 1976, the year which turned out to be the very peak of the uranium frenzy afflicting the Colorado Plateau, the BIA had approved a total of 303 leases encumbering 250,000 acres of Navajo land for corporate mining and milling purposes. 77 Aside from the effects of all this upon those working underground, the shaft mining on Navajo had an increasingly negative impact upon the physical well-being of their families and communities on the surface. One indication of this resides in the fact that, once real ventilation of the mines began to occur during the mid-60s, the vents were often situated right in the middle of residential areas, the inhabitants of which were then forced to breathe the same potent mixtures of radon, thoron, and other toxic substances which were plaguing their husbands, fathers, and neighbors below. 78 There was also the matter of pumping out the groundwater which seeped constantly into scores of the deeper shafts, a process called dewatering, all of it heavily contaminated. To appreciate the volume of this outpouring, it should be considered that just one site, Kerr-McGee's Church Rock No. 1 mine, was pumping more than 80,000 gallons of irradiated effluents per day into the local supply of surface water in 1980. 79 The millions of gallons of radioactive water carry deadly selenium, cadmium, and lead that are easily absorbed into the local food chain, as well as emitting alpha and beta particles and gamma rays. Human ingestion of radioactive water can result in alpha particles recurrently bombarding human tissue and eventually tearing apart the cells comprising that tissue, causing cancer. 80 Figure 5.1 Four Corners Area Energy Exploitation. Small wonder that, by 1981, the Navajo Health Authority had documented increasing rates of birth defects, notably cleft palate and Down syndrome, among babies born after 1965 in mine-adjacent reservation communities like Shiprock, Red Rock, and Church Rock. 81 At the same time, it was determined that children living in such localities were suffering bone cancers at a rate 5 times the national average, ovarian cancers at an astonishing 17 times the norm. 82 Yet another study concluded that, overall, there was a twofold excess of miscarriages, infant deaths, congenital or genetic abnormalities, and learning disabilities among uranium area families. 83 Although funding was requested from the Department of Health, Education, and Welfare to conduct more extensive epidemiological studies throughout the Grants Belt, the request was promptly denied. In fact, in 1983, one agency, the Indian Health Services, sent a report to Congress, stating that there was no evidence of adverse health effects on Indians in uranium development areas and there is no need for additional studies or funding for such studies. 84 Meanwhile, beginning in 1952, an ARCO subsidiary, the Anaconda Copper Corporation, had been operating under AEC/BIA authority on the nearby Laguna Reservation, near Albuquerque. By the early 1970s, the approximately 2,800 acres of Anaconda's Jackpile-Pagwit complex at Laguna, from which 22 million tons of ore and more than 44 million tons of other minerals were removed, was the largest open-pit uranium mine in the world. 85 Ultimately, the excavation went so deep that groundwater seepage became as much an issue as in a shaft mine. Mining techniques require dewatering, i.e., the pumping of water contaminated by radioactive materials to facilitate ore extraction. Since 1972, the Jackpile mine has wasted more than 119 gallons per minute through this dewatering procedure. Altogether, more than 500 million gallons of radioactive water have been discharged. A 260-acre tailings pond either sinks back into the aquifer, evaporates, or seeps out into the arroyos and drainage channels of the tiny Rio Micano stream that is fed by a natural spring near the tailings dam. 86 In 1972, and again in 1977, the Environmental Protection Agency notified the Laguna Tribal Council that both the Rio Molino and the nearby Rio Paguit, both of which run through the Anaconda leasing area, and which together comprise the Pueblo's only source of surface water, were badly contaminated with radium-226 and other heavy metals. 87 This was followed, in 1979, by a General Accounting Office announcement that the aquifer underlying the entire Grants Belt, from which Laguna draws its groundwater, was similarly polluted. 88 The trade-off was, of course, jobs. But, while most able-bodied lagunas, and a considerable proportion of neighboring Acamas, were employed by the corporation, a matter touted by the BIA as a miracle of modernization, most received poverty-level incomes. 89 And, although the adverse health effects of open-pit uranium mining seem somewhat less pronounced than those associated with shaft mining, disproportionately high rates of cancer among long-term miners were being noted by the early 1980s. 90. All told, about 3,200 underground and 900 open-pit miners were employed in uranium operations by 1977, and Kermagee was running a multimillion-dollar U.S. Department of Labor-funded job training program in the Navajo community of Church Rock, Arizona, to recruit more. 91 The stated governmental/corporate objective was to create a workforce of 18,400 underground and 4,000 open-pit miners to extract ore from approximately 3.5 million acres along the Grants Belt by 1990. 92 Only the collapse of the market for U.S. domestic uranium production after 1980. The AEC met its stockpiling quotas in that year, and it quickly became cheaper to acquire commercially designated supplies mined abroad, first from Namibia, then from Australia, and finally from the native territories of northern Saskatchewan. In Canada, averted realization of this grand plan. 93. As the dust settled around the Four Corners, the real outcomes of uranium mining began to emerge. The AEC's constellation of corporations had profited mightily as a result, and not just because of their refusal to meet the expense of providing even the most rudimentary forms of worker safety, or their having to pay only the artificially depressed wages prevailing within the reservation's colonial economies. The BIA, exercising the government's self-assigned trust prerogatives, had written contracts requiring the corporations to pay royalties pegged at an average of only 3.4% of market price in an environment where 15% was the normative standard. 94 Moreover, the contracts often included no clauses requiring post-mining cleanup of any sort, thus sparing Kermagee and its cohorts what would have been automatic and substantial costs of doing business in off-reservation settings. When lucrative mining was completed, the corporations were thus in a position to simply close up shop and walk away. 95. The already much impoverished indigenous nations upon which the uranium extraction enterprise had been imposed in the first place, which seldom if ever made money from the process, and whose prior economies had been demolished into the bargain, were then left holding the bag. 96 On Navajo, this involves the necessity of dealing with hundreds of abandoned mine shafts ranging from 50 to several hundred feet in depth, some subject to caving in and all of them steadily emitting radon and thoron from their gaping maws. 97 At Laguna, conditions are even worse. 98 As Dr. Joseph Wagoner, Director of Epidemiological Research for NIOSH, would later put it, with conspicuous understatement, the situation presents serious medical and ethical questions about the responsibility of the federal government, which was the sole purchaser of uranium during the period. 99. Milling. Milling, the separation of pure uranium from its ore, is the first stage of the production process. Ore pockets across the Grants Belt range from 0.4 to 3% uranium content, yielding an average of about 4 pounds of yellow cake per ton. 100 The remaining 1,996 pounds per ton of waste reduced to the consistency of coarse sand called tailings during milling invariably accumulates in huge piles alongside the mills, which, for reasons of cost efficiency, tend to be situated in close proximity to mines. Tailings retain approximately 85% of the radioactivity of the original ore, have a half-life estimated at 10,000 years, and are a source of continuous radon and thoron gas emissions. They are also subject to wind dispersal and constitute an obvious source of groundwater contamination through leaching. 101. As with uranium mining, over 90% of all milling done in the U.S. occurred on or just outside the boundaries of American Indian reservations. 102. Also, as was the case in the mines, conditions in the mills were deplorable. 103. Even the most elementary precautions to assure worker protection were ignored as an unnecessary expense. As Laguna poet Simon J. Ortiz, who was employed in a Kermagee mill during the early 1960s, would later reflect. Right out of high school I worked in the mining and milling region of Ambrosia Lake. I was 19 years old. At the mill, I worked in crushing, leaching, and yellow cake, usually at various labor positions. I had a job, and for poor people with low education and no skills and high unemployment, that was the important thing, a job. In 1960, there was no information about the dangers of radiation from yellow cake with which I worked. In the milling operation at the end of the leaching and settling process, the yellow liquid was drawn into dryers that took the water out. The dryers were screen constructions which revolved slowly in hot air. Yellow pellets were extruded and crushed into fine powder. The workers were to keep the machinery operating, which was never smooth, and most of the work was to keep it in free operation, i.e., frequently having to unclog it by hand. There was always a haze of yellow dust flying around, and even though filtered masks were used, the workers breathed in the fine dust. It got in the hair and cuts and scratches and in their eyes. I was 19 then, and 20 years later I worried about it. 104. The situation was so acute at Kermagee's first mill on the Navajo Reservation, established at Shiprock in 1953, that after it was abandoned in 1974 inspectors discovered more than $100,000 in uranium dust had settled between two layers of roofing, and former workers recalled having been routinely instructed by their supervisors to stir yellow cake by hand in open, steam-heated floor pans. 105. Needless to say, by 1980, those who'd been lured into the mills with the promise of a small but steady paycheck during the 1950s and 60s were suffering rates of lung cancer and other serious respiratory illnesses rivaling those of their counterparts in the mines. 106. By far the greater impact of milling, however, has been upon the broader Navajo, Laguna, and Acoma communities. The environmental degradation inflicted by a single mill, the Kermagee plant at Grants, once again, the largest such facility in the world, may equal that of all the shaft mines along the uranium belt combined. At its peak, the monstrosity processed 7,000 tons of ore per day, piling up 23 million tons of tailings in a 100-foot-high mound which covers 265 acres. 107. And this is just one of more than 40 mills, several of them not much smaller, operating simultaneously on and around Navajo during the late 1970s. 108. A similar situation prevailed at plants established by Kermagee, Sohio Reserve, Bocum Minerals, and several other corporations in the immediate vicinity of Laguna and Acoma. 109. At the Blue Water Mill, 18 miles west of the Laguna Reservation near the bed of the San Jose River, Anaconda has added a 107-acre pond and a 159-acre pile comprising 13,500 tons of active tailings and 765,033 tons of inactive residues. 110. In August 1978, it was discovered that Anaconda, as a means of holding down costs, had also made massive use of tailings as fill in its improvement of the reservation road network at Laguna. At the same time, it was revealed that tailings had constituted the sand and gravel mix of concrete with which the corporation had with much fanfare about the civic benefits it was thereby bestowing upon its indigenous partners poured footings for a new tribal council building, community center, and housing complex. 111. All were seriously irradiated as a result, a matter which may well be playing into increasing rates of cancer and birth defects, even among the non-miner sectors of Laguna's population. 112. Probably the worst single example of mill-related contamination occurred about a year later, on July 16, 1979, at the United Nuclear Plant in Church Rock, New Mexico, when a tailings dam gave way, releasing more than 100 million gallons of highly radioactive water into the nearby Rio Puerco. 113 About 1,700 Navajos living downstream were immediately affected, as were their sheep and other livestock, all of whom depended on the river for drinking water. 114 Shortly thereafter, with spill area cattle exhibiting unacceptably high levels of lead-210, polonium-210, thorium-230, radium-236, and similar substances in their tissues, all commercial sales of meat from such animals was indefinitely prohibited. 115. Still, even as the ban went into effect, IHS Area Director William Moeller, rather than calling for allocation of federal funds to provide emergency rations to those most directly at risk, approved consumption of the very same mutton and beef by local Navajos. 116 At about the same time, a request by downstream Navajos for United Nuclear to provide them with trucked-in water, at least in quantities sufficient to meet the immediate needs of the afflicted human population, was met with flat refusal. 117 The corporation stonewalled for another 5 years until it was revealed by the Southwest Research and Information Center, an Albuquerque-based environmental organization, that it had known about cracks in the dam at least 2 months before it broke and had failed to repair it before agreeing to a minimal, state-facilitated settlement of $525,000. 118. By and large, however, it was not outright disasters such as the Church Rock spill, but the huge and rapidly proliferating accumulation of mill tailings throughout the Four Corners region, more than 500 million tons in 200 locations by 1979, figures which were projected to double by the end of the century, that provoked a team of Los Alamos experts, utterly at a loss as to what to do with such vast quantities of radioactive waste, to recommend the zone of uranium mining and milling districts, so as to forbid human habitation. 119. The idea dovetailed perfectly with the conclusions drawn in a contemporaneous study undertaken by the National Institute for Science, that desert lands subjected to strip mining can never be reclaimed. 120 Since the Peabody Coal Company, among others, is engaged in ever more massive coal stripping operations on Navajo. 121 The logical outcome of the Los Alamos and NAS studies was the formulation of a secret federal policy option declaring the Four Corners, and the Black Hills region of the Northern Plains as well 122 national sacrifice areas in the interests of energy development. 123. Not coincidentally, the pair of localities selected contain the largest and second largest concentrations of reservation-based Indians remaining in the United States. Navajo, with over 120,000 residents in 1980, is by far the biggest reservation both by acreage and by population in the U.S. Also sacrificed in the Four Corners region would be at a minimum the Hopi, Zuni, Laguna, Acoma, Isleta, Rama Navajo, Canoncito Navajo, Ute Mountain, and Southern Ute reservations. The 50,000 odd residents of the Sioux complex of reservations in North and South Dakota, Pine Ridge, Rosebud, Crow Creek, Cheyenne River, and Standing Rock in particular make up the second most substantial concentration. Also sacrificed in the Black Hills region would be the Crow and Northern Cheyenne reservations in Montana, and possibly the Wind River Reservation in Wyoming. 124. As American Indian Movement leader Russell Means observed in 1980, shortly after existence of the plan had been disclosed, to sacrifice the land base of land-based peoples is tantamount to sacrificing the peoples themselves, a prospect he aptly described as genocide while calling for appropriate modes of resistance. 125. Figure 5.2. U.S. corporate interests in the Greater Sioux Nation. Source: The Black Hills National Sacrifice Area, a study in U.S. internal colonialism. Although a policy of deliberately creating national sacrifice areas out of American Indian reservations was never formally implemented, the more indirect effect may well be the same. With wind-blown tailings spread over wide tracts of Navajo ground and surface water alike contaminated with all manner of radioactive substances, and Navajo children literally using abandoned mounds of tailings as sand piles, it is not unreasonable to suspect that both the land and the people have already been sacrificed on the altar of U.S. armaments development. 126 If so, they and their counterparts at Laguna, Acoma, and elsewhere will have become victims of what may be, to date, history's subtlest form of physical extermination. 127. Weapons research and production. The Los Alamos lab might well have extended its zoning recommendations to include not just uranium mining and milling districts but localities in which nuclear weapons research and production have been carried out, beginning with itself. Here again, although the sites at which yellow cake is enriched and or transformed into plutonium have been scattered across the country in localities not typically associated with indigenous people, the great weight of contamination in this connection has been offloaded by the dominant society onto Indian country. 128. The extent of radioactive contamination at Los Alamos is astonishing. A half-century of nuclear weapons research on the 43-square-mile campus which adjoins not only San Ildefonso, but the Santa Clara, San Juan, Jemez, and Zia reservations has produced some 2,400 irradiated pollution sites containing plutonium, uranium, strontium-90, tritium, lead, mercury, nitrates, cyanides, pesticides and other lethal leftovers. 129. A single 1950 experiment in which simulated nuclear devices were exploded in order to track radioactive fallout patterns was not only kept secret for decades, but left nearby Bayo Canyon heavily contaminated with strontium. 130. The facility also has a long history of secretly and illegally incinerating irradiated wastes, a practice producing significant atmospheric contamination as was acknowledged by the EPA in 1991.131. The greatest concentration of hazardous materials in the Los Alamos compound is situated in what is called Area G, which began taking radioactive waste in 1957. Since 1971, 381,000 cubic feet of generated transuranic waste has been stored there. No one knows how much went in before 1971, since records are scanty. Wastes were interred without liners or caps, in bulldozed pits they may be presumed to be leaking. 132. This, in combination with the lab's chronic release of radioactive substances into the atmosphere, is thought to be correlated to dramatic increases in cancers and birth defects among local native populations over the past 20 years. 133. Plutonium contamination of surface water has been found downstream at least as far as the Cachiti Reservation, 30 miles away. 134. At present, Area G is slated for considerable expansion. 135. In the new plan, strongly opposed by area Indians, it would be able to contain 475,000 cubic yards of mixed waste in pits 2,000 feet long and divided into 25,000 cubic yard segments. 136. An even worse situation prevails at Hanford, which was closed in 1990. Despite frequent official denials that it presented any sort of public health hazard during the span of its operation, the complex exhibits an unparalleled record of deliberate environmental contamination, beginning with a secret experimental release of radioactive iodides in 1945, the first of 7, which equaled or surpassed the total quantity of pollutants emitted during the disastrous 1986 Soviet reactor meltdown at Chernobyl. 137. Also in 1945, Hanford officials secretly instructed staff to begin disposing of irradiated effluents by the simple expedient of pouring them into unlined sumps from which they leached into the underlying aquifer. All told, before the plant was closed, something in excess of 440 billion gallons of water laced with everything from plutonium to tritium to ruthenium had been dumped in this cost-efficient manner. 138. Another 900,000 gallons of even more highly radioactive fluids were stored in a 117-unit underground tank farm maintained under contract by ARCO, several components of which were found to be leaking badly. 139. Not only has regional groundwater been severely contaminated, but wastes have been found to have passed into the nearby Columbia River in quantities sufficient to irradiate shellfish at the river's mouth, more than 200 miles distant. 140. Not only has the Hanford plant been discharging and leaking radiation into the river for 45 years, but serious accidents have occurred at the reactors. One could perhaps excuse the accidental release of radiation, but on several occasions huge clouds of isotopes were created knowingly and willingly. In December, about 7,800 curies of radioactive iodine-131 were deliberately released in an experiment designed to detect military reactors in the Soviet Union. 141. The true extent of the ecological holocaust perpetrated at and around Hanford is unknown, and is likely to remain so over the foreseeable future, given that most information about the facility is permanently sealed as a matter of national security, and DOE/Pentagon/corporate officials claim to have lost much of what is supposedly accessible. 142 Such information as has come out, however, tends to speak for itself. Abnormally high incidence of thyroid tumors and cancers have been observed in populations living downstream from Hanford. Strontium-90, cesium-137, and plutonium-239 have been released in large quantities, as was, between 1952 and 1967, ruthenium-106. People in adjacent neighborhoods were kept uninformed about these releases before, during and after, and none were warned that they were at risk for subsequent development of cancer. 143. In sum, the probability is that Los Alamos, Hanford, and surrounding areas should be added to the extensive geographical sacrifices already discussed with respect to uranium mining and milling. To the extent that this is true, and it is almost certainly the case at Hanford, several more colonized indigenous nations must be added to the roster of those implicitly but officially identified peoples whose sacrifice is deemed necessary, useful, or at least acceptable, in the interests of U.S. nuclear development. Weapons testing. Nuclear weapons, once designed, must be tested. During the period immediately following World War II, the U.S. asserted its trust authority over the Marshall Islands, gained by its defeat of Japan, for purposes of conducting more than 100 such tests on the natives' mid-Pacific atolls by 1958. 144 Meanwhile, the search for a more suitable continental locality, codenamed Nutmeg, began as early as 1948. 2 years later, the AEC/Pentagon combo finally settled on the Las Vegas/Tonopah bombing and gunnery range in Nevada, an area which it had already decided really wasn't much good for anything but gunnery practice. You could bomb it into oblivion and never notice the difference. 145. Of course, nobody bothered to ask the Western Shoshone people, within whose unceded territory the facility was established, whether they felt this was an acceptable use of their land, or whether they were even willing to have it designated as part of the U.S. public domain for any purpose. 146 Instead, in 1952, having designated 435,000 acres in the Yucca Flats area of Nellis as a Nevada test site, another 318,000 acres were added in 1961, bringing the total to 753,000. The AEC and its military partners undertook the first of what by now add up to nearly 1,000 atmospheric and underground test detonations. 147 In the process, they converted the peaceful and pastoral Shoshones, who had never engaged in an armed conflict with the U.S., into what, by any estimation, is far and away the most bombed nation on Earth. 148. The deadly atomic sunburst over Hiroshima, in 1945, produced 13 kilotons of murderous heat and radioactive fallout. At least 27 of the 96 above-ground bombs detonated between 1951 and 1958 at the Nevada test site produced a total of over 620 kilotons of radioactive debris that fell on downwind Earths. The radioactive isotopes mixed with the scooped-up rocks and earth of the southwestern desert lands and lay down a swath of radioactive fallout over Utah, Arizona, and Nevada. In light of the fact that scientific research has now confirmed that any radiation exposure is dangerous, the virtual inhabitants residing in the small towns east and south of the test site were placed in jeopardy by the AEC atomic test program. 149. Those most affected by the estimated 12 billion curies of radioactivity released into the atmosphere over the past 45 years have undoubtedly been the native communities scattered along the periphery of Nellis. 150 These include not only 3 Shoshone reservations, Duckwater, Yamba, and Timbisha, but the Las Vegas Paiute Colony and the Pahrump Paiute, Goshute, and Mopa reservations as well. Their circumstances have been greatly compounded by the approximately 900 underground test detonations which have, in a region where surface water sources are all but non-existent, resulted in contamination of groundwater with plutonium, tritium, and other radioactive substances at levels up to 3,000 times the maximum safe limits. 151. Radionuclides released to groundwater include antimony 125, barium 140, beryllium 7, cadmium 109, cerium 141, cesium 137, cobalt 60, europium 155, iodine 131, iridium 192, krypton, lanthanum 140, plutonium 238, plutonium 239, plutonium 240, rhodium 106, ruthenium 103, sodium 22, strontium 90, and tritium. 152. Although the government has been steadfast in its refusal to conduct relevant epidemiology studies in Nevada, especially with respect to indigenous peoples, it has been credibly estimated that several hundred people had already died of radiation-induced cancers by 1981.153. Rather than admit to any aspect of what it was doing, the military simply gobbled up increasingly gigantic chunks of Shoshone land, pushing everyone off and creating ever larger security areas that rendered its activities less and less susceptible to any sort of genuine public scrutiny. 154. Today, in the state of Nevada, in addition to Nellis Air Force Base and Nevada Test Site, we can add the following military reservations: Fallon Navy Training Range Complex with its airspace, the Hawthorne Army Ammunition Depot, with its restricted airspace, the Reno Military Operations Area airspace, the Hart Military Operations Area airspace, the Paradise Military Operations Area airspace, and parts of the Utah Training Range Complex with its airspace. Military ranges in Nevada alone amount to 4 million acres. Approximately 40% of Nevada's airspace is designated for military use. 155. Across the state line in California, it is separated from the gargantuan sprawl of military facilities in Nevada only by the width of the interposed Death Valley National Monument. Lies the million-acre China Lake Naval Weapons Center. 156 butted up against the Army's equally sized estate at Fort Irwin, and close to both the half-million-acre Edwards Air Force Base and the 800,000-acre Marine Corps Base at 29 Palms, China Lake, an oddly named facility in that it incorporates no lake at all, uses its share of the Mojave Desert in the same manner as White Sands, only more so. 157 Established in November 1943 and expanded steadily thereafter, it was crediting itself by 1968 with being the location in which over 75% of the airborne weapons of the free world, 40% of the world's conventional weapons, had been tested and perfected. 158 As in Nevada, local indigenous communities, both Shoshone and Paiute, have been pushed out while their lands, including sacred sites, have been bombed, strafed, and shelled relentlessly for more than 50 years. 159. Probably the only concession made to native peoples in the region during this entire period has been that the 3 largest nuclear devices ever detonated underground, culminating in a monstrous 5-megaton blast in 1971, were exploded not at the Nevada test site, but on Amchitka Island, off Alaska. The reason for this change in procedure had nothing to do with concern for the well-being of human beings, however. Rather, it was brought on by fears among AEC officials that the shockwaves from such large blasts might cause serious damage to casinos and other expensive buildings in downtown Las Vegas, thereby provoking a backlash from segments of the regional business community. 160 Hence, the brunt of the environmental/biological consequences wrought by the 3 biggest bangs was shifted from the Indians of Nevada to the Aleuts indigenous to the Aleutian Archipelago. 161. Exactly how large an area has been sacrificed to nuclear testing and related activities is unknown, but most certainly includes the bulk of southern Nevada and contiguous portions of California. 162 Indications are that it may encompass northern Nevada as well, given the insistence of Reagan-era Defense Secretary Caspar Weinberger, selected for this position, appropriately enough, on the basis of his credentials as a senior vice president of the Bechtel Corporation, the second largest U.S. nuclear engineering contractor. That the rail-mounted MX missile system should be sited there, a move which would have effectively precluded human habitation. 163 Given prevailing wind patterns, the sacrifice area likely encompasses northwestern Arizona as well, including 3 indigenous people Hualapai, Havasupai, and Kaibab whose reservations are located there. 164 Also at issue are the more westerly reaches of Utah, a region which includes the small Goshute and Skull Valley reservations in addition to another huge complex of military bases and proving grounds. 165. Figure 5.3. The nuclear landscape. Shaded areas here designate military airspace and military operations areas. Such areas extend the zone of military operations far beyond land holdings. Source: Valerie L. Kolitz, The Tainted Desert: Environmental and Social Ruin in the American West. Waste disposal. Plutonium, an inevitable byproduct of most reactors and the essential ingredient in nearly all nuclear weapons, has been aptly described as being the most toxic substance in the universe. 166 Only 10 micrograms, a microscopic quantity, is an amount almost certain to induce cancer, and several grams, dispersed in a ventilation system, are enough to cause the death of thousands. 167 Indeed, it has been estimated that a single pound of plutonium, if evenly distributed throughout the Earth's atmosphere, would be sufficient to kill every human being on the planet. 168 Viewed from this perspective, the quantity of this material created by the United States during the course of its arms race with the Soviet Union as of 1989, the US alone had amassed some 21,000 nuclear weapons is virtually incomprehensible. 169. By 1995, military weapons-grade plutonium, in the form of active and dismantled bombs, amounted to 270 metric tons. The commercial stockpile of plutonium in nuclear reactor wastes and isolates from spent fuel amounts to 930 metric tons and will double to 2,130 tons by 2005. Every 4 or 5 years we're making about as much plutonium in the civil sector as we did during the whole Cold War. And this is only plutonium. Fission reactors create 80 radionuclides that are releasing ionizing radiation, which causes harm to human beings in the form of genetic mutations, cancer, and birth defects. 170. Leaving aside the proliferation of commercial reactors and other such facilities, as well as the mining and milling zones, there are 132 sites in 30 states where one or another facet of nuclear weapons production has left radioactive contamination of varying orders of magnitude, all of them unacceptable. 171 The DOE currently estimates that it will cost about $500 billion to return these to habitable condition, an absurdly low figure in view of the department's admission that neither concepts nor technologies presently exist with which to even begin the cleanup of large contaminated river systems like the Columbia, Clinch, and Savannah, most groundwater nuclear test areas on the Nevada test site. 172. It is also conceded that there is no known method of actually disposing of, i.e., decontaminating plutonium and other radioactive wastes after they've been cleaned from the broader environment. 173 Instead, such materials, once collected, can only be sealed under the dubious premise that they can be somehow safely stored for the next 250,000 years. 174 The sheer volume is staggering. Hanford stores 8,200,000 cubic feet of high-level waste and 500,000 cubic feet of transuranic waste. Hanford buried 18,000,000 cubic feet of low-level waste and 3,900,000 cubic feet of transuranic waste. 175 And, daunting as they are, these numbers associated exclusively with weapons production, and commercial reactors don't begin to include the millions of tons of accumulated mill tailings and similar byproducts of front-end nuclear processing. 176. Such facilities as now exist to accommodate warhead and reactor wastes are all temporary installations designed to last a century or less, even under ideal conditions which seem never to prevail. 177 The steadily escalating rate of waste proliferation has led to the burning of plutonium and other substances, a practice which certainly reduces the bulk of the offending materials, but also risks sending clouds of radioactivity into the atmosphere. 178 And an increasingly urgent quest for safer interim facilities, called monitored retrievable storage sites, and permanent repositories into which their contents could eventually be moved. 179 Here, as always, emphasis has been on offloading the problem onto captive indigenous nations. 180. The reason, predictably enough, is that despite a chorus of official assurances that neither an MRS nor a repository would present a health hazard, the precise opposite is true. John Goffman has calculated that if only 0.01% of the plutonium now in storage were to escape into the environment, a record of efficiency never remotely approximated by the nuclear establishment, some 25 million people could be expected to die of resulting cancers over the following half-century. 181 Those most proximate to any dump site can of course expect to suffer the worst impact. Consequently, only one county in the United States has proven amenable to accepting an MRS within its boundaries, and its willingness to do so was quickly overridden by the state. 182. Federal authorities have therefore concentrated all but exclusively on siting the dumps in Indian country. As longtime indigenous rights activist Grace Thorpe has observed, the U.S. government targeted Native Americans for several reasons. Their lands are some of the most isolated in North America, they are some of the most impoverished and, consequently, most politically vulnerable and, perhaps most important, tribal sovereignty can be used to bypass state environmental laws. How ironic that, after centuries of attempting to destroy it, the U.S. government is suddenly interested in promoting Native American sovereignty just to dump its lethal garbage. 183. There can be little doubt that during the early 1990s DOE negotiators played heavily upon the colonially imposed destitution of indigenous peoples in peddling their wares. Tribes initially applied for $100,000 grants from DOE to study the MRS option on native lands. The lucrative DOE offer included up to $3 million to actually identify a site for an MRS and as much as $5 million per year for any tribe to accept the deal. The government also offered to build roads, hospitals, schools, railroads, airports, and recreation facilities. 184. Another $100,000 was passed along in 1992 to the federally oriented National Congress of American Indians to garner its assistance in selling the proposition to its constituents, while a whopping $1.20 million, 80% of the DOE's budget for such purposes, was lavished on the Council of Energy Resource Tribes, a federally/corporately funded entity created for the sole purpose of systematizing the wholesale brokering of native mineral rights. 185 Despite the best efforts of both organizations, CERT in particular went beyond the MRS concept to promote acceptance of a repository at Hanford by the Yakimas, Nez Perce, and Umatillas. The campaign was largely a failure. 186 By 1995, only 3 reservations, Mescalero, Skull Valley, and Ft. McDermott in northern Nevada, indicated any degree of willingness to accept a dump, regardless of the material incentives offered. The reasoning which led to this result is instructive. At Skull Valley, the feeling expressed by many residents was that they and their land may already have been sacrificed, in part to radiation blown in over the years from the not far distant Nevada test site, in part to a host of nuclear, chemical, and bacteriological contaminants emanating from military bases closer to home. Even the specific area committed as an MRS site has long been leased to several corporations as a rocket testing range. 187 As tribal member Leon Baer observes, people need to understand that this whole area has already been deemed a waste zone by the federal government, the state of Utah, and the country. Tooele Depot, a military site, stores 40% of the nation's nerve gas and other hazardous gas only 40 miles away from us. Dugway Proving Grounds, an experimental life sciences center, is only 14 miles away, and it experiments with viruses like plague and tuberculosis. Within a 40-mile radius there are 3 hazardous waste dumps and a low-level radioactive waste dump. From all directions, north, south, east, and west, we're surrounded by the waste of Tooele County, the state of Utah, and U.S. society. 188. The sentiment at Skull Valley, that it is better to at least charge for one's demise than endure the suffering free of charge, is shared by an appreciable segment of the Mescalero population. As one reservation resident noted, The feeling of many people is that since they are getting impacted by nuclear waste, they should have a chance to benefit economically. 189 Or, as another put it, the federal government has forced us to choose between being environmentally conscious starving. 190 Such perspectives notwithstanding, local activists like Rufina Laws were able to engineer a no-acceptance vote on an MRS proposal at Mescalero during the winter of 1995. It seems that only a policy of outright bribery by pro-nuclear tribal chairman Wendell Chino, reputedly the payment of $2,000 per yes vote, was sufficient to reverse the outcome by a narrow margin in a second referendum conducted a few months later. 191. More important than such subsidies, however, may be the fact that many mescaleros are now experiencing an overwhelming sense of hopelessness, based in the knowledge that not only are they just downwind from White Sands, but that over their strong objections the first U.S. nuclear repository has been sited in the Carlsbad Caverns area, immediately to their east. 192 This is the so-called Waste Isolation Pilot Plant, a facility intended to house virtually all military transuranics produced after 1970 to 57,359 cubic meters of it in a subsurface salt bed already fissured by underground nuclear detonations. 193. The disposal area will exceed 100 acres, although the site's surface area covers more than 10,000 acres. The repository's design calls for creeping salt to seal the wastes, a process that is supposed to isolate the substances for tens of thousands of years. Controversy over the WIP focuses on potential groundwater contamination, gases which would be generated by the decomposing wastes, and the hazards posed by transporting approximately 30,000 truckloads of waste to the site, among other things. 194. It now appears that the deep salt beds below Carlsbad are not so dry as was once believed by the National Institute for Sciences, a matter which could lead to relatively rapid corrosion of the storage canisters in which the repository's plutonium is to be contained, and correspondingly massive contamination of the underlying Rustler Aquifer. 195 Serious questions have also arisen as to whether the mass of materials stored in such close quarters, after accommodating its present allocation of transuranics, the WIP will still retain some 70% of its space availability to meet future requirements. Official shorthand for continuing nuclear weapons production might not go critical and thereby set off an incalculably large atomic explosion. 196. Even worse problems are evident at Yucca Mountain, located on the southwestern boundary of the Nevada test site, where a $15 billion repository to accommodate 70,000 tons of mostly civilian high-level waste is being imposed on the long-suffering Western Shoshones and Paiutes. 197 Not only is spontaneous detonation just as much a threat as at the WIP, but Yucca Mountain, located in a volcanically active region, is undercut by no less than 32 geological fault lines. 198 Needless to say, no amount of engineering brilliance can ensure the repository's contents will remain undisturbed through 250,000 years of earthquakes interspersed with volcanic eruptions. Once again, however, the project is being moved forward as rapidly as possible. As if this were not enough, it was announced in 1993 by the Southwestern Compact, a consortium of state governments, that it had decided to keep the option of siting a huge low-level waste dump in the Mojave Desert's Ward Valley, near the small town of Needles on the California/Arizona boundary. 199 Envisioned as being large enough to accept the contents of all 6 existing and failed low-level facilities in the U.S. with room to spare for the next 30 years, the proposed site is less than 18 miles from the Colorado River and directly above an aquifer. 200 It is also very close to the Fort Mojave, Kemehuevi Valley and Colorado River Indian Tribes reservations, and upstream from those of the Cacopas and Quechones around Yuma, Arizona. Taken as a whole, the pattern of using deserts as dumps which has emerged in nuclear waste disposal practices over the past decade serves to confirm suspicions, already well-founded, that creation of sacrificial geographies within the U.S. has been an integral aspect of Cold War policies and planning for nearly 50 years. 201 In many ways, the siting of repositories in particular, since they are explicitly intended to remain in place forever, may be seen as a sort of capstone gesture in this regard. the collateral genocide of those indigenous peoples whose lands lie within the boundaries of the sacrifice zones, nations whose ultimate negation has always been implicitly bound up in the very nature and depth of their colonization, is thus, finally and irrevocably, to be consummated. 202. Freeing the miner's canary. The radioactive colonization of native North America has involved fundamental miscalculations at a number of levels. In retrospect, the very idea that environmental contamination and consequent epidemiologies could be contained within U.S. internal colonies, hidden from polite society and afflicting only those deemed most expendable by federal policymakers, seems ludicrous. Wind-blown uranium tailings have never known that they were supposed to end their ongoing dispersal at reservation boundaries, no more than irradiated surface water has realized it was meant to stop flowing before it reached the domain of settler society, or polluted groundwater that it was intended to concentrate itself exclusively beneath Indian wellheads. Still less have clouds of radioactive iodides and strontium-impregnated fallout been aware that they were scripted to remain exclusively within Yakima or Shoshone or Puebloan territories. As Felix S. Cohen once observed, American Indians serve as the proverbial miner's canary of U.S. social, political, and economic policies. Whatever is done to Indians, he said, invariably serves as a prototype for things intended by America's elites for application to others, often to society as a whole. The effects of policy implementation upon Indians can thus be viewed as an early warning device for the costs and consequences of policy formation upon the broader society. In paying attention to what is happening to Indians, Cohen concluded, non-Indians equip themselves to act in their own self-interest. In the alternative, they will inevitably find themselves sharing the Indians' fate. 203. Cohen's premise plainly holds in the present connection, and not simply in the more obvious ways. If the citizens of Troy, New York, which became an unanticipated hotspot for fallout from atmospheric testing during the early 1950s, can now advance the same claims concerning health impacts as can the residents of Nevada. 204, so too can everyone within a 50-mile radius of any of the more than 100 nuclear reactors in the United States, all of them made possible by the uranium mined and milled on native land. 205 as well, there are scores of nuclear weapons manufacturing centers, storage facilities, and the more than 4 tons of plutonium and comparable materials missing from U.S. inventories by 1977. 206. If the disposal of mountainous accumulations of transuranic and other wastes has become a problem admitting to no easy solution, its existence essentially accrues from the fact that even the most progressive and enlightened sectors of the settler society have busied themselves for 40 years with the protesting of nuclear proliferation at its tail end rather than at its point of origin. For all the mass actions they have organized at reactors and missile bases over the years, not one has ever been conducted at a mining/milling site like Church Rock, Shiprock, or Laguna. 207 Had things been otherwise, it might have been possible to choke off the flow of fissionable materials at their source rather than attempting to combat them in their most proliferate and dispersed state. The opposition, however, has for the most part proven itself as willing to relegate native people to stations of marginality, even irrelevancy, as has the order it ostensibly opposes. And here, to borrow from Malcolm X, it can be said that the chickens have truly come home to roost. 208 This takes the form of the increasingly ubiquitous cancers that have made their appearance across the spectrum of American society since World War II, and the spiraling rates of congenital birth defects and suppressed immune systems evident among those whose lives began during the 1940s or later. 209 Plastering no smoking signs on every flat surface in North America will have absolutely no effect in preventing or curing these and myriad other radiation-induced maladies. 210 Wherein lies the cure? In a technical sense, it must be admitted that no one knows. We are very far down the road. The wages of radioactive colonialism are by and large being visited upon the colonizing society itself, and will likely continue to be in what is, in human terms, a permanent fashion. Such effects as have already obtained may well prove irreversible. 211 Whether or not this is true, one thing is clear: any effort to counter the effects of nuclear contamination must begin by halting its continuing proliferation. Unavoidably, then, success devolves first and foremost upon devising means of stopping still more uranium from coming out of the ground. Until that is accomplished, struggles to shut down individual reactors, to clean up specific mill sites and production facilities, to reduce the number of nuclear warheads in military inventories, or even to figure out how to dispose of the existing accumulation of wastes will prove futile. 212. Figure 5.4. Areas of continental United States crossed by more than one nuclear cloud from above-ground detonations. Source: J.M. Gould, The Enemy Within, The High Cost of Living Near Nuclear Reactors. The principle, of course, is as time-honored as it is true: to correct a problem it is necessary to confront its source rather than its symptoms. In and of itself, however, uranium mining is not the source of the affliction at hand. Underlying the mining process is the nature of the relationship imposed by the United States upon indigenous peoples within its borders, that of internal colonization, without which such things could never have happened in the first place. And underlying that is a mentality shared by the North American settler population as a veritable whole, a core belief that it is somehow inherently, singularly, even mystically, entitled to dominate all it encounters, possessing, or at least benefiting from that which belongs to others, regardless of the costs and consequences visited upon those thereby subjugated and dispossessed. 213. It can thus be said with certainty that if the dominant society is to have the least prospect of addressing the steadily mounting crisis of nuclear pollution, it has no real option but to end the radioactive colonization of native North America. This can happen only if U.S. elites are forced to abandon their ongoing pretense of holding legitimate and perpetual trust authority over native peoples, thus facilitating the genuine exercise of indigenous self-determination and our more general decolonization. 214. In turn, this can happen only to the extent that there is a wholesale alteration in the genocidal mentality which marks the settler population. 215. The key in this regard is a breaking down of the codes of denial, both individual and institutional, by which the settler society has always shielded itself from the implications of its own values and resulting actions. 216. The process is in part simply a matter of insisting that things be called by their right names rather than the noble-sounding euphemisms behind which reality has been so carefully hidden. Terms like discovery and settlement do not reflect the actualities of invasion and conquest they are used to disguise. Colonialism is not a matter of trust, it is colonialism, a crime under international law. Genocide isn't an inadvertent outcome of progress, it is genocide, an always avoidable crime against humanity. Ecocide is not development, it is ecocide, the most blatant and irremediable form of environmental destruction. Mere possession constitutes 9/10 of the law only among thugs devoted to enjoying the fruits of an organized system of theft. 217. Thus accurately described, many of the measures heretofore accepted by the American public in the name of forging and defending its way of life become viscerally repulsive, to average Americans no less than to anyone else. Unlike a society based on discovery and settlement, progress and trust, there are few who would queue up to argue the defensibility of a way of life predicated in / sustained by invasion, conquest, genocide, ecocide, colonization, and other modes of systemic theft. This is all the more true when it can be demonstrated, as it can in the present connection, that the process of intergroup victimization is bound to subject victims and victimizers alike to an identically ugly destiny. In sum, it is not unreasonable to expect an increasing proportion of the settler population to move towards the position sketched above, if not from a sense of altruism, then on the basis of newly perceived self-interest. 218. It is worth observing that the ensuing decolonization of native North America would offer benefits to humanity extending far beyond itself. Every inch of territory and attendant resources withdrawn from U.S. domestic hegemony diminishes the relative capacity of America's corporate managers to project themselves outward via multilateral trade agreements and the like, consummating a new world order in which most of the globe is to be subordinated and exploited in accordance with models already developed, tested, and refined through their applications to Indian country. 219. Overall, elimination of this threat yields the promise of an across-the-board recasting of relations between human beings, and of humans with the rest of nature, which is infinitely more equitable and balanced than anything witnessed since the beginnings of European expansionism more than 500 years ago. 220. In the alternative, if the current psychopolitical/socioeconomic status quo prevails, things are bound to run their deadly course. Felix Cohen's figurative miners will inevitably share the fate of their canary, the genocide they so smugly allow as an acceptable cost of doing business, blending perfectly into their own auto-genocide until the grim prospect of species extinction has at last been realized. There is, to be sure, a certain unmistakable justice attending the symmetry of the scenario. 221 But, surely, we all of us, settlers as well as natives, owe more to our future generations than to bequeath them a planet so thoroughly irradiated as to deny the possibility of life itself. 6. Like sand in the wind. The making of an American Indian diaspora in the United States. We told them that we would rather die than leave our lands, but we could not help ourselves. They took us down. Many died on the road. 2 of my children died. After we reached the new land, all my horses died. The water was very bad. All our cattle died, not one was left. I stayed till 158 of my people had died. Then I ran away. Standing Bear, January 1876. Within the arena of diaspora studies, the question of whether the field's analytical techniques might be usefully applied to the indigenous population of the United States is seldom raised. In large part, this appears to be due to an unstated presumption on the part of diaspora scholars that because the vast bulk of the native people of the U.S. remain inside the borders of that country, no population dispersal comparable to that experienced by Afro-Americans, Asian Americans, Latinos or, for that matter, Euro-Americans is at issue. Upon even minimal reflection, however, the fallacy embedded at the core of any such premise is quickly revealed. To say that a Cherokee remains essentially at home so long as he resides within the continental territoriality claimed by the U.S. is equivalent to arguing that a Swede displaced to Italy, or a Vietnamese refugee in Korea, would be at home simply because they remain in Europe or Asia. Native Americans, no less than other peoples, can and should be understood as identified with the specific geographical settings by which we came to identify ourselves as peoples. Mohawks are native to the upstate New York/southern Quebec region, not Florida or California. Chiricahua Apaches are indigenous to southern Arizona and northern Sonora, not Oklahoma or Oregon. The matter is not only cultural, although the dimension of culture is crucially important, but political and economic as well. Struggles by native peoples to retain use and occupancy rights over our traditional territories, and Euro-American efforts to supplant us, comprise the virtual entirety of U.S./Indian relations since the inception of the Republic. All 40 of the so-called Indian Wars recorded by the federal government were fought over land. 1 On some 400 separate occasions between 1778 and 1871, the Senate of the United States ratified treaties with one or more indigenous peoples by which the latter ceded portions of their land base to the U.S. In every instance, a fundamental quid pro quo was arrived at. Each indigenous nation formally recognized as such through a treaty ratification was simultaneously acknowledged as retaining a clearly demarcated national homeland within which it might maintain its socio-political cohesion and from which it could draw perpetual sustenance, both spiritually and materially. 2. At least 5 succeeding generations of American Indians fought, suffered, and died to preserve their people's residency in the portions of North America which had been theirs since time immemorial. In this sense, the fundamental importance they attached to continuing their links to these areas seems unquestionable. By the same token, the extent to which their descendants have been dislocated from these defined, or definable, land bases is the extent to which it can be observed that the conditions of diaspora have been imposed upon the population of native North America. In this respect, the situation is so unequivocal that a mere sample of statistics deriving from recent census data will suffice to tell the tale. By 1980, nearly half of all federally recognized American Indians lived in off-reservation locales, mostly cities. The largest concentration of indigenous people in the country 90,689 was in the Los Angeles metropolitan area. 3 By 1990, the proportion of urban-based Indians is estimated to have swelled to over 55%. 4. All federally unrecognized Indians, a figure which may run several times that of the approximately 2 million the U.S. officially admits still exist within its borders, are effectively landless and scattered everywhere across the country. 5. Texas, the coast of which was once one of the more populous locales for indigenous people, reported a reservation-based Native American population of 859 in 1980. 6 The total Indian population of Texas was reported as being 39,7407. Even if this number included only members of peoples native to the area, it would still represent an upper 90th percentile reduction from an estimated 1.5 million human beings residing there at the point of first contact with Europeans. 8. A veritable vacuum in terms of American Indian reservations and population is now evidenced in most of the area east of the Mississippi River, another region once densely populated by indigenous people. Delaware, Illinois, Indiana, Kentucky, Maryland, New Hampshire, New Jersey, Ohio, Pennsylvania, Rhode Island, Tennessee, Vermont, Virginia, West Virginia show no reservations at all. 9 The total Indian population reported in Vermont in 1980 was 968. In New Hampshire, the figure was 1,297. In Delaware, it was 1,307, in West Virginia, 1,555. The reality is that a greater number of persons indigenous to the North American mainland now live in Hawaii, far out in the Pacific Ocean, than in any of these easterly states. 10. The ways in which such deformities in the distribution of indigenous population in the U.S. have come to pass were anything but natural. To the contrary, the major causal factors have consistently derived from a series of official policies implemented over more than 2 centuries by the federal government of the United States. These have ranged from forced removal during the 1830s to concentration and compulsory assimilation during the 1880s to coerced relocation beginning in the late 1940s. Interspersed through it all have been periods of outright liquidation and dissolution, continuing into the present moment. The purpose of this essay is to explore these policies and their effects on the peoples targeted for such exercises in social engineering. The formative period. During the period immediately following the American War of Independence, the newly formed United States was in a desperate financial plight, saw its salvation in the sale to settlers and land companies of western lands lying outside the original 13 colonies. 11 Indeed, the war had been fought in significant part to negate George III's proclamation of 1763, an edict restricting land acquisition by British subjects to the area east of the Appalachian Mountains and thereby voiding certain speculative real estate interests held by the U.S. Founding Fathers. During the war, loyalty of rank-and-file soldiers, as well as major creditors, had been maintained through warrants advanced by the Continental Congress with the promise that rebel debts would be retired through issuance of deeds to parcels of Indian land once independence had been attained. 12 A substantial problem for the fledgling republic was that, in the immediate aftermath, it possessed neither the legal nor the physical means to carry through on such commitments. In the Treaty of Paris, signed on September 3, 1783, England quit-claimed its rights to all present U.S. territory east of the Mississippi. Contrary to subsequent Americana, this action conveyed no bona fide title to any of the Indian lands lying west of the mountains. 13 Rather, it opened the way for the United States to replace Great Britain as the sole entity entitled under prevailing international law to acquire Indian land in the region through negotiation and purchase. 14 The U.S., already an outlaw state by virtue of its armed rejection of lawful crown authority, appears to have been prepared to seize native property through main force, thereby continuing its initial posture of gross illegality. 15 Confronted by the incipient indigenous alliance advocated by Tecumseh in the Ohio River Valley and to the south by the powerful Creek and Cherokee confederations, however, the U.S. found itself militarily stalemated all along its western frontier. 16 The Indian position was considerably reinforced when England went back on certain provisions of the Treaty of Paris, refusing to abandon a line of military installations along the Ohio until the U.S. showed itself willing to comply with minimum standards of international legality, acknowledging the Indian right in the soil long since recognized under the doctrine of discovery. 17 To the south, Spanish Florida also aligned itself with native nations as a means of holding the rapacious settler population of neighboring Georgia in check. 18 Frustrated, federal authorities had to content themselves with the final dispossession and banishment of such peoples as the Wyandots and Lenni Lenapes, whose homelands fell within the original colonies, and who had been much weakened by more than a century of warfare to points beyond the 1763 demarcation line. There, these early elements of AU's precipitated indigenous diaspora were taken in by stronger nations such as the Ottawa and Shawnee. 19 Meanwhile, George Washington's initial vision of a rapid and wholesale expulsion of all Indians east of the Mississippi, expressed in June 1783,20 was tempered to reflect a more sophisticated process of gradual encroachment explained by General Philip Schuyler of New York in a letter to Congress the following month. As our settlements approach their country, must, from the scarcity of game, which that approach will induce, retire farther back, and dispose of their lands, unless they dwindle to nothing, as all savages have done, when compelled to live in the vicinity of civilized people, and thus leave us the country without the expense of purchase, trifling as that will probably be. 21 As Washington himself was to put it a short time later, policy and economy point very strongly to the expediency of being on good terms with the Indians, and the propriety of purchasing their lands in preference to attempting to drive them by force of arms out of their country. The gradual extension of our settlements will certainly cause the savage as the wolf to retire. In a word, there is nothing to be gained by an Indian war but the soil they live on, and this can be had by purchase at less expense. 22 By 1787, the strategy had become so well accepted that the U.S. was prepared to enact the Northwest Ordinance, codifying a formal renunciation of what it had been calling its rights of conquest with respect to native peoples. The utmost good faith shall always be observed towards the Indian, their land shall never be taken from them without their consent, and in their property, rights, and liberty, they shall never be invaded or disturbed, but laws founded in justice and humanity shall from time to time be made, for wrongs done to them, and for preserving peace and friendship with them. 23. The era of removal. By the early years of the 19th century, the balance of power in North America had begun to shift. To a certain extent, this was due to a burgeoning of the Anglo-American population, a circumstance actively fostered by government policy. In other respects, it was because of an increasing consolidation of the U.S. state and a generation-long erosion of indigenous strength resulting from the factors delineated in Schuyler's policy of gradual expansion. 24 By 1810, the government was ready to resume what Congress described as the speedy provision of the extension of the territories of the United States through means of outright force. 25 Already, in 1803, provision had been made through the Louisiana Purchase for the massive displacement of all eastern Indian nations into what was perceived as the vast wasteland west of the Mississippi. 26 The juridical groundwork was laid by the Supreme Court with Chief Justice John Marshall's opinion in Fletcher v. Peck, a decision holding that the title of U.S. citizens to parcels of Indian property might be considered valid even though no Indian consent to cede the land had been obtained. 27 With the defeat of Great Britain in the War of 1812, the defeat of Tecumseh's Confederation in 1811, and General Andrew Jackson's defeat of the Creek Red Sticks in 1814, the clearing of the East began in earnest. 28 By 1819, the U.S. had wrested eastern Florida from Spain, consummating a process begun in 1810 with assaults upon the western portion of the territory. 29 Simultaneously, the first of three Seminole Wars was begun on the Florida Peninsula to subdue an amalgamation of resident Miccosukes, recalcitrant Creek refugees, and runaway chattel slaves naturalized as free citizens of the indigenous nations. 30 In 1823, John Marshall reinforced the embryonic position articulated in Peck with Johnson v. McIntosh, an opinion inverting conventional understandings of indigenous status in international law by holding that U.S. sovereignty superseded that of native nations, even within their own territories. 31 During the same year, President James Monroe promulgated his doctrine professing a unilateral U.S. right to circumscribe the sovereignty all other nations in the hemisphere. 32 In this environment, a tentative policy of Indian removal was already underway by 1824, although not codified as law until the Indian Removal Act was passed in 1830. This was followed by John Marshall's opinions, rendered in Cherokee v. Georgia and Worcester v. Georgia, that Indians comprised domestic dependent nations, the sovereignty of which was subject to the higher authority of the federal government. 33 At that point, the federal program of physically relocating entire nations of people from their eastern homelands to what was then called the Permanent Indian Territory of Oklahoma west of the Mississippi became full-fledged and forcible. 34 The primary targets were the prosperous 5 civilized tribes of the Southeast, the Cherokee, Creek, Chickasaw, Choctaw, and Seminole nations. They were rounded up and interned by troops, concentrated in camps until their numbers were sufficient to make efficient their being force-marched at bayonet point, typically without adequate food, shelter, or medical attention, often in the dead of winter, as much as 1,500 miles to their new homelands. 35 There were, of course, still those who attempted to mount a military resistance to what was happening. Some, like the Sauk and Fox nations of Illinois, who fought what has come to be known as the Black Hawk War against those dispossessing them in 1832, were simply slaughtered en masse. 36 Others, such as the hardcore of Seminoles who mounted the Second War bearing their name in 1835, were forced from the terrain associated with their normal way of life. Once ensconced in forbidding locales like the Everglades, they became for all practical intents and purposes invincible. One group refused to make peace with the U.S. until the early 1960s, but progressively smaller and more diffuse in their demography. 37 In any event, by 1840 removal had been mostly accomplished, with only the smallest, least offensive, and most thoroughly integrated tribes escaping the pressure to clear the eastern half of the continent from its original inhabitants. 38 The results of the policy were always catastrophic for the victims. For instance, of the approximately 17,000 Cherokees subjected to the removal process, about 8,000 died of disease, exposure, and malnutrition along what they called the Trail of Tears. 39 Additionally, the Choctaws are said to have lost 15% of their population, 6,000 out of 40,000, and the Chickasaw, surely suffered severe losses as well. By contrast, the Creeks and Seminoles are said to have suffered about 50% mortality. For the Creeks, this came primarily in the period immediately after removal. For example, of the 10,000 or more who were resettled in 1836, 37, an incredible 3,500 died of bilious fevers. 40. Nor was this the only cost. Like the Seminoles, portions of each of the targeted peoples managed through various means to avoid removal, remaining in their original territories until their existence was once again recognized by the U.S. during the 20th century. One consequence was a permanent socio-cultural and geographic fragmentation of formerly cohesive groups, while the bulk of the identified populations of these nations now live in and around Oklahoma. Smaller segments reside on the tiny Eastern Cherokee Reservation in North Carolina, Mississippi Choctaw Reservation in Mississippi, the Miccosukee and Big Cypress, Hollywood, and Brighton Seminole Reservations in Florida. 41 An unknown but significant number of Cherokees also went beyond Oklahoma, following their leader, Sequoyah, into Mexico in order to escape the reach of the U.S. altogether. 42 This established something of a precedent for other peoples, such as the Kickapoos, a small Mexican colony of whom persists to this day. 43 Such dispersal was compounded by the fact that throughout the removal process varying numbers of Indians escaped at various points along the route of march, blending into the surrounding territory and later intermarrying with the incoming settler population. By and large, these people have simply slipped from the historical record, their descendants today inhabiting a long arc of mixed-blood communities extending from northern Georgia and Alabama through Tennessee and Kentucky, and into the southernmost areas of Illinois and Missouri. 44. Worse was to come. At the outset of the removal era proper, Andrew Jackson, a leading proponent of the policy, who had ridden into the White House on the public acclaim deriving from his role as commander of the 1814 massacre of the Red Sticks at Horseshoe Bend and a subsequent slaughter of noncombatants during the First Seminole War, offered a carrot as well as the stick he used to compel tribal cooperation. 45. In 1829, he promised the Creeks that your father has provided a country large enough for all of you, and he advises you to remove to it. There your white brothers will not trouble you, they will have no claim to the land, and you can live upon it, you and all your children, as long as the grass grows or the water runs, in peace and plenty. It will be yours forever. 46. Jackson was, to put it bluntly, lying through his teeth. Even as he spoke, he was aware that the Mississippi, that ostensible border between the U.S. and permanent Indian Territory proclaimed by Thomas Jefferson and others, had already been breached by the rapidly consolidating states of Louisiana, Arkansas, and Missouri in the south, Iowa, Wisconsin, and Minnesota in the north. 47. Nor could Jackson not have known that his close friend, Senator Thomas Hart Benton of Missouri, had stipulated as early as 1825 that the Rocky Mountains rather than the Mississippi should serve as an everlasting boundary of the U.S. 48. By the time the bulk of removal was completed a decade later, Anglo-American settlement was reaching well into Kansas. Their cousins who had infiltrated the Mexican province of Texas had revolted, proclaimed themselves an independent republic, and were negotiating for statehood. The eyes of empire had also settled on all of Mexico north of the Rio Grande, and the British portion of Oregon as well. 49. Peoples such as the Shawnee and Potawatomi, Lenni Lenape and Wyandot, Peoria, Kickapoo, Sac, and Fox, already removed from their eastern homelands, were again compulsorily relocated as the Western Indian Territory was steadily reduced in size. 50. This time, they were mostly shifted southward into an area eventually conforming to the boundaries of the present state of Oklahoma. Ultimately, 67 separate nations, only 6 of them truly indigenous to the land at issue, were forced into this relatively small dumping ground. 51. When Oklahoma, too, became a state in 1907, most of the territorial compartments reserved for the various Indian groups were simply dissolved. Today, although Oklahoma continues to report the second largest native population of any state, only the Osage retain a reserved land base which is nominally their own. 52. Subjugation in the West. The U.S. winning of the West, which began around 1850, that is, immediately after the northern half of Mexico was taken in a brief war of conquest, was, if anything, more brutal than the clearing of the East. 53. Most of the U.S. wars against native people were waged during the following 35 years, under what has been termed an official rhetoric of extermination. 54. The means employed in militarily subjugating the indigenous nations of California and southern Oregon, the Great Plains, Great Basin, and northern region of the Sonora Desert devolved upon a lengthy series of wholesale massacres. Representative of these are the slaughter of about 150 Lakotas at Blue River in 1854, some 500 Shoshones at Bear River in 1863, as many as 250 Cheyennes and Arapahoes at Sand Creek in 1864, perhaps 200 Cheyennes on the Washita River in 1868, 175 Piegans at the Marias River in 1870, and at least 100 Cheyennes at Camp Robinson in 1878. The parade of official atrocities was capped by the butchery of more than 300 unarmed Lakotas at Wounded Knee in 1890.55. Other means employed by the government to reduce its native opponents to a state of what it hoped would be abject subordination included the 4-year internment of the entire Navajo Nation in a concentration camp at the Bosque Redondo, outside Fort Sumner, New Mexico, beginning in 1864. The Dine, who had been force-marched in what they called the Long Walk, a 300-mile trek from their Arizona homeland, were held under abysmal conditions, with neither adequate food nor shelter, and died like flies. Approximately half perished before their release in 1868.56. Similarly, if less dramatically, food supplies to the Lakotas were cut off in 1877, militarily defeated the year before. They were being held under army guard at the time until starvation compelled their leaders to cede the Black Hills area to the U.S. 57 The assassination of resistance leaders such as the Lakotas Crazy Horse and Sitting Bull was also a commonly used technique. 58 Other recalcitrant figures like Geronimo and Satanta were separated from their people by being imprisoned in remote facilities like Fort Marion, Florida. 59 In addition to these official actions, which the U.S. Census Bureau acknowledged in an 1894 summary as having caused a minimum of 45,000 native deaths, there was a far greater attrition resulting from what were described as individual affairs. 60 These took the form of Anglo-American citizens at large killing Indians, often systematically, under a variety of quasi-official circumstances. In Dakota Territory, for example, a $200 bounty for Indian scalps was paid in the territorial capital of Yankton during the 1860s. The local military commander, General Alfred Sully, is known to have privately contracted for a pair of Lakota skulls with which to adorn the city. 61 In Texas, first as a republic and then as a state, authorities also placed a bounty upon the scalp of any Indian brought into a government office, man, woman, or child, no matter what tribe, no questions asked. 62 In California and Oregon, the enormous decrease from about 250,000 to less than 20,000 due chiefly to the cruelties and wholesale massacres perpetrated by the miners and early settlers. 63 Much of the killing in California and southern Oregon Territory resulted, directly and indirectly, from the discovery of gold in 1848 and the subsequent influx of miners and settlers. Newspaper accounts document the atrocities, as do oral histories of the California Indians today. It was not uncommon for small groups or villages to be attacked by immigrants, and virtually wiped out overnight. 64 It has been estimated that Indian deaths resulting from this sort of direct violence may have run as high as 500,000 by 1890. 65 All told, the indigenous population of the continental United States, which may still have been as great as 2 million when the country was founded, had been reduced to well under 250,000 by 1890. 66 As the noted demographer Sherburne F. Cook has observed, the record speaks for itself. No further commentary is necessary. 67 Under these conditions, the U.S. was able to shuffle native peoples around at will. The northern Cheyennes and closely allied Arapahoes, for instance, were shipped from their traditional territory in Montana's Powder River watershed to the reservation of their southern cousins in Oklahoma in 1877. After the Cheyenne remnants, more than a third of whom had died within a year of malaria and other diseases endemic to this alien environment, made a desperate attempt to return home in 1878, they were granted a reservation in the North Country, but not before the bulk of them had been killed by Army troops. Moreover, they were permanently separated from the Arapahoes, who were temporarily assigned to the Wind River Reservation of their hereditary enemies, the Shoshones, in Wyoming. 68 A faction of the Chiricahua Apaches who showed signs of continued hostility to U.S. domination in the 1880s were yanked from their habitat in southern Arizona and resettled around Fort Sill, Oklahoma. 69 Hinmatan Yalatkit of the Nez Perce and other leaders of that people's legendary attempt to escape the army and flee to Canada were also deposited in Oklahoma, far from the Idaho Valley they'd fought to retain. 70 Most of the Santee Dakotas of Minnesota's woodlands ended up on the windswept plains of Nebraska, while a handful of their relatives remained behind on tiny plots which are now called the Upper and Lower Sioux Reservations. 71 A portion of the Oneidas, who had fought on the side of the rebels during their war for independence, were moved to a small reservation near Green Bay, Wisconsin. 72 An even smaller reserve was provided in the same area for residual elements of Connecticut's Mohegans, Mohegans, and other peoples. All of them lumped together under the heading Stockbridge-Munsee Indians. 73 On and on it went. Allotment and assimilation. With the native ability to militarily resist U.S. territorial ambitions finally quelled, the government moved first to structurally negate any meaningful residue of national status on the part of indigenous peoples, and then to dissolve them altogether. The opening round of this drive came in 1871, with the attachment of a rider to the annual Congressional Appropriations Act suspending any further treaty making with Indians. This was followed, in 1885, with passage of the Major Crimes Act, extending U.S. jurisdiction directly over reserved Indian territories for the first time. Beginning with 7 felonies delineated in the initial statutory language, and combined with the Supreme Court's opinion in U.S. v. Kagama that Congress possessed a unilateral and incontrovertible right to exercise its authority over Indians as it saw fit, the 1885 Act opened the door to subsequent enactment of the more than 5,000 federal laws presently regulating every aspect of reservation life and affairs. 74. In 1887, Congress passed the General Allotment Act, a measure designed expressly to destroy what was left of the basic indigenous socio-economic cohesion by eradicating traditional systems of collective land holding. Under provision of the statute, each Indian identified as such by demonstrating 1/2 or more degree of Indian blood was to be issued an individual deed to a specific parcel of land. 160 acres per family head, 80 acres per orphan or single person over 18 years of age, and 40 acres per dependent child within existing reservation boundaries. Each Indian was required to accept U.S. citizenship in order to receive his or her allotment. Those who refused, such as a substantial segment of the Cherokee full-blood population, were left landless. 75. Generally speaking, those of mixed ancestry whose blood quantum fell below the required level were summarily excluded from receiving allotments. In many cases, the requirement was construed by officials as meaning that an applicant's blood had to have accrued from a single people. Persons whose cumulative blood quantum derived from intermarriage between several native peoples were thus often excluded as well. In other instances, arbitrary geographic criteria were also employed. All Cherokees, Creeks, and Choctaws living in Arkansas, for example, were not only excluded from allotment, but permanently denied recognition as members of their respective nations as well. 76. Once all eligible Indians had been assigned their allotments within a given reservation, usually from the worst land available therein, the remainder of the reserved territory was declared surplus and open to non-Indian homesteaders. Corporate acquisition, and conversion into federal or state parks and forests. 77. Under the various allotment programs, the most valuable land was the first to go. Settlers went after the rich grasslands of Kansas, Nebraska, and the Dakotas, the dense black soil forests of Minnesota and Wisconsin, and the wealthy oil and gas lands of Oklahoma. In 1887, for example, the Sisseton Sioux of South Dakota owned 918,000 acres of rich virgin land on their reservation. But since there were only 2,000 of them, allotment left more than 600,000 acres for European American settlers. The Chippewas of Minnesota lost their rich timber lands. Once each member had claimed his land, the government leased the rest to timber corporations. The Colvilles of northeastern Washington lost their lands to cattlemen, who fraudulently claimed mineral rights there. In Montana and Wyoming the Crows lost more than 2 million acres, and the Nez Perces had to cede communal grazing ranges in Idaho. All 67 of the tribes in Indian Territory underwent allotment. On the Flathead Reservation, which included Flatheads, Pend Oreilles, Kootenays, and Spokanes, the federal government opened 1.1 million acres to settlers. A similar story prevailed throughout the country. 78. By the time the allotment process had run its course in 1934, the residue of native land holdings in the U.S. had been reduced from approximately 150 million acres to less than 50 million. 79 of this, more than 2/3 consisted of arid or semi-arid terrain deemed useless for agriculture, grazing, or other productive purposes. The remaining 1/3 had been leased at extraordinarily low rates to non-Indian farmers and ranchers by local Indian agents exercising almost dictatorial powers over remaining reservation property. 80. Indians across the country were left in a state of extreme destitution as a result of allotment and attendant leasing practices. Worse, the situation was guaranteed to be exacerbated over succeeding generations insofar as what was left of the reservation land base, already insufficient to support its occupants at a level of mere subsistence, could be foreseen to become steadily more so as the native population recovered from the genocide perpetrated against it. 81 A concomitant of allotment was thus an absolute certainty that ever-increasing numbers of Indians would be forced from what remained nominally their own land. During the 20th century, dispersed into the vastly more numerous American society at large. There, it was predictable that they would be digested, disappearing once and for all as anything distinctly Indian in terms of socio-cultural, political, or even racial identity. 82 The record shows that such outcomes were anything but unintentional. The purpose of all this was assimilation, as federal policymakers described their purpose, or to put the matter more unabashedly, to bring about the destruction and disappearance of American Indian peoples as such. In the words of Francis E. Loop, Commissioner of Indian Affairs from 1905 through 1909, the Allotment Act in particular should be viewed as a mighty pulverizing engine for breaking up the tribal mass which stood in the way of complete Euro-American hegemony in North America. Or, to quote Indian Commissioner Charles Burke a decade later, "It is not desirable or consistent with the general welfare to promote tribal characteristics and organization." 83. The official stance was consecrated in the Supreme Court's determination in the 1903 Lone Wolf v. Hitchcock opinion extended from John Marshall's domestic dependent nation thesis of the early 1830s that the U.S. possessed plenary power over all matters involving Indian affairs. In part, this meant the federal government was unilaterally assigning itself perpetual trust prerogatives to administer or dispose of native assets, whether these were vested in land, minerals, cash, or any other medium, regardless of Indian needs or desires. 84 Congress then consolidated its position with passage of the 1906 Burke Act, designating the Secretary of the Interior as permanent trustee over Indian country. In 1924, a number of loose ends were cleaned up with passage of the Indian Citizenship Act, imposing U.S. citizenship upon all native people who had not otherwise been naturalized. The law was applied across the board to all Indians, whether they desired citizenship or not, and thus included those who had foregone allotments rather than accepted. 85. Meanwhile, the more physical dimensions of assimilationist policy were coupled to a process of ideological conditioning designed to render native children susceptible to dislocation and absorption by the dominant society. In the main, this assumed the form of a compulsory boarding school system administered by the Interior Department's Bureau of Indian Affairs, wherein large numbers of indigenous children were taken, often forcibly, to facilities remote from their families and communities. Once there, the youngsters were prevented from speaking their languages, practicing their religions, wearing their customary clothing or their hair in traditional fashion, or in any other way overtly associating themselves with their own cultures and traditions. Instead, they were indoctrinated typically for a decade or more in Christian doctrine and European values such as the work ethic. During the summers, they were frequently farmed out to Euro-American foster homes where they were further steeped in the dominant society's views of their peoples and themselves. 86. Attendance was made compulsory and the agent was made responsible for keeping the schools filled, by persuasion if possible, by withholding rations and annuities from the parents, and by other means if necessary. Who were guilty of misbehavior might either receive corporal punishment or be imprisoned in the guardhouse. A sincere effort was made to develop the type of school that would destroy tribal ways. 87. The intention of this was, according to federal policymakers and many of its victims alike, to create generations of American Indian youth who functioned intellectually as little white people, facilitating the rapid dissolution of traditional native cultures desired by federal policymakers. 88 In combination with a program in which native children were put out for wholesale adoption by Euro-American families, the effect upon indigenous peoples was devastating. 89 The systematic transfer of children not only served to accelerate the outflow of Indians from reservation and reservation-adjacent settings, but the return of individuals mentally conditioned to conduct themselves as non-Indians escalated the rate at which many native societies unraveled within the reservation contexts themselves. 90. The effects of the government's allotment and assimilation programs are reflected in the demographic shifts evidenced throughout Indian country from 1910 through 1950. In the former year, only 0.4% of all identified Indians lived in urban locales. By 1930, the total had grown to 9.9%. As of 1950, the total had grown to 13.4%. Simultaneously, the displacement of native people from reservations to off-reservation rural areas was continuing apace. 91 in 1900, this involved only about 3.5% of all Indians. By 1930, the total had swelled to around 12.5% and, by 1950, it had reached nearly 18%. 92 hence, in the latter year, nearly one-third of the federally recognized Indians in the United States had been dispersed to locales other than those government officials had defined as being theirs. Reorganization and colonization. It is likely, all things being equal, that the Indian policies with which the United States ushered, in the 20th century would have led inexorably to a complete eradication of the reservation system and the corresponding disappearance of American Indians as distinct peoples by some point around 1950. There can be no question but that such a final consolidation of its internal land base would have complemented the phase of transoceanic expansionism into which the U.S. entered quite unabashedly during the 1890s. 93 That things did not follow this course seems mainly due to a pair of ironies, one geological and the other unwittingly embedded in the bizarre status of quasi-sovereignty increasingly imposed upon native nations by federal jurists and policy makers over the preceding 100 years. As regards the first of these twin twists of fate, authorities were becoming increasingly aware by the late 1920s that the worthless residue of territory to which indigenous people were consigned was turning out to be extraordinarily endowed with mineral wealth. Already, in 1921, an exploratory team from Standard Oil had come upon what it took to be substantial fossil fuel deposits on the Navajo Reservation. 94 During the next 3 decades, it would be discovered just how great a proportion of U.S. domestic resources lay within American Indian reservations. For example, Western reservations in particular, possess vast amounts of coal, oil, shale oil, natural gas, timber, and uranium. More than 40% of the national reserves of low-sulfur, strippable coal, 80% of the nation's uranium reserves, and billions of barrels of shale oil exist on reservation land. On the 15 million-acre Navajo Reservation, there are approximately 100 million barrels of oil, 25 trillion cubic feet of natural gas, 80 million pounds of uranium, and 50 billion tons of coal. The 440,000-acre Northern Cheyenne Reservation in Montana sits atop a 60-foot thick layer of coal. In New Mexico, geologists estimate that the Jicarilla Apache Reservation possesses 2 trillion cubic feet of natural gas and as much as 154 million barrels of oil. 95. This led directly to the second quirk. The more sophisticated federal officials, even then experiencing the results of opening up Oklahoma's lush oil fields to unrestrained corporate competition, realized the extent of the disequilibriums and inefficiencies involved in this line of action when weighed against the longer-term needs of U.S. industrial development. 96 Only by retaining its trust authority over reservation assets would the government continue to be in a position to dictate which resources would be exploited, in what quantities, by whom, at what cost, and for what purpose, allowing the North American political economy to evolve in ways preferred by the country's financial elite. 97 Consequently, it was quickly perceived as necessary that both Indians and Indian country be preserved, at least to some extent, as a facade behind which the socialistic process of central economic planning might occur. For the scenario to work in practice, it was vital that the reservation-based indigenous nations be made to appear self-governing enough to be exempt from the usual requirements of the U.S. free market system whenever this might be convenient to their federal guardians. On the other hand, they could never become independent or autonomous enough to assume control over their own economic destinies, asserting demands that equitable royalty rates be paid for the extraction of their ores, for example, or that profiting corporations underwrite the expense of environmental cleanup once mining operations had been concluded. 98 In effect, the idea was that many indigenous nations should be maintained as outright internal colonies of the United States rather than being liquidated out of hand. 99 All that was needed to accomplish this was the creation of a mechanism through which the illusion of limited Indian self-rule might be extended. The vehicle for this purpose materialized in 1934, with passage of the Indian Reorganization Act, or IRA, as it is commonly known. Under provision of this statute, the traditional governing bodies of most indigenous nations were supplanted by tribal councils, the structure of which was devised in Washington, D.C., functioning within parameters of formal constitutions written by BIA officials. 100 A democratic veneer was maintained by staging a referendum on each reservation prior to its being reorganized, but federal authorities simply manipulated the outcomes to achieve the desired results. 101 The newly installed IRA councils were patterned much more closely upon the model of corporate boards than of governments, and possessed little power other than to sign off on business agreements. Even at that, they were completely and voluntarily subordinated to U.S. interests. All decisions of any consequence rendered by these tribal councils were made subject to the approval of the Secretary of the Interior or his delegate, the Commissioner of Indian Affairs. 102. One entirely predictable result of this arrangement has been that an inordinate amount of mining, particularly that related to energy development, has occurred on Indian reservations since the mid to late 1940s. Virtually all uranium mining and milling during the life of the U.S. Atomic Energy Commission or buying program occurred on reservation land. Anaconda's Jackpile Mine, located at the Laguna Pueblo in New Mexico, was the largest open-pit uranium extraction operation in the world until it was phased out in 1979.103 every year. Enough power is generated by Arizona's Four Corners power plant alone, every bit of it from coal mined at Black Mesa, on the Navajo Reservation, to light the lights of Tucson and Phoenix for 2 decades, and present plans include a fourfold expansion of Navajo coal extraction. 104 Throughout the West, the story is the same. On the face of it, the sheer volume of resource development in Indian country over the past half-century should, even under disadvantageous terms, have translated into some sort of material improvement in the lot of indigenous people. Yet the mining leases offered to selected corporations by the BIA in behalf of their native wards and duly endorsed by the IRA councils have consistently paid such a meager fraction of prevailing market royalty rates that no such advancement has been discernible. Probably the best terms were those obtained by the Navajo Nation in 1976, a contract paying a royalty of 55 cents per ton for coal. This amounted to 8% of market price at a time when Interior Secretary Cecil Andrus admitted the minimum rate paid for coal mined in off-reservation settings was 12.5%. 105 Simultaneously, a 17.5 cents per ton royalty was being paid for coal on the Crow Reservation in Montana, a figure which was raised to 40 cents, less than half the market rate only after years of haggling. 106 At issue are not profits, but the sort of super profits usually associated with U.S. domination of economies elsewhere in the world. 107 Nor has the federally coordinated corporate exploitation of the reservations translated into wage income for Indians. As of 1989, the government's own data indicated that reservation unemployment nationwide still hovered in the mid-60th percentile, with some locales running persistently in the 90th. 108 Most steady jobs involved administering or enforcing the federal order, reservation by reservation. Such business-related employment as existed tended to be temporary, menial, and paid the minimum wage, a matter quite reflective of the sort of transient, extractive industry which brings its cadre of permanent, skilled labor with it the BIA had encouraged in Indian country. 109 Additionally, the impact of extensive mining and associated activities had done much to disrupt the basis for possible continuation of traditional self-sufficiency, destroying considerable acreage which held potential as grazing or subsistence garden plots. 110 In this sense, U.S. governmental and corporate activities have underdeveloped native North America in classic fashion. 111 Overall, according to a federal study completed in 1988, reservation-based Indians experienced every indicia of extreme impoverishment, by far the lowest annual and lifetime incomes of any North American population group, highest rate of infant mortality, highest rates of death from plague disease, malnutrition, and exposure, highest rate of teen suicide, and so on. The average life expectancy of reservation-based Native American males is 44.6 years, that of females about 3 years longer. 112 The situation is much more indicative of a third world context than of rural areas in a country that claims to be the world's most advanced industrial state. Indeed, the poignant observation of many Latinos regarding their relationship to the U.S., that your wealth is our poverty, is as appropriate to the archipelago of Indian reservations in North America itself as it is to the South American continent. By any estimation, the open veins of Native America created by the IRA have been an incalculable boon to the maturation of the U.S. economy, while Indians continue to pay the price by living in the most grinding sort of poverty. 113. And there is worse. One of the means used by the government to maximize corporate profits in Indian country over the years, again rubber-stamped by the IRA councils, has been to omit clauses requiring corporate reclamation of mined lands from leasing instruments. Similarly, the cost of doing business on reservations has been pared to the bone by simply waiving environmental protection standards in most instances. 114 Such practices have spawned ecological catastrophe in many locales. As the impact of the Four Corners plant, one of a dozen coal-fired electrical generation facilities currently online on the Navajo reservation, has been described elsewhere. The 5 units of the 2,075 megawatt power plant have been churning out city-bound electricity and local pollution since 1969. The plant burns 10 tons of coal per minute, 5 million tons per year, spewing 300 tons of fly ash and other waste particulates into the air each day. The black cloud hangs over 10,000 acres of the once pristine San Juan River Valley. The deadly plume was the only visible evidence of human enterprise seen from the Gemini 12 satellite, which photographed the Earth from 150 miles in space. Less visible, but equally devastating, is the fact that since 1968 the coal mining operations and power plant requirements have been extracting 2,700 gallons from the Black Mesa water table each minute, 60 million gallons per year, causing extreme desertification of the area, and even the sinking of some ground by as much as 12 feet. 115. Corporations engaged in uranium mining and milling on the Navajo reservation and at Laguna were also absolved by the BIA of responsibility for cleaning up upon completion of their endeavors, with the result that hundreds of tailings piles were simply abandoned during the 1970s and 80s. 116. A fine sand retaining about 85% of the radioactive content of the original ore, the tailings constitute a massive source of wind-blown carcinogenic/mutagenic contaminants affecting all persons and livestock residing within a wide radius of each pile. 117. Both ground and surface water have also been heavily contaminated with radioactive byproducts throughout the Four Corners region. 118. In the Black Hills region, the situation is much the same. 119. At its Hanford nuclear weapons facility, located near the Yakima Reservation in Washington state, the AEC itself secretly discharged some 440 billion gallons of plutonium, strontium, celsium, tritium, and other high-level radioactive contaminants into the local aquifer between 1955 and 1989. 120. Given that the half-life of the substances involved is as long as 250,000 years, the magnitude of the disaster inflicted upon native North America by IRA colonialism should not be underestimated. The Los Alamos National Scientific Laboratory observed in its February 1978 mini-report that the only solution its staff could conceive of to the problems presented by wind-blown radioactive contaminants would be to zone the land into uranium mining and milling districts so as to forbid human habitation. Similarly, a National Academy of Sciences report states bluntly that cannot be done in areas with less than 10 inches of rainfall a year. The rainfall over most of the Navajo Nation ranges from 6 to 10 inches a year. The NAS suggests that such areas be spared development or honestly labeled National Sacrifice Areas. 121. Tellingly, the two areas considered most appropriate by the NAS for designation as national sacrifices, the Four Corners and Black Hills regions, are those containing the Navajo and Sioux complex of reservations, the largest remaining blocks of acknowledged Indian land and concentrations of land-based indigenous population in the U.S. For this reason, many American Indian activists have denounced both the NAS scheme and the process of environmental destruction which led up to it, as involving not only national sacrifice areas, but national sacrifice peoples as well. 122 At the very least, having the last of their territory zoned so as to forbid human habitation would precipitate an ultimate dispersal of each impacted people, causing its disappearance as a human group. Per SE 123 As American Indian movement leader Russell Means has put it, it's genocide, no more, no less. 124. Regardless of whether a policy of national sacrifice is ever implemented in the manner envisioned by the NAS, it seems fair to observe that the conditions of dire poverty and environmental degradation fostered on Indian reservations have contributed heavily to the making of the contemporary native diaspora in the United States. In combination with the constriction of the indigenous land base brought about through earlier policies of removal, concentration, allotment, and assimilation, they have created a strong and ever-increasing pressure upon reservation residents to cooperate with other modern federal programs meant to facilitate the outflow and dispersal of Indians from their residual land base. Chief among these have been termination and relocation. Termination and relocation. As the IRA method of administering Indian country took hold, the government returned to such tasks as trimming the fat from federal expenditures allocated to support Indians, largely through manipulation of the size and disposition of the recognized indigenous population. By 1940, the system of colonial governance on American Indian reservations was largely in place. Only the outbreak of World War II slowed the pace of corporate exploitation, a matter that retarded initiation of maximal development activities until the early 1950s. By then, the questions concerning federal and corporate planners had become somewhat technical: what to do with those indigenous nations which had refused reorganization? How to remove the portion of Indian population on even the reorganized reservations, whose sheer physical presence served as a barrier to wholesale strip mining and other profitable enterprises anticipated by the U.S. business community. 125. The first means to this end was found in a partial resumption of 19th-century assimilationist policies, focused this time on specific peoples, or parts of peoples, rather than upon Indians as a whole. On August 1, 1953, Congress approved House Resolution 108, a measure by which the federal legislature empowered itself to enact statutes terminating selected native peoples, typically those who had rejected reorganization, or lacked the kind of resources necessitating their maintenance under the IRA. 126. Among the involved were the comparatively large and wealthy Menominee of Wisconsin and the Klamath of Oregon, both owners of extensive timber resources. Also passed were acts to terminate the Indians of Western Oregon, small Paiute bands in Utah, and the mixed bloods of the Uinta and Ouray reservations. Approved, too, was legislation to transfer administrative responsibility for the Alabama and Coushatta Indians to the state of Texas. Early in the first session of the 84th Congress, bills were submitted to Wyandotte, Ottawa, and Peoria of Oklahoma. These were enacted early in August of 1956, a month after passage of legislation directing the Colville Confederated Tribes of Washington to come up with a termination plan of their own. During the second administration of President Dwight D. Eisenhower, Congress enacted 3 termination bills relating to the Choctaw of Oklahoma, for whom the termination process was never completed, the Catawba of South Carolina, and the Indians of the Southern California Rancherias. 127. It is instructive that the man chosen to implement the policy was Dillon S. Meyer, an Indian commissioner whose only apparent job qualification was having headed up the internment program targeting Japanese Americans during the Second World War. 128. In all, 109 indigenous nations encompassing more than 35,000 people were terminated before the liquidation process had run its course during the early 1960s. 129. Only a handful, like the Menominee and the Siletz of Oregon, were ever reinstated. 130. Suddenly landless, mostly poor, and largely unemployed, the others were scattered like sand in the wind. 131. In this, they were joined by a rapidly swelling exodus of people from unterminated reservations, a circumstance fostered by yet another federal program. Passed in 1956, the Relocation Act followed a steady diminishment throughout the first half of the decade of federal allocations to provide assistance to people living on reservations. The statute provided funding to underwrite the expenses of any Indian agreeing to move to an urban area, establish a residence, and undergo a brief period of job training. The quid pro quo was that each person applying for such relocation was required to sign an agreement that he would never return to his or her reservation to live. It was also specified that all federal support would be withdrawn after relocates had spent a short period, often no more than 6 weeks, adjusting to city life. 132 Under the conditions of near starvation on many reservations, there were many takers. Nearly 35,000 people signed up to move to places like Los Angeles, Minneapolis, San Francisco, Chicago, Denver, Phoenix, Seattle, and Boston during the period 1957 to 59 alone. 133. Although there was ample early indication that relocation was bearing disastrous fruit for those who underwent it, all that was happening was that relocates were exchanging the familiar squalor of reservation life for that of the alien Indian ghettos that shortly emerged in most major cities. The government accelerated the program during the 1960s. As a result of termination and relocation during the 50s, the proportion of native people who had been urbanized rose dramatically, from 13.5% at the beginning of the decade to 27.9% at the end. During the 60s, relocation alone drove the figure upwards to 44.5%. During the 1970s, as the program began to be phased out, the rate of Indian urbanization decreased sharply, with the result that the proportion had risen to only 49% by 1980. 134 Even without a formal federal relocation effort on a national scale, the momentum of what had been set in motion over an entire generation carried the number into the mid-50th percentile by 1990, and there is no firm indication the trend is abating. 135. Despite much protest to the contrary, those who migrated to the cities under the auspices of termination and relocation have already begun to join the legions of others, no longer recognized as Indians even by other Indians, who were previously discarded and forgotten along the tortuous route from 1776 to the present. 136 Cut off irrevocably from the centers of their socio-cultural existence, they have increasingly adopted arbitrary and abstract methods to signify their Indianness. Federally sanctioned certificates of tribal enrollment have come to replace tangible participation in the political life of their nations as emblems of membership. Federally issued certificates of degree of Indian blood have replaced discernible commitment to Indian interests as the ultimate determinant of identity. 137 In the end, by embracing such standards, Indians are left knowing no more of being Indian than do non-Indians. The process is a cultural form of what, in the physical arena, has been termed autogenocide. 138. Looking ahead. The Indian policies undertaken by the United States during the 2 centuries since its inception appear on the surface to have been varied, even at times contradictory. Openly genocidal at times, they have more often been garbed, however thinly, in the attire of humanitarianism. In fact, as the matter was put by Alexis de Tocqueville, the great French commentator on the early American experience, it would occasionally have been impossible to destroy men with more respect to the laws of humanity. 139 Always, however, there was an underlying consistency in the sentiments which begot policy, to bring about the total dispossession and disappearance of North America's indigenous population. It was this fundamental coherence in U.S. aims, invariably denied by responsible scholars and officials alike, which caused Adolf Hitler to ground his own notions of Lebensraumpolitik in the U.S. example. 140. Neither Spain nor Britain should be the models of German expansion, but the Nordics of North America, who had ruthlessly pushed aside an inferior race to win for themselves soil and territory for the future. To undertake this essential task, sometimes difficult, always cruel, this was Hitler's version of the white man's burden. 141. As early as 1784, a British observer remarked that the intent of the fledgling United States with regard to American Indians was that of extirpating them totally from the face of the earth, men, women, and children. 142 In 1825, Secretary of State Henry Clay opined that U.S. Indian policy should be predicated on a presumption that the Indian race was destined to extinction in the face of persistent expansion by superior Anglo-Saxon civilization. 143 During the 1870s, General Phil Sheridan is known to have called repeatedly for complete extermination of targeted native groups as a means of making the West safe for repopulation by Euro-Americans. 144 Subsequent assimilationists demanded the disappearance of any survivors through cultural and genetic absorption by their conquerors. 145 Well into the 20th century, Euro-America as a whole typically referred often hopefully to indigenous people as the vanishing race, decimated and ultimately subsumed by the far greater number of invaders who had moved in upon their land. 146. Many of the worst U.S. practices associated with these sensibilities have long since been suspended. Yet, large-scale and deliberate dislocation of native people from their land is anything but an historical relic. Probably the most prominent current example is that of the Big Mountain Dine, perhaps the largest remaining enclave of traditionally oriented Indians in the United States. Situated astride an estimated 24 billion tons of the most accessible low-sulfur coal in North America, the entire 13,500-person population of the Big Mountain area is even now being forcibly expelled to make way for the Peabody Corporation's massive shovels. There being no place left on the remainder of the Navajo reservation to accommodate their sheep-herding way of life, the refugees, many of them elderly, are being resettled in off-reservation towns like Flagstaff, Arizona. 147 Some have been sent to Phoenix, Denver, and Los Angeles. All suffer extreme trauma and other maladies resulting from the destruction of their community and consequent transition. 148. Another salient illustration is that of the Western Shoshone. Mostly resident to a vast expanse of the Nevada desert secured by their ancestors in the 1863 Treaty of Ruby Valley, the Shoshones have suffered the fate of becoming the most bombed nation on Earth by virtue of the U.S. having located the majority of its nuclear weapons testing facilities in the southern portion of their homeland since 1950. During the late 70s, despite being unable to demonstrate that it had ever acquired valid title to the territory the Shoshones call New Segovia, the government began to move into the northern area as well, stating an intent to construct the MX missile system there. While the MX plan has been dropped, the Shoshones are still being pushed off their land, freeing it for use in such endeavors as nuclear waste dumps like the one at Yucca Mountain. 149. In Alaska, where nearly 200 indigenous peoples were instantly converted into village corporations by the 1971 Alaska Native Claims Settlement Act, there is a distinct possibility that the entire native population of about 22,000 will be displaced by the demands of tourism, North Slope oil extraction, and other developmental enterprises by some point early in the 21st century. Already, their land base has been constricted to a complex of tiny townships and their traditional economy mostly eradicated by the impacts of commercial fishing, whaling, and sealing, as well as the effects of increasing Arctic industrialization on regional caribou herds and other game animals. 150 Moreover, there is a plan apparently conceived in all seriousness to divert the waterflow of the Yukon River southward all the way to the Rio Grande, an expedient to supporting continued non-Indian population growth in the arid regions of the lower 48 states and creating the agribusiness complex in the northern Mexican provinces of Sonora and Chihuahua envisioned in the North American Free Trade Agreement. 151 It seems certain that no traditional indigenous society can be expected to stand up against such an environmental onslaught. Eventually, if such processes are allowed to run their course, the probability is that a final solution of the Indian question will be achieved. 152 The key to this will rest, not in an official return to the pattern of 19th century massacres or the emergence of some Auschwitz-style extermination program, but in the erosion of socio-cultural integrity and confusion of identity afflicting any people subjected to conditions of diaspora. Like water flowing from a leaking bucket, the last self-consciously Indian people will pass into oblivion silently, unnoticed and unremarked. The deaths of cultures destroyed by such means usually occur in this fashion, with a faint whimper rather than resistance and screams of agony. 153. There are, perhaps, glimmers of hope flickering upon the horizon. One of the more promising is the incipient International Convention on the Rights of Indigenous Peoples. Drafted over the past decade by the United Nations Working Group on Indigenous Populations, the instrument is due for submission to the General Assembly at some point in the near future. When it is ratified, the convention could at last extend to native peoples the essential international legal protections enjoyed by their colonizers the world over. 154 Should it be adhered to by this nation of laws, the instrument will effectively bar the United States from completing its quietly ongoing drive to obliterate the remains of native North America. If not, and the U.S. has historically demonstrated a truly remarkable tendency to simply ignore those elements of international legality it finds inconvenient, the future of American Indians looks exceedingly grim. 155. 7. The bloody wake of Alcatraz. Repression of the American Indian movement during the 1970s. The reality is a continuum which connects Indian flesh sizzling over Puritan fires and Vietnamese flesh roasting under American napalm. The reality is the compulsion of a sick society to rid itself of men like Nat Turner and Crazy Horse, George Jackson, and Richard Oakes, whose defiance uncovers the hypocrisy of a declaration affirming everyone's right to liberty and life. The reality is an overwhelming greed which began with the theft of a continent and continues with the merciless looting of every country on the face of the earth which lacks the strength to defend itself. Richard Lundstrom. In combination with the fishing rights struggles of the Puyallup, Nisqually, Muckleshoot, and other nations in the Pacific Northwest from 1965 to 1970, the 1969-71 occupation of Alcatraz Island by the San Francisco Bay Area's Indians of All Tribes Coalition ushered in a decade-long period of uncompromising and intensely confrontational American Indian political activism. 1 Unprecedented in modern U.S. history, the phenomenon represented by Alcatraz also marked the inception of a process of official repression of indigenous activists without contemporary North American parallel in its virulence and lethal effects. 2. The nature of the post-Alcatraz federal response to organized agitation for native rights was such that by 1979 researchers were describing it as a manifestation of the U.S. government's continuing Indian wars. 3 For its part, in secret internal documents, the Federal Bureau of Investigation, the primary instrument by which the government's policy of anti-Indian repression was implemented, concurred with such assessments, abandoning its customary counterintelligence vernacular in favor of the terminology of outright counterinsurgency warfare. 4 The result, as the U.S. Commission on Civil Rights officially conceded at the time, was the imposition of a virtual reign of terror upon certain of the less compliant sectors of indigenous society in the United States. 5. In retrospect, it may be seen that the locus of both activism and repression in Indian country throughout the 1970s centered squarely upon one group, the American Indian movement. Moreover, the crux of AIM activism during the 70s, and thus of the FBI's campaign to neutralize its six, can be found in a single locality, the Pine Ridge Reservation, in South Dakota. The purpose of the present essay, then, is to provide an overview of the federal counterinsurgency program against AIM on and around Pine Ridge, using it as a lens through which to explore the broader motives and outcomes attending it. Finally, conclusions will be drawn as to its implications, not only with respect to American Indians, but concerning non-Indigenous Americans as well. Background. AIM was founded in 1968 in Minneapolis, by a group of urban Anishinabes including Dennis Banks, Pat Balanger, Clyde Belcourt, Eddie Benton Benet, and George Mitchell. Modeled loosely after the Black Panther Party for Self-Defense, established by Huey P. Newton and Bobby Scale in Oakland, California, 2 years previously, the group took as its first tasks the protection of the city's sizable Native community from a pattern of rampant police abuse, and the creation of programs for jobs, housing, and education. 7 Within 3 years, the organization had grown to include chapters in several other cities, and had begun to shift its focus from civil rights issues to an agenda more specifically attuned to the conditions afflicting Native North America. What AIM discerned as the basis of the latter was not so much a matter of socio-economic discrimination against Indians as it was our internal colonization by the United States. 8 This perception accrued from the fact that, by 1871, When federal treaty making with native peoples was permanently suspended, the rights of indigenous nations to distinct, self-governing territories had been recognized by the U.S. more than 370 times through treaties duly ratified by its Senate. 9 Yet, during the intervening century, more than 90% of treaty-reserved native land had been expropriated by the federal government, in defiance of both its own constitution and international custom and convention. 10 One consequence of this was creation of the urban diaspora from which AIM itself had emerged. By 1970, about half of all Indians in the U.S. had been pushed off their land altogether. 11 Within the residual archipelago of reservations, an aggregation of about 50 million acres, or roughly 2.5% of the 48 contiguous states, indigenous forms of governance had been thoroughly usurped through the imposition of U.S. jurisdiction under the federal government's self-assigned prerogative of exercising plenary power over Indian affairs. 12 Correspondingly, Indian control over what had turned out to be rather vast mineral resources within reservation boundaries. An estimated 2/3 of all U.S. domestic uranium deposits, a quarter of the low-sulfur coal, 20% of the oil and natural gas, and so on was essentially non-existent. 13 It followed that royalty rates set by the U.S. Bureau of Indian Affairs, in its exercise of federal trust prerogatives vis-a-vis corporate extraction of Indian mineral assets, amounted to only a fraction of what the same corporations would have paid had they undertaken the same mining operations in non-reservation localities. 14 The same principle of underpayment to Indians, with resulting super-profit accrual to non-Indian business entities, prevailed with regard to other areas of economic activity handled by the Indian Bureau, from the leasing of reservation grazing land to various ranching interests to the harvesting of reservation timber by corporations such as Weyerhaeuser and Boise Cascade. 15 Small wonder that, by the late 1960s, Indian radicals like Robert K. Thomas had begun to refer to the BIA as the Colonial Office of the United States. 16 In human terms, the consequence was that, overall, American Indians who, on the basis of known resources, comprised what should have been the single wealthiest population group in North America, constituted by far the most impoverished sector of U.S. society. According to the federal government's own data, Indians suffered, by a decisive margin, the highest rate of unemployment in the country, a matter correlated to our receiving by far the lowest annual and lifetime incomes of any group in the country. 17 It also corresponded well with virtually every other statistical indicator of extreme poverty, a truly catastrophic rate of infant mortality and the highest rates of death from malnutrition, exposure, plague disease, teen suicide, and accidents related to alcohol abuse. The average life expectancy of a reservation-based Indian male in 1970 was less than 45 years. Reservation-based Indian females could expect to live less than 3 years longer than their male counterparts. Urban Indians of either gender were living only about 5 years longer on average than their relatives on the reservations. 18 AIM's response to its growing apprehension of this squalid panorama was to initiate a campaign consciously intended to bring about the decolonization of native North America, only by re-establishing our rights as sovereign nations, including our right to control our own territories and resources, and our right to genuine self-governance, as Dennis Banks put it in 1971, can we hope to successfully address the conditions currently experienced by our people. 19 Extrapolating largely from the example of Alcatraz, the movement undertook a multifaceted political strategy combining a variety of tactics. On the one hand, it engaged in activities designed primarily to focus media attention, and thus the attention of the general public, on Indian rights issues, especially those pertaining to treaty rights. On the other hand, it pursued the sort of direct confrontation meant to affirm those rights in practice. It also began to systematically reassert native cultural/spiritual traditions. 20 Eventually, it added a component wherein the full range of indigenous rights to decolonization/self-determination were pursued through the United Nations venue of international law. 21 In mounting this comprehensive effort, AIM made of itself a bona fide national liberation movement, at least for a while. 22 Its members consisted of the shock troops of Indian sovereignty, To quote non-AIM Oglala Lakota activist Virgil Kills Straight. 23 They essentially reframed the paradigm by which U.S. Indian relations are understood in the late 20th century. 24 They also suffered the worst physical repression at the hands of the United States of any domestic group since the 1890 massacre of Bigfoot's Minneconjus by the 7th Cavalry at Wounded Knee. 25 Prelude. AIM seizure of the public consciousness may in many ways be said to have begun at the point in 1969 when Dennis Banks recruited a young Oglala named Russell Means to join the movement. Instinctively imbued with what one critic described as a bizarre knack for staging demonstrations that attracted the sort of press coverage Indians had been looking for, 26 Means was instrumental in AIM's achieving several of its earliest and most important media coups, painting Plymouth Rock red before capturing the Mayflower replica on Thanksgiving Day 1970, for example, and staging a 4th of July counter-celebration by occupying the Mt. Rushmore National Monument in 1971.27. Perhaps more important, Means proved to be the bridge which allowed the movement to establish its credibility on a reservation for the first time. In part, this was because when he joined AIM he brought along virtually an entire generation of his family brothers Ted, Bill, and Dale, cousin Madonna Gilbert, and others, each of whom possessed a web of friends and acquaintances on the Pine Ridge Reservation. It was therefore rather natural that AIM was called upon to set things right concerning the torture murder of a middle-aged Oglala in the off-reservation town of Gordon, Nebraska, in late February 1972.28, as Bill Means would later recall. When Raymond Yellow Thunder was killed, his relatives went first to the BIA, then to the FBI, and to the local police, but they got no response. Severt Young Bear then asked AIM to come help clear up the case. 29. Shortly afterwards, Russell Means led a caravan of some 1,300 Indians into the small town, announcing from the steps of the courthouse that, "We've come here today to put Gordon on the map, and if justice is not immediately forthcoming, we're going to take Gordon off the map." The killers, brothers named Melvin and Leslie Hare, were quickly arrested, and a police officer who had covered up for them suspended. The Hares soon became the first whites in Nebraska history sent to prison for killing an Indian, and AIM's reputation soared among reservation Indians. What tribal leaders had dared not do to protect their people, AIM had done. 30. By fall, things had progressed to the point that AIM could collaborate with several other native rights organizations to stage the Trail of Broken Treaties caravan, bringing more than 2,000 Indians from reservations and urban areas across the country to Washington, D.C., on the eve of the 1972 presidential election. The idea was to present the incumbent chief executive, Richard M. Nixon, with a 20-point program redefining the nature of U.S. Indian relations. Publicity attending the critical timing and location of the action, as well as the large number of Indians involved, were calculated to force serious responses by the administration to each point. 31. In the event, Interior Department officials who had earlier pledged logistical support to caravan participants once they arrived in the capital reneged on their promises, apparently in the belief that this would cause the group to meekly disperse. Instead, angry Indians promptly took over the BIA headquarters building on November 2, evicted its staff, and held it for several days. Russell Means, in fine form, captured the front page of the nation's newspapers and the 6 o'clock news by conducting a press conference in front of the building while adorned with a makeshift war club and a shield fashioned from a portrait of Nixon himself. 32. Desperate to end what had become a major media embarrassment, the administration publicly agreed to formally reply to the 20-point program within a month, and to immediately provide $66,600 in transportation money, in exchange for a peaceful end to the occupation. 33 AIM honored its part of the bargain, leaving the BIA building on November 9. But, explaining that Indians have every right to know the details of what's being done to us and to our property, it took with it a vast number of confidential files concerning BIA leasing practices, operation of the Indian Health Service, and so forth. The originals were returned as rapidly as they could be Xeroxed, a process that required nearly 2 years to complete. 34. Technically speaking, the government also honored its end of the deal, providing official and exclusively negative responses to the 20 points within the specified time frame. 35 At the same time, however, it initiated a campaign utilizing federally subsidized Indian leaders in an effort to discredit AIM members as irresponsible, renegades, terrorists, and self-styled revolutionaries. 36 There is also strong indication that it was at this point that the Federal Bureau of Investigation was instructed to launch a secret program of its own, one in which AIM's capacity to engage in further political activities of the kind and effectiveness displayed in Washington was to be, in the vernacular of FBI counterintelligence specialists, neutralized. 37 Even as this was going on, AIM's focus had shifted back to the Pine Ridge area. At issue was the January 23, 1973, murder of a young Oglala named Wesley Bad Heart Bull by a white man, Darrell Schmitz, in the off-reservation village of Buffalo Gap, South Dakota. As in the Yellow Thunder case, local authorities had made no move to press appropriate charges against the killer. 38 At the request of the victim's mother, Sarah, Russell Means called for a demonstration at the Custer County Courthouse, the jurisdiction in which the crime occurred. Terming western South Dakota the Mississippi of the North, 39 Dennis Banks simultaneously announced a longer-term effort to force abandonment of the anti-Indian attitudes which result in Indian killing being treated as a sort of local sport. 40 When the Custer demonstration occurred on February 6, it followed a very different course than that of the protest in Gordon a year earlier. An anonymous call had been placed to the main regional newspaper, the Rapid City Journal, on the evening of February 5. The caller, saying he was with AIM, asked that a notice canceling the accession because of bad weather be prominently displayed in the paper the following morning. Consequently, relatively few Indians turned out for the protest. 41 Those who did were met by an amalgamated force of police, sheriff's deputies, state troopers, and FBI personnel when they arrived in Custer. 42 For a while, there was a tense standoff. Then, a sheriff's deputy manhandled Sarah Bad Heart Bull when she attempted to enter the courthouse. In the melee that followed, the courthouse was set ablaze reportedly by a police tear gas canister, and the local Chamber of Commerce building burned to the ground. Banks, Means, and other AIM members, along with Mrs. Bad Heart Bull, were arrested and charged with riot. Banks was eventually convicted, sentenced to 3 years imprisonment, and became a fugitive. Sarah Bad Heart Bull herself served 5 months of a 1 to 5 year sentence. Her son's killer never served a day in jail. 43 Wounded Knee. Meanwhile, on Pine Ridge, tensions were running extraordinarily high. The point of contention was an escalating conflict between the tribal administration headed by Richard Dickey Wilson, installed on the reservation with federal support in 1972, and a large body of reservation traditionals who objected to Wilson's nepotism and other abuses of his position. 44 Initially, Wilson's opponents had sought redress of their grievances through the BIA. The BIA responded by providing a $62,000 grant to Wilson for purposes of establishing a tribal ranger group, a paramilitary entity reporting exclusively to Wilson, which soon began calling itself Guardians of the Oglala Nation, with which to physically intimidate the opposition. 45 The reason underlying this federal largesse appears to have been the government's desire that Wilson sign an instrument transferring title over a portion of the reservation known as the Sheep Mountain Gunnery Range, secretly known to be rich in uranium and molybdenum, to the U.S. Forest Service. 46 In any event, forming what was called the Oglala Sioux Civil Rights Organization, the traditionals next attempted to obtain relief through the Justice Department and FBI. When this too failed to bring results, they set out to impeach Wilson, obtaining more signatures of eligible voters on their petitions than had cast ballots for him in the first place. The BIA countered by naming Wilson himself to chair the impeachment proceedings, and the Justice Department dispatched a 65-member Special Operations Group of U.S. Marshals to ensure that order was maintained during the travesty. Then, on the eve of the hearing, Wilson ordered the arrest and jailing of several members of the tribal council he felt might vote for his removal. Predictably, when the impeachment tally was taken on February 23, 1973, the tribal president was retained in office. Immediately thereafter, he announced a reservation-wide ban on political meetings. 47. Defying the ban, the traditionals convened a round-the-clock emergency meeting at the Calico Hall, near the village of Oglala, in an effort to determine their next move. On February 26, a messenger was sent to the newly established AIM headquarters in nearby Rapid City to request that Russell Means meet with the Oglala elders. As one of them, Ellen Moves Camp, later put it, "We decided we needed the American Indian movement in here. All of our older people from the reservation helped make that decision. This is what we needed, a little more push. Most of the reservation believes in AIM, and we're proud to have them with us." 48. Means came on the morning of the 27th, then drove on to the village of Pine Ridge, seat of the reservation government, to try and negotiate some sort of resolution with Wilson. For his trouble, he was physically assaulted by goons in the parking lot of the Tribal Administration Building. 49. By then, Dennis Banks and a number of other AIM members had arrived at the Calico Hall. During subsequent meetings, it was decided by the elders that what was necessary was to draw public attention to the situation on the reservation. For this purpose, a 200-person AIM contingent was sent to the symbolic site of Wounded Knee to prepare for an early morning press conference. A much smaller group was sent back to Rapid City to notify the media, and to guide reporters to Wounded Knee at the appropriate time. 50. The intended press conference never occurred because by dawn Wilson's goons had established roadblocks on all 4 routes leading into the tiny hamlet. During the morning, these positions were reinforced by uniformed BIA police, then by elements of the Marshal's SOG unit, and then by FBI observers. As this was going on, the AIM members in Wounded Knee began the process of arming themselves from the stores of the local Gildersleeve trading post and building defensive positions. 51. By afternoon, General Alexander Haig, military liaison to the Nixon White House, had dispatched 2 special warfare experts, Colonel Volney Warner of the 82nd Airborne Division, and Colonel Jack Potter of the 6th Army to the scene. 52. Documents later subpoenaed from the Pentagon revealed Colonel Potter directed the employment of 17 APCs, 130,000 rounds of M16 ammunition, 41,000 rounds of M40 high explosive, as well as helicopters, Phantom jets, and personnel. Military officers, supply sergeants, maintenance technicians, chemical officers, and medical teams. 300 miles to the south, at Fort Carson, Colorado, the Army had billeted a fully uniformed assault unit on 24-hour alert. 53. Over the next 71 days, the AIM perimeter at Wounded Knee was placed under siege. The ground cover was burned away for roughly a quarter mile around the AIM position as part of the federal attempt to staunch the flow of supplies, food, medicine, and ammunition backpacked into the Wounded Knee defenders at night. At one point such material had to be airdropped by a group of supporting pilots. 54. More than 500,000 rounds of military ammunition were fired into AIM's jerry-rigged bunkers by federal forces, killing 2 Indians, an Apache named Frank Clearwater and Buddy Lamont, and Oglala, and wounding several others. 55. As many as 13 more people may have been killed by roving goon patrols, their bodies secretly buried in remote locations around the reservation, while they were trying to carry supplies through federal lines. 56. At first, the authorities sought to justify what was happening by claiming that AIM had occupied Wounded Knee, and that the movement had taken several hostages in the process. 57. When the latter allegation was proven to be false, a press ban was imposed, and official spokespersons argued that the use of massive force was needed to quell insurrection. Much was made of 2 federal casualties who were supposed to have been seriously injured by AIM gunfire. 58. In the end, it was Dickie Wilson who perhaps expressed matters most candidly when he informed reporters that the purpose of the entire exercise was to see to it that AIM dies at Wounded Knee. 59. Despite Wilson's sentiments and those of FBI senior counterintelligence specialist Richard G. Held, expressed in a secret report prepared at the request of his superiors early in the siege, 60, an end to the standoff was finally negotiated for May 7, 1973. AIM's major condition, entered in behalf of the Pine Ridge Traditionals and agreed to by government representatives, was that a federal commission would meet with the chiefs to review U.S. compliance with the terms of the 1868 Fort Laramie Treaty with the Lakota, Cheyenne, and Arapaho nations. 61 The idea was to generate policy recommendations as to how the United States might bring itself into line with its treaty obligations. A White House delegation did in fact meet with the elders at the home of Chief Frank Fools Crow, near the reservation town of Manderson, on May 17. The delegates' mission, however, was to stonewall all efforts at meaningful discussion. 62 They promised a follow-up meeting on May 30, but never returned. 63 On other fronts, the authorities were demonstrating no comparable lack of vigor. Before the first meeting at Fools Crow's, the FBI had made 562 arrests of those who had been involved in defending Wounded Knee. 64 Russell Means was in jail awaiting release on $150,000 bond. Oscro leader Pedro Bissonette was held against $152,000, AIM leaders Stan Holder and Leonard Crow Dog against $32,000 and $35,000 respectively. Scores of others were being held pending the posting of lesser sums. 65 By the fall of 1973, agents had amassed some 316,000 separate investigative file classifications on those who had been inside Wounded Knee. 66 This allowed federal prosecutors to obtain 185 indictments over the next several months. 67 Although in 1974 AIM and the Traditionals used the 1868 treaty as a basis upon which to challenge in federal court the U.S. government's jurisdiction over Pine Ridge, the trials of the Wounded Knee leadership went forward. 68 Even after the FBI's and prosecution's willingness to subvert the judicial process became so blatantly obvious that U.S. District Judge Fred Nickel was compelled to dismiss all charges against Banks and Means, cases were still pressed against Crow Dog, Holder, Carter, Camp, Madonna Gilbert, Lorelei Decorah, and Phyllis Young. 69 The whole charade resulted in a meager 15 convictions, all of them on such paltry offenses as trespass and interference with postal inspectors in performance of their lawful duties. 70 Still, in the interim, the virtual entirety of AIM's leadership was tied up in a seemingly endless series of arrests, incarcerations, hearings, and trials. Similarly, the great bulk of the movement's fundraising and organizing capacity was diverted into posting bonds and mounting legal defenses for those indicted. 71 On balance, the record suggests a distinct probability that the post-Wounded Knee prosecutions were never seriously intended to result in convictions at all. Instead, they were designed mainly to serve the time-honored and utterly illegal expedient of disrupting, misdirecting, destabilizing, or otherwise neutralizing a politically objectionable group. 72 There is official concurrence with this view, as Army counterinsurgency specialist Volney Warner framed matters at the time. AIM's best leaders and most militant members are under indictment, in jail, or warrants are out for their arrest. The government can win, even if nobody goes to. 73 The Reign of Terror. While AIM's notables were being forced to slog their way through the courts, a very different form of repression was being visited upon the movement's rank-and-file membership and the grassroots traditionals of Pine Ridge. During the 3-year period beginning with the Siege of Wounded Knee, at least 69 members and supporters of AIM died violently on the reservation. 74 During the same period, nearly 350 others suffered serious physical assault. Overall, the situation on Pine Ridge was such that, by 1976, the U.S. Commission on Civil Rights was led to describe it as a reign of terror. 75 Using only documented political deaths, the yearly murder rate on the Pine Ridge Reservation between March 1, 1973 and March 1, 1976 was 170 per 100,000. By comparison, Detroit, the reputed murder capital of the United States, had a rate of 20.2 per 100,000 in 1974. The U.S. average was 9.7 per 100,000. In a nation of 200 million persons, a murder rate comparable with that on Pine Ridge between 1973 and 1976 would have left 340,000 persons dead for political reasons alone in 1 year, 1.32 million in 3. The political murder rate at Pine Ridge was almost equivalent to that in Chile during the 3 years after a military coup supported by the United States killed President Salvador Allende. 76. Despite the fact that eyewitnesses identified the assailants in 21 of these homicides, the FBI, which maintains preeminent jurisdiction over major crimes on all American Indian reservations, was responsible for ensuring that not one of the killers was ever convicted of murder. 77. In many cases, no active investigation of the murder of an AIM member or supporter was undertaken by the Bureau. 78. In others, those associated with the victims were falsely arrested as perpetrators. 79. When queried by reporters in 1975 as to the reason for his office's abysmal record of investigating murders on Pine Ridge, Georgia Clark, agent in charge of the FBI's Rapid City Resident Agency, which has operational authority over the reservation, replied that he was too short of manpower to assign agents to such tasks. 80. Clark omitted to mention that, at the time, he had at his disposal the highest sustained ratio of agents to citizens enjoyed by any FBI office in the history of the Bureau. 81. He also neglected the fact that the same agents who were too busy to look into the murders of AIM people appear to have had unlimited time to undertake the investigative activities covered in the preceding section. Clark's pat explanation was and remains implausible. A far more likely scenario begins to take shape when it is considered that in each instance where there were eyewitness identifications of the individuals who had killed an AIM member or supporter, those identified were known goons. 82. The FBI's conspicuous inability to apprehend murderers on Pine Ridge may thus be located, not in the incompetence of its personnel, but in the nature of its relationship to the killers. In effect, the goons seem to have functioned under a more or less blanket immunity from prosecution provided by the FBI so long as they focused their lethal attentions upon targets selected by the Bureau. Put another way, the appearance is that the FBI used the goons as a surrogate force against AIM on Pine Ridge in precisely the same manner that Latin American death squads have been utilized by the CIA to destroy the opposition in countries like Guatemala, El Salvador, and Chile. 83. The roots of the FBI/goon connection can be traced back at least as far as April 23, 1973, when U.S. Marshals Service Director Wayne Colburn, driving from Pine Ridge Village to Wounded Knee, was stopped at what the Wilsonites referred to as the Residence Roadblock. One of the goons manning the position, vocally disgruntled with what he called the soft line taken by the Justice Department in dealing with AIM, leveled a shotgun at the head of Colburn's passenger, Solicitor General Kent Frizzell. Colburn was forced to draw his own weapon before the man would desist. Angered, Colburn drove back to Pine Ridge and dispatched a group of his men to arrest everyone at the roadblock. When the marshals arrived at the Pennington County Jail in Rapid City with those arrested, however, they found an FBI man waiting with instructions to release the goons immediately. 84. By this point, Dickie Wilson himself had re-established the roadblock, using a fresh crew of goons. Thoroughly enraged at this defiance, Colburn assembled another group of marshals and prepared to make arrests. Things had progressed to the point of a high noon-style showdown when a helicopter appeared, quickly landing on the blacktop road near the would-be combatants. In it was FBI counterintelligence ace Richard G. Held, who informed Colburn that he had received instructions from the highest level to ensure that no arrests would be made and that the roadblock stays where it is. 85. Humiliated, and increasingly concerned for the safety of his own personnel in a situation where the FBI was openly siding with a group hostile to them, Colburn ordered his men to disarm goons whenever possible. 86. Strikingly, as the marshals impounded the sort of weaponry the Wilsonites had up until then been using, conventional deer rifles, World War II surplus M1s, shotguns, and other firearms normally found in a rural locality, the same goons Colburn's men had disarmed began to reappear, well stocked with ammunition and sporting fully automatic military-issue M16s. 87. The Brewer Revelations. It has always been the supposition of those aligned with AIM that the FBI provided such hardware to Wilson's goons. The Bureau and its apologists, meanwhile, pointing to the absence of concrete evidence with which to confirm the allegation, have consistently denied any such connection, charging those referring to its probability with journalistic or scholarly irresponsibility. 88 Not until the early 1990s, with publication of extracts from an interview with former Goon commander Dwayne Brewer, was AIM's premise borne out. 89. Not only does the one-time death squad leader make it clear that the FBI provided him and his men with weaponry, but with ample supplies of armor-piercing ammunition, hand grenades, det cord and other explosives, communications gear, and additional paraphernalia. 90 Agents would drop by his house, Brewer maintains, to provide key bits of field intelligence which allowed the goons to function in a more efficient manner than might otherwise have been the case. And, perhaps most important, agents conveyed the plain message that members of the death squad would enjoy virtual immunity from federal prosecution for anything they did, so long as it fell within the realm of repressing dissidents on the reservation. 91. Among other murders which Brewer clarifies in his interview is that of Jeanette Bissonnette, a young woman shot to death in her car as she sat at a stop sign in Pine Ridge Village at about 1 o'clock in the morning of March 27, 1975. The FBI has all along insisted, for reasons which remain mysterious, that it is probable Bissonnette was assassinated by AIM members. 92 Brewer, on the other hand, explains on the basis of first-hand knowledge that the killing was a mistake on the part of his execution team, which mistook Bissonnette's vehicle for that of area resistance leader Ellen Moves Camp. 93. It is important to note, before moving ahead, that at the time he functioned as a goon leader, Dwayne Brewer also served as second in command of the BIA police on Pine Ridge. His boss as a policeman, Delmar Eastman, primary liaison between the police and the FBI, was simultaneously in charge of all goon operations on the reservation. 94 In total, it is reliably estimated that somewhere between one-third and one-half of all BIA police personnel on Pine Ridge between 1972 and 1976 moonlighted as goons. Those who didn't become directly involved, actively covered for their colleagues who did, or at least kept their mouths shut about the situation. 95. Obviously, whatever meager hope for relief AIM and the Oglala traditionals might have extended to the workings of local law enforcement quickly disappeared under such circumstances. 96 In effect, the police were the killers, their crimes not only condoned, but for all practical intents and purposes commanded and controlled by the FBI. Other federal agencies did no more than issue largely uncirculated reports confirming that the bloodbath was in fact occurring. 97 Due process on Pine Ridge during the crucial period was effectively non-existent. The Oglala Firelight. By the spring of 1975, with more than 40 of their number already dead, it had become apparent to the Pine Ridge resistors that they had been handed a choice of either acquiescing to the federal agenda or being annihilated. All other alternatives, including a 1974 electoral effort to replace Dickie Wilson with AIM leader Russell Means, had been met by fraud, force, and unremitting violence. 98 Those who wished to continue the struggle and survive were therefore compelled to adopt a posture of armed self-defense. Given that many of the traditionals were elderly, and thus could not reasonably hope to accomplish the latter on their own, AIM was asked to provide physical security for them. Defensive encampments were quickly established at several key locations around the reservation. 99. For its part, the FBI seems to have become increasingly frustrated at the capacity of the dissidents to absorb punishment, and the consequent failure of the Bureau's counterinsurgency campaign to force submission. Internal FBI documents suggest that the coordinators of the Pine Ridge operation had come to greatly desire some sensational event which might serve to justify in the public mind a sudden introduction to the reservation of the kind of overwhelming force which might break the back of the resistance once and for all. 100. Apparently selected for this purpose was a security camp set up by the Northwest AIM group at the request of traditional elders Harry and Cecilia Jumping Bull on their property, along Highway 18, a few miles south of the village of Oglala. During the early evening of June 25, 1975, two agents, Ron Williams and Jack Kohler, escorted by a BIA policeman named Bob Ekafe, entered the Jumping Bull compound. They claimed to be attempting to serve an arrest warrant on a 17-year-old Lakota and AIM supporter named Jimmy Eagle on spurious charges of kidnapping and aggravated assault. 101. Told by residents that Eagle was not there and had not been seen for weeks, the agents and their escort left. On Highway 18, however, the agents accosted three young AIM members, Mike Anderson, Norman Charles, and Wilfred Wish Draper, who were walking back to camp after taking showers in Oglala, drove them to the police headquarters in Pine Ridge Village, and interrogated them for more than 2 hours. As the young men reported when they finally returned to the Jumping Bulls, no questions had been asked about Jimmy Eagle. Instead, the agents had wanted to know how many men of fighting age were in the camp, what sort of weapons they possessed, and so on. Thus alerted that something bad was about to happen, the Northwest AIM contingent put out an urgent call for support from the local AIM community. 102. At about 11 a.m. the following morning, June 26, Williams and Kohler returned to the Jumping Bull property. Driving past the compound of residences, they moved down into a shallow valley, stopped and exited their cars in an open area, and began to fire in the general direction of the AIM encampment in a tree line along White Clay Creek. 103. Shortly thereafter, they began to take a steadily growing return fire, not only from the tree line, but from the houses above. At about this point, Agent J. Gary Adams and BIA police officer / goon Glenn Two Birds attempted to come to Williams and Kohler's aid. Unexpectedly taking fire from the direction of the houses, they retreated to the ditch beside Highway 18.104. Some 150 SWAT-trained BIA police and FBI personnel were prepositioned in the immediate locale when the firefight began. This, especially when taken in combination with the fact that more than 200 additional FBI SWAT personnel were on alert awaiting word to proceed post-haste to Pine Ridge from Minneapolis, Milwaukee, and Quantico, Virginia, raises the probability that Williams and Kohler were actually assigned to provoke an exchange of gunfire with the AIM members on the Jumping Bull land. 105. The plan seems to have been that they would then be immediately supported by the introduction of overwhelming force, the Northwest AIM group destroyed, and the FBI afforded the pretext necessary to launch an outright invasion of Pine Ridge. 106. A number of local AIM members had rallied to the call to come to the Jumping Bulls. Hence, instead of encountering the 8 AIM shooters they anticipated, there were about 30, and the two agents were cut off from their erstwhile supporters. 107. While the BIA police, reinforced by goons, put up roadblocks to seal off the area, and the FBI agents on hand were deployed as snipers, no one made a serious effort to get to Williams and Kohler until 5:50 p.m. By that point, they'd been dead for some time, along with a young Coeur d'Alene AIM member, Joe Stuntz Kills Wright, killed by FBI sniper Gerard Waring as he attempted to depart the compound. 108. Aside from Kills Wright, all AIM participants had escaped across country. By nightfall, hundreds of agents equipped with everything from APCs to Vietnam-style Huey helicopters had begun arriving on the reservation. 109. The next morning, Tom Call, an FBI public information specialist imported for the purpose, convened a press conference in Oglala. The media was barred from the firefight site itself, in which he reported that the dead agents had been lured into an ambush by AIM, attacked with automatic weapons from a sophisticated bunker complex, dragged wounded from their cars, stripped of their clothing, and then executed in cold blood, while one of them pleaded with his killer to spare him because he had a wife and children. Each agent, Call asserted, had been riddled with 15 to 20 bullets. 110. Every word of this was false, as Caldwell knew the FBI had been in possession of both the agents' bodies and the ground on which they were killed for nearly 18 hours before he made his statements, and the report was retracted in full by FBI Director Clarence Kelly at a press conference conducted in Los Angeles a week later. 111. By then, however, a barrage of sensational media coverage had sensitized the public to the need for a virtually unrestricted application of force against the Mad Dogs of AIM. Correspondingly, the Bureau was free to run air assaults and massive sweeping operations on Pine Ridge, complete with the wholesale use of no-knock searches and John Doe warrants for the next 3 months. 112. By the end of that period, its Miss Zion had largely been accomplished. 113. In the interim, On July 27, 1975, it was finally felt, given the preoccupation of all concerned parties with the FBI's literal invasion of Pine Ridge, that the time was right for Dickie Wilson to sign a memorandum transferring the gunnery range to the federal government. On January 2, 1976, a more formal instrument was signed and, in the spring, Congress passed a public law assuming U.S. title over this portion of Oglala Territory. 114. The case of Leonard Peltier. It is unlikely that the FBI intended that its two agents be killed during the Oglala firefight. Once Kohler and Williams were dead, however, the Bureau capitalized upon their fate, not only as the medium through which to pursue its anti-AIM campaign with full ferocity, but as a mechanism with which to block an incipient congressional probe into what the FBI had been doing on Pine Ridge. This last took the form of a sympathy play. Bureau officials pleaded that the natural emotional volatility engendered among their agents by the deaths made it inopportune to proceed with the investigation at the present time. Congress responded, on July 3, 1975, by postponing the scheduling of preliminary interviews, a delay which has become permanent. 115. Still, with two dead agents, it was crucial for the Bureau's image that someone be brought directly to account. To fill this bill, 4 names were selected from the list of 30 shooters field investigators had concluded were participants in the exchange. Targeted were a pair of Anishinaabe/Lakota cousins, Leonard Peltier and Bob Robideau, and Darrell Dino Butler, a Toonie, the heads of Northwest AIM. Also included was Jimmy Eagle, whose name seems to have appeared of expediency, since the Bureau claimed Williams and Kohler were looking for him in the first place. 116. Butler and Robideau, captured early on, were to be tried first, as co-defendants, separate from Peltier. 117. The latter, having managed to avoid arrest in a trap set for him in Oregon, had found sanctuary in the remote encampment of Cree leader Robert Smallboy in northern Alberta. 118. By the time he could be apprehended, extradited via a thoroughly fraudulent proceeding involving the presentation of an eyewitness affidavit from a psychotic Lakota woman named Myrtle Pourbaix to a Canadian court, and docketed in the U.S., the proceedings against Peltier's cohorts were ready to begin. 119. He was thus scheduled to be tried later and alone. At the Butler/Robideau trial, conducted in Cedar Rapids, Iowa, during the summer of 1976, the government's plan to turn the defendants and AIM itself into examples of the price of resistance began to unravel. Despite the calculated ostentation with which the FBI prepared to secure the judge and jurors from AIM's potential for violence, and another media blitz designed to convince the public that Butler and Robideau were part of a vast terrorist conspiracy, the carefully selected all-white Midwestern panel of jurors was unconvinced. 120. After William Muldrow of the U.S. Commission on Civil Rights was called by the defense to testify regarding the FBI-fostered reign of terror on Pine Ridge, and Director Kelly himself was forced to admit under oath that he knew of nothing which might support many of the Bureau's harsher characterizations of AIM, the jury voted to acquit on July 16, 1976. 121. The not guilty verdict was based in the panel members' assessment that although both defendants acknowledged firing at the agents, Robideau that he had in fact hit them both. 122. They had acted in self-defense. Under the conditions described by credible witnesses, jury foreman Robert Bolin later recounted, "We felt that any reasonable person would have reacted the same way when the agents came in there shooting." Besides, Bolin continued, their personal observations of the behavior of governmental representatives during the trial had convinced most jury members that it was the government, not the defendants or their movement, which was dangerous. 123. Although the Cedar Rapids jury had essentially determined that Kohler and Williams had not been murdered, the FBI and federal prosecutors opted to proceed against Peltier. In a pre-trial conference they analyzed what had gone wrong in the Butler/Robideau case and, in a report dated July 20, 1976, concluded that among the problems encountered was the fact that the defendants had been allowed to present a self-defense argument, their lawyers allowed to call and question witnesses and subpoena government documents. 124. They then removed the Peltier trial from the docket of the judge at Cedar Rapids, Edward McManus, and reassigned it to another, Paul Benson, whom they felt would be more amenable to their viewpoint. 125. When Peltier was brought to trial in Fargo, North Dakota, on March 21, 1977, Benson ruled virtually everything presented by the defense at Cedar Rapids, including the Butler/Robideau trial transcript itself, inadmissible. 126. Prosecutors then presented a case against Peltier which was precisely the opposite of what they and their FBI witnesses professed to believe was true in the earlier trial. 127. A chain of circumstantial evidence was constructed, often through resort to fabricated physical evidence. 128. Perjury. 129. And the use of demonstrably suborned testimony. 130. To create a plausible impression among jurors, again all white Midwesterners, that the defendant was guilty. Following a highly emotional closing presentation by Assistant Prosecutor Lynn Crooks, in which he waved color photos of the agents' bloody bodies under the jury's collective nose and graphically described the cold-bloodedness with which Leonard Peltier executed these two wounded and helpless human beings, they voted on April 18, after only 6 hours of deliberation, to convict on both counts of first-degree murder. 131. Benson then sentenced Peltier to serve 2 consecutive life terms in prison, and he was transported straight away to the federal super-maximum facility at Marion, Illinois. 132. Almost immediately, an appeal was filed on the basis of FBI misconduct and multiple judicial errors on Benson's part. The matter was considered by a 3-member panel of the Eighth Circuit Court composed of Judges William Webster, Donald Ross, and Gerald Heaney during the spring of 1978. Judge Webster wrote the opinion on behalf of his colleagues, finding that although the record revealed numerous reversible errors on the part of the trial judge, and many unfortunate misjudgments by the FBI, the conviction would be allowed to stand. 133. By the time the document was released, Webster was no longer there to answer for it. He had moved on to a new position as director of the FBI. On February 12, 1979, the U.S. Supreme Court declined, without stating a reason, to review the lower court's decision. 134. Undeterred, Peltier's attorneys had already filed a suit under the Freedom of Information Act to force disclosure of FBI documents withheld from the defense at trial. When the paperwork, more than 12,000 pages of investigative material, was finally produced in 1981, they began the tedious process of indexing and reviewing it. 135. Finding that the Bureau had suppressed ballistics reports which directly contradicted what had been presented at trial, they filed a second appeal in 1982. 136. This led to an evidentiary hearing and oral arguments in 1984, during which the FBI's chief ballistics expert, Evan Hodge, was caught in the act of perjuring himself. 137. And Lynn Crooks was forced to admit that the government really has no idea who shot those agents. 138. Crooks then attempted to argue that it didn't matter anyway, because Peltier had been convicted of aiding and abetting in the murders rather than of the murders themselves. 139. This time, the Circuit Court panel, now composed of Judges Heaney and Ross, as well as John Gibson, took nearly a year to deliberate. On October 11, 1986, they finally delivered an opinion holding that the content of Crooks' own closing argument to the jury, among many other factors, precluded the notion that Peltier had been tried for aiding and abetting. They also concluded that the circumstantial ballistics case presented by the prosecution at trial was hopelessly undermined by evidence even then available to the FBI. 140. Still, they refused to reverse Peltier's conviction because, "We recognize that there is evidence in this record of improper conduct on the part of some FBI agents, but we are reluctant to impute even further improprieties to them by remanding the matter to trial." 141. On October 5, 1987, the Supreme Court once again refused to review the lower court's decision. 142. Most recently, a third appeal, argued on the basis of habeas corpus if Peltier was never tried for aiding and abetting, and if the original case against him no longer really exists, then why is he in prison, was filed. In November 1992, the Eighth Circuit, without ever really answering such questions, allowed his conviction to stand. 143. 8 years later, although he'd repeatedly insinuated that a pardon was in the offing, President Bill Clinton knuckled under to extreme pressure from the FBI by declining to commute Peltier's sentence. 144. Aftermath. The government repression of AIM during the mid-70s had the intended effect of blunting the movement's cutting edge. After 1977, things occurred in fits and starts rather than a sustained drive. AIM's core membership, those who were not dead or in prison, scattered to the winds, many, like Wounded Knee security head Stan Holder, seeking other avenues along which to channel their activism. 145 others, exhausted and intimidated by the massive violence directed against them, retired altogether from active politics. 146 among the remainder, personal, political, and intertribal antagonisms, often exacerbated by the rumors spread by federal provocateurs, instilled a deep and lasting factional fragmentation. 147. In 1978, Dennis Banks, occupying the unique status in California of having been officially granted sanctuary by one state of the Union against the extradition demands of another, sought to bring things back together by organizing what he called the Longest Walk. 148, to some extent replicating on foot the Trail of Broken Treaties caravan of 1972, the walk succeeded in its immediate objective. The walkers made it from Alcatraz Island, selected as a point of departure because of the importance of the 1969-71 occupation in forging AIM to Washington, D.C., presenting a powerful manifesto to the Carter administration in July. 149, but there was no follow-up, and the momentum was quickly lost. Much hope was placed in the formation of the Leonard Peltier Defense Committee the same year, and, for a time it seemed as though it might serve as a kind of spark plug re-energizing the movement as a whole. 150, however, with the February 12, 1979, murder of AIM chair John Trudell's entire family on the Duck Valley Reservation in Nevada, apparently as a deterrent to the effectiveness of Trudell's fiery oratory, things took an opposite tack. 151, the result was the abolition of all national officer positions in AIM. These titles do nothing but provide a ready-made list of priority targets for the feds. As Trudell put it at the time. 152, the gesture consummated a trend against centralization which began with the dissolution of AIM's national office at the time Banks had gone underground in 1975, a fugitive from sentencing after his conviction on charges stemming from the Custer Courthouse confrontation. 153. In 1979 and 80, large-scale survival gatherings were held outside Rapid City in an attempt to bring together Indian and non-Indian activists in collaborative opposition to uranium mining and other corporate development of the Black Hills. 154, an ensuing organization, the Black Hills Alliance, achieved momentary national prominence, but petered out after the demise of domestic uranium production in the early 80s dissolved several of the more pressing issues it confronted. 155. Meanwhile, Russell Means, fresh out of prison, launched a related effort in 1981, occupying an 880-acre site in the Black Hills to establish a sustainable, alternative, demonstration community and to initiate the physical reoccupation of Pahasepa by the Lakota people and our allies. The occupation of what was dubbed Win Canyon Zitos Paye in memory of Raymond Yellow Thunder lasted until 1985. 156, by that point, its organizers had obtained what on its face was landmark judicial opinion from a federal district judge. Not only did the Yellow Thunder occupiers have every right to do what they were doing, the judge decreed, but the Lakota and other Indians as well are entitled to view entire geographic areas such as the Black Hills, rather than merely specific sites within them, to be of sacred significance. 157, the emergent victory was gutted, however, by the Supreme Court's controversial Geo Road decision in 1988. 158. Elsewhere, an AIM security camp was established on Navajo land near Big Mountain, Arizona, during the mid-80s, to support the traditional Dine elders of that area in their resistance to forced relocation. 159, it is maintained through the present, and, somewhat comparably, AIM contingents began to become involved in the early 90s in providing physical security to Western Shoshone resistors to forced removal from their land in Nevada. 160, similar scenarios have been played out in places as diverse as northern Minnesota and Wisconsin, Oregon, California, Oklahoma, Illinois, Florida, Georgia, Nebraska, Alaska, and upstate New York. The issues confronted have been as wide-ranging as the localities in which they've been confronted. Another potential bright spot which was ultimately eclipsed was the International Indian Treaty Council. Formed at the request of the Lakota elders in 1974 to carry the message of indigenous people into the community of nations and to serve more generally as AIM's international diplomatic arm, it had by August 1977 gotten off to a brilliant start, playing a key role in bringing representatives of 98 native peoples throughout the Americas together in an unprecedented convocation before the United Nations Commission on Human Rights. This led directly to the establishment of a formal working group on indigenous populations mandated to draft a universal declaration of the rights of indigenous peoples for incorporation into international law under the UN Economic and Social Council. 161. Despite this remarkable early success, with the 1981 departure of its original director, Cherokee activist Jimmy Durham, IITC began to unravel. 162. By 1986, his successors were widely perceived as using the organization's reputation as a vehicle for personal profit and prestige, aligning themselves for a fee with various state governments against indigenous interests. Allegations that they were also using their de facto diplomatic status as a medium in which to engage in drug trafficking also abounded. Whether or not such suspicions were well-founded, IITC today has reduced itself to the stature of a small sectarian corporation, completely divorced from AIM and the traditional milieu which legitimated it, subsisting mainly on donations from the very entities it was created to oppose. 163. The early 90s, with the imminence of the Colombian quincentennial celebration, presented opportunities for the revitalization of AIM. Indeed, the period witnessed a more or less spontaneous regeneration of autonomous AIM chapters in at least 16 localities around the country. 164. In Colorado, an escalating series of confrontations with Columbus Day celebrants organized by the local AIM chapter beginning in 1989 led to the galvanizing of a coalition of some 50 progressive organizations, Indian and non-Indian alike, by 1992. 165. In Denver, the city where Columbus Day was first proclaimed an official holiday, quincentennial activities were stopped in their tracks. A similar process was evident in San Francisco and, to a lesser extent, other locales. Perhaps ironically, the most vicious reaction to the prospect of a resurgent movement came, not from the government per se, but from a small group in Minneapolis professing itself to be AIM's legitimate leadership. How exactly it imagined it had attained this exalted position was a bit murky, there not having been an AIM General Membership Conference to sanction the exercise of such authority since 1975. Nonetheless, in July 1993, the clique constituted itself under the laws of the state of Minnesota as National AIM, Inc., announced formation of a national board and central committee, and provided the address to what it described as the AIM National Office. 166. Among the very first acts of this interesting amalgam, which proudly reported it was receiving $4 million per year in federal funding, and more than $3 million annually from corporations like Honeywell, was the issuance of letters expelling most of the rest of the movement from itself. 167. A legacy. It may be, as John Trudell has said, that AIM died years ago. It's just that some people don't know it yet. 168. Certainly, as a viable organization, the evidence exhibits every indication of bearing him out. And yet there is another level to this reality, one which has more to do with the spirit of resistance than with its tangible form. Whatever else may be said about what AIM was, it must be acknowledged that, as Russell Means contends, before AIM, Indians were dispirited, defeated, and culturally dissolving. People were ashamed to be Indian. You didn't see the young people wearing braids or chokers or ribboned shirts in those days. Hell, I didn't wear em. People didn't sun dance, they didn't sweat, they were losing their languages. Then there was that spark at Alcatraz, and we took off. Man, we took a ride across this country. We put Indians and Indian rights smack dab in the middle of the public consciousness for the first time since the so-called Indian Wars. And, of course, we paid a heavy price for that. Some of us are still paying it. But now you see braids on our young people. There are dozens of sun dances every summer. You hear our languages spoken again in places they had almost died out. Most important, you find young Indians all over the place who understand that they don't have to accept whatever sort of bullshit the dominant society wants to hand them, that they have the right to fight, to struggle for their rights, that in fact they have an obligation to stand up on their hind legs and fight for their future generations, the way our ancestors did. Now, I don't know about you, but I call that pride in being Indian. And I think that's a very positive change. And I know AIM had a lot to do with bringing that change about. We laid the groundwork for the next stage in regaining our sovereignty and self-determination as nations, and I'm proud to have been a part of that. 169. To the degree this is true, and much of it seems very accurate, AIM may be said to have succeeded in fulfilling its original agenda. 170 The impulse of Alcatraz was carried forward into dimensions its participants could not yet envision. And that legacy is even now being refashioned and extended by a new generation, as it will be by the next, and the next. The continuity of native North America's traditional resistance to domination was reasserted by AIM in no uncertain terms. There are other aspects of the AIM legacy, to be sure. Perhaps the most crucial should be placed under the heading of lessons learned. These go to defining the nature of the society we now inhabit, the lengths to which its government will go to maintain the kinds of domination AIM fought to cast off, and the techniques it uses in doing so. The experience of the American Indian movement, especially in the mid-1970s, provides what amounts to a textbook exposition of these things. It teaches what to expect, and, if properly understood, how to overcome many of these methodologies of repression. The lessons are applicable, not simply to American Indians, but to anyone whose lot in life is to be oppressed within the American conception of business as usual. 171. Ultimately, the gift bestowed by AIM is in part an apprehension of the fact that the Third World is not something out there. It is everywhere, behind the facade of liberal democracy masking the substance of the United States as much as anywhere else. 172 It is there on every reservation in the country, in the teeming ghettos of Brownsville, Detroit, and Compton, in the barrios and migrant fields and sharecropping farms of the Deep South. 173 It is there in the desolation of the Appalachian coal regions. It is there in the burgeoning prison industry of America, warehousing what is proportionally the largest incarcerated population on the planet. 174 The Third World is there in the nation's ever more proliferate and militarized police apparatus. And it is there in the piles of corpses of those not just AIM members, but Black Panthers, Brown Berets, Puerto Rican independentistas, labor organizers, civil rights workers, and many others who tried to say no and make it stick. 175 It is there in the fate of Malcolm X and Fred Hampton, Mark Clark and Che Payne, Geronimo G. Jagaprat and Alejandrina Torres, Susan Rosenberg and Martin Luther King, George Jackson and Ray Luke Levasseur, Rob Paxton and Reyes Tijerina, Mutualo Shakur and Marilyn Buck, and so many others. 176 To win, it is said, one must know one's enemy. Winning the sorts of struggles engaged in by the individuals and organizations just mentioned is unequivocally necessary if we are to effect a constructive change in the conditions they faced, and that we continue to face. In this, there are still many lessons to be drawn from the crucible of AIM experience. These must be learned by all of us. They must be learned well. And soon. Part 3. Culture Wars. One should not speak lightly of cultural genocide, as if it were a fanciful invention. The consequence in real life is far too grim to speak of cultural genocide as if it were a rhetorical device to beat the drums for human rights. The cultural mode of group extermination is genocide, a crime. Nor should cultural genocide be used in the game, which is more horrible, to kill and torture, or, remove the reason and will to live. Both are horrible. Robert Davis and Mark Zanis. The Genocide Machine in Canada, 1973. 8. Fantasies of the Master Race. The Cinematic Colonization of American Indians. Now those movie Indians wearing all those feathers can't come out as human beings. They're not expected to come out as human beings because I think the American people do not regard them as wholly human. We must remember that many American children believe that feathers grow out of Indian heads. Stefan Fricke. Motion picture director, 1964. The cinematic depiction of indigenous peoples in America is objectively racist at all levels. This observation encompasses not only the more than 2,000 Hollywood movies featuring or at least touching upon such subject matters over the years, but the even greater number of titles made for television. Point 1. In this film is linked closely to literature of both the fictional and ostensibly non-fictional varieties, upon which most scripts are based. It is thus both fair and accurate to observe that all modes of projecting images and attendant conceptualizations of native people to the mainstream public fit the same mold. Point 2. Moreover, it is readily observable that within the confines of this mold are included only the narrowest and most negative range of graphic/thematic possibilities. Point 3. While the same points might undoubtedly be made with respect to the celluloid portrayals accorded any/all primitive peoples, or even people of color per se, the vast weight, more than 4,500 productions in all, has fallen upon American Indians. Point 4. On balance, it seems no overstatement to suggest that throughout the 20th century mass audiences have been quite literally saturated with very specific and repetitive dramatic characterizations of Indians. It follows, as with anything pursued with such intensity, that these characterizations themselves have been carefully contrived to serve certain ends. Point 5. It would be well, then, to come to grips with the manner in which Indians have been displayed on both tube and silver screen, as well as the stimulus underlying it. And, since the former may be easily divided into several distinct but related categories of stereotyping, indeed, it virtually divides itself in this way, it seems appropriate to take each in turn, using the whole as a basis upon which to explore the question of motive. Indians as creatures of a particular time. Nothing, perhaps, is more emblematic of Hollywood's visual pageantry than scenes of Plains Indian warriors astride their galloping ponies, many of them trailing a flowing headdress in the wind, thundering into battle against the blue-coated troops of the United States. By now, more than 500 feature films and half again as many television productions have included representations of this sort. Point 6. We have been served such fare along with that of the teepee and the buffalo hunt, the attack upon the wagon train and the ambush of the stagecoach, until they have become so indelibly imprinted upon the American consciousness as to be synonymous with Indians as a whole. Point 7. It's not the technical inaccuracies in such representations that are most problematic, although these are usually many and often extreme. Rather, it is the fact that the period embodied in such depictions spans barely the 3 decades running from 1850 to 1880, the interval of warfare between the various Plains peoples and the ever-encroaching soldiers and settlers of the United States. Point 8. There is no before to the story, and there is no after. Cinematic Indians have no history before Euro-Americans come along to momentarily imbue them with it, and then, mysteriously, they seem to pass out of existence altogether. Point 9. So it has been since the earliest experimental flickers like Buck Dancer and serving rations to the Indians in 1898. Never, with the exception of the sublimely ridiculous Windwalker, has an effort been made to produce a movie centering on the life of native North Americans 1,000 years before Columbus, a time frame corresponding rather favorably to that portrayed in such Eurocentric epics as Robert Wise's 1955 Helen of Troy, or Cecil B. DeMille's extravagant remake of his 1924 The Ten Commandments in 1956. Nowhere will one find a Native American counterpart to Quo Vadis, The Robe, Ben-Hur, Spanacus, Cleopatra, or any of scores of less noteworthy releases set deep in what Euro-America takes to be its own heritage. Point 10. Much the same vacuum pertains to depictions of things Indian after conclusion of the so-called Indian Wars. Point 11. While a relative few films have been devoted to, or at least include, 20th century Native Americans, they have largely served to trivialize and degrade us through humor. These include such classics as Busby Berkeley's Whoopee, the Marx Brothers Go West and the W.C. Fields' Mae West Hit My Little Chickadee, as well as Abbott and Costello's Ride 'Em Cowboy. 12 Other heavy hitters include the Bowery Boys, Bowery Buckaroo, Bob Hope's Paleface, Son of Paleface and Cancel My Reservation, not to mention Lewis and Martin's Hollywood or Bust. 13. As Daniel Francis comments, Euro-Americans did not expect Indians to adapt to the modern world. Their only hope was to assimilate, to become white, to cease to be Indians. In this view, a modern Indian is a contradiction in terms. Whites could not imagine such a thing. Any Indian was by definition a traditional Indian, a relic of the past. 14. To find real or serious Indians, then, it was necessary to look back upon the vanishing species of the 19th century, a theme diligently pursued in early documentaries like Edward Sheriff Curtis' perversely titled In the Land of the Headhunters and Robert Flaherty's Nanook of the North, and subsequently picked up in commercial movies like The Vanishing American, Eskimo, The Last of the Red Man, Last of the Comanches, The Last Frontier, The Last Hunt, The Apache's Last Battle, and, most recently, the Academy Award-winning Dances with Wolves, The Last of the Mohicans, and Last of His Tribe. 15 All the while, untold thousands of doomed savages have been marched off to the oblivion of their reservations at the end of literally hundreds of lesser films. In its most virulent form, Hollywood's famous disappearing Indian trick was backdated onto the 19th century's crimsoned prairie itself, rendering native people invisible even there. One will look in vain for any sign of an indigenous presence, even as backdrop, in such noteworthy westerns as High Noon, Shane, Gunfight at the OK Corral, Warlock, Pat Garrett and Billy the Kid, Heaven's Gate, and Tombstone. It's as if, observes Cherokee artist/esthetician/cultural theorist Jimmy Durham, at some point late at night, by the campfire, presumably, the Lone Ranger ate Tonto. By the time Alan Ladd becomes the Lone Ranger in Shane, his Indian companion has been consumed. 16. In the alternative, when not being depicted as drunken buffoons, as in Flap, or simply as buffoons, as in the 1989 road movie Powwow Highway, modern Indians have been mostly portrayed in a manner deriving directly from the straitjacket of temporal stereotype. 17 The ways in which this has been accomplished are somewhat varied, ranging from 1950s war stories like Battle Cry and Never So Few to monster flicks like Predator and 1998's Deep Rising, and they have sometimes been relatively subtle. As in One Flew Over the Cuckoo's Nest, but the rule nonetheless applies. Creatures of a particular place. Constricting the window of Native America's celluloid existence to the mid-19th century, simply because it was then the locus of Indian/white warfare, has had the collateral effect of confining natives to the geographic region known generically as the West. In truth, the area is itself subdivided into several distinct bi-original locales, of which Hollywood selected two, the Plains and the Upper Sonoran Desert region of New Mexico and Arizona, as being representative. It follows that the bulk of Tinseltown's film stock would be expended in setting forth images of the peoples indigenous to its chosen domain. 18. The plains of filmdom are shown to be inhabited primarily by Sioux to the north, Cheyennes in the center, and Comanches to the south. Not infrequently, smaller peoples like the Arapahoes and Kiowas make appearances, and, every now and again, Pawnees and Crows as well. 19 Leaving aside a host of glaring inaccuracies otherwise conveyed by filmmakers about each of these cultures, it can be said that they at least managed to get the demographic distribution right. Not so the Southwest. Although the empty desert was/is filled with a host of peoples running the gamut from the Hopi, Zuni, and other Pueblones to the Pima, Maricopa, Cacopa, Yuma, Yaqui, and Navajo, anyone taking their ethnographic cues from the movies would be led rapidly to the conclusion that there was but one, the Apaches. 20 In fact, more films have been dedicated to supposedly depicting Apacheria than the domain of any other native people, the mighty Sioux included. 21. The roster began with silent movies like Apache Gold, The Curse of the Red Man, On the Warpath, and A Prisoner of the Apaches, was continued with talkies like Badlands and Stagecoach in the 1930s, and has most recently included Cherokee actor Wes Studi playing the title role in the third remake of Geronimo. Along the way, there have been Apache Trail and Apache Chief, Apache Warrior, and Apache Woman, Apache War Smoke and Apache Uprising, Apache Country and Apache Territory, Apache Rifles and Fury of the Apaches, The Battle at Apache Pass, Stand at Apache River, Rampage at Apache Wells, and 40 Guns to Apache Pass. On and on and on. The count at this point is nearly 600 titles and rising, plus an untold number of skits made for TV. 22. The reasoning here is true to form. The people of Victorio and Geronimo, Mangus, and Cochise, sustained their resistance to Euro-American invasion longer, and in a proportionately more effective fashion, than any group other than the Seminoles. 23 Give the duration and intensity of their martial interaction with whites, Apaches could be seen as consequential, and therefore worthy of an equal intensity of cinematic attention. There is a certain consistency to this prioritization, albeit a patently objectionable one. Things really become confusing, however, when one considers the approach taken by John Ford, perhaps the most esteemed director of the entire Western movie genre. Simultaneously fixated on the beadwork, buckskins, and feather heraldry of Plains Indians and the breathtaking desert geography of the Southwest's Monument Valley, both for what he described as aesthetic reasons, Ford exercised his artistic license by simply combining the two. Still, he and his publicists proudly, loudly, and persistently proclaimed his unparalleled achievement in capturing an ultimately authentic flavor in visually evoking the Old West. 24. Ford won Academy Award nominations for 2 of the 7 pictures he shot in Monument Valley between 1939 and 1964, all of which received substantial critical acclaim. 25 Meanwhile, in Stagecoach, The Searchers, and Cheyenne Autumn, 2 generations of American moviegoers were brought to understand that western Kansas looks just like northern Arizona, and, consequently, the environments of the Comanches and Cheyennes were indistinguishable from that of the Apaches. As Lakota scholar Vine Deloria, Jr., explains, it's the same as if Hollywood were claiming to have made the most realistic movie ever about the Cossacks, and it turned out to have been filmed in fishing villages along the Irish coast, or with the Matterhorn as a backdrop. It makes a difference, because culture and environment are pretty intimately connected. 26. The situation was even more muddled by the fact that before 1965, an era in which location shooting was beyond the budgets of all but the most prestigious directors, the very same Plains topography was represented in literally hundreds of B-movies and TV segments via the Span Movie Ranch and similar sets scattered across Southern California. 27 By the 70s, when increasing attention began to be paid to the idea that films might be validated by way of the technical accuracy inherent in their physical details, the damage had long since been done. American Indians, already denied any sort of genuinely autochthonous history in the movies, had been thoroughly divorced from material reality as well. Scene 1 Indian, Scene M all. The space/time compression imposed by Hollywood upon Native America has generated other effects, to be sure. You would think, writes Cherokee law professor Renard Strickland, if you relied on the Indian films, that there were no east of the Mississippi, none but the Plains Indians, except possibly the Mohawks, and that the country was unoccupied throughout the entire Great Lakes and Central region except for an occasional savage remnant, perhaps a stray Yaqui or 2 who wandered in from the southwest. We almost never have a Chippewa or a Winnebago or a Hopi or even a Navajo on the screen. 28. In the few instances filmmakers decided, for whatever reason, to make a movie about Native people in the East, the results have usually been bizarre. A prime example, pointed out by Strickland, is that of Seminole Uprising, in which we see Florida Everglades-dwelling Seminoles wearing Plains feathered bonnets and battling bluecoat cavalry on desert buttes. 29 The same principle pertains in somewhat less blatant form to the attire displayed in 4 other films: Distant Drums, Seminole, War Arrow, and Yellowneck, made about the Seminoles during the same period. 30. Nor is the displacement of Plains Indian attributes onto other peoples the end of it. The Plains cultures themselves have become distorted in the popular conception, often wildly so, by virtue of a succession of cinematographers' obsessions with conjuring up great images out of whatever strikes their fancy. Perhaps the best example will be found in A Man Called Horse, a movie prefaced with a scrolled testimonial from the Smithsonian Institution's chief ethno-historian, Wilcom Washburn, that it was the most authentic description of American Indian life ever filmed. 31. In actuality, borrowing its imagery willy-nilly from the full body of George Catlin's graphic survey of Northern Plains cultures during the 1830s, 32 director Elliot Silverstein's staff had decided that the Lakotas depicted in the film should wear an array of hairstyles ranging those typical of the Assiniboine to those of their mortal enemies, the Crows. Their teepee design and decoration is also of a sort unique to Crows. About the only thing genuinely Sioux about these supposed Sioux is the name, and even then there is absolutely no indication as to which Sioux they are supposed to be. Oglalas, Hunkpapas, Minnekangas, Sikangas, Bohinanpas, Ituzipkos, Sihasipas. The Lakotas, after all, were/are a populous people, divided into 7 distinct bands, at least as different from one another as Maine Yankees are from Georgia Crackers. 33. Probably the most repugnant instance of transference in A Man Called Horse occurs when Silverstein has his Sioux prepare to conduct a sun dance, their central spiritual ceremony, in a domed below-ground structure of the sort unknown to Lakota culture but habituated by Mandans along the Missouri River. The ritual itself is then performed in a manner more or less corresponding to Catlin's description of the Mandan, not the Lakota practice of it. 34. Finally, the meaning of the ceremony, sublimely reverential for both peoples, is explained as being something akin to medieval Europe's macho tests of courage, thence manhood, by the ability to unflinchingly absorb pain. Surveying the ubiquitousness of such cinematic travesties as Delawares dressed as Sioux and Indians of Manhattan Island, dwelling in teepees, even an establishmentarian like Alanson Skinner, curator of the Department of Anthropology at the American Museum of Natural History, prefigured Deloria. Condemning such things as ethnographically grotesque farces in the pages of the New York Times, he posed the obvious question: if Indians should stage a white man's play, and dress the characters in Romanian, Swiss, Turkish, English, Norwegian, and Russian costumes, and place the setting in Ireland, would there please that they thought all Europeans alike save them from arousing our ridicule? 35. Skinner might also have inquired as to the likely response had Indians portrayed High Mass as a Protestant communion, interpreted the wine and wafers as symbolic cannibalism, and then implied that the whole affair was synonymous with Satanism. It matters little, however, since until very recently no Indians with the momentary exception during the 1930s of Will Rogers, a Cherokee have ever been in a position to make either plays or films in which they could personify themselves more accurately, much less parody their white tormentors. 36. A major reason the Scene 1 Indian, Scene M all attitude had become quite firmly entrenched among the public by the end of the 50s was that the public was literally seeing no Indians of any sort in Hollywood's endless renderings of things native. Aside from Molly Spotted Elk, a Penobscot cast as the lead in Silent Enemy, and Rogers, who filled the same bill in several comedies during the 30s, no Indian appeared in a substantial film role prior to 1970.37. The same can be said with respect to directors and script writers. 38. Instead, pleading all along that it just couldn't find Indians capable of playing themselves on screen convincingly, Hollywood consistently hired whites to impersonate native people in a more believable manner. As a consequence, the history of American cinema is replete with such gems as the 6'4" blonde, blue-eyed former professional baseball pitcher Chuck Connors being cast as the swarthy, 5'3", obsidian-eyed title character in Geronimo. And, if this makes about as much sense as casting Wilt Chamberlain to play J. Edgar Hoover, as one native actor lately put it, there are plenty of equally egregious examples. 39. Take Victor Mature being cast as the great Lakota leader in Chief Crazy Horse. Or Gilbert Roland and Ricardo Montalban as the no less illustrious Dull Knife and Little Wolf in Cheyenne Autumn. Or Jeff Chandler cast as Cochise, an Apache of comparable stature, in Broken Arrow. Or Rock Hudson cast in the title role of Taza, son of Cochise. Or Burt Lancaster as the Sack and Fox superathlete in Jim Thorpe All-American .40, or J. Carol Naish as Sitting Bull. Or Tony Curtis cast as Pima war hero Ira Hayes in The Outsider. Or Robert Blake in the title role of Tell Them Willie Boy Is Here. Or how about Robbie Benson playing Lakota Olympic gold medalist Billy Mills in Running Brave? The list could obviously be extended to include thousands of such illustrations. 41. Women. Try Deborah Paget as Cochise's daughter in Broken Arrow. How about Mary Pickford as the little Indian maiden paid her debt of gratitude to the white man with sex in Iola's Promise? Or Dolores Del Rio in the title role of Ramona? Or Linda Darnell as the Indian female lead in Buffalo Bill? Or Jennifer Jones as the sultry half-breed in Duel in the Sun? May Wynn as a nameless Indian maiden in They Rode West? Donna Reed as Sacagawea in The Far Horizon? And then there's Julie Newmar, complete with a pair of designer slacks, as the indigenous sex symbol in McKenna's Gold. Again, the list might go on for pages. 42. We should perhaps be grateful that John Wayne was never selected to play Red Cloud, or Madonna Pocahontas, but given Hollywood's overall record, Wayne was cast as the Mongol leader Genghis Khan in a 1956 release entitled The Conqueror. Such things seem more a matter of oversight than of design. 43. Even when Indians were deployed on screen, usually as extras, a job Oneida actor/comedian Charlie Hill likens to serving as a prop, or, more accurately, a pop-up target to be shot full of holes by cowboys and cavalrymen. 44. Little concern was ever given to accuracy. John Ford, for instance, habitually hired Navajos to impersonate the peoples of the plains with no apparent qualms about the groups being as physically dissimilar as Swedes and Sicilians. 45. Cumulatively, Hill describes the results of Hollywood's and the television industry's imaging as the creation of a weird sort of Indian stew rather than anything resembling a valid apprehension of indigenous realities. 46. Peoples without culture. The emulsification of native cultural content embodied in Hollywood's handling of it amounted, in essence, to its negation. As Renard Strickland points out, in the thousands of individual films and the millions of frames in those films, we have few, if any, real Indians, who have individuality or humanity. We see little, if any, of home or village life, of the day-to-day world of Native Americans or their families. 47. Creation of this vacuum has, in turn, allowed filmmakers to figuratively reconstruct native culture in accordance with their own biases, preconceptions, or senses of expediency and convenience. Mostly, they elected to follow the quasi-official script traditionally advanced by the Smithsonian Institution, that Native North Americans were, until Euro-Americans came along to civilize us, typically brutish Stone Age savages, maybe a million primitives wandering nomadically about the landscape, perpetually hunting and gathering our way along the bare margins of subsistence, devoid of all that might be called true culture. 48. An astonishing example of such perceptions at play will be found in the 1954 film Apache, in which the sullen Southwesterners are taught to cultivate corn by a group of displaced Southeasterners, Cherokees, who supposedly picked up the art from their benevolent white neighbors in Georgia. 49. Never mind that it is an established fact that corn was hybridized from grass by indigenous Americans centuries before an Italian seaman, now revered as a great navigator, washed up on a Caribbean beach half a world away from where he thought he was. Never mind that, like corn, 2/3 of the vegetal foodstuffs now commonly consumed by humanity were undeniably under cultivation in the Americas and nowhere else at the time of the Columbian landfall. 50. Never mind that, as a matter of record, American military commanders from John Sullivan to Anthony Wayne, even Kit Carson, had to burn off miles of native croplands in order to starve Indians onto reservations where we could be taught to farm. 51. Agriculture is indicative of civilization, not savagery, and so, ipso facto, Indians could not have engaged in it, no matter how self-evident the fact that we did, or how extensively so. 52. In its stead, the Smithsonian, and therefore Hollywood, bestowed upon us an all-consuming and wholly imaginary warrior mystique, that is to say, a certain propensity to use force in stealing from others that which we had, in their telling, never learned to do or make for ourselves. Thus were the relational roles of Indian and white in American history quite neatly and completely reversed, so that those who stole a continent might be consistently portrayed as the victims of their victims' wanton and relentless aggression. 53. Such themes have always been exceedingly difficult to apply to the East, where it had taken Europe fully 2 centuries of armed conflict with masses of native people to win the day. How to explain that we who were supposedly so few had managed, generation after generation, to field so many in the course of our resistance? And how, once our real numbers were to some extent admitted, to explain either where we went, or how we'd been able to sustain ourselves for all those thousands of years before the coming of the white man supposedly endowed us with the miracle of growing our own food. 54. To be fair, Hollywood has tried to incorporate such matters into its master narrative, especially during its formative years. From 1908 to 1920, not less than 28 feature films and perhaps 101 real shorts purported to deal with Indian/white relations during the 16th, 17th, and 18th centuries. 55 Without substantially altering the structure of narrative itself, however, the task proved impossible, or nearly so, and thereafter the number of such pictures declined steadily, centering mainly in the above-mentioned Seminole movies and periodic remakes of James Fenimore Cooper's Leather Stocking. Fables. 56. Thus, by 1935 Movieland had locked in all but monolithically upon the final round of wars in the West as its interpretive vehicle. The choice carried obvious advantages in that it placed Indians entirely within a geography remote from, and thus alien to, the vast majority of non-Indians residing east of the Mississippi. From there, it seemed reasonable to expect that the people inhabiting the area might seem equally alien and remote. Also helpful was the fact that western lands do not appear suitable for farming, and that the events ostensibly depicted occurred at the very point when the native population, already reduced by some 90% and suffering severe dislocation from its traditional ways of life, was fighting most frantically to stave off being liquidated altogether. 57. Having attained such utter decontextualization, filmmakers were free to indulge themselves and their audiences almost exclusively in fantasies of Indians as warriors. Not just any warriors, mind you, but those of a most hideously bestial variety. This is exemplified in John Ford's Stagecoach, where the director uses techniques common to monster movies of the era, and which would later be employed to great effect in the sci-fi flicks of the 50s, in building among his viewers a tremendous sense of dread long before any Indian is allowed to appear. Then, late in the movie, when the Apaches finally materialize, they are portrayed in an entirely dimensionless and inhuman fashion. 58. Some directors went Ford one better, hiring actors known mostly for their portrayals of actual cinematic monsters to play native people. Bela Lugosi, for instance, who would later gain fame as the vampire in Dracula, was cast as Uncas in a 1922 German-made version of Last of the Mohicans, which was received quite well in the U.S. 59 Cecil B. DeMille selected Boris Karloff, already famous as the creature in Frankenstein, to play an Indian in his 1947 movie Unconquered. 60 Wolfman Lon Chaney was also cast repeatedly in such roles, most notably in The Pathfinder and the Mohican, Along the Mohawk Trail, and The Long Rifle, a ghastly trilogy pasted together from episodes of the Hawkeye and the Last of the Mohicans TV series. 61. In other instances Robert Mulligan's The Stalking Moon comes to mind. Things are put even more straightforwardly. Here, a fictional Apache named Salvahe is withheld from view for most of the movie as he tracks a terrified Gregory Peck and Eva Marie Saint across 2 states. Towards the end of the film Salvahe is finally revealed, but always from a distance and garbed in a strange and very un-Apachean set of caveman furs, conveying the distinct impression that he is actually a dangerous form of animal life. 62. Hundreds of movies and television segments follow more or less the same formula. Those that don't revolve around the notion of individual Indians being caught up in the full-time job of menacing unoffending whites most often have us far too busy attacking the same victims in swarms, howling like wolves, slaughtering and mutilating the innocent or carrying them away as captives upon whom we can work our animalistic wills at leisure. 63 And believe it or not, those, for Hollywood, are our good points. The downside is that, even as warriors, we are in the end abysmally incompetent. Witness how gratuitously we expend ourselves while riding our ponies around and around the circled wagons of our foes. Watch as we squander our strength in pointless frontal assaults upon the enemy's most strongly fortified positions. 64 Worst of all, observe that we don't even know how to use our weapons properly, a matter brought forth most clearly in A Man Called Horse, when scriptwriter Jack DeWitt and director Silverstein team up to have an Englishman, played by Richard Harris, teaching his Sioux captors how best to employ their bows and arrows when repelling an attack by other Indians. 65. Small wonder, given our continuous bombardment with such malignant trash, that by the 1950s, probably earlier, American Indian children had often become as prone as anyone else to root for the cavalry in its cinematic extermination of their ancestors. 66 After all, asked a native student in one of my recent film classes, who wants to identify with such a bunch of losers? Yes, who indeed? The only good Indian. The only good Indians I ever saw, General Phil Sheridan famously observed in 1869, were dead. 67 Filmmakers, for their part, brought such sentiments to life on the screen with a vengeance, beginning at least as early as D.W. Griffith's The Battle of Elderbush Gulch in 1913. 68 By the mid-30s, native people were being symbolically eradicated in the movies at a truly astounding rate, often with 5 or 6 of us falling every time a single bullet was fired by gallant white men equipped with what were apparently 50-shot 6-shooters. 69 The celluloid bloodbath by no means abated until a general decline of public interest in westerns during the mid to late 1960s. 70 So fixated was Hollywood upon images of large-scale Indian killing by the military during the late 19th century that it transplanted them to some extent into Western Canada, where nothing of the sort occurred. Apparently preoccupied with the possibility that the redcoats of the Northwest Mounted Police might look better on screen than U.S. Army blue, directors simply shifted the Mounties into the role traditionally filled by the cavalry and cranked away. 71 The first such epic, The Flaming Forest, appeared in 1926 and has the NWMP putting down the first Métis rebellion 5 years before the Mounties actually appeared on the scene. In 1940, DeMille made a picture entitled Northwest Mounted Police, about the Second Métis Rebellion. 3 features Fort Vengeance, Saskatchewan, and the Canadians were then produced on the theme of Mounties battling Sitting Bull's Lakota refugees during their brief Canadian sojourn in the late 1870s. 72 In the style of the shoot-'em-up Western, Indians in the Mountie movies attacked wagon trains, burned settlers' cabins and roasted captives at the stake, all things that never took place in the Canadian West. The Canadian frontier had its problems, the illicit trade in alcohol, the disappearance of the buffalo, the spread of disease. But these were not the problems moviegoers saw. Rather, the Mountie movie provided another opportunity for the Hollywood dream machine to act out its melodramatic fantasies about the American Wild West. 73 Meanwhile, another sort of good Indian was being cultivated. Based archetypally on Fenimore Cooper's Chingachgook and / or Daniel Defoe's Friday in Robinson Crusoe, the character is exemplified by Tonto. The word literally means fool, dunce, or dolt in Spanish. Faithful Indian companion of the Lone Ranger radio program's masked white hero from 1933 onward. 74 By 1938, the formula had proven so popular that it was serialized by movie makers as Saturday Matinee Fare. The serial was condensed into a 1940 feature entitled Hi-Ho Silver before mutating into a long-running ABC TV series in 1948. 75 Back in theater venues with The Lone Ranger in 1956 and The Lone Ranger and the City of Gold in 1958, The Masked Man and Tonto did not make their final big screen appearance until a 1979 remake of the 1956 film. 76 As Cherokee analyst